Wouldn't it be weird if for once I was early? Okay, it's just a minute. But as Fozzie says, every minute counts. I'm early. Hi, guys. Here we go. Oh, sugar, I forgot one thing. Someone said check my Cash App. We might have more minutes. But it usually tells me when I get something, right? Nothing. Okay. I checked. I did what I was told. Maybe they meant Venmo. I don't want to mess up. I don't even know. Nope. And then what else did we give them? We gave them PayPal. No. So we are up to like 8 hours, 9 hours. I'll figure it out as I'm going. And we have plenty of time. Nope. We have plenty of time to figure it all out because we're going to be here for a long, long time. We are going to take a break, not a break in the stream. We are going to take a break of court cases, a tiny break when you look at the whole stream, an hour long, because I want to show you guys something so cool. Oh my gosh. But for now, we're going to start with, we watched this judge, Stansbury, and he does the small little traffic tickets and things like that. We see the cutest little old ladies get in front of him and the cutest little old men get in front of him because, you know, they trespassed or something, you know, real stupid. We love him. He did a trial. And it wasn't a bad trial either. I got a whole trial with Stansbury. Yes, I do. That's not the good part, guys. The good part you're going to see in approximately 5 hours. In 5 hours, oh my gosh. Now, I'm trying to decide. I have a couple options here. There's not enough minutes to show everything. There's not enough minutes to finish the, oh my God, you guys are going to love this one. So, I might give Bill some. And you have to see the end on Bill's channel. We'll see. I don't know. I might just keep going. I'm probably just going to keep going. But can everybody please listen? Because I know you're going to ask me. There is no OJ today. Okay? There is no OJ today. Freaking don't ask me for OJ. If you want to watch OJ, I leave the link in the description to what I'm showing. Go watch it. And when Judge Fleischer's streams comes on, please go to Judge Fleischer's stream. This is recorded. You can come back whenever you want. You don't have to stay here for 8-9 hours. Anthony, shut up. Get the trash out. Go take the trash out.
I think people are still wondering if OJ is going to jail or not.
Yes.
Okay, no.
Yes. Unsub.
Yeah.
I'm making my kids take the trash out at 4:30 in the morning.
Yes.
Parenting 101. All right. We're going to start. We're going to start because we're never going to get through these hours if we don't start. We've already used up 4 minutes. Judge Stansbury. Oh, and don't worry. Jury selection gone. I didn't play it. I have it, but I didn't play it.
All right. Her spouse works for ATF, so we would like to not have her address stated on the record.
Which one?
It'll be the second witness.
Well, just
Ms.
what's the
Mesner.
name? So when they call Ms. Mesner, just don't ask her address. Just do the name, spell, house seat. Mr. Cal, anything else?
No, Your Honor.
Mr. Calceric, anything on behalf of the defendant before we get underway?
Separation of witnesses.
Any objection?
No, Your Honor.
Does the state have the choice to designate a state's witness?
Yes.
No.
No objection to this separation. That'll be granted. Any objection to designating the deputy as the state's witness?
Is it really my stream if it's not muted? I mean, is it really my stream if the mute button doesn't bite me right in the tush?
And when? What basis?
I don't like it.
Okay, overruled.
Okay, calm down, calm down. Anybody who heard that? The judge said, is there any reason we can't blah, blah, blah? And the lawyer said, yes, there's a reason. And the lawyer says to the judge, because I don't like you. They are best friends. These two, the lawyer and the judge, they've been best friends since wee little boys. So there's only one person watching this trial, and it's me. So it's not strict. He's not strict with this one lawyer because it's just me watching this trial. He doesn't know all of us are going to watch it.
Anything further, Mr. Calceric? Anything further?
No, sir.
Do counsel intend to use the podium to examine the witnesses, or are you going to?
No.
You like it? You do use
I
it?
do use
Yeah,
it.
that's
I
fine.
can't tell you I'll use it every time, but I do use it.
Okay, well, we'll position it accordingly. Let's bring in the jury.
All rise for the jury.
It sure is.
All right, please be seated. The record should reflect that the jury is now back in the courtroom. Welcome back, ladies and gentlemen, and I should say all 9 jurors have returned to the courtroom. Well, what I'm now going to say is intended to serve as an introduction to the entire trial of the case. Now, it's not a substitute for the detailed instructions on the law that I'll give to you at the end of the case before you begin your deliberations. Those later instructions will be given to you both orally and in writing, so it's not necessary to try to
I cut
memorize
them
what I'm
out.
saying. Now, during the trial and beginning with these preliminary instructions, you're going to hear me use a few terms which you may not have heard before, so let me briefly explain some of the most common to you. This is a criminal case. It's been commenced by the state of Ohio, which I may refer to sometimes as the prosecution or the state, against Ryan W. Johnston, who I will refer to from time to time as the defendant. You'll hear me refer to counsel quite a bit. Counsel is just a fancy way of saying lawyers or attorneys. I'll sometimes refer to myself as the court. The prosecution and the defendant are the parties. They're called the parties to this case. The case itself was initiated by the filing of a complaint. Please understand that the complaint is simply a charge by the prosecution to begin a case, and it's not in any sense evidence of the allegations or the statements that it contains. The defendant has pleaded not guilty to the charge. In a criminal case, the prosecution has the burden of...
It's okay. Okay. Are you ready for this one, guys? You're going to love this part.
any information...
His screen went off. Like his whole stream shut down. He was offline. I want this trial. I wanted this trial so bad. I wanted to see him do a trial. So what do when his stream goes down? I call them. At this point, I am calling Ohio. I am calling the court coordinator, and I am saying, yo, Judge Stansbury's stream just went down. His live feed just went down. Hurry up. You got to put it back on. I did. I swear. And they put it back on. We didn't miss much.
From any source outside the confines of this courtroom. Until you retire to deliberate, you must not discuss the case with anyone at all, even with your fellow jurors. After you begin your deliberations, you may begin discussing the case with other jurors, but you cannot discuss the case with anyone else until you've returned a verdict and the case is concluded. I certainly hope that for all of you, this case is interesting and noteworthy. I know that many, if not every single one of you, uses a cell phone or a smartphone, gets on the internet, and uses other tools of technology. But you must not talk to anyone about the case or use these tools to communicate electronically with anyone about the case or to disseminate information about our proceedings. This does include your family and your friends. You may not communicate with anyone about the case on your cell phone or through email or text messaging or on Twitter, through any blog or website, through any internet chat room, or by way of any other social networking websites, including but certainly not limited to Facebook, Snapchat, Instagram, TikTok, Pinterest, LinkedIn, YouTube, etc., etc. After the verdict is announced in open court and you're discharged, you may speak freely about the case and your experience as a juror, but until such time, you're specifically instructed to follow the directions as I've given them to you today. At this time, counsel for the parties may have an opening statement. Opening statements of counsel are concise and orderly descriptions of each side's claims and defenses and the evidence that counsel expects to produce in support of those claims and defenses. Opening statements are not evidence. Each side will address you once in this matter, and the state will proceed first. Ms. Yeager.
May we approach, Your Honor?
All right, Ms. Yeager, you may proceed with your opening statement.
Yeager, Mike.
Right. Hello again, and either congratulations or condolences, depending on how you feel about sitting up here, but
Okay, real quick, so you guys are prepared. We are in a tiny little town in Ohio. I don't know what the population is. I don't know, but it's not a lot. She's not some swanky New York lawyer. She's not. She's a small town prosecutor. So listen, lower the bar to small town, okay?
at least congratulations on the nice chairs. You're going to be much more comfortable than when you were out here. So again, thank you for taking the time to serve on our jury pool. We can dive into the details of this case. Mr. Ryan Johnston, he's charged with 1 count of domestic violence. In Ohio, that basically means he assaulted a family member. Specifically in this case, the evidence is going to show that on or about November 17th, 2024, in the township of Granville in Licking County, Ohio, that Ryan Johnston knowingly caused or attempted to cause harm, physical harm specifically, to his wife, Julie Johnston. Now, if you recall earlier, I asked about, did anybody have to see, like stitches, broken bone, blood, guts, whatever, in this case? The reason why I asked that is because you'll be given a definition of what physical harm means. And that is the definition you will follow. And the judge will give you.
I'm not saying it's okay. I'm just saying it's barely. It's a barely injury. Okay. She didn't get injured. I'm not saying that doesn't mean it's okay or anything. I'm just saying you are fine. You're not going to hear gory details, and she's okay. Really, it's just his personality that's more injurious.
You it verbally, and he will give it to you in writing. It means any injury, illness, or physiological impairment, regardless of its gravity or duration. Okay, so I want you to keep that in mind. Now, the state has several potential witnesses, but we're going to rely upon Ms. Johnston's testimony probably most significantly. And so what's she going to tell you? Well, she's going to tell you that, on that date, November 17th, 2024, she was living in a house in the township of Granville in Licking County, Ohio, that she and the defendant were together for about 33 years, married for 26. They have children together. And then as any married couple, they work as a team to run their household. But every team member has some of their shared responsibilities that they both do, and then some have something that might be exclusively done by one person. And Ms. Johnston will tell you that she mostly handled the couple's finances because the defendant really wasn't interested in that. Plus, she had her own business. So she had all the business finances to tend to as well. Now, despite all of these years together, unfortunately, they had become unhappy, and they had been discussing terminating their marriage. And so much so, she's going to tell you that they actually got to the point where she had earmarked money in the bank account for that process, specifically for a dissolution, which is basically terminating a marriage where the couple agrees to distributions of assets, debts, responsibilities and parenting rights and responsibilities. So they work together again as a team to create.
Me and Kelly just worked as a team, but I am not arguing with her. I didn't know she was putting that down. I put the population of the entire county. She put the population of Greenville, which is 6,251.
A plan going forward. So she takes money out, sets it aside. So, okay, that expense is provided for. Here we go. So when we get that ball rolling officially, get the paperwork going, we have this ready. And then she's going to say that he found the bank statement or bank receipt for those funds and confronted her about it. What are you doing with the money? He's accusing her of hiding money. His voice escalates. He's shouting at her, shouting about the money.
I think I hide money from myself because I can't find it.
What are you doing with the money? Now, her cell phone is on the table, right there when they're engaging in this altercation. She gets a message on her phone, so she looks down, looks at her phone, and she tells you, she's going to tell you that at that point, he grabs the phone, and he's a lot taller than she is. I mean, everybody in the world's probably taller than me, but he's a lot taller than she is, so you'll be able to see that reference. So he's holding her phone, and she's reaching up to get it back. Give me my phone, give me my phone. Remember, she has her own business, so her cell phone's very important for personal and professional reasons. So they're arguing about, give me the phone, and he's arguing back, no, I'm going to look at it. She's going to tell you he drops the phone. They both try to get to it, but he gets to it first. He's quicker than she is. He snatches it up, and he's refusing to give it back to her, despite her begging him to please give me back my phone. And he's still yelling at her about the money. What are you doing with the money? And he's yelling at her about how he's going to go through her phone. And he's looking at people in her phone and asks her about who some people are. Who's Patty? Who's Patty? Is that your attorney? She's going to tell you, she continues to beg, stop, give me my phone, stop it. And during all this time, while she's trying to get her phone, that he will not give back to her, he adamantly refuses. He hits her in the chest with the heel, like the palm of his hand. She tells him to stop hitting her. She again tries to reach for her phone. And to stop her from being able to get her phone, he grabs her arm, twists it, and pushes her to the ground. On her way down, she hits her hand, like the corner of like a chest or a table. That's right there, some piece of furniture. He still has her phone. He still won't give her the phone. So she tells him, I'm going to call the police. Well, how's she going to do that? He has her phone. So she runs to the neighbor's house. Neighbors are home. They hear her knocking. They let her in. Call 911 for the police to respond. She'll tell you while she's waiting at the neighbor's house, the defendant leaves. Now you're going to hear.
I was going to show you Fozzie like 2 or 3 days after you said that a while ago. I saw him walk into the courtroom with no cane or anything. He seemed to be fine. Maybe he just hurt himself.
From Ms. Mesner, the neighbor, and she's going to tell you about what she saw and heard. Now, she's going to tell you she wasn't in the house when this happened, but she's going to tell you what she observed on Miss Johnston. She's going to tell you how she appeared when she came over to the house. She's going to tell you the injuries she herself observed on Miss Johnston. You're also going to hear from Deputy Nicely, which is a wonderful name, by the way, Nicely. And she's going to testify about how the Sheriff's Department sent officers to respond to this call about the domestic violence call, and that she took statements from Mrs. Johnston and from the neighbors, and that she also observed injuries on Miss Johnston. She'll tell you what those were. And then she's going to say that based on the Sheriff's Office investigation, we submitted the police report, witness statements, all this information to my office to review for criminal charges. By the way, if you aren't familiar with how we do it in Lincoln County Municipal Court, that's how criminal charges arise here. The law enforcement submit them to the prosecutor's office, we review, and we, the state, file any complaints for criminal charges. Now, Deputy Nicely will also tell you the efforts that they went through to find and apprehend the defendant, because remember, he left. He does come back, goes to leave again. The police tracked him through if you are familiar with flock camera systems, the government cameras where they can see who's driven down the street. So she'll describe how that works and how they went through to find out where he was and to arrest him for his conduct. And that he was not willing to talk to them about what happened. He didn't want to talk to them. Now, you heard Robert Kalisaric mention, the Fifth Amendment and all that. Yes, he has the right to remain silent, but just so that you have all the facts before you, law enforcement did give him an opportunity to share his side. Now, something else that might be presented today, I don't know, maybe I'll use it, Rob might use it, we both probably will, is a recording that the defendant himself made of this incident. Unbeknownst.
Just in case you missed that, the defendant is the man. And he made this recording and provided it to prove his innocence. Yes, he did.
To Mrs. Johnston. So you'll be able to, at least, it's just an audio recording. So you'll be able to hear, kind of play-by-play part of this incident to help you in your deliberations and help you reach a decision today. And I believe that after hearing all the evidence presented, I am confident that you will return a guilty verdict to the charge of domestic violence. Thank you.
Ms. Yeager? Well, sir?
Thank you, Your Honor. Ryan Wesley Johnston and Julie Johnston been married for over 26 years. They have property together. They've got children together. They've got a marital residence together. All their resources and finances are commingled. I mean, they've been married 26 years with everything going into similar accounts. Now, around January 2024, Julie and Wes actually separate. Wes moves out to give them some space to work on some stuff, and Julie maintains the marital residence. The parties live apart about a year before this incident. Now, Wes maintains his keys and everything else, and he comes back to the house and goes in and gets what he needs because he doesn't take all his stuff with him. Now, there had been talk of doing a dissolution and maybe working something out, but the details had not been worked out, and it had not been communicated to Wes what was happening. And his belief was that there was no attorneys involved at that point, and they were just going to try to split everything up. Then on November 17th, 2025, Wes discovered Julie wrote a check to herself, not to an attorney, to herself for cash, for $3,000. Now, $3,000 might be a lot to some people, might be nothing to some people, but it was significant in this case. And this is a large sum of money to come out of their account. Wes wanted to know why she removed the money and where it went, because it was such a big chunk of savings. Wes calls Julie, doesn't get an answer as it relates to what was done with the money. He needed some stuff, so he drove over there and to get some things, and he figured he'd confront Julie about, where the heck this money is. Walks into the house. She must have just been on the phone or something because her phone was sitting there and it was unlocked and open. He picks it up. Before this happened, though, Wes is becoming concerned with possible false allegations and things that he's getting hinky feelings about. So he starts recording when he's going to be around here. It's an audio recording. And he does that to protect himself. So he observes the phone sitting unlocked, begins to go through it. She asks for it back. She begins freaking out, like someone way overreacting, and you'll hear it. She asks for it back. He says no, and he's holding it. No. Now she grabs multiple times. She begins to hit Wes and slap him, and you'll actually hear this on the audio. At some point, he's trying to push her back because she's coming at him. She's not going at her, she's coming at him. At some point, he actually runs around the table, actually, or is it an island, to get away from her. But she was the aggressor, and you can clearly hear that on the audio tape recording. Now, at the end of this, you'll hear she just leaves. She just leaves. Wes looks around and finds out his daughter's there. Didn't even know his daughter was there, but his teenage daughter's there. But yet, Julie left. So, you won't like Wes holding the phone. It seems a little childish. But people are having problems, and you know how when you argue, you're not necessarily your best. But it does not excuse or allow Julie to assault Wes to get it back, especially when it's just marital property anyway. It's not like he took it and kept it. Looking through her phone doesn't give the person a right to attack you. It wasn't a great day for Julie, and it wasn't a great day for Wes. But Wes is still befuddled why he's here instead of over in domestic relations court. The government cannot prove, by proof beyond a reasonable doubt, that Wes assaulted Julie. It's just that simple. The only thing we need from you is to keep an open mind until the end of the case, until you hear all the evidence. And once you hear all the evidence, you'll definitely be filing a not guilty verdict. Thank you.
Thank you, Mr. Counsel. Ms. Kyle, will you go ahead and reposition the podium, please? And your first witness, Ms. Yeager.
The state would call Julie Johnston.
Just be mindful of the cord. Ms. Johnston, please come forward, be sworn.
Do you solemnly swear or do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury? Please have a seat. For the record, give your name and spell your last name.
My name is Julie Johnston. Last name is Johnston.
Your address also. Go ahead and give your address.
It's 237 Klaus Lane, Granville, Ohio 43023.
Thanks.
You may inquire, Mrs. Johnson, if you can, try to keep your voice up because we are recording everything and we want to make sure the jurors can hear you. You may proceed.
Thank you. Mrs. Johnston, I'm going to ask you some questions, and I'm actually going to do it from here just because I think this is easier. Plus, if I'm handing you things, it'll be easier than over there. But after I'm done asking you questions, then Mr. Calisaric here to my right, he will. If at any time you don't understand what we're asking, if we're talking too fast, your brain kind of shuts down for a second, things happen. Just say so we can adjust accordingly, okay?
Okay.
So
What if your brain shuts down for like 5 minutes? Is that okay?
this may sound like a dumb question, but how do you know Mr. Ryan Johnston?
He is my husband.
How long have you been together?
We've been together for 33 years,
And how long have you been married?
26 years.
That's a lot of time. Do you have any children?
We have 3 children. Our son is 23 and he's out of the house, but we also have 2 girls that are 14 and 12 and they live at home.
So 2 teenage girls at home.
Yes,
Does Mr. Johnson have a nickname or something that he goes by besides Ryan?
he does. He goes by Wes.
And that's a middle name?
Yes,
Now, do you see Wes in the courtroom today?
yes, he's here.
Can you please describe what he is wearing to the court, please?
Blue and white pinstripe shirt and khaki pants.
Your Honor, let the record reflect the witness has identified the defendant.
Any objection, Mr. Calisaric?
Nope.
Record will so reflect.
Ms. Johnson, what do you do for a living?
I own an interior design business.
How long have you been doing that?
I've owned the business since 2004, but I've done it since college.
Oh, wow. So how did you do during COVID?
COVID actually was really good because people, once we started a project, we were confined to their house, and so it was okay. We were like the safe people coming in and out. So actually did well during COVID.
So what is the name of your business?
It's called Colors Interior Design.
Colors Interior Design. Oh. So do you have separate bank accounts for that business
I do.
from your personal accounts, your marital accounts?
I do. I started the business account in 2023.
And so who's in charge of like balancing the books, so to speak, for your business accounts?
I do the accounting.
And then what about like your personal or marital bank accounts?
I've always been in charge of the finances.
So I want to draw your attention to November 17th of 2024. The address you gave, is that in the township of Granville in Licking County, Ohio?
Yes, it is.
Okay. Now, who all lived with you at that time?
Both my daughters.
And were you and your husband separated at that point? Like not living separately?
No, we were not separated. There were nights that he slept somewhere else.
So he didn't stay, he wasn't at home all the time?
No, he was not. He came and went as he wanted.
Would you say he spent more days at home or more days away?
More days away.
More days away, okay. So moving up to that day, was there an altercation between you and the defendant?
Yes,
And did that occur at your house?
it did.
And who all was there when this happened?
It was myself and our 12-year-old Lucy.
Lucy? Okay, so let's start with, let's lead up to that. Let's start with what were you doing that day? Let's walk the jury through a little bit of your day leading up to this altercation.
Okay, so that was a Sunday. It was a day off. We didn't have any activities, and I had chosen to finish up a project at the house. He was not there. I was painting the living room ceiling, doing a second coat of paint on it. So I got up that day and just kind of put on work clothes to start working on that.
Hold up. Because you said your name is pronounced Tona? Tana? Tana. Not Tanya? Or Tonya? Help me. Somebody help me. Spell it in English. Spell it out. Oh, Tona. Hi, Tona. Don't get it wrong, guys.
And he showed up mid-morning, so no one knew that he was going to be there. So the girls kind of, when he was there, would hide out in their room. So they were mostly upstairs, and I was working in the living room. And the day had been passing, and he just was kind of hanging around outside, working in the yard, which was sort of unusual because he hadn't been coming and going, and he hadn't been helping around the house. So him being there and working in the yard was off. It was different than normal. And my 14-year-old had asked me to take her to a friend's house, just lives across the street, really neighborhood across the street. So I had taken her over there, and I came back, and he came in the house and he said, "Oh, I thought you were getting in the shower." And I said, "No, I'm still working on the ceiling." And I thought that was weird that he even brought that up. So I went back to working on the living room, and then I did go and hop in the shower at some point. And when I got out of the shower, I thought, wow, it's really odd. He took the trash out from my office. He doesn't normally take the trash out.
Do you normally do the cleaning of your office area?
Yeah, that was really odd. And I thought, well, he was working outside, so I guess he decided to do a few things in the house. And then I thought, I should check my computer. And when I checked the computer, he had deleted a whole bunch of files from my computer.
You're going to forget this later. Just so you know, you're going to forget this later. But he deleted a whole bunch of files from the computer as well.
And so he's still hanging around outside. I realized that he had done that. And then he left the house. And I don't know exactly what time it was, but it's getting close to dinner time. So it might have been like 5 or 6 that he left. And I thought, he doesn't ever, when he comes and goes like that, he just goes. He doesn't come in and say, "I'm leaving, I'm going here or there." He just leaves. And so I was like, I guess he's gone for the day. And then he sent me a text message with a picture of a receipt. And I was like, I throw those receipts in my office trash.
What kind of receipt was it?
It was a bank deposit slip.
That's the only one I
And
see.
so immediately I knew he took out the trash because he was going through the trash. And we also have recycling in the garage. So it goes from my office to the garage. He'd also gone through the recycling in the garage. So it was part of what he was doing there. And so he wanted to know what that receipt was.
Did you tell him?
So he had texted me and told me at one point that I was not allowed to hire a lawyer. If I hired a lawyer, he would withdraw his paycheck from our bank account. I would receive no income to help with anything.
I believe that.
So when he said, well, what was this money withdrawn for? I was so worried that he was going to get angry because he had already threatened to take his money from the family. And so at first I said, well, I pulled it out for work. And he said, no, you didn't, Julie. What'd you pull it out for? So I said, fine. I pulled it out for attorney fees because we're talking about dissolution and there will be attorney fees. And he called me. Now, he was speaking to me on the phone now. And he said, I don't believe you. That's not what the money's for. I said, it is what the money's for. And then we hung up.
You mentioned he threatened to withdraw his paycheck from the bank. What does he do for a living?
He works in excavating, so for a construction type company.
She a liar? Her fault.
Okay, so after he sent you the text or the receipt, he calls you. What happens after that?
I was in my office and I was recovering all the files that he had deleted. I figured out how to do that. So I was restoring all those to the computer. And I got up from my desk and he had pulled in and he was coming in the back door and he came in very quickly and he started demanding that I answer his questions. And then he grabbed my cell phone. And at that point, when he grabbed my cell phone, I do start saying, give me back my cell phone, give me my cell phone. And I kept reaching out my hand, give me my cell phone. And he's like, you know, like you do with a child where you're trying to keep something from them. That's what he was doing.
Okay, I'm going to interrupt just to clarify that. How tall are you?
I'm 5'6".
5'6"? And how tall is he?
He is 6'3".
And when you say he's holding this like a child, do you mean he's holding the phone? Is it over his head? Like this?
Yeah, like here. Like if I'm on this side of his body and saying, give me that phone, he's like this.
So keeping as far from you as he can reach?
Yeah.
Okay.
You can.
Yeah.
Thank you.
So this might be silly, but I played basketball, he played basketball. So it's almost like if you're holding a basketball and you reach in for it, you reach in to tip the ball up like this. That's how you play. And that's the way it was. I was trying to get my phone. And he went into the bedroom as if he was going to get something. He did rip, and when he did that, he did rip the wires out of the wall for the internet at that point, which I discovered later that we had no internet in the house because he had pulled those wires out. But he had the phone in his hands. He was lodged between our dresser and our bed, which isn't a lot of room. He was standing there and I was closer to the door, so he kind of was like at a dead end. And I did reach in, I did tip the phone, and it did fall to the floor. And where it fell, it was close, I couldn't get to it. It was like in the corner, and he was able to reach down and get it. So there's some commotion where he's trying to get to the phone. He gets it. I was unable to get it. And then we go from there to our living room.
So I'm going to stop you there. So he's holding the phone, you're trying to get the phone, you tap it, the phone falls, and he manages to get the phone back. Is that all correct? Did I get that right?
Yeah.
Okay.
Almost like, I'm going to say again, like basketball. When you're boxing somebody out, that's kind of what he did to me. He boxed me out and he was able to get the phone.
Okay.
Yeah.
Now, at any time during that portion of this interaction where you're trying to get your phone back, did you slap the defendant?
No.
Did you strike him or scratch your husband in any way?
No, it was really the palm up, like saying, like you do to a child, like, give me the phone, give me the phone.
I don't believe her.
So you said, so that was,
She's
and then
lying.
so please continue. You went into, was it the kitchen?
So
or
then
the
we
dining?
go into our living room / dining room, the same room, and we get into that room, and he's standing on one side of the dining table, and I'm on the opposite side. So he has my phone, and he's looking at it, and when he's looking at it, he's reading a message, one of the text messages. His text message is open. So he's reading like the first text message that's on the phone. And he says, "Who is Patty Holden? Is this your lawyer?" I didn't have a lawyer.
Who is Patty Holden?
I thought he would come to that conclusion on his own as he read the text message, because he was reading the text message. Patty Holden was my 14-year-old daughter's boyfriend's mother. The text message says, when my son comes over to your house, I just want to make sure they're not in the basement or some room with the lights off. I gave him enough time to look at the phone and read it, and I thought he would come to that conclusion on his own of, this is not a lawyer. A lawyer would not be texting these words to my wife. But he didn't. And I thought, there's something wrong that he can't read that and understand what that message is. So then he comes around the table, and I believe I would start saying then, like, just give me back my phone, give me my phone. And he then grabbed my arm because of the, like, giving my phone. He grabs my arm and he twists it. And it was this arm. And my elbow and my arm, they were hurt. And when I looked up at him, when he was twisting my arm like that, I looked up at him in his eyes, and they were so dark. It was like, he's not really in there. He's not there.
Objection. Come on. Lawyers, come on, let's go. We need to get this trial done right.
And I felt like what he was thinking in his mind right then when he looked at me was, I can break your arm right now.
You can't say what he's thinking. You know he's not thinking that. He's not. There's nothing in his mind right now.
And then he released me and he threw me to the ground. And when I hit the ground, I also hit the chest that we have right by the back door. And that's how I injured my hand. And I forgot to say this. Can I say something I forgot to say? Sure. When I was asking
say whatever you want. Doesn't matter.
In the dining room area, he was using the palm of his hand, whatever you call the heel of his hand, to hit me in the chest when I would ask for that multiple times. And I said, stop hitting me, Wes, stop hitting me. I forgot to tell you guys that. So that was before the arm. Before he grabbed
It was the chest first, then the arm?
Mm-hmm.
Okay. If you need a break at any time, please just say so, okay?
Yeah.
Okay. Are you all right?
Yeah.
Okay.
So when he threw me to the ground, I hurt my hand on the chest, on that wooden chest, and it was immediately cut up and bruised, and I was laying there on the ground, and I was right by the back door, and that's where we leave our shoes. And I thought, this is too much. This can't keep happening. This is escalating way too far, and I can't keep doing this. My shoes were right there, so I put my shoes on. And when he threw me to the ground, he just walked away. He was on the other side of the room.
Did he still have your phone?
He was scrolling, and I put the shoes on, and I said, I'm going to call the police. And he just kept scrolling, and I just went out the front door, and I was in tears when I went out the front door, and I thought, what am I going to do? Whose house am I going to go to? Of course, I'm thinking like, oh, it's late. I feel like I'm going to be bothering them. I have two neighbors that I knew I could go to right across the street, which was Betty, Joe, and Ernie. They're older. What is she going to do? He's got Alzheimer's. And the other neighbor, he's a police officer, and his wife is a friend of mine, and I went to their house. I had no phone to be able to call and get help, so I went to their house to call the police.
Okay.
I absolutely believe every single thing she just said there, because he brought an audio tape of the whole thing. He submitted that as proof that he's a good guy. Do I believe her? Because I heard it.
So were you aware at the time that he was recording?
No,
Did you found out later?
he told my daughter.
Told your daughter? Okay. Have you heard that recording?
I've not heard it.
But would you recognize your voice?
Yeah.
Would you recognize it even if it wasn't just how you're talking right now? Like if you were crying or if your speech was altered because of an emotion?
I believe I would.
Okay. And would you recognize your husband's voice as well?
Yes.
Or at this time the state would play what is marked as Plaintiff's Exhibit 1. single CD.
Is that the only recording on the DVD?
Yes.
No, you can't say that yet. You gotta listen to what he says first. It's what he says that makes this so good.
I don't know if the video or if the audio will play without the video feed.
It should play, but it won't turn on the TV because the TV doesn't have an audio that goes.
I know, it's weird.
You gonna talk to me?
Whose voices did we just hear?
Mine and Wes's.
Wes, your husband?
Yes.
Are you gonna talk to me? Give me my phone! No, sorry, it's my phone. No, it's not! It's my phone. Stop! Right now! Stop! Stop hitting me! Stop it! Stop it! You stop it! Get off my phone! No! I'm gonna take this thing and I looked at everything. What? No, I didn't. Yes, you did. I haven't yet. But, okay, listen. Listen, are you gonna talk to me?
So this part so far, this altercation, was this in the living room, dining room, bedroom?
This would be the office.
In the office? Okay. And at one point, oh no, so, and this is just, again, the only two people present at this point are you and the defendant?
Right. My daughter, who's home, is upstairs in the shower.
Okay.
Are you gonna talk to me? Get off my phone! Let's see here. Thanks for remembering this too hard, but yes, just have the what is this? Everything I do is embarrassing. Oh, okay. Alright. Okay. Listen. Stop. Stop. Right now. Oh, stop.
What happened right there?
I honestly don't remember.
Stop it. You gonna talk to me? Are you gonna talk to me? Are you gonna talk to me about this? No? We're gonna talk about this. Yes, we are. Listen, what did you do with the money? Stop me like that! Stop trying to touch me! What did you do with the money? What are you doing 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 with the money? You ain't phone! Jules, so help me God, I will take this and I'll find every little thing and I will let everybody know. What? I'll let everybody know. Stop! Stop! What did other people do? Stop! I don't know, my husband's a very bad man! You need my phone? He's probably hurting. You don't need it now! Oh, okay, so let me just send this thread over to me. Okay, let's see here. Twice. Sounds good to me. It's embarrassing. I told him.
I mean, maybe. There's no video, so she says no, he says yes. Maybe. It could be, Michael, and this is what I choose to believe, because I'm delusional, that she is trying to smack the phone out of his hand. And that's what we hear. That's what I'm choosing to believe. Period.
This is your attorney. Questions. Is this your attorney? All right, what are your thoughts about kids? My family looked at Hayden's been what? Sorry? Let's see here. What else we got? Let's just look up, see who you have been texting. Patty Horton Barker. Hey, shoot. You're the one that kept coming. Yeah, you kept coming. Nope.
Not
There. Nope. Let's do that. You're a bad man. Yes, I am. Yes, I am. Yes, I am. Yes, I am. You're gonna call the police right now. I'm not gonna call the police. You can't. No, you're not. This is allowed. No. Don't do it.
So at this point, is that when you left to go to the neighbor's house?
The reason it sounds like that, he started recording her before he went in the house. He pressed record and he was wearing a hoodie, not a zip-up hoodie, a pullover, and he shoved the phone in the pouch of his hoodie. So it's like moving around in there while he's, getting assaulted.
Yes. Okay. And I'm sorry, you might have said it, but whose house did you go to again?
I went to Carrie and Shane Mesner's house.
Mesner's, okay. As a result of this altercation with your husband, did you sustain any injuries?
I did.
What kind of injuries?
The visible injuries that night were my hand. That was the one that was visible. My arm and my elbow, I wasn't able to use it for a few days. I was able to extend it. And then my chest, where he had hit me in the chest, those bruises did not show up that night, but they did. I have progression pictures where they do show up so that you can see that there was an injury there. And there's some redness on my arm where he had grabbed me that night.
Your Honor, may I approach the witness?
You may.
She looks like she's about to get a lot happier.
I'm just going to show you quite a few things. I'm just going to stand up here for you.
The bullets
This is
coming.
Plaintiff's Exhibit 2. Okay.
Yes.
What are we looking at here in this photo?
These are, my neighbor took some photos when I went to her house, and this is just showing redness on my arm, and it was the arm that he had grabbed and twisted.
And when you say your neighbor took it, is that Carrie Mesner?
It is.
And what date was that photo taken?
On the 17th.
Evidence,
That's
you mean like
that night.
pictures of injuries? That kind of evidence?
Injury to your hand?
Yes.
You mean like an audio tape where she's saying, "Don't hit me," and she does not know she's being recorded?
Tell us what's pertinent about that photo?
Oh, she
It's
does.
Plaintiff's 3?
So this is a progression picture of my hand that was hurt when I was thrown to the ground. Significance of it, it shows that knuckle that had been hurt and how it's progressing, the wound.
Is it bleeding in the photo, scabbed over?
Scabbed over and bruised.
Okay. And who took that photo?
This one, I took this photo
And when did you take that?
on 11/20, 3 days later.
3 days later. And I'm showing you it was marked as 4A, 4B, 4C, and 4D. Let's start with photograph, the first one, 4A. Well, I guess for all 4 of these photographs, who took the photographs?
I took these
You took
photographs.
those photographs?
Yes.
So what is significant about 4A?
For you really can't see the bruising in it, but that is where the pain was. So I knew that's where the injury was. So I took a picture in case the bruising were to show up.
Okay, and what date was that?
This is the day after, so 11/18.
And then if you want to flip to 4B, what are we looking at there?
The same spot highlighted. It's getting just a little bit bruised. The bruising is coming to the skin.
And what day was that?
The 19th.
And then 4C?
or C, you can see the bruising is becoming more evident, and there's
Lori, is she lying? She got hit. There was no bruising that day. So she's like, this is where it hurts. I'm going to take a picture here. Next day, she takes a picture. It's getting a little red. Next day, bruise. Lori, is she lying?
2 spots that are showing up.
And what day was that?
The 20th.
So 3 days later?
Yeah.
Okay. And then finally to 4D?
4 days later, there's two injuries.
4 days later, so 11/21?
Yes.
Okay. And the bruising area that you said was highlighted, what's different about the fourth picture from the first one, between 4A and 4D?
You actually see the darkness of the wound where you can't see it on the first one.
And when did the police respond?
Yes, they did.
Did they take photographs as well?
Yeah, it was the sheriff, and they did.
And I'm going to show you what's 5A, 5B, 5C. Are these flip through those quickly, and then let me know, are those the photographs that were taken by the Lincoln County Sheriff's Office?
We were at my house then, so yes, that's when he took the pictures. I was there.
No. You want to know why? Her dog never stepped on a bee.
Filling out my statement, and that's when he took those pictures, yes.
Okay, so starting with the first one, 5A, what does that photo depict?
The 5A is the arm that he grabbed and twisted, so it's showing a little bit of the redness that you could see that night.
And then 5B?
5B shows my knuckle where I had been injured when I hit the chest.
Okay. And then the final one, 5C?
Same thing. I think it's a different angle. So instead of like the right side, it's the left side.
Show the class, please.
Okay, got the same hand, same injury?
Same hand, yeah.
Thank you. All the photographs that you've reviewed there, those true and accurate depictions of your injuries that you sustained that night and through the progression over the next few days?
Yes, they are.
Cut, bruise, cut, and cut.
So
When she fell, she hit some
while all
furniture.
of this altercation was going on between you and her husband, how'd that make you feel?
I was very scared.
You were scared?
I was scared. I was scared because these actions of his had been becoming more intense, and this was probably the worst one ever.
So when you went to the Mesner's residence, they contacted the police?
They did.
They did, okay.
Yeah, Shane was the one who called.
Okay. When the police responded, did you speak with them and provide a written statement?
Yes.
Okay.
Yo, those nuns did way worse to me than he did to her. They did.
Did you ever find your cell phone?
Yes. So when I went to Shane and Carrie's house, they kept checking out the window, and Wes left almost immediately after I got over there. And we texted my youngest from the house and said, Lucy, Mom's next door. Why don't you come next door right now? And if you see Mom's phone laying around, can you bring it too? That's when I got my phone back.
And when the police did arrive, was the defendant still gone?
Yes.
Did he ever come back?
He did come back.
Okay. What happened when he came back?
So after the sheriff, when they were getting ready to leave, I asked if I could change the code on the back door, which is a keypad to get in. I said, am I allowed to change that? And they said, yes, that would be fine, because they said we are out looking for him. We have all the cameras on to see if we can find him. Right now we've seen him. He's on 79 and Heath. So when they said it was okay to change the keypad, I changed the keypad right away.
Women stalkers are way more stalkery than men stalkers. They take it to the extreme.
And then my friend and business partner, she came to the house right away. And when she got there, she was sort of like brainstorming, like, what if he comes back and they don't catch him? And I thought, oh, come on, they have cameras. They're going to catch him. They said they would catch him. And so we got in an extension cord and we wrapped it like a 8 shape over the fridge doors in the back because he's strong enough. He could have just pushed those in if he wanted. So
This, I literally have a scar right here from those cats. Those cats hurt me. I could sue them. I could sue each one of them.
we did the extension cord, and then we put a chair up against the door, and then I shut all the blinds and turned off the lights. And we were discussing some of the things that had happened, and I said, earlier today he took my debit card and he went and bought gas.
Hold on a minute. We have an objection. Basis.
A lot of rambling here that's not relevant.
Ms. Yeager, your response.
Yeah, well, it's showing how, you know what, I'll just move on. I'll move on. It's fine.
Jury will disregard the witness's last statement. You may continue.
So you were discussing with this friend things that had happened and things that you were going to do for your safety. At what point did the defendant come back?
I'm trying to say it so that I don't get wrap that around, but I was on the phone calling the sheriff to tell them that I believed he was at a bar because he had just made a transaction on my business card and I knew where he was.
Okay.
So I wanted to call and say he's at this bar. And while I was on dialing the number to call, not the 911 number, just the regular call-in number to the sheriff's
line?
Right. I heard the keypad on the back door beeping, and I said, he's here. I know he's here. And so I hung up that number, and I did call 911. That's what I was instructed to do by the police before they left. If you were to come back, call 911 if you heard anything. So I called 911.
Did the police come back out?
They did.
Okay. And when you, did he end up making entry into the house?
He did not.
He did not, okay. Nothing further on record this time.
All right, Mr. Calasseri.
Because she called the police. Well, the neighbors called the police the first time after she ran to their house. And then he left. So the police came out, took pictures of her injuries, and left. And he wasn't there. So they were trying to find him. So he charged something on her business card so she knew where he was. So she called the sheriff and said to try to tell him this is where he is. While she was trying to call the sheriff, he was trying to get in the house. And she changed the numbers on the keypad so that he couldn't, get into the keypad. And so when he was trying to get in, she heard the beeping, then she called 911, and then the police came out. And he was still there trying to get in.
Examination.
Thank you, Your Honor. You've been married 26 years, something like that?
Yes.
3 children,
Yes.
and the youngest, Lucy, 12, was at home.
That's right.
Okay. And this home, how long have you guys had that?
I think 7 years.
Okay. Bought it during the course of the marriage, right?
Correct.
Okay. And you obviously care and love for your children, right?
Yes.
And would protect them, right?
Correct.
Now, Wes works in construction.
Yes.
You stated earlier that Wes came and went, but you didn't really consider it separated.
I meant our marriage wasn't
Legally separated.
right legally.
Okay. Because there is a
separated.
legal process to do a legal separation.
Right. He just was choosing not to be at our home.
Okay. And that had been going on for about a year?
Yeah.
Fine. And you, because of everything that's obviously going on, I mean, it's a huge red flag and stuff, obviously. You guys started talking about dissolving the marriage, right?
Yeah. He texted me that he wanted to dissolve the marriage.
Okay. And for the jury to understand, dissolution is basically where you guys come to an agreement on everything, right?
That's correct.
Sometimes you use lawyers, sometimes you don't, right? For dissolutions.
You have to have someone to sign off on the official paperwork, so I believe 100% that there's some sort of counsel you use.
Okay. And then on November 17th, 2024, Wes wants to know where this $3,000 is, right?
Yeah, but it wasn't $3,000. But if you want to round up by a few hundred, you can. It was $2,700.
$2,700?
Mm-hmm.
Okay. Well, that's what I'll refer to if I make a mistake and say 3,000. So he asked you about that, and you're telling us that you told him what it was for.
Correct.
Not soon thereafter, he shows up at the house.
Right.
Okay. Comes in the residence. I mean, he has come and gone, right? That's nothing unusual, right?
Except for the way he came in the residence was quite different.
Did he come in the front door, or did he come in the back door, or?
We only used the back door, so he came in the back door.
Okay. You don't remember walking in and picking up your phone? Seeing your phone?
He walked in, he started demanding I answer his question, and then he grabbed my phone.
Okay. And you weren't holding your phone, right?
I believe I had gotten a text message, which I had looked at. The phone was unlocked, and I sat it down, and then he grabbed it because it was unlocked.
Okay.
And he kept it unlocked.
I understand that. I'm trying to break this down a little bit, though. So, you weren't holding your phone when you grabbed it, right?
No.
Okay. And you had just been on it, so it was unlocked?
Correct.
Okay. And then he grabs the phone and begins going through the phone, seeing conversations, correct?
I didn't know what he was going to look at, but he was saying he was looking at the text messages.
Okay. All right. And when you set that phone down, you set it down on the kitchen counter?
Well, I was in the office, so it was on my desk.
Okay, where's the office from the kitchen?
Right next door.
Okay. Now, and you're obviously getting upset that he's going through your phone. He won't give you your phone, right?
Mm-hmm.
I mean, you can hear it, right? You have to answer out loud, I'm sorry.
Yes.
Okay. And you tried multiple times to grab for your phone and get it back from Wes, correct?
Correct.
Okay. And you get frustrated to the point to where you start hitting and slapping him?
No. Where I start reaching for my phone.
Okay.
You remember when I said he deleted
Ma'am,
the files?
you have to wait for a question to be asked.
Okay.
You never told Wes on November 17th during this conversation when he's asking about what the money's for. You never tell him. It's for the lawyer, stupid. Do you?
You don't call him stupid, no.
Okay, well, I'm being exaggerated. Okay, it's you never.
For the attorney fees is what I said. I didn't say lawyers. I believe I said attorney fees.
Okay. Based upon this case and your discussion with the officers, you decided to file for a civil protection order, right?
Correct.
All right, and you filed for divorce, correct?
After that,
I know. After that, you filed for divorce. That's different than a dissolution, right?
correct.
Okay. Now, I'm going to ask you a couple questions about this audio tape.
Yes, sir. Yes, sir. Yes, sir. The defendant's attorney is about to play the audio tape to try to make points for his side. Yes, sir.
Stop. You're gonna talk to me? You're gonna talk to me? Are you gonna talk to me?
Give me my phone.
No, sorry, it's my phone. No, it's not. It's my phone.
This is my phone. This is my phone.
Stop.
So it sounds like, according to the audio tape, he picks up the phone, your phone, before you guys really even entertain any conversation. Would that be fair?
Yeah, he's saying it's his phone.
I know.
But it's my phone.
He has the phone first, right? Before he says it's my phone, he says.
He had the marital phone that certainly doesn't belong to you, woman, because it's marital property first, right?
My phone. Before you guys start arguing, right?
Right now, stop. Stop hitting me. Stop it. Stop it. You stop it. Get off my phone. My phone. Stop. Right now. Stop. Stop hitting me.
No, it said, what are you doing? Didn't you hear that?
Did you hear the slap?
No, put it again.
Talk to me. Give me my phone. No, sorry, it's my phone. No, it's not. It's my phone. Stop. Right now. Stop. Stop hitting me. Stop it. Stop it. You stop it. Get off my phone. No. I'm gonna take this thing. And I looked at everything. What? No, I didn't. Yes, you did. I haven't yet.
Did you hear that? Okay, she's about to say something. I heard a stop and a start. And so I believe her when she says this. I'm going to rewind it. You tell me if this just flows naturally.
Stop it. Get off my phone. No. I'm gonna take this thing. And I looked at everything. What? No, I didn't. Yes, you did. I haven't yet. Okay, listen. Listen, are you going to talk to me? Are you going to talk to me? Get off my phone. Let's see here. What's wrong, man? This is so hard, but yes, kiss my butt. What is this? Everything I do is embarrassing. Okay.
Sounds like you guys are moving. Are you moving from one location to another location in the house a little bit?
So,
Is that
I'm
yes or no?
confused in this message, though.
Audio tape?
Yeah, is some of it cut off?
Yes, it is.
Did you delete some of it?
Yes, he did.
You
I did.
certain?
So, going back to my question, I can't even remember now.
Oh, I almost got caught manipulating evidence. Now I can't remember my question.
Let's see here. What's wrong, man? This is so hard, but yes, kiss my butt. What is this? Everything I do is embarrassing. Okay. All right. Okay. Stop.
As we're listening to this tape, it sounds like there's a lot of movement, is what I was asking you earlier. And it sounds like you're moving from room to room or around an island or a table. Or, am I asking the question right? Are you not grasping what I'm asking?
I am. I'm visualizing.
Okay, so you're just
That's-
trying to...
So we were moving around the table, and he's on the opposite side of the table, and there's a pause because I'm letting him read that message from the boyfriend's mother so he can understand that that's not a lawyer, that's a boyfriend's mother.
So there's a pause.
What he's trying to get to the jury, which he's not. She's the aggressor. She's chasing him.
So you pause, letting him read the message. So you stop chasing him to let him read that message.
He's on that side of the table, and I'm on this side. And I thought if he just reads the message, he's going to know it's not an attorney, it's not a lawyer. I've not talked to an attorney or a lawyer. This is just someone's mother.
But the pause
Is to allow his brain time to read the message and come to the conclusion on his own that this is not Julie reaching out to an attorney. This is someone's mom.
Right. But before you came to that conclusion that there needs to be a pause, you were chasing him, trying to get your phone back, right?
I was following him, not chasing. Chasing to me is like
I
I'm
just don't want the
running
jury to
down the
believe
hall.
that he's
going
chasing
from room
you.
to room, taking my phone, and it's my phone. I believe I should have it back.
So, okay, thank you.
Stop. Right now. Oh, stop it. Stop it. You gonna talk to me? Are you gonna talk to me? Are you gonna talk to me about this? No, we're gonna talk about this. Yes, we are. What did you do with the money?
We're going to talk about this. No. Yes, we are.
Stop trying to touch me. What did you do with the money? What are you doing with the money? What are you doing with the money?
What are you doing with the money? What are you doing with the money? What are you doing with the money?
Okay, that's a slap. I'm still going with he's trying to get the phone out of his hand, but that sounds like a slap.
Now, it would be fair to say you don't say what you're doing with the money during this conversation, correct?
Say that again? It's fair to
You don't say what you keep saying that you told him what you did with the money.
I did. It's in a text message. You could read it.
But in this conversation, this situation, you don't tell him what you're doing with the money, do you?
I feel like he deleted that from the beginning of the recording.
Okay, answer my question.
When he came in the door, I told him what it was for. I told him over the phone.
Just so help me God, I will take this and I'll find every little thing and I will let everybody know.
What?
I will let everybody know. Stop.
I didn't let people know. I don't know, my husband's a very bad man. You need my phone?
Who's Patty Holden?
You don't need to know.
Oh, okay. So let me just send this thread over to me. Okay, let's see here. Twice. Sounds good to me. Embarrassing.
That part pisses me off a lot too. He doesn't know the name of the parents of his daughter's boyfriend? Come on, Dad, do better. That guy is dating your little girl. You should know their social security numbers.
So let's return. I was just asking questions. Is this your attorney? All right, what are your thoughts about kids? My family, I looked in Hayden's been, what? Sorry? Let's see here. What else we got? Let's just look up, see who you have been texting. Patty Holden Barker. Hey, shoot, you're the one that kept coming. No, you kept coming. Nope, not there. Nope. Not doing that. Right. You're a bad man. Yes, I am. Yes, I am. No. Yes, I am. No. Yes, I am. You're gonna call the police. I'm not gonna call the police. You're getting it. No, you're not. This is how. No. Don't do it.
I don't know what he said there, but I think he said, you're not going to call the police. This is mine.
And you left the residence at that point, right?
Yes.
While he was sending threads, he said, oh, what's this? I'm going to send this thread to me. What? Who?
Okay. Now the photographs, can I see those?
I believe there's you may.
Just so you know, attorney, thank you for playing that for us again, because I missed a few things the first time.
Five A, B, and C, those were taken that night, correct?
Yeah, by the neighbor, yes.
Okay. You're sitting at the kitchen table. It looks like you go.
Oh, I'm sorry. Those were the sheriff. You're correct.
Okay. All right. And then the pictures taken. Well, this one. Is
That's
that
the neighbor. Yeah.
And that's the 17th. Now, who put the dates and stuff on there?
I put the dates on there so
Put the
you
dates.
knew.
And then the neighbor or you took the pictures? All of the different, did the neighbor take the pictures every day or did you take them?
I took them.
Okay.
Actually my daughter helped, but yes.
Okay, your daughter helped. You took these ones on the 18th then?
Yes.
And then that one's on the 20th. Oh, you got some 20th on here too. Does that make sense? So like this, you took those.
I was advised to.
And you didn't have to seek any medical treatment or anything?
No.
Okay. You were asked by the police whether or not you thought Wes was intoxicated or impaired or anything. You said no. Correct?
I don't recall.
Don't recall. Okay. You weren't. Your daughter was still in
No.
the house.
No. JK, that's what I thought too. No, I thought he was listening to what he was saying and he felt like, oh gosh, I'm so embarrassed that I did that. No, that's not why he has his head in his hands.
After you left, correct?
That is correct.
Okay. And then the police ended up showing up and you did tell them your story at that time, right?
Yes.
Okay. You say you started a business in 2004, but you didn't open a separate checking account for it until 2023?
Correct.
So between 04 and 23, was it just not very busy?
It wasn't very busy because I was a full-time mom.
Okay, so it was
However-
more of a part-time thing at that time?
At that time it was, and if you're just a sole proprietor, you can do it under your social security number, and I didn't need a different account for the business. When I brought on a partner, that's when I established the business account.
I'm sorry, ma'am, but no, everything you do wraps around him. So obviously you starting a business account with a partner is because of something you're doing to him.
No further question at this time.
Redirect examination, Ms. Yeager?
Yes, Your Honor.
He doesn't.
Ms. Johnston, I just have a couple of questions to follow up and clarify a few things, okay?
Yeah.
You said Patty Holden is the mother of your daughter's boyfriend,
Right.
right? Okay. How long, as of November, were they boyfriend and girlfriend?
They probably dated 2 months.
2 months?
When she's asking for her phone back, that part?
Now, during this altercation with your husband, you said you were trying to grab for the phone. When you were reaching for the phone, did your hand ever make contact with his body?
It may have touched his arm. Yeah, I mean, when I reached
Just
out.
as you're reaching, okay. Were you trying to slap him?
I wasn't trying to slap him. No, I was trying to reach and grab my phone, take my phone back.
Okay. And Mr. Calisaric asked you if you went and got a civil protection order after this. Why did you get a protection order?
I was very scared. I was scared for my life. I was barricading the doors. The girls were scared.
Meaning your daughters?
My daughters were scared, and for them and for me, I wanted protection against him. His rage was too much.
And that was ultimately became what's called just a restraining order that's
Yes.
enforceable in that court, correct?
Correct.
But did it still have some of the same provisions about restrictions on contact?
It did.
Yeah, okay. Is that still in
A
effect?
14-year-old daughter was there in the shower.
It's a 2-year-long restraining.
years, okay.
Yeah.
They didn't sound like little smacks.
Since that's
Like
been in
these
effect,
smacks.
has the defendant violated it?
He did.
Your Honor. Objection.
Ms. Yeager?
Okay, he opened the door asking about her protection under the divorce.
I'm going to sustain the objection, and the jury will disregard the witness's last statement. You may continue with your redirect examination.
Is your The divorce proceedings, are those still pending?
They're very slow. They're in process.
They're in process? And so that would have happened sometime between November 17th and today?
Yes.
Okay, so it's just been a couple of months. And then lastly, when you told him, just because I got confused, when you told him the $2,700 was for dissolution, was that when he called you, or was that a text message that you told him what it was for?
He texted me, he said, "What is it for?" And then he picked up the phone and he called me. So it was over the phone that I told him
No,
what
we
it was
don't.
for.
Thank you. Nothing further. Your Honor.
Any recross?
You stated when he dropped the phone, he kind of blocked you out like basketball. He used a lot of basketball analogies.
Objection, Your Honor. This is beyond the scope of redirect.
Mr. Calceric, response?
It goes to the questions or answers on some of his, on the contacts she had with Wesley.
I'll overrule it for now.
When you played basketball, it could be a rough sport in itself at times, right?
True.
I assume you got some bruises sometimes?
Yeah.
No further questions.
All right, Ms. Johnston, you may step down. Thank you very much. You can go ahead and return to the witness room. Your next witness?
Your Honor, actually, maybe we have like 5 minutes.
Well, why don't you come on up?
I thought I fast forwarded this. I really thought I did. I'm just going to go ahead 30 seconds.
All right.
And now the father comes. Now we get to hear the father. Hi, Debbie. I know, Licking County.
24 CRB 1550. The defendant is present in the courtroom with counsel. Ms. Yeager is here on behalf of the state. The jury is not in the courtroom, but we're coming back from recess. Ms. Yeager, you ready to get
They
going?
ignore everything
Mr.
she
Calceric?
said. They never
All right,
address
please bring
it.
in the jury.
All rise for the jury.
Please be seated. And the record should reflect that the jury is now back in the courtroom. And ladies and gentlemen, as an aside, I wanted to point out, we stand when you leave and enter the courtroom, not to honor the court or the parties. We do that to honor you and the very vital part that you play in this process. So thank you. Your next witness, Ms. Yeager.
Thank you. The state will call Carrie Mesner.
Very well. Go ahead and step up onto the witness stand if you would, please, and then turn and face the bailiff.
Do you solemnly swear to you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, and nothing but the truth? Yes. Please have a seat. For the record, give your name and spell your last name.
My name is Carrie Mesner, last name Messner. Thank you.
You may inquire.
Thank you. Mrs. Mesner, have you ever testified in a court before?
Never.
Okay. Well, congratulations on your first time here with us.
Thanks.
I will ask you some questions first, and this gentleman here, Mr. Rob Calceric, he will have the opportunity to ask you any questions should he feel the need. If at any time you don't understand what either one of us say, if we talk too fast, trail off into nothingness, just let us know so we can adjust accordingly, okay? So, Ms. Mesner, what do you do for a living?
I own a fitness studio in Granville.
Oh, which fitness studio?
It's called Village Core Fitness.
And how long have you had that?
Almost 11 years.
Oh, wow. Right. Now, please don't look at me. I need to go to the gym. And does your husband work there with you, or?
No.
And what is your husband's name?
Shane.
Shane? Okay. And I'm just going to draw your attention back to November 17th of last year. At that time, were you and Shane living in the township of Granville in Licking County, Ohio?
Yes.
Okay. And do you know someone named Ryan Johnston?
I do.
And is he in the courtroom today?
Yes.
And can you please point out where he is seated and describe what he is wearing to the court, please?
He's wearing a blue and white striped shirt.
Thank you. Your Honor, let the record reflect the witness identified
You said you didn't care if it was fake.
by the defendant.
Any objection? No, sir. Record so reflect.
And you also know a Julie Johnston?
I do.
So how long do you live near Mr. and Mrs. Johnston?
That
We
is
live
a
right
great
next door.
question. It sounds like Johnston versus Johnston. No. This would be the state. State v. Johnston, Licking, Ohio. If that helps. I don't know the case number.
And how long have you all lived in the same neighborhood?
We moved in April of 2017.
And how well do you know your neighbors, the Johnstons?
Very well. My daughter is very good friends with their girls, and obviously being neighbors right next door, a lot of family carpools and passing by and things like that. So, yeah, know them very well.
Do you guys, you, not just your children, but the adults, do you guys end up spending a lot of time together?
In the yard, per se, yeah, mostly.
So that evening on November 17th, the evening hours, where were you?
My husband and I were in our kitchen.
Okay. And what were you doing in your kitchen?
We were making dinner.
So while you were there making dinner, did Mrs. Johnston come over unannounced?
Yes.
When she came over, can you describe like her demeanor? How was she acting?
Yeah, absolutely. So she rang our Ring camera, and we saw the video of her immediately on the camera, and immediately ran to the door to get her. And she was very shooken up, crying, and very having a hard time to breathe. And we knew something was wrong, and we immediately grabbed her and pulled her into the house to get her to talk to us.
And you said you rushed to the door. Could you see her? See this distress on the camera?
We could. Yeah.
So when you pulled her inside, did you ask her why she was so upset?
Yes.
And did she tell you what happened with your husband that day?
She did.
Okay. And did you or your husband call 911?
My husband.
And did you see any injuries on Mrs. Johnston?
We did. She was holding her arms, and she visibly had red marks on her arms, and her hands were shaking, and there was visible marks on the top of her hand.
Okay. And when you say visible marks on her arm and on her hand, do you mean one arm and one hand?
I didn't really notice on one hand. I noticed on one of the arms and one of the hands.
Okay. Just wanted to make sure.
Yeah.
Your Honor, may I approach the witness?
Yes, you may.
I'm going to show you. This one is marked as Plaintiff's Exhibit 2. Do you recognize this photo?
Yep, that's in my kitchen.
It's in your kitchen. All right. So was this on the day that this happened?
Yes.
And who took this photograph?
Actually, I did.
You did? Okay. Do you see the injuries that you noticed in those photos? Okay. And would you say that's a fair and accurate depiction of the injury to her arm? And I'm also showing you what's marked as Plaintiff's Exhibit 5. There's A, B, and C, but I'm going to have you focus on 5B and 5C. Now, what do you see in 5B and 5C?
The top of her left hand, with visible marks.
Okay. Now, is that the injury that you saw when she came to your house on November 17th?
Yes.
I almost retired.
And I know I asked you on the first one. Would you say that's a fair and accurate depiction of the injury?
Yeah.
Okay. To her hand. And so when your husband called 911, did you hear his call with the 911 operator?
I did.
Okay. And did the police respond to the address?
Yes.
Did you speak with the police?
We did.
Okay. And did you also provide a written statement to law enforcement?
Yes.
Thank you. Nothing further from Mrs. Mesner at this time.
All right, cross-examination, Mr. Kalsaric.
Did Julie happen to tell you that she'd been chasing her husband slapping him throughout the house.
Objection calls for hearsay.
I'll sustain the objection. Court will disregard the witness's last statement.
No questions.
All right. Well, then technically you didn't ask a question since your objection was sustained. So, Ms. Mesner, you may step down. Your next witness?
The state will call Deputy Ashley Nicely.
Deputy, please come forward and be sworn.
I know it's you.
You solemnly swear or do you affirm that the testimony you give is the truth, the whole truth, and nothing but the truth, and nothing but the perjury? Please have a seat, Deputy. For the record, give your name and spell your last name.
I'm Deputy Ashley Nicely. Nicely is K-N-I-C-E-L-Y.
Thank you. And the address of your employer.
Is 125 East Main Street.
You may inquire.
Deputy Nicely, sometimes it's hard to hear, so please be sure to speak up. You're currently employed with the Licking County Sheriff's Office?
Yes, ma'am.
Okay. And what are your general duties as a sheriff's deputy?
Respond to calls and uphold the law.
Thank you. And as a deputy, have you received all the
Does she
training
know?
that is required by the Licking County Department?
Yes, ma'am.
Does she really?
And does that include things like training that includes classroom and practical exercises?
Yes, ma'am.
Did you also have to shadow and work with other deputies?
Yes, I've had training.
Okay. And then as of November 17th, 2024, actually even as of now, are you current on all required education, training, and certifications for
Yes,
your
ma'am.
position? And were you working on November 17th of 2024?
Yes, ma'am.
What shift or hours were you working?
I was working second shift, which is 4 p.m. to midnight.
And were you wearing a uniform of the day, much like you are in court?
Yes, ma'am.
Although probably long sleeves since it was November?
Yeah. I believe it was long sleeves that time.
Were you driving a marked cruiser with a working visible light bar?
Yes.
So at about 7:15ish, a little after that, in the evening on November 17th, were you dispatched to a call for service to a residence in Granville Township in Licking County, Ohio?
Yes.
What was the nature of that call for service?
It came in as a physical domestic violence call.
It's a small town. So the judge and the defense lawyer are best friends. And, you know, the prosecutor and the defense lawyer work together every day. And the police officer they work with all the time. So they all know each other. They're all like friends.
And did you and other deputies respond to that location?
Yes.
And when you arrived, did you speak to the victim in this case, Mrs. Johnston?
Yes.
Did she provide a written statement?
Yes.
When you spoke with her, what was her demeanor when you met her?
She was visibly upset, shaking, been crying, just overall worked up.
Did you also speak with the witnesses, Carrie and Shane Mesner?
Yes, ma'am.
And collect statements from them as well?
Yes, ma'am.
And when you were speaking with them, were they all together?
Yes.
Okay. Did deputies later speak with Miss Johnston alone in her house?
Yes.
And did you notice any physical injuries to Mrs. Johnston?
Yes, I noticed on her left upper arm some pink redness and a cut on the back of her left hand that had been bleeding. I believe at that time it had stopped.
Excuse me. Thank you. And did the sheriff's office take photos of the injuries?
Yes, ma'am.
May I approach her?
Yes, you may.
We are 1 hour and 45, 2 hours and 45, maybe 3 hours away from the main event, guys. Oh, I can't wait. I hope this hurries up. Although, in 1 hour and 45 minutes, I'm going to show something outstandingly special. So it'll take about an hour long, and it's so good.
I'm showing you what's marked as plaintiff's exhibits 5A, 5B, and 5C. Do you recognize those photos?
Yes.
And could you please describe to the jury what is relevant about those photographs?
So the first one is of the victim's upper arm with some pinkness. Second photo is left hand, back of the hand. Shows some cut.
CJ, in an hour, it gets very emotionally feely. But it's so good.
and the thickness.
Hour 45.
And the third photo shows the same hand, same cut, same thickness from a different angle.
And were those the photographs that were taken by the sheriff's office?
Yes, ma'am. I believe Deputy Babcock.
And are those a fair and accurate depiction of the injuries you observed on Miss Johnston's arm and hand that night?
Yes, ma'am.
And when you arrived, was the defendant present?
No, ma'am.
And did you later make contact with him?
Yes, ma'am.
Do you see him in the courtroom today?
Yes.
Could you please point him out and describe what he is wearing?
He's wearing khakis and blue and white striped shirt.
Thank you. Your Honor, let the record reflect the witness identify the defendant.
Any objection?
No, sir.
Record will so reflect.
All right, and can you please explain to the jury how you came into contact with him if he was not at that residence when you responded?
So we have a camera system called Flock that takes photos of vehicles on the roadway. They're in different spots, and we ran a possible license plate, and we're able to get, I believe it was 3 hits back from recent time of the vehicle traveling. Julie gave us a possible address that he could be staying at on South 30th Street. So we had deputies attempt contact there. They had negative contact there. They weren't able to reach him. He either didn't answer the door, or they didn't see him, whatever it was. I was not one of the deputies on that address. At that point, we cleared out of the call. We had made all of our efforts we could until we
Belgian
received a call
triple.
from Julie.
So the Mrs. Johnston, when she made that second call, was she reporting that he was back at the residence?
Yes, ma'am.
Okay. So did you and deputies respond back as well?
Yes.
You guys don't even know what crazy you're about to walk into soon. I can't wait.
Were you able to locate the defendant?
Yes.
Was he in his vehicle or a different vehicle?
I don't recall if it was his vehicle or another person's vehicle.
Was there another person with him?
Yes, ma'am.
Okay. And do you know who that was?
I believe her name was Kyla.
Something with a K?
Something with a K, yes, ma'am.
But a female?
Yes, ma'am.
And when officers approached him, what was his demeanor?
He seemed upset, not exactly cooperative. We got him out of the vehicle and he was placed under arrest.
Did you observe any injuries on him?
I did not see any injuries on him, no.
Okay. And did he complain to you of any injuries?
Not that I recall.
Okay. And what was he placed under arrest for?
Domestic violence.
Okay. And did you submit a report to the law director's office for charges of domestic violence against him?
Yes, ma'am.
And I did want to actually clarify the Flock camera system. You said you got 3 hits. Are those hits on a license plate number?
Yes.
So for the camera does its thing, but for the sheriff's office to try to locate a vehicle, they just type in that plate number, and if it
type in a plate number or a vehicle description.
Okay.
Either works.
And then it will just return if there is anything matching that plate number or that description.
Yeah.
My vehicle description. Might be a car, mostly duct tape. I love my car so much, though. I love it.
Okay, thank you. Keep that further for Deputy Nelson, please.
Cross-examination?
Yes, Your Honor. So when you arrived, do you arrive at the Julie's residence or the neighbor's residence?
The first time?
Yeah.
We arrived in front of Julie's residence, looked to see if she was there, and she was not. We then saw her at the neighbor's house and walked over.
Okay. And you took those photographs were taken that night?
I did not take those photos, no, sir.
Okay. Do you know who took them?
Yes, Deputy Babcock took those photos.
Okay. And you're working with Babcock's hand in hand, side in side during this, right?
Yes, he was my trainer at the time.
Okay. So those pictures appear to be fair and accurate depiction of what you observed?
Yes.
And you didn't see bruising or anything on Miss Johnston's chest?
Not that I recall.
Okay. And you only saw a little bit of pink on the arm.
Yes, at that time.
Okay. And then after speaking with Julie, Ms. Johnston, you and Babcock make the statement that you're going to find, as long as you can find Mr. Johnston, he's going to jail tonight. Do you remember that?
I don't recall those exact words.
Okay. Well, forgetting the words, that you guys were going out to arrest him based on Julie's complaint, right?
Yes, we're looking for him to complete our investigation.
Okay. Did Julie ever tell you her daughter was home?
I do not recall her daughter being said to be home.
So you didn't interview her?
No.
Okay. And obviously Wes Johnston is not there at this time, so you didn't interview him at that time, right?
Correct.
So you don't know about the daughter that's in the house. You haven't interviewed Johnston, but yet you guys are going out to arrest Mr. Johnston based upon just that evidence?
The physical evidence, yes, sir.
Okay. And Mr. Johnston is located. Do you locate him or does someone else?
We received a call from Mrs. Johnston that she was back at her residence.
Okay.
Or their residence.
And did you go to that
recall.
residence then?
Yes.
Okay. And Wes is arrested pretty much immediately, right?
Yes.
Okay. And after he's arrested, he asked for an attorney?
After he was arrested, he was read Miranda, asked if he would still like to speak with us. He said no.
Okay. And he asked for an attorney, right?
I do not recall if he asked for an attorney. I just know that he did not wish to speak with us. So he asked no further questions.
So it's fair to say that he was arrested before you got his point of view, correct?
He was unwilling to give us his point of view, correct?
Well, when was he unwilling to give you his point of view? After he was
Whenever
cuffed?
He said that he was not willing to speak with us.
Right after he was arrested?
Yes.
So you don't think there was a little bit of rushed judgment there, arresting him without getting his side of the story first?
I do not believe that there was a rush, no, sir.
You didn't know anything about an audio tape of the incident either at that time, did you?
I did not know of an audio tape, no, sir.
No further questions?
Any redirect?
Good job, lawyer.
Thanks.
Can we just stop and see what a great job he did there, making the jury think that the father was definitely arrested before he should have been.
Deputy Commissioner, what is the sheriff's office policy on arresting suspects on domestic violence complaints with injuries?
I don't know the exact wording on the policy off the top of my head.
Meaning, are you required to arrest if there's a domestic violence complaint with injuries and you locate the suspect?
If we can determine a primary aggressor, then yes.
Yes. Okay. And is that what happened in this case?
Yes, ma'am.
Thank you. Nothing further.
Any recross?
No, sir.
All right, Deputy, you may step down. You can go ahead and retake your seat at the table. Any additional witnesses on behalf of the state? You can return those to Ms. Yeager.
The state has no further witnesses for its case in chief, Your Honor.
Counsel, approach, please. Okay, well, ladies and gentlemen, the state has no further witnesses to call. It seems like an opportune time to take our lunch recess. It's now 12:30. We're going to give you 1 hour. I'll be back here about 25 after 1, please. And at this time, I would remind you not to discuss the case amongst yourselves or with anybody else. Do not allow anybody to discuss the case in your presence. Anybody asks you about it, you say, Judge Stansbury told me I wasn't allowed to tell you anything about it, including what type of a case that it is. And it is your sworn duty not to form any opinion on this case until it's finally been submitted to you. So with that, we'll stand in the recess.
All right.
Stuff like that. You ask for an attorney, by the way.
Also very valid.
Oh my gosh.
All right.
So good. I think it was stop today.
Please be seated. We're back on the record in the Ryan Johnston case. It's 24 CRB 1550. Defendant's present in the courtroom with his counsel, Mr. Kalsaric. Ms. Yeager's here on behalf of the state. The jury has not been brought back into the courtroom. We're returning from our lunch recess. The state had indicated that it had no more witnesses to call, but let's go ahead and address your exhibits.
Thank you, Your Honor. The state would like to introduce exhibits 1, 2, 3, 4A, B, C, D, and then 5A, B, C.
Any objection, Mr. Kalsaric?
I don't think so.
Audio.
The court would require a more definitive statement than I think so, or don't think so.
No objection.
Alrighty. So states 1, 2, 3, and then 4 and 5 inclusive will be admitted into the record without any objection. Does the state officially rest?
Yes, Your Honor.
All right, Mr. Kalsaric.
Mr. Johnston.
No, you're Mr. Kalsaric. Did you wish to bring anything else up before we get underway?
Oh, I'd like to make a Rule 29 motion, Your Honor, based upon the evidence and based upon the
Of course he
audio
does.
tape.
Yep.
Obviously, Mr. Johnston was not the aggressor in this case. We think that the court should grant a Rule 29.
Response?
Yep, he's right. Just case dismissed. Poor guy. We all beat it up on him.
Your Honor, the issue that Mr. Kalsaric raised is an issue for the jury. We believe we've presented sufficient evidence that, if believed, could return a judgment of guilty. So we'd ask that you deny the Rule 29.
The court finds that the state has introduced evidence of each and every essential element of the offense sufficient for it to go to the finder of fact. So at this time, the Rule 29 motion will be overruled. Anything else on behalf of the defendant before we get underway?
What? That didn't work?
No.
Anything
But
else on behalf of the
Judge.
state?
No, Your Honor.
Let's bring him in.
All rise for the jury.
Very well. Please be seated.
She's
Record should
the
reflect that the
aggressor.
jury,
She's
all
taken
9
down.
members of the jury, have returned from our lunch recess. Welcome back, ladies and gentlemen. While you were gone, the state addressed its exhibits, and all the exhibits that were testified about during the state's case in chief have been admitted into evidence, and you'll have those items with you in the jury room for your deliberations. At this time, Mr. Kalsaric, please call your first witness.
Mr. Johnston, please, Your Honor.
Mr. Johnston, please come forward and be sworn, sir.
Let's go. If anybody had any doubt, it's about to be washed away. Don't worry.
Just go ahead and step up onto the witness platform, if you would, please, and then turn face the bailiff and raise your right hand.
Solemnly swear, do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Please have a seat, sir. For the record, you're going to give your name and spell your last name,
Ryan W. Johnston, Johnston.
your address.
237 Klaus Lane,
Yes, Jeff.
Granville, Ohio, 43023.
You may inquire, Mr. Kalsaric.
Thank you, Your Honor. That address you just gave, is that the marital residence?
It is.
And is that the residence that Ms. Johnston was talking about when she was testifying?
Yes, sir.
Okay. And she testified that you have 3 children. Is that accurate?
Yes, sir.
Okay. Let me ask you a couple questions. Are you employed?
I am.
What do you do?
I'm a pipe foreman for an excavating contractor.
Okay. And what kind of hours do you work for that?
Very long hours. I'm up at 5, usually home by 7, even later in the summer.
Okay. Hey, can you do me a favor, Wes?
Sir.
Do you go by Wes?
I do.
Can you make sure you speak up, because some of the people in the back of the jury might not be able to hear you?
Absolutely.
Okay. Now, Mrs. Johnston testified that she handled most of the finances. Was that correct?
Yes, sir.
Okay. Does that mean she handled the accounts, the bills, and the checks and stuff?
Yes.
Okay. And you've been married? How long you been married?
It's 26 years in October.
Well, let me ask you a couple of things about the finances. It's pretty much, did you guys pretty much buy stuff together once you got married? Like the house, the cars, the phones, and stuff like that?
It was probably more like, this is what she wants, so that's what we got.
That's right. This demon woman, she only did what she wanted to do. His opinion meant nothing for 26 years.
Okay. But you would purchase and make financial decisions
Yes.
together?
Yes, for the most part, yes.
Let me direct your attention to November 17th, 2024. What were you doing earlier in the day?
I was working out in the yard, just getting ready for, putting umbrellas up, putting patio furniture away.
Getting ready for winter?
Yeah, getting the yard kind of ready for, because I was done with the grass cutting and just getting ready for winter, yes.
Okay.
72 was a great year.
And that was at Klaus Lane, the marital residence, you said?
Correct.
And during the course of being over there or some point during the day, did you become aware of some money missing? And how did you come about
It was, I think that might have been a day or so before I had noticed that.
Okay, what did you notice? Tell me.
Well, I was, we were in the process of talking about splitting up, and I know that the family computer has like our tax stuff on it, things that I would need or that we would need. I wanted to make sure.
Paperwork?
Yes, copies of our taxes, so forth. I also, I noticed some what looked like bank receipts, sitting right there beside the desk.
So both of their testimonies about when he found this deposit slip for $2,700 are none of their testimonies make sense or equal each other. Or he's saying he found it a couple days ago, but then he also makes it sound like he found it that morning. She's saying, her trash was taken out. I don't know. We never clear that up.
The trash. So I picked them up, and I was very taken back. And
why were you taken back?
Well, I found a bank receipt for around I say nearly $3,000, but $2,700 and change that was taken out in cash. She generally doesn't use cash. She uses electronic forms or a check card. Also found another bank receipt that had some sort of transaction on it, but it showed a balance of over $29,000. It wasn't a account that I was familiar with or had access to. So I began digging a little deeper. I went out to the recycling, bin that we have in the garage, and I dug through it, just to see what I could find. Trying to do my due diligence as far as, my money went into it, is direct deposited into a joint account. After this all happened, I was able to go to.
Yeah, with my partner, if I found out my partner had $30,000 sitting in a different account that I didn't know about, and I've been married to this partner for 26 years, yeah, I would be upset too. I mean, I don't think I would hit him. Maybe. I don't know.
Local credit union and get our bank statements for the last 6 months. And I found out that there were so many other accounts, money coming in, money going out, that I had no idea about, wasn't privileged to that information.
Okay.
So, yeah.
Okay. So you found this stuff.
I did.
And at some point, it was November 17th when you started trying to address it?
That was on the night of the 17th.
How did it get addressed and how did it?
Well, I took a picture of the receipt with the $2,700 and I sent it to her, and I just said question mark.
Oh my God, guys!
And
Oh my
I didn't hear
God!
anything, so I sent another. Said I'd like to get an answer about this. Tried to call her. She answered but hung up on me.
Yo, this guy sounds just like Bill. Doesn't he? Emily, are you okay? Emily.
So I went and I left to go there to ask her about it, to question her about it. I mean, it's I live.
Let me ask you this much: how much money was in your account?
I don't know. I don't. That information I could get, but I just never got it.
Okay.
I didn't have any access to any of the other accounts, her business accounts and Venmo and PayPal and all these other accounts. I didn't have that. I wasn't even allowed to look at the phone bill, the itemized phone bill. I was essentially.
Oh, come on. Come on. You go way too far, sir. You go way too far trying to make it seem like she controlled everything and I wasn't allowed to do anything. We heard you. We heard you controlling her. He blocked her from leaving at one point. That's going to come out later. No, you're going to talk to me. Where did the money go? You're going to talk to me. And he's not allowed. He's not allowed to see the phone bill. Okay? Okay.
I was not one of the primary people on that, unfortunately. But I did not know how much we had, and I just, I was the labor department.
Okay. So you mentioned
the labor department. Okay.
You mentioned you got a text. You sent some text back, a picture of a photograph.
Yes, sir.
What ended up happening after that?
I didn't hear anything back from her, so I drove to the house and what you heard on the audio is what happened next.
Okay. What's your perspective on what happened next? I assume you drove there?
Yeah, I drove there, and
how do you get into the house?
Angrily.
Walked into the back door. It's unlocked, just like it normally is.
Vigorously.
And what happens after you walk in?
I walk in, and I don't see her. I walk through the dining room.
Aggressively.
Into the kitchen. I see her phone sitting there, unlocked.
Innocently.
Open. I don't see her. So I picked up her phone. It was sitting there on the counter. Okay. And a few seconds later, she came around the corner and started to demand her phone back. Started grabbing for her phone. And
exactly.
She became loud. I became loud.
You became loud.
What ended up? Does she try to get the phone or anything? Or
oh yeah, she's
describe
well, so she's got a 6-digit lock on it, and when it goes dark, if it were to go dark, I wouldn't be able to get it. So I got it.
Sir, if it were to go dark, why wouldn't you be able to get into it? It's your phone, you said. So why wouldn't you be able to get into it? Oh, because it's her phone.
In one hand, trying to scroll, and with my other hand, I'm trying to hold her back at arm's length.
And what's she doing?
She's slapping. She's yelling. She keeps coming and coming. I walk,
she wishes.
I walk around the dining room table, just trying to create some space. She keeps coming and yelling. I'm upset too at that point. I came there I wanted to find out what that money was for. Why do you need the cash?
Did she ever tell you it was for a lawyer before you were confronting her?
No, sir.
Okay. And at any time, what she's grabbing at you and stuff that you just described, basically that situation that you just described, do you grab her and twist her arm?
No, I don't. never grabbed her and twisted her arm. I just was trying to hold her from getting to me, because if that phone goes dark, then it's all, then I can't get it back on. So I'm not.
I mean,
I'm
I
not
have
really.
to throw her to the ground, because how am I supposed to snoop if she is preventing me from snooping? She has to go down. She has to. Self-defense.
I'm trying to look at her. I'm trying to look at the phone.
What it started? You said you started mentioning that you picked up the phone in the kitchen.
Yes, sir.
And then you mentioned being around a dining room table.
I went from the started in the kitchen, moved to the dining room, just trying to get away from her, create some space.
And where to go from there?
From the dining room, then it went back into the bedroom.
Okay.
And she came in there.
Okay. Tell me what happened.
She, again, tried to go for her phone. Told me I was a bad man.
Shit. Now it's driving me nuts. Guys. He has a little curl right here that every time he turns his head, it pops out. We can't listen to the rest of his testimony. I'm gonna have to fast forward it.
Knocks the phone out of my hand. It goes in this kind of space in between the dresser and the kind of side table where the internet router is. And then we're kind of fumbling for it. I happened to grab it, and when I did, I inadvertently pulled the.
Me and my ex did a fun little game with our finances. So both of our paychecks went into the same account, and then he spent it whatever he wanted, and then I had to find money to pay bills. That was fun.
The internet cord out, whatever the Wi-Fi, into the router. She yells a few more times, and I believe she said she was going to call the police. And I'm sorry.
Go ahead.
I just didn't. I told her that, I just remember thinking, like, why are you calling the police? Like, we're just, it was an argument. It was a heated argument, but why are you calling? Like, you're not calling the police. I didn't. If anything, I felt like maybe I had to call the police because,
Canada was supposed to help me on Saturday and didn't. So Canada said that they were going to help me on Sunday, and they didn't. Now Canada says that they're going to help me on Monday. Maybe.
But all the slaps I took. But
now, there's an audio recording of this in this case. Why is there?
I had started recording our conversations when it came to talking about the upcoming divorce. Some to protect me, so I could go back and listen to what we had said. There was a few conversations that we had, before that night. The first one was at Panera. It was about 2 hours long. I'm sorry.
Let me stop you there, because I don't want to draw an objection.
Okay.
So basically, just kind of generally tell us without getting into specifics.
Well, for our entire marriage, whenever we had a disagreement, or maybe not even that, she would say, well, you said this, or you did that. And I remember thinking, like, I don't remember saying that. So it was, kind of a, more of a way to protect me, and also so I could go back and listen to, what was actually said. Sometimes maybe I don't remember remember it the right way. So,
hear the whole thing.
You heard the audio tape played in court earlier. Does that seem like the audio tape that you made?
It is.
How did you record it?
I had just an
Device
app
or
on my phone.
or-
I had an app on my phone, and I was wearing a hoodie, and I had it in the front pouch pocket.
Okay.
Beside my meth? No, just kidding.
I know it's basically goofy, but that sounded like a door.
Was the door, the back door, walking in. Yes.
Oh, it was a door. He's innocent. We're hearing more. Don't worry.
Stop. You gonna talk to me? You gonna talk to me? You gonna talk to me? Give me my phone.
Yep, she's the aggressor.
No, sorry, it's my phone. No, it's not. It's my phone. Stop. Right now. Stop. Stop hitting me. Stop it. Stop it. You stop it. Get off my phone. No. I'm gonna take this thing.
What's happening there?
I walked into the kitchen. I saw her phone and picked it up.
And what are all those sounds that we hear on the audio recording?
Her trying to get her phone back.
Okay.
That's all she wanted back the whole time.
And is this in the kitchen now?
This was in the kitchen, yes.
Did he just say that out loud? Did he just say that in front of the jury? That's all she wanted was her phone back. He said that.
And I looked at everything. What? No, I didn't. Yes, you did. I haven't yet. But, okay, listen. Listen, are you gonna talk to me? Are you gonna talk to me? Get off my phone. Let's see here. That's right, man. This is so hard, but yes, just have been. What is this? Everything I do is embarrassing. Oh, okay. All right. Okay. Listen. Stop. Stop. Cut it out. Oh, stop it.
What's happening?
He threw her to the ground.
Trying to read her phone. Obviously, you hear me. You know, trying
Why
to
did
read
you
it.
yell stop? What's happening?
Why is she?
Why do you yell stop?
Because she's like keeps coming in my space. Keeps you know, clawing and grabbing, and you know, I'm trying to, you know, I can't keep her away, and you know, I'm trying to keep her away and look at her phone and scroll through, and you know, at the same time.
Are you backing up or going forward?
I'm backing up.
Stop it. You gonna talk to me? Are you gonna talk to me? Are you gonna talk to me about this? No? We're gonna talk about this. Yes, we are. Listen, what did you do with the money? Stop me like that! Stop trying to touch me! What did you do with the money? What are you doing with the money? What are you doing with the money?
What are you doing with the money? What are you doing with the money? What are you doing with the money? You're my phone!
Sounds like slapping back there. What is that?
That's exactly what it is.
Are you slapping her?
No, sir.
Just so help me God, I will take this and I'll find every little thing, and I will let everybody know.
What?
I will let everybody know. Stop.
There's nothing to let people know. I don't know, my husband's a very bad man. You mean my
Who's Patty Holden?
You don't need to know.
Oh, okay. So let me just send this thread over to me. Patty, let's see here. And twice. Sounds good to me. Embarrassing. I told him what's the return. I was just asking questions.
Probably.
Oh, is this your attorney? Hi, what are your thoughts about kids? My family looked in Hayden's minute. What? Sorry? Let's see here.
Yeah.
What else we got?
A little bit.
Let's just look up, see who you have been texting. Patty Holden Barker. Hey, you're the one that kept coming. No, you kept coming. No.
Is your hair or something? It sounds like people are moving.
Mm-hmm.
Are you at the same spot now?
We are. At this point, I walked back to the bedroom, in my...
Does she follow you there?
Yes.
Did she aggressively follow you there?
Yes, I am. Yes, I am. Yes, I am. Yes, I am.
You're gonna call the police right now.
I'm not gonna call the police. You're not. This is allowed. No.
Was that when the phone got dropped on the floor?
See, I think he says there, this is mine. I think that's what he says.
Yep.
Don't do it.
What are you doing now?
Now I'm realizing that the phone had gone dark, so I'm trying to...
Oh, that made me so happy. The phone went dark. Now he can't touch it anymimore.
See if I can figure out what the 6-digit passcode is, which I failed to do.
Okay, and where is she?
I think she's still in the house, but I know now that she had left.
So you think she's in the house?
I thought she was still in the house somewhere. I didn't hear any doors open or close.
Okay.
So I'm assuming she's still in the house, yes.
I was pushing her away. She was trying to get the phone. I was pushing her away. Sorry, that was me.
Gathering up some clothes.
More stuff?
Yes.
Where you at? Sorry.
What was that?
That was my youngest daughter, Lucille. She had just gotten out of the shower. I didn't realize that she was home. She was upstairs in the bathroom. I had heard something upstairs, so I went up there.
So at this point, you don't know that probably around this time she's talking to the neighbors and having them call the police?
No.
You still think there's maybe she's even in the house?
Yes, and that's why I said, where you at? I think I called out her name. I think I did later on.
car door?
Yep.
So are you leaving?
Yep. I had walked out to my car.
Okay. Anything else happen that fairly and accurately depict what the audible version of what happened that evening?
That's everything.
Okay. So you didn't mess with it or anything?
No, sir.
They both think that this is severely damning to her.
Now, you get in your car, and at some point, you decide you need to come back.
Yeah, I realized I forgot some stuff for work.
Okay.
So I came back. I didn't.
Did you think anything you didn't?
No, I didn't. I had no idea. You know. I walked to the back door. It wasn't unlocked. I used the normal key code or number sequence. It turned red. Did it again, turned red. So okay. So I'm starting to, something's going on. So I had my keys. I never use them, but I went to the front door, and I could feel somebody on the other side, holding the deadbolt back, and they started to yell at me to leave, and that they called the police. And I explained I just want my work stuff. That's all I want. Still not believing that that's what happened. Turns out she had set my work stuff out in a tote right in front of the garage door, and I walked right past it. Off in the distance, I could hear the sirens. Still, I figured it was something else. I kind of took my time, if you will. And lo and behold, I see, I don't know, four cruisers pull down the road and arrest me right in front of my home. 11 o'clock, 10:30 at night. My children inside.
Okay. Did you hit Julie?
No, sir.
Did you chase her around, causing her to think that you were going to harm her?
No, sir.
Did you threaten to harm Julie?
No, sir.
I have no further question at this time, Your Honor.
Cross-examination?
Thank you. Mr. Johnston, the address you provided on Klaus Lane, that's your wife's and your children's address, correct?
That is where they're living, yes.
Where are you living?
I'm living
Street.
in Newark.
I'm sorry?
In Newark.
Newark. You've been married 26 years?
Yes, ma'am.
Is this the only time you've been married?
Yes, ma'am.
You said you do pipe fitting?
We're a pipe crew. We do water lines, storm lines, sewer lines, dirt work for new housing projects or whatever site, whatever new builds.
Sounds kind of physical.
It's very.
Very?
Very
you have to
physical.
stay in pretty good shape to be able to do that job?
I suppose, yes.
So, in November of 2024, you'd agree that you and your wife were no longer happy together, correct?
Correct.
And you two had discussed splitting up, right?
Yes, ma'am.
By this time, you were rarely coming home at most nights, correct?
That's not entirely correct.
Liar.
Not entirely, so it's somewhat correct.
Somewhat, but not entirely.
Liar.
And at that, so on the night of this altercation, pardon me if I jump around a little here. After this altercation with your wife, you left your house, correct?
Yes.
And you came back and you were eventually located by the Licking County Sheriff's deputies, correct?
They drove down the street and arrested me right in front of my house, yes.
And your girlfriend was with you in your truck, right?
I had a friend of mine that was
His girlfriend was there.
driven me to the house, correct?
I love her.
And you and her had been dating for a while by that point? Like your wife already knew about her and everything?
No.
You didn't call the police that night though yourself, correct?
No, ma'am.
And when the police did arrest you, you didn't tell them anything about what happened that night, correct?
No, ma'am.
Thank you.
They didn't ask me.
That's
Now we
I'm
do
not
Rebecca.
Question to ask Mr. Johnston.
so when Mr. Callister was asking you about finances and you mentioned cash, cards, and so forth, you knew your wife had a small business, correct?
Yes.
And obviously that's going to earn money and have money go in and out, correct?
Correct.
And you testified on direct that you found this receipt showing a $2,700.
I'm just saying, if he has a girlfriend, that's not his phone. That's not marital property.
And change withdrawal cash from the bank, right?
Yes.
And that you took a photo of that, sent that with a question mark to your wife, right?
Yes.
And then you went through the recycling to see what else you could find, correct?
That's correct.
All right. And this the $2,700, that was out of a joint account, right?
I do not remember which account that was out of.
But you have access to your joint bank accounts if you needed any information, right?
I could get it, yes.
Okay. And you said she didn't respond to
No, you don't understand, lawyer. He's not responsible to go find out information on his own about accounts. She's supposed to tell him everything. He's not, he can't log in. He can't, how is he supposed to remember his password? She's supposed to tell him everything.
your text, so you called her to ask about the money.
Yes.
Okay. And you said she hung up on you, correct?
Correct.
So then you went to question her about it and you drove over there. Where were you?
Where was I?
Well, you said that you went through the you went through all the receipts in the trash. You found the receipt for $2,700. You took a picture. You sent it to your wife. She did not respond to your text message. You called her. She hung up.
You said you drove over there. Where were you at to have to drive to there if you were at the house going through the stuff in the office and the recycling in the garage?
Okay, I'm sorry. Where would I have to?
You testified.
I was.
You testified on direct.
Mhm.
You found the receipt.
Yes.
In the office trash.
Correct.
Okay. You testified that you had sent her the text. You called her,
Yes.
and then you came over.
I had found it the day before, maybe 2 days before. So I was sitting on it.
Okay.
And I didn't know how was I going to approach her? Okay.
Okay.
And I was, I think I was walking out of Walmart or something, and got to my car, and
JK, that says it all right there. That wraps it up. Good comment. Look at that, guys. Now we know.
that's where I texted her a picture of. I finally was like, you know what, I want to know, what's going on.
Right. All right. So then, so you drive over there. How far? I have no idea how far the Walmart is from the house.
10 minutes.
10 minutes. Okay. So you drive over there in that 10 minutes.
Did you give her a breakdown of what you spent money on at Walmart? You were asking her where the money went. Did you tell her where the money went there? Or is it only because it was going to a lawyer? Or is it only because it was $2,700?
And so you decide, hey, I'm going to talk to her about this, figure out what the money is, where the money is. I heard the recording a few times now, right? And at the beginning, you said you walk in the back door, and you said you walked in, you saw her phone, you picked it up, and she says, "What are you doing?" And that's the start of everything, right? And then you start yelling at her. You heard that, right? You heard you yelling, "Stop, don't, stop, stop." You heard you yelling that, correct?
Yes.
Yes? Okay. So if you're just trying to figure out where this money is from, is this normally how you would ask her about that?
It's the only way she'll respond to me. That's
Sent her
yo.
a text, multiple texts. I called her.
She
Like
doesn't
multiple
have to.
texts? You said it was one text with a receipt and then a question mark.
I sent her a text with a picture.
Mm-hmm.
Okay. Question mark. I sent her another text saying, I would like to have an answer on this, with no response.
That's not how
I
he
called
worded
her,
it.
and she hung up on me.
She doesn't have to talk to you. She
I
just
gave
doesn't
her
have
every
to.
opportunity to do it, not face to face. It's quite a bit of money. I'm sorry. Like, might not be to you, Ms. Yeager, but it is to us.
Us
So
as in
when
you
you're
and your
in there,
girlfriend,
you have-
or us as in you and your wife? I'm confused.
Have her phone, and so you don't know her 6-digit passcode,
No.
is what I'm gathering? Okay. So when you have her cell phone and you're looking at it, and she's trying to get the phone from you, you testified on direct that you were walking away from her, like walking backwards. Is that correct?
Tried to avoid her, yes.
Okay.
Yes.
So if I'm you and I have the phone, are you doing like this number where you have the phone out here?
Like this?
Yeah. So, and she would be here?
Yes.
Okay. And you're still trying to look at the phone, trying to see the messages
Keep
and
it
stuff?
from going dark, yes.
And so you're still looking at the phone, trying to keep her away?
It's okay. Don't worry. It's okay. Don't worry. It stops soon.
Why didn't you just give her her phone? It was her phone, right? And your joint accounts you both have access to, right?
That wasn't a joint account, I don't believe. I don't have access to that one. It wasn't, because if it was, I probably could have got the information on it.
So then it would have been her business account if it wasn't the joint account.
Well, there's like 14 different accounts that she has.
Okay.
And I am exaggerating a little bit, but there's at least 5. Plus Venmo, plus PayPal, plus who knows what else.
there's probably one or two
So-
in business accounts.
Just to clear that, so you said Venmo and everything else. So how many like bank accounts are we talking here?
I don't know how many.
Okay.
You know, we're
Vibers are always Team Myco every day, all the time, even if he's wrong, which he never is.
in the process of figuring that out.
Okay. And we also heard on the recording, as you guys are in this argument here, her say, "I'm leaving," and you said, "No, you're not." Why wouldn't you let her leave if she just wanted to leave?
I said, we're talking about this. We're going to talk about this. Yeah. She could have left. She didn't want to leave. I wasn't holding her back. She could have left at any time.
There was a part he was blocking
She
her.
could have
She
just
couldn't
told
leave.
me what the money was for.
She was trying to leave. She said, "I'm leaving," and you said, "No, you're not."
She could have left. Nobody was holding her back. She obviously left when
So,
later on. Right?
well, yeah, that's later on. I meant at this point. So when the phone goes dark and you finally figure out like, oh, it went dark, and you tried to guess a passcode, but you did not guess it, correct?
Correct.
Okay. And you thought she was still in the house? So as you testified on direct, you walked around, you opened a closet, you were gathering some things.
It is quite possible. I think it's probable. And I don't know that. I'm going to say men, but I'll just say bigger aggressors, men or women. They don't understand how big they are when they are blocking an exit, and they're mad, and they're yelling, and they're standing at the only exit to a room. I don't think they realize how big they are, how trapped just them standing in that spot is for people. So they don't know, they don't understand that. They say, yeah, she could have left at any time. Not if you're blocking the exit. She couldn't.
At some point you were still looking for her, right?
I had hollered for her, thought she was still there.
Who did you think was in the bathroom?
One of my daughters, I heard something upstairs. Went up there to see who it was. I didn't know if both of them were home. None of them were home. One of them. Yeah.
So when
I can't believe nobody asked that, if the wife was allowed to go through his phone and send everything to herself.
So when you were going through her phone, and you're walking and you're holding her phone, and you say, "Let's see who you've been texting." You heard that part of the recording?
Yes.
Okay. And we heard you ask about Patty, and you asked if that was her lawyer. You guys were splitting up. She's allowed to talk to a lawyer, isn't she?
Of course.
But you didn't want her to.
I thought we were going to be able to do this without the attorneys and not have to pay thousands and thousands of dollars unnecessarily. I thought we were going to be able to do that. And we had
So,
talked mutually about, doing that. Civilly.
You're right, Mike.
Are you a lawyer, sir?
I am not.
And you've never been through any kind of
I'm almost a
custody agreement or anything like that before this?
No, ma'am.
Okay. So when and you hear her say she's going to call the police, and you say, "No, you're not," and then you say, "This is mine." Are you talking about her phone?
Yeah.
So you're saying her phone is yours, so she doesn't need to call the police?
So, I mean, it's marital property, right? I mean,
That's not what I asked. I said,
Okay.
so your words were, "This is mine,"
It's mine.
and you were talking about her phone.
Exactly.
Okay.
I'm also a judge too.
So while you were holding her phone, trying to get into it, see who she's texting, asking who Patty is, asking if that's her lawyer, you grabbed her by the arm, didn't you? Twisted it, pushed her down. Didn't you smack her in the chest with the palm of your hand when you're trying to push her back? No. Okay.
You might want to reserve that opinion until you hear her closing statements, because I'm probably going to rip her up a little bit there.
So,
I
and then when you came
prejudge
back the
everyone.
last time because you forgot your work stuff, you said you walked right past it. It was in a box outside that she had put outside.
He goes to jail.
A tote. Sorry, a tote outside.
It was dark. It was almost 11 o'clock at night.
Okay. And your keypad, the code you had wouldn't work.
Correct.
So we went around. You tried to use your house key to unlock I think you said a deadbolt.
Yes, ma'am.
Yes. But you said somebody was holding the deadbolt. How do you know somebody was holding the deadbolt?
Because it started to turn
Absolutely.
and then you could feel it go back.
Everybody just read that again and just make sure. Listen, if you're getting into an argument, you just never let them get to that spot. Never, ever, 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 ever. You get to that spot. Don't be the aggressor. But you get to that spot. You can stand in that spot. Don't let them get into that spot.
And then her and her friend Ann I could hear them.
And you said that you heard them say they were calling the police.
Yeah.
And then the sirens came, 4 cruisers came, and you testified that you still figured that was for something else?
Well, when I heard it off in the distance, okay, while I'm walking towards the garage to get my tote, I could hear the sirens off in the distance. And I still...
Dude is just lucky that when he had the tote, a mattress didn't fall on him. He doesn't even know how close he was. He has no idea.
Figured it was an emergency for someone else. I still didn't, until I saw the lights coming down the street. That's when I went, oh, okay.
And did you seek any medical treatment or anything that night?
No.
And it's your testimony here today that at no time did you strangle your wife, grab her arm, push her, or have any physical contact with her person?
The only physical contact was from her coming at me.
No, I said, did you have any physical contact with her?
No, ma'am.
At no time?
No, ma'am.
Okay. Nothing further.
Any redirect?
No redirect.
Mr. Johnston, you may retake your seat at the council table. Any additional witnesses on behalf of the defense?
No, Your Honor.
Council approach.
Miguel, that spot, if they are standing in the doorway, it's defeating, it's intimidating, you're trapped. You're already defensive. You're just, if they're in any other spot, it's fine. It's different. They're in that spot, the whole situation changes.
All right, well, ladies and gentlemen, with the defense resting, and I just confirmed with the state that they're not going to be calling any, presenting any rebuttal testimony, we've come to the conclusion of the evidentiary portion of our trial. So what's left now is closing arguments and the final jury instructions, and then you deliberate. It's customary for me to give the attorneys a short break before closing arguments to organize their thoughts, and we're going to do that now. We're going to call it...
Never did either. When I was dating and when I was married for 19 years, okay, while we were married, never argued, never said a bad thing about them, didn't hurt their feelings at all. Okay, and then once, we were separated and divorced, then they found out. But while we were married, I never got into a fight and said hurtful things just to hurt them. Never.
We'll call it 2:20, and we're going to take a 10-minute recess, so we'll be back here about 2:27, but this will be the last break we take before you deliberate, okay? But even though you're not going to hear any more evidence, Remember, you're not to discuss the case amongst yourselves or with anybody else. You're not to permit anyone to discuss the case in your presence. If anybody asks you about it, you tell them the judge said you're not allowed to tell them anything about it, including what type of a case it is. And I would sternly remind you that it is your sworn duty not to form any opinion on this case until it's finally been submitted for your deliberations. And with that, we stand in recess.
All rise. All rise. Lincoln County Municipal Court is reconvened.
Please be seated.
Now I'm going back to remind you, these are just small town lawyers. Just give them some leeway, okay? They're not high paid lawyers. They're doing their best. Although I'm going to tear them apart. They're doing their best.
Back on the record in the Ryan Johnston case, it's 24 CRB 1550. Defendant's present in the courtroom with counsel. Ms. Yeager's here on behalf of the state of Ohio. The jury's not back. Both parties have rested their cases. We're ready for summations and final instructions. I did provide proposed jury instructions. Ms. Yeager.
Assault of a family member, I think.
Yes, Your Honor. The state has been reviewing the proposed jury instructions. We would object to the inclusion of the self-defense instruction.
All right, Mr. Kalsirik.
Well, I obviously want it, so I guess I would like to know the basis for the objection to not thinking that it's applicable.
Well, Your Honor, it starts with the defendant is allowed to use non-deadly force in self-defense. That requires the use of force. He testified himself that he never touched her and that he never did anything.
Never said that.
He said he never hit her, struck her, and at no point did any of his body come in contact with her person.
He did say that.
I think we'll need to listen to the audio tape, Your Honor.
Well, here's the thing.
It dealt with aggressiveness. She was distinguishing different types of touches. And did you aggressively touch her?
I never used the word aggressive.
Yes,
Well,
you did.
here's the thing. The case law is pretty clear. When they first made the change and put the burden on the state,
No.
The case law said if there was even a suggestion of self-defense, that the court is required to instruct on that. So I will note the state's objection, but I do believe that it's warranted given the testimony. Do you want to address your flight instruction?
That's a stupid law.
Your Honor, the state would request
No.
jury instruction for consciousness of guilt, I believe is the general title of it. And that's just that after the criminal offense occurred, the defendant fled. He did leave. He took off his truck. He was and left the premises. He knew the police were supposed to be called. And I believe there's case law that states if he is aware that that is the case, leaving can be a consciousness of guilt. And he knew that because she said, I'm calling the police. And he said, no, you're not. She was putting on her shoes. She leaves to go do that. So I believe the state has met its burden to support inclusion of that instruction.
Mr. Kalsirik.
It did cross my mind. It really did cross my mind. Like a couple days ago. Man, what if I get hit by a bus before Monday? I have to give my kids instructions on how to do this stream because this stuff, the next two things are so good.
I disagree. I think that I know we're all shocked.
Yes,
First
John.
of all, I don't think it applies even to the first instance when he leaves. But the fact that he even comes back definitely negates any leaving. Do we get an instruction on if he comes back to the residence, that's evidence of innocence?
Well, no, because it's not. Maybe he came
Well,
back.
the court's going to take that question as rhetorical. Here's what the court's kind of logic on this is.
For 48 minutes, yeah.
The audio recording reflects, and during the presentation of the defense's case in chief, we heard more of that audio than was played during the prosecutions. What we heard was probably about at least 5 minutes of him rummaging around the house and as he testified, collecting things that he needed for work. I think the consciousness of guilt by way of flight contemplates a more immediate departure from the scene. And I think that's there's also evidence that he was not aware that she was calling the police because at some point after the interaction, you hear him call out for her. And he testified he believed that she was still in the house. So I don't think that the departure from the scene is immediate enough to warrant a consciousness of guilt. And as far as the second is concerned, the testimony was unrefuted that he simply stayed there in the driveway as the police approached the house and cooperated in his arrest. So the court will note the state's objection to the inclusion of the self-defense instruction and also the objection to the court's decision to not include the consciousness of guilt by way of flight. Other than that, is the state ready to proceed with closing?
Sure.
And Mr. Calceric?
Yes, sir.
All right, let's bring him in.
All rise for the jury.
And it is warm.
Guys, I was going to do $1 for 5 minutes, and then I changed it because I got scared that it would be too much. Okay, see? JK did not say this is for more minutes. JK did not say it. I don't know. I'll calculate it when it gets closer because I don't know. It's like 9 hours. It's almost 9 hours. We are at almost 1 hour right now. So we have almost 8 more hours to go. So that's it.
Evidence, it's got a warm right here. Everything's going on. Yeah, that's on purpose.
Thanks.
Having hot flash.
Put a gag order in there too.
Ohio, Licking County, Ohio.
All right, please be seated. The record should reflect that the jury is now back in the courtroom. Ladies and gentlemen, as I promised, we are now finished with the evidentiary portion. We've taken care of a few procedural matters in your absence, and at this time we are ready for closing arguments. Because it does bear the burden of proof, the state will proceed first. Ms. Yeager, you may begin.
Good afternoon, everyone. We're in the home stretch. I want to again thank you all for taking the time to serve on the jury today.
They had
And we
to.
can get into the details of the end. As I started off telling you this morning, Mr. Johnston here is charged with domestic violence for assaulting his wife. And I said, hey, I was going to prove all this stuff to you, right? And I was going to do that through witnesses, photos, so on and so forth. So let's talk about what evidence was presented for you to review.
Thank you.
Well, I believe every single person that took the stand today mentioned the events that were in question occurred on November 17th of 2024. Well, got that one. Things occurred in the township of Granville in Licking County, Ohio. Okay. That the parties, Mr. Johnston and his wife, Julia Johnston, they were family or household members. They were a married couple, even though talking about splitting up under the law counts. And then the question is whether or not Mr. Johnston knowingly caused physical harm to his wife. Yes.
No. That's the officer that arrested him. The wife's gone. She just gave her testimony and left.
You heard from his wife. She sat up here and told you, hey, she started off the day. You know, it's a Sunday. They didn't have, activities for the kids, day off, that kind of thing. They're at home, they're doing stuff.
Thank you, Jude.
She testified that, she handled the finances, always has. Mr. Johnston agreed with that too. She's always done the money. She's always taken care of that stuff. Fine. They both told you that, yeah, they were discussing splitting up, then terminating their marriage. Nothing unusual there. Okay, they're both in agreement on that. And then you heard her testify about what happened when he was mad and came home and asked her, where's the money? What are you doing with the money? You heard that recording. You've heard it a couple times. You'll have it with you to listen to it again. It starts off with, some sound of like him opening a door, entering the premises and whatnot. But the start of the interaction, he picks up her phone. She says, what are you doing? And then it's a bunch of raised voices between the two of them. He's yelling at her, and you hear him repeatedly throughout yell, stop. You also hear her yell, stop, give me my phone. It's her phone. Married or not, it's her phone. It's the one she uses. She used it for her business and her personal life. He said, you heard him testify, well, it's marital property, but yes, it was her phone. She just wanted her phone back. And he wanted to know where this money was, why she has this money. Well, why is he suddenly concerned about their finances when he never cared before? It was always, in her purview. And I asked him, like, is this always how you address questions to your wife when you have a question about what she's doing with something? Do you always walk in and, where's the money? And start an argument and start screaming and yelling? Now, I'm a very small person, and I generally get offended when people try to point that out as a negative. But I do want to point it out as just reality. Miss Johnston sat here and told you she's 5'6". Defendant here is 6'3". So that's what, 9 inches between the two of them? How much of a reach is that? And then of course there's the weight size difference, and the fact that of course he's got to stay strong for his very physical job. And he's the one who comes into the house and is acting aggressively and out of control. He's the one who comes in and starts yelling about the money, grabbing her stuff. In one breath he says, oh, the phone's marital property, but in the other he's like, well, we're splitting up, so how much is it? You heard her testify that here's this altercation. Yes, there are words. Unfortunately, there's no videos to accompany it. All we have is the audio. So I do recommend that you listen to it again. And listen to the words. Listen to the tone of the voices in that recording. Because every single time the defendant is speaking, he's being aggressive. He's being loud. He's not acting or sounding at all scared, terrified. He's not crying. He's even condescending her. Oh, stop it. And then listen to her. Stop, give me my phone. That's how she says it. It's a different tone because she's meaning it in a different way. She's not threatening. She's not being aggressive in that same manner. She's trying to get her property back. It's her phone. She wants it. Nothing wrong with that. It's her phone. He won't give it to her. He's trying to go through her phone. I don't know about anybody else. I'm very private about that. I would be upset about that. But why is this such a big deal? Why can't he just give her her phone? Go to the bank and get the information if he wants to know what's going on with this money. Get more involved. No, he does none of these things. He goes up, he confronts her, where's the money? And as she tries to get her property back, he's holding the phone in one hand. Now he says he does this. So I want you to use your common sense here. How can he do this? Look at the phone. Scroll through, read a text, find out, oh, who's Patty Holden? Who is that? How can he do that and
easily
never have his eyes this way and ask her about it? And how can he do this and she not just run around the other way and get through? Doesn't make sense. Doesn't make sense. You heard her testify that while he's doing this and holding the phone away, he's also trying to keep her away. He strikes his hand back, and the palm of his hand hits her chest. Okay? And if that wasn't enough, he then grabs her by the arm and twists her arm to get her to stop while he's trying to get through the phone and go through her messages, see what information on her phone that he decides he wants to have. And as he grabs her arm and twists it, pushes her to the ground, she falls and hits her hand on the furniture, scratches up her hand. And you heard her testify that, hey, I had this redness on my arm and it hurt. I had this cut on my hand. You saw that she took my term was the progression photos, where the photo the first day of her chest, you see the area, you don't really see anything. And she says that. She said that when she testified. She said she knew that was the spot because that's where it hurt. And then as the days go by, she takes photos again and again to keep track of what is happening and to keep track of her injuries. And lo and behold, there's the bruising from where he put his hands on her. You see her arm, you see the redness from the photograph that the sheriff's office took, and you also see it in the photograph that was taken by the neighbor, Mrs. Mesner. Speaking of Mrs. Mesner, you heard her sit here and testify that Yeah, we're neighbors. We've all hung out, you know, in the yards. We've seen each other. We've talked to each other. We've known each other for years. Our kids know each other. That day, Julie came over. We saw her in the Ring camera, visibly upset. And they described how she was. She was shaking, she was crying, she was upset. And Carrie sat here and described the same injuries. She saw redness on Julia's arm. She saw the cut on her hand. She testified about a woman who had just ran to her house, terrified and upset about what just happened to her. At no point did Mr. Johnston ever call the police. When the police did find him, at no point did he say, "What are you talking about? None of that happened." That's not how it went down. He explained up, wouldn't talk. Looks, I think if you listen to that recording, think about the testimony of the witnesses here today. I think when you do that, you'll come back with a guilty verdict, because you will find that on November 17th of 2024 in Granville Township in Licking County, Ohio, Brian Johnston knowingly caused physical harm to his wife, Julie Johnston. Now, keep in mind what I said earlier about what physical harm means. Okay? The judge is going to give you definitions of everything that you need. That one doesn't mean it has to be of a certain severity, a certain duration. No, it's any harm. Any physical harm, even if it's slight. And as you will see on the photos, that happened here. Mr. Johnston struck his wife, and he is guilty of domestic violence. Thank you.
Mr. Kalseric?
Thank you, Your Honor.
Hello. Thank you. Thank you very much for being here. I don't talk about that at the beginning because I don't really know who's going to sit here, but you guys have been the ones doing the work, so I'm here to thank you. And why am I thanking you? I'm thanking you because we asked you to be here to hear our case. The government obviously would take a guilty plea, but we're not willing to do that because we didn't do it. So we're here and we asked you to be here to screen this.
Dude, shut up. Happy birthday, Terry. Happy birthday. And thank you. Happy birthday. Oh, I hate to press play and make him talk on your birthday, but I'm going to.
Screen this evidence. Basically, you're here to vet the case. Okay? This phone. You can't assault someone to get your phone back. It doesn't work that way. Mr. Johnston is not guilty
Go ahead.
of domestic violence. He might be guilty, and I think Julie's guilty too, of being jerks to each other and not being able to communicate like people should be able to do in a relationship. But obviously this relationship's gone down the toilet. So, but the question is not who do we like more or who do we dislike more or anything like that. The question is, did domestic violence occur, or was this some big over-dramatized event? I fall back on the latter one. Credibility. Credibility encompasses everything that's consistent. And if it's not consistent, in most cases, it's not credible. There are some things that aren't consistent in this case. First of all, most of us that are parents would not leave our child alone in the house with someone who's a raging lunatic. So that's not consistent. The injuries, none of them, do we agree, came from Wes. However, when she was in the process, you heard it. You heard there was physical contact there.
That's what I would have said years ago when the case started. I would have said, oh yeah, the injuries suspiciously showed up 3 days later. Anybody could have put them there. She probably put them there just to get him in trouble. You know, I might have done that once. No, I didn't. It's a joke. But he could say that. He could have said that. I would have said it a while ago.
You could hear slapping and things like that, but it wasn't Wes. Wes was being slapped. but he's definitely trying to hold her back. So there was physical contact, but it's not aggressive, like he was the aggressor in this situation.
He was.
You can clearly hear from the videotape he was not. His tone, you might not like, but there's nothing about his tone where he says that he's going to harm her or hit her or said that he hit her or is going to beat her ass or do anything like that in that tone. It's because it wasn't happening.
When I get into a fight with someone, I don't say, okay, now I'm going to punch you. Now I'm going to hit you in the chest to back you off of me. Now I'm going to grab your arm. Okay, now I'm going to twist it. Okay, now you're going down. I might say that last part, but
He wasn't threatening her and he did not harm her. The only harm that was caused, she caused by herself coming at him. That's the harm. That's when she went down. That's when she's trying to grab everything. She described it as a blockout in basketball, you know, where they go down for the phone. That is not knowingly causing or attempting to cause physical harm to another person. That's more of a basketball game, as she made reference to it. Let's look at the audio. Corroborates West was not the physical aggressor.
thank you for the 2 minutes. Thank you, thank you.
We know that. We know through the testimony and the audio tape. We know that there were slaps and hits. We know that she never said that he slapped or hit her. But we know that she slapped and hit him. You can hear it. He doesn't turn around and punch her. Is he scared or crying? No, he's bigger than her. He's not scared or crying, but he's not assaulting her. He's just taking it. Never says anything about what that money was used for. The government wants to say, why didn't you just give her phone back? Why didn't she just say $2,732, returning Joe Smo or whatever? She doesn't. She doesn't even respond.
She doesn't have to.
You can hear chasing and sound on that audio tape, and that's movement that's made from Wes trying to get away from her as she's chasing him through the house. And she admitted that she was following him through the house because at one point, and this goes back to the argument that was just being made about texting and going through and scrolling, she pauses. She pauses chasing him through the house so he can take time and actually read the text. That was her testimony. Factually.
Yes, it was.
You don't have to like Wes taking the phone and going through it. This is an emotional situation for two people that have been married 26 years. They got 3 kids together, real estate together. I mean, they've done everything together. And she wants to assault him over him looking at her
Actually, she was controlling him that whole time. Weren't you listening?
phone. It's not a crime what he did. Might not like it, but it's definitely not a crime, and there's definitely no self-defense for getting your phone back, that you're allowed to assault someone to get your phone back. Let's assume it's her phone. But he has no interest in that phone. You still couldn't do it. I could take my phone over here, she could take it, and I couldn't beat the hell out of her to get it back. I'd have to call her to get it back. So that's how that works. He has a right to defend himself reasonably. Would it be reasonable for someone who's 6'2", not 6'3", 6'2", to punch Julie or kick her as a result of her trying to get her phone? I think we would all say no. That would not be reasonable. You're much bigger than she is. That would be unfair, and that's not right. Did he do that?
Dude, I usually love delusional men, but not this time.
No, he did. He kept pushing her back like this while looking at the phone. He testified to it. He showed you. It's almost like the Heisman move, you know? But at no point did he turn around and hit her. Now, these parties are going through ending a 26-plus year relationship. They've got to untangle a lot of stuff. And Wes just coming in and Actually, let me withdraw that. So Wes comes and goes in the house. She thinks as he pretty much wants. That sounds a little negative when you say it that way, but that was her testimony.
Oh yeah, that was what she
She's
said.
not really tracking him because he's getting up at 5 a.m. and getting back at 7. She has no clue where he is, when he's there, and when he's not there. The neighbors. Yeah, she played that one good. She was very upset, very emotional. You have a 26-year marriage turning into crap in front of you. She's very upset. She's very emotional. And she'll say whatever she needs to do to please the neighbors to get them on her side. Now, she does hire a lawyer secretly and uses marital funds for her lawyer without...
Objection, Your Honor. That assumes facts not in evidence. There's no testimony or evidence about her hiring an attorney.
Objection will be sustained. Jury will disregard. You may continue, Mr. Counselor.
As you said...
Oh, that's just not right. How dare her? The whole thing about this was because the husband doesn't want her to get an attorney. So of course she got an attorney just to make him mad. So of course that should be allowed in evidence because he says so.
Somehow there's a divorce been filed. CPO's filed. Those take attorneys. And in this case, she never told what she did with that money, even though she says that she did. From a partner's point of view, if you go home and your partner, business, wife, husband, whatever, takes $3,000 from a joint checking account, you're probably going to ask them, hey, what's up with this? That's not unusual. Now, there's some anger towards Julie, towards Wes, and some of it's probably deserved. And there's some anger from Wes towards Julie, and some of it's probably deserved. But what's not deserved are false allegations of being an assaulter. Those statements are not warranted by these facts. We talked earlier about walking into the courtroom, having an opinion. By now you've had enough to where probably that opinion is probably settled and you're probably looking at the facts of the case, which is good. We talked about the scales of justice. Proof beyond a reasonable doubt, burden of proof, proof beyond, it has to be like this, presumption of innocence. Those three rules.
The lawyer is hiding the scales of justice from the jury. They can't reach him. He's going to pull them to the ground.
Make the scale start out like this. You've got to tip them up to proof beyond a reasonable doubt. It's quite a burden, especially in a case like this. Especially when we probably all want to know what 12-year-old Lucy heard that day. That'd be interesting. Imagine what this trial would have been if Wes hadn't recorded that audio tape.
Imagine.
Really? Nothing to corroborate him? It would have been her up there telling her story however she wanted to tell it, but thank God we had the audio tape.
Thank God we have the audio tape.
Take a look at that. Take a look at all the evidence.
Look at the audio.
There's no way the evidence weighs out to proof beyond a reasonable doubt for guilty, so it has to be not guilty. Thank you.
Ms. Yeager, your rebuttal argument?
Yes, first, Mr. Counselor, your phone?
She didn't steal it.
Did not.
Stand by.
Yes. All right, last time, then I'll be off to the races for you. I'm gonna probably jump around here a little bit, but let's get to all the points real quick. Mr. Counselor brought up.
Now that you heard Dad's testimony, do you feel that he was like holding his head in shame the whole trial because he thinks what he did was, not okay?
Why would you leave your 12-year-old child at home with a...
Or is Fozzie right?
Raging lunatic. I don't believe anyone who was sitting in that chair ever used the words raging lunatic. So keep that in mind. His words, not the witnesses. And there's no evidence by anyone that said Mr. Johnston posed physical harm to his daughter or had hurt her before. But what I do question is how one of his children was dating, like the oldest daughter was dating a boy for a few months. And he had no idea who that child's mother was. Who's Patty? Who's Patty Holden?
Triggered.
I mean, I'd want to know my kid, whoever they're dating, I want to know their parents. I'd know their names. If they're texting my spouse, I'm going to know who that is. It is because he was coming and going as he decided he saw fit. His level of involvement had changed as their marriage went downhill. You heard Mr. Calcer say, at no point did she just say, look, right here, $2,700, blah, 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 blah. Well, I mean, she couldn't do it that way because he had her phone. And she testified that she told him those were for attorney fees for the dissolution. I don't see why that's such a problem if they both wanted to terminate the marriage. Now, many of the definitions the judge is going to give you, I'm not going to read you all of them or even all of the one or two that I'm going to touch on. But domestic violence requires that he knowingly caused the physical harm. Not like, hey, oh my gosh, he fell and poof, she just happened to be under him. No, he knowingly does something. A person acts knowingly regardless of the purpose. Okay? When he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will be of a certain nature. So even if he's doing this at her, even if he's not like, hey, I hope I knock her out, that doesn't matter if that was his purpose. Okay. And
She's trying.
you also heard Ms. Mesner up here testifying. She knew both people. She didn't seem to have any dislike towards either of them in general. And she made her own judgments based on her own observations that day. And you heard her testify about that. She believed Julie was scared. She was shaking. She observed injuries herself. She took photos herself of those injuries to Mrs. Johnston that were caused by the defendant. I heard a lot of things from Mr. Kalasaric about both Mr. and Mrs. Johnston probably basically being jerks to each other. Okay. A lot of people do that. Thankfully, that's not a crime or we'd all be in trouble. But keep in mind, Mrs. Johnston is not on trial. The person on trial is the defendant, and he's sitting right here. We're worried about his conduct. Now, you also heard about the civil protection order and the divorce. Those proceedings began after this event, and the CPO because of this event. And Mr. Kalasaric's belief that the audio recording corroborates Mr. Johnston, well, I'm sure it'll surprise you that I believe the exact opposite, and that is that it corroborates what Mrs. Johnston says occurred. But that's why you were all here. You will listen to that.
Guys, I'm so sorry. We're getting closer. We're getting closer to what we're going to see after this trial.
Make your own determination.
Oh my God.
Now, Mr. Kalasaric hinted at something but didn't actually use the words that Judge Stansbury will, and those involve self-defense against the danger of bodily harm. So the defendant here is saying everything he did was because
colorful poop.
His wife was aggressive to him. She was coming at him. So that's why he did what he did. But then yet he didn't lay a hand on her, so that's a little confusing. But there's a bunch of instructions that go with self-defense that the judge will read to you. It says that, the defendant can use non-deadly force in self-defense. Okay. But when does self-defense not apply? In this case, it does not, and here's why. Because for self-defense to apply, the defendant cannot be at fault for creating the situation that gave rise to the altercation. Well, he did. He went, he sent a text message, he asked a question, he called her, she hung up, he was pissed. So he went over there to the house from Walmart, walked in, her phone was on the table, he grabs her phone right off the table, right in front of her, and she goes, "What are you doing?" And he immediately starts yelling and getting aggressive with her. She keeps saying, "Give me my phone." She's begging for her phone. He didn't give it to her. You were saying he didn't want it. Okay. He's the one who made this whole situation occur. He hadn't have been acting the way he did. He was the one out of control. He was the one creating all the problems that day. And there's another part to that, and it's whether or not he had reasonable grounds to believe and an honest belief that he was in imminent danger of bodily harm. Now, it doesn't mean that, he thought someone's going to take his head off or something. Bodily harm. He's not afraid of her. He's not scared. He wasn't afraid she was going to do anything. He was doing this, and it wasn't that, "Oh my God, I thought she was going to hurt me." You heard him say, "No, I was holding back so I could see her phone."
That's true. It is true. What she said is just true. However, even though I said at the beginning, I don't think he was getting slapped by her. And no one wants to get, even if it doesn't hurt, get slapped in the face, in the eye, in the head. So, maybe there is an element of self-defense here. But that does not mean he did not assault her.
That's what he was afraid of, is that he would not be able to get through her phone to see what information he hoped was on there or believed in whatever way might be there. Now, again, as you go through all the evidence and the instructions Judge Stansbury gives you, I believe that you will find Mr. Johnston did not, in fact, act at all in self-defense, and that you will return a guilty verdict to the charge of domestic violence. Thank you all again for your time.
Well, ladies and gentlemen of the jury, you've heard the evidence and the arguments of counsel. The court and the jury have separate functions. You decide the disputed facts, and the court provides instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law or apply your own conception of what the law should be. There will be copies of these written instructions with you in the jury room, so please do not concern yourself with trying to memorize what I'm telling you now.
As many as you
A
want.
criminal case begins with the filing of a complaint. A complaint informs the defendant that he has been charged with an offense. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charge and puts at issue all the essential elements of the offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be found not guilty unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged in the complaint. Reasonable doubt is present when, after you've carefully considered and compared all the evidence, you cannot say that you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Evidence is all the testimony received from the witnesses and the exhibits that were introduced during the trial. Evidence may be direct, circumstantial, or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. This includes...
I really thought I canceled it. I canceled the jury. No, we're not listening to jury instructions. We're just not. Okay, the jury is deliberating. Anybody want to guess what they're going to say? Thank you, Fozzie. Anybody? Anybody? Okay. I'm putting it on now. Verdict. Thank you, Carla. Thank Thank you, JK. Thank you, security. Thank you, Donald. She's in the courtroom. You
All right, please be seated.
See her?
The record should now reflect that the jury is back in the courtroom, all 8 members of the jury, the alternate having been excused. Juror number 4, it's my understanding that you were elected foreperson of the jury?
I was.
And has the jury reached a unanimous verdict?
We have.
Please provide the envelope containing the verdict forms to the bailiff. Thank you, ma'am.
Plot twist. The whole jury finds the mom guilty, the wife guilty, even though she's not on trial right now.
All right. In the case of the State of Ohio versus Ryan W. Johnston, case number 24 CRB 01550, on the charge of domestic violence, we, the jury in this case, find the defendant, Ryan W. Johnston, guilty of the offense charged in the complaint. It appears to have all 8 signatures as well as the foreperson signature in the designated line. Mr. Calceric, do you wish to have the jury polled?
Yes, sir.
Very well. At this time, I'm going to go ahead and have the jury go back into the jury room. I'm going to come in and very, very briefly speak with you before we can get you guys on your way. The parties have a position on sentencing. Would you prefer to do it now?
I know. We all took the girl's side. We all just automatically took the girl's side on the poor innocent man again. Men get the short end of the stick, guys.
I really don't have a preference, Your Honor.
Do you wish to go forward today?
I mean, we're all here, but it doesn't matter to me either.
No, I think it's fine. I think it's more efficient to do it that way. So I will endeavor to be as brief as possible with the jury. But at this time, we'll take our recess and the jury will go back into the jury room.
All right.
You're right, he won't.
We're back on the record in the
Won't
Johnston
screw up.
case, which is 24 CRB 1550. The defendant's present in the courtroom with counsel. The prosecutor's here. The jury has been excused after returning a verdict of guilty to the sole count in the complaint, that of domestic violence, as a misdemeanor of the first degree. Mr. Calceric, prior to the court imposing sentence, do you care to make a statement of mitigation on behalf of your client?
Yes. One of the benefits of having the trial is the court's had the opportunity to hear the allegations, so we don't have to really go over all that. My client is gainfully employed, supports his family. He has no violent criminal history. We believe that he's a good candidate for community control sentence, Your Honor.
All right, thank you. Mr. Johnston, you have a right to address the court before any sentence is imposed, but you're not required to. Is there anything that you'd like to say, sir?
Oh, CJ, you got busted. CJ, he saw you. I can say anything I want, but he can read your text. Fozzie, go back to eating crayons. Don't eat the white ones.
Very well. And Ms. Yeager, did the state wish to be heard regarding the matter of sentencing? And has Ms. Johnston been advised of her right to address the court before sentence is imposed?
Yes, Your Honor. Mrs. Johnson has been so advised. She is present in the courtroom. She would defer to the court's judgment regarding sentencing. And as far as the state is concerned, I know we've discussed other possible outcomes in this situation. While Mr. Johnston does not have any violent criminal history, and he does have like an OVI from a few years ago, we would agree that community control sanctions would be appropriate with terms of getting a mental health assessment, going through with any treatment recommendations on that, and then whichever anger management / VIP program probation would find appropriate, we would ask that he be assigned to do that as well.
All right, thank you very much.
And then abide by the terms of the
protection order.
I think it's called restraining order, but yes, that.
From my understanding, is that issued by the DR court in conjunction with the proceedings over there?
Yes.
They dismiss the CPO and they enact
It's just so hard to find the right one.
My understanding, if I remember the testimony correctly, was that that's through 2026.
2 years, I think. Something like that.
All right. Is there any jail time credit? Were you ever arrested as a consequence?
Yeah, he was arrested that night, so he has at least one night, right?
So it was the 17th of November.
He was arraigned the next day.
The very next day. So it looks like he's got 1 day worth of jail time coming.
Fozzie, can you please talk to me for 1 second? Real quick, Fozzie. I know you're working, but can you talk to me for 1 second?
All right.
Yes, Your Honor, I just found the section of the entry that that order should remain in effect for 2 years from the filing date, which was December 9th, 2024. So it's effective until, unless otherwise modified, December 9th, 2026.
All right, thank you. And it is technically referred to as a restraining order?
It says agreed judgment entry.
It is a restraining order.
But yeah, they dismissed the civil protection order and are establishing a no contact restraining order. It's the terms used.
All right, thank you. Okay, so I just wanted to share one thing that the jury talked about when I was in there. The reason that the verdict took so long to reach is because they really parsed out every single element of the offenses and the entire instructions. In fact, one of the jurors thanked the fellow jurors for being as thorough as they were. So I want the parties to know that this wasn't just some sort of knee-jerk, what do you feel like? Yeah, let's do this. The jurors did what they were supposed to do. They thought about it. They decided what they believed the facts to be, and they applied the law. Now, as far as sentencing is concerned, another thing that I said to the jurors was, we often talk about the least serious form of the offense, the most serious form of the offense. This probably isn't the least serious form of the offense, but it certainly trips towards that end of the spectrum. So I'm going to impose a 90-day jail term with 89 days suspended and credit for 1 day previously served. The defendant will be placed on probation for a period of 1 year. He'll be required to undergo a drug and alcohol assessment and successfully complete an anger management program as directed by the probation department. I will put on a prohibition about the consumption of alcohol, illegal drugs, or the abuse of prescription medication. He's to maintain suitable employment and abide by that restraining order and follow any other rules the probation department sets. The fine is going to be $200 plus the court costs. You'll get information about making those payments when you get to the clerk's office. And the other thing I need to advise you of, which I'm sure your attorney's already done, Mr. Johnston, is by virtue of the conviction of an offense of violence which involves a family or household member, it's now unlawful under both Ohio and federal law for you to be in possession of a firearm or even ammunition. There's a portion of this judgment entry of sentence that the bailiff will go over with you, and we'll have you sign off on that. Now, as far as your rights to appeal, you have the right to have a notice of appeal filed on your behalf within 30 days of today's date. You have a right to obtain a transcript of the trial as well as any other relevant proceedings, and you have the right to be represented by an attorney throughout the course of your proceedings. If you qualified as indigent, you would have the right to have a counsel appointed at no cost to you and a transcript provided at the public expense. So, Mr. Johnston, do you have any questions either as to the sentence that's been imposed or your rights to appeal?
No, sir.
Mr. Kalsaric, anything further?
No, sir.
Anything else, Ms. Yeager?
No, Your Honor.
All right, very well. This court stands in recess. Thank you.
So we'll go down.
All right.
So you put you on probation, give you credit for the daily.
Sorry. I was getting ready for the next one. Yeah, you're frozen because it's over. It's over. I thought I had enough time. Nope, not muted. Thought I had enough time to get. I ran away for just a second, and I ran out of time. Now, listen. For the next one, I have a special guest coming. I just need one more second for this special guest. So, talk amongst yourselves real quick while I text somebody. I'll be right back. It'll just take a second. Okay. All right. We're good now. Any second, our special guest is going to come. And I don't want to start talking about it without the special guest because it's my daughter. She's going to explain things so much better than me. Now, just so you know, the next hour of this stream is not a court case at all. It has absolutely nothing to do with court. Okay? It's a field trip to something else. I am begging you. I am begging you. I really doubt anybody in here has ever seen this or knows what's going to happen. I am begging you. All right, here she is. I am begging you. No spoilers. Don't spoil anything, okay? So we're leaving the courtroom just for an hour. And we're going to see something spectacular, okay? No, I have a diaper on. Yes, I did. I did, Kay. You guys can hear me now, right? You're not frozen now, right?
I can hear you.
Hi, Tiffany. That's Tiffany. That's my daughter. So we have a delay. Can you see chat, Tiff? Because there's a delay between what I say and what they read.
I think so, yes.
Can you guys hear me? Okay. Thanks, Jude. Thank you, Jude. I have to ask Jude. I have to. Do you get annoyed when people start singing the song? You know the song. You know what I'm talking about. TJ. Okay. We're leaving court, and let's see if I can do us both full screen. No, I can't. It's fine. It's fine. We're going to go to someone elite at his job. It's just great because he's elite at his job. We watch court cases where people are doing the dumbest stuff and making the worst decisions, but we also watch court cases because we see prosecutors, defense attorneys, and judges elite at their job, and we love watching that. This man is elite at what he does, and when he plays Minecraft, okay? His name is Technoblade, right? He died. He's no longer with us. You're gonna hear the saying Technoblade never dies a bit in these videos, but he actually did. He passed away from cancer, all right?
In the shoulder, yeah.
It was very sad. It is very sad. Very, very sad. Now, we're about to watch something spectacular and so mean. It is so mean, but it is spectacular and it is funny and it's just an hour.
It's just mean.
It was
some
mean.
people are born better.
Okay. See, kids these days, they don't think like we think. This is mean, but it's not because it's a game. And when you're in a game, you compete. And what they're competing over is the toe. Think about a football player. How often does a football player exercise his pinky toe? Never. Is his pinky toe important to him? Yeah, but his arms, his legs, those are way more important. Nobody ever exercises the pinky toe. Well, we're arguing. I mean, we're competing over the pinky toe of Minecraft. Now, Tiffany's going to explain it better than I ever could. But that's what we're about to do. All right, Tiffany.
I am echoing, they said. I don't know why I'm echoing.
When I mute myself, then see if you echo. Is it echo, or is it you can't hear us?
I say something, but I say it twice, only two times. Like I can hear me talking on the stream.
Oh yeah, mute your YouTube or turn off your YouTube. Don't have YouTube on at all.
I don't have YouTube on. I'm just in the stream. The link you sent me.
All right. I'm going to mute myself in a second, Tiffany, and then you talk and see if you still echo.
Hello? Yeah, I'm still echoing.
How, whatever you're listening to,
I'm not listening.
where's your earbud? Where's your ear? Sorry, guys.
AirPods are next to me.
Put them in. Try that.
Well,
That'll
I
work.
think it'll help.
It will.
Okay.
I can't hear you.
Yeah, I didn't think so. I can still hear me
Do you have a headset?
echoing. I'm on my iPad.
So you can't wear a headset?
I was this the exact same link or whatever from
Call it on your phone.
that.
Do it on your phone.
This is but it worked before when we did it with Jess. I wasn't echoing.
Oh, okay. Well, then continue on because it works.
Do you have it open on yours?
No.
Like, do you have the link that you sent me open and making sound yours?
No.
Because I think it's coming from your computer.
No, it's not.
Okay.
Now talk.
Hello?
All right. Is it still echoing?
I was not echoing. Nope.
Okay. I got it. We fixed it.
On your end. There we go.
All right, guys. She's going to tell you what we're about to watch. And just so you know, it's so good. It's so hilarious. Oh my God, it's so funny. There's a 90% chance that what I'm about to show you is going to bomb completely, and you guys might be bored. There's a 10% chance that this is going to be epic. There's 100% chance that I'm going to cry at the end. I just know it. But here we go. Tiffany. Go ahead. Take it away. Tell the story.
Okay. So Technoblade was known as one of the best Minecraft players ever. He broke several world records. He did incredible, amazing things in this game. And one version of the game that he played that he was outstanding in was Hypixel Skyblock, which is Skyblock is a type of Minecraft that you can play where you gather resources yourself when you're on this itty bitty little island, and it's very hard. But in a Hypixel, it's your island connected to a bunch of other people's islands, and you're all competing just to see who can have the best island. However, you're also all working together in order to gather materials and build things and whatnot, all together, but also against each other at the exact same time. So it's collaborative, but it's also competitive. It's both. Well, there are different tasks that you can do in this Hypixel Skyblock, and one of them that you can do is that you can become a potato farmer in order to craft potato, just to get more potatoes to eat and whatnot for everybody on the server. It's good, but it's not the best thing you could do in the server. It's
like my football thing. You can work on your arms, you can work on your legs as a football player, or you can work on your toe. Your toe is helpful, but
it doesn't help you. I mean, it doesn't hurt you, but it doesn't help really. But Technoblade decided randomly one day that he was going to be the #1 potato farmer in the world. He just decided that that's what he was going to do. So he started this series about how that journey to become the #1 potato farmer in the world versus one other person, Squid Kid, who was at the time the #1 potato farmer in the world, and who also took this title extremely seriously, despite the fact that it is a worthless title. It means nothing. But they both took it so seriously. They went back and forth for months, nonstop. They were on the computer, I think, somewhere like 23/7.
Yep. So Squid Kid is just a kid, college kid. He's not like a little boy.
Around the time, they were like maybe 19, 20-ish When this is done,
Technoblade was a superstar. He was like
Yes.
LeBron James.
And
This
this
kid,
Squid
Squid
was
Kid, is just a
nobody.
kid, and he took this title in Minecraft, potato farmer, #1 potato farmer, and he had it. It meant nothing, but he was so proud of it. And then one day, Technoblade walks by and says,
I want that.
I want
I
that.
want to do that.
We're going to watch it. Guys, it's so good. I'm
It's-
telling
it's-
you.
They got so
All right.
competitive over this worthless title. It's amazing.
Just so you know, this is also, he died from cancer, and his father continues
To upload videos
releasing
on his
content
account,
for him
and
and
you
raise
can
money.
donate. Yep, and every single if you buy merch from him, I think around 30 to 40% of every single sale goes to the Sarkova
Yes,
Foundation.
Bobby. All right, here we go, guys. I have to turn the echo back on, Tiffany, so you might have to mute yourself.
Okay. I can't hear the video.
Blade, where have you been all this time? Well, you see, I've been farming potatoes in Skyblock. That wasn't a joke. It all started months ago. I just got in a set of superior armor and wanted hot potato books to upgrade it. I could have just bought some from the auction like a normal person, but if Hypixel has taught me anything, it's that if you have a problem, the answer is slavery. So I had 20 potato minions with 20 enchanted lava buckets, 20 super compactors, 20 diamond spread-ins, because it's just free money. Get this.
I get it. This makes no sense to anybody. What you're hearing you don't understand. It doesn't make sense. A little boring. Just trust me. Hang in there. Hang on by a thread and keep going because it's hilarious.
Upgrade, and with this setup, I was making about 242,000 potatoes per day. At this point, I had enough potatoes for my armor. I could have stopped. I could have put an end to this, but I thought, no, what if I went even further? You can check your ranking in each individual collection, and I was already top 50 in potatoes. I decided at that moment that I was going to be the #1 potato farmer in Skyblock. How hard could it be? First, I needed to get more minion slots. Now, I already spent a lot of time getting to 20 minion slots because I believe minions are important. I mean, they work 24/7, gathering resources even if you never bother to log in, and as such represent the only way to achieve the dream that all Skyblock players share, which is to not have to play anymore. Unfortunately, each minion slot requires exponentially more resources than the last, so I did what any self-respecting Skyblock player would do, and sat in the shop menu buying ice for 30 minutes. I'm having fun.
Hold on, it gets better. I
I
promise.
dropped out of college for this. And after spending many hours and 15 million coins, I finally unlocked the 22nd minion slot. At this point, I thought I had first place in the bag. I mean, there's only a couple of solo players that have 23 minion slots, and I figured if anyone went to that much trouble to get more minion slots, they'd probably spend it on a minion that actually makes money, like clay minions. But I thought to myself, you know what? I'm gonna go even more overkill, alright? I'm gonna upgrade my level 7 potato minions to level 9. Now you might be thinking to yourself, oh, Technoblade, isn't that obvious? Isn't it just more potatoes? Why wouldn't you do that immediately? No, it's not, alright? Upgrading past level 7 on minions never makes sense. You're never getting that money back because upgrading cost over 100,000 potatoes just to get to potato 9. That'll take over 2 months to get that money back, over 8 months for level 11. It's just a bad idea. Oh, but Technoblade, isn't that just a long-term investment? No, it's not. Remember Cactus Farms? Remember how they were great for like 5 days and then the admins obliterated them in an update? Yeah, you really think your dreams are going to go that long without getting crushed by the admins? No, you're never seeing that money again. I'm sorry, it's gone. But I wasn't farming potatoes for profit. I was farming them for honor, for glory. So I started upgrading them to level 9. My last hidden weapon was the Farming Crystal, which increases the speed of nearby farming minions by 10%. I could only fit 12 minions in that radius, but I thought, you know what? Whatever. I'll just make a second Farm Crystal. Here we go! Oh, okay. No, I'm glad Skyblock tells you that after you make a second crystal. I mean, it's not like you could just tell me that after I make the first crystal. Whatever. It's not a total waste of money. At least I can auction. Thank you, Hypixel. If I wanted to fit all my minions in that 8-block radius, I'd have to think in the 3rd dimension. And so, after restructuring my farm, the potato pyramid was complete, yielding 309,000 potatoes per day. But as an ex-English major, I decided that math wasn't enough to defeat my enemies. I needed to consult the classics. In The Art of War, Sun Tzu says, if you know the enemy and know yourself, You need not fear the result of 100 battles. So I decided to do some investigative journalism. I discovered a forum post from September in which a user named I'm a Squid Kid bragged about being ranked #1 in potatoes. By stalking his profile, I found another post weeks later in which he suggested he was now around 7 million potatoes.
This poor kid is so happy about this title. This poor kid is the #1 at something in Minecraft.
By putting these two data values on a grid, I could calculate the slope to estimate his average daily potato yield. It wasn't perfect, but it was the best method I could think of to estimate how strong his potato farm was. I mean, it's not like I could just go to his island and look at it. Wait, that worked? But what I found shocked me to my very core. No, this can't be. This man made 8 potato 11 minions. And then he painted the Mona Lisa! It was at this moment I realized that I wasn't dealing with a potato madman, but a potato supervillain. At this point I fell into despair, all sense of rationality, even the slightest hope of making his money back. This man had thrown them all away to farm potatoes. I had 2 more minion slots than him, but his minions were so high level that he was still making more potatoes than me at 310,000 potatoes per day. But I wasn't even worried about his potato farm. I mean, I still had some minions to upgrade. I was confident I could make a stronger farm. I was worried about his head start. The month I spent farming the Pigman sword, he'd already been farming potatoes. According to my calculations, he was already 7.5 million potatoes ahead of me. Even if all my minions magically became level 11 at that very moment, it would take 107 days to catch up. I can't go that.
Just so you know, your kids know math. Your kids who play these video games, they know math better than you think they do.
Long without uploading, my fans will murder me. So was that it? Was my quest to become the #1
And what he meant there is he was trying to get to 3 million subs. He's way over that now. But he only had 2 million some subs. And the only way to get subs is to upload content. So if he went for these potatoes, he was just giving away his YouTube stuff completely.
potato farmer in Skyblock destined to end in failure? No, I refused. The sunk cost fallacy wouldn't allow it. If I wanted to defeat a man that had descended into potato madness, I would have to take his insanity and triple it. It was at this moment I spoke words that had never been uttered in the history of Skyblock. I should get minion expanders. Minion expanders have long been known as the most useless item in Skyblock. So you know how all minions have this like 5x5 area in which they work? They don't actually need this area. They could work with 1 block just as fine, because all I do is break a block and then they place it right back. They don't need options. So what the minion expander does is it turns that 5x5 area into a 7x7 area. Why? Why would the minion need more options so it doesn't get bored? But with the Slayer update, they added a hidden attribute to minion expanders, which buff minion speed by 5%, which is still garbage. Diamond spreading gives like 5 times the value, and I didn't have enough space to put both of them in my minions. But unfortunately, diamond spreading only gives diamonds. If I wanted to become #1, I'd have to sacrifice all that free money for 5% more potatoes. With the minion expanders taking up so much extra space, the potato pyramid was no longer enough to fit all my minions within the farming crystals radius. So I built the Potato Dome! Boasting 5 floors, the Potato Dome could fit all 22 expanded minions. And after I'd finished upgrading the rest of them to level 9, the Potato Dome could now produce 337,000 potatoes per day. At this point, the Potato Dome was the most powerful potato farm in Skyblock. I was ranked 20 on the leaderboards and rising fast, and yet I knew, in my heart, that it wasn't enough. It wasn't even close. But what more could I do?
I know, just
farm
watch.
potatoes by
Just watch.
hand? I actually did for like an hour. It made a tiny dent. Sure, it would have worked eventually, but come on, is mindlessly repeating the same task for hundreds of hours really what Skyblock's all about? Okay, yeah, pretty much, but I wasn't about to do that, man. When I said 100 hours, I was not kidding. And yet, as time went on, it began to seem like that was truly the only way. The opportunity of defeating the enemy is provided by the enemy himself. Sun Tzu. I'd done it. I discovered a critical flaw with Squid Kid's potato farm. His minions were too close together. Now, with any other kind of minion, that wouldn't have mattered at all, but potato minions are unique. When they're too close together, they'll start trying to plant in spots the other minions already planted and get stuck in an infinite loop, dragging down the overall farm's potato output by as much as 90%. The reason he hadn't noticed this and was still first place in potatoes is because this only happens when someone is online and on the island, because otherwise Skyblock just runs a calculation to guess how many resources your minions would have made while you were offline. Anyways, he left the door to his AFK machine open, so I left my alt in there. Welcome to the real world, Squid Kid. Okay, can we take a moment to talk about Jerry, alright? I got a Jerry here. I got a Jerry there. There's actually 2 Jerrys in there. I have video evidence, okay?
He put his alt in there so that it says potato minions. This guy's poor potato minions could not plant anymore. This guy's just living his best life. And he's just starting to destroy him.
Look at this. He's multiplying. He's undergoing mitosis. But that's not all. The other day I was just minding my business and then... why is he there? I knew I couldn't rely just on sabotage to get first place, because who knows if there's other people out there just like Squid Kid throwing away everything just to farm more potatoes. So I decided to look into alternate fuel sources for my minions. I mean, enchanted lava buckets are already the most efficient permanent fuel source in the game, but what about temporary fuel sources? So I got a bunch of hamster wheels, which give twice as much of a boost, 50%, but for only a day. And I threw like 100 of them into the potato dome, and it started making 450,000 potatoes per day. And so the days went by. Every day I'd log in and AFK on Squid Kid's island with my alt, while my minions burned through hamster wheels, quickly bringing me into the potato top 10. I was finally making good progress, until one day, when I went to AFK on his island again. Oh god, he's online. What do you want? Why do you keep doing this? I just wanted to check on the Last Supper, man. You AFK'd on my island for 12 hours! It was a good painting! I figured Squid Kid would find it a little bit suspicious if the same guy was AFK at his island every day, so I got a second account. And then I left them both in there. Be extremely subtle, even to the point of formlessness. What? Why? Why are you guys here? I've been buying some enchanted baked potatoes from the auction house. It's not the most efficient use of my money, but look, I need potato 11 minions if I want to catch up as quickly as possible. We can't only have 2. It's not enough. Well, I mean, it is enough, but I want to upload within the next year. But the problem with the auction house is that it's filled with crazy people. Look at this guy. He's bidding 3.9 mil for 26. You think that's bad? 11 million. I could see someone bidding 7 million on a stack of enchanted baked potatoes. 8 million. I could understand that. 11 million. Deranged psychopath. There's no justification. Send this man to prison. After a couple days of minion farming and buying enchanted baked potatoes, we have 102, which in regular potatoes is over 2.6 million, and we can only make 4 maxed potato minions with it. That's all we can make. That's how expensive maxed potato minions are. They're so good, but it doesn't matter because they cost so much. It's never going to pay off. They're all gone. Whatever. It's for the leaderboards. I had to sell everything so that I could invest it in potatoes, man. I had to sell my young dragon armor, my rare cake collection, massively overinflated Halloween items. I had to mortgage my house. It's crazy out there. I actually did pretty well during the Halloween events, which allowed me to raise a lot of money. But I'm just saying, look at this spooky pile, right? Limited edition item with my name and pig rank stamped on them. Could you imagine how much money I would make if I put this on the auction? I would make Dan TDM's 15 mil water bottle look like tap water. He left a sign for me, whitelisted. What do you want from me? I'm just ruining Squid Kid's whole life. He's traumatized. He's just living in fear. Why are they here? Why do they keep showing up? But after a few days, I ran out of hamster wheels, and I had to resort to my final weapon. The catalyst. The catalyst is the strongest fuel source in the game, tripling your minion output, but they only last for 3 hours. Fortunately, I had a couple. With the power of catalysts, my potato output skyrocketed, and I put that all back into leveling up my minions. And in a matter of days, I had 22 Potato 11 minions producing 893,000 potatoes per day. I don't make hot potato books, I make hot potato libraries. Originally, I thought I'd have to go bankrupt buying catalysts if I wanted to catch up to Squid Kid, but I actually discovered that catalysts are amazing. I can buy the materials to make one for like 10,000 coins on the auction, and then each of them makes 14,000 coins in potatoes. This is a miracle. It's free money. So every day I sold hot potato books, and then I bought more crystals, and then I sold more hot potato books, and then I bought more crystals. And that's the story of how I made infinite money. Well, not really, because you can only use so many per day, but I made a lot, and now I was ranked 3 in potatoes. I did some more investigative journalism and found the guy ranked number 2 in potatoes. I'm gonna give you guys 3 guesses as to who left a funny rating on his post. Squid Kid! I was right on his tail, but I decided to visit his island to see just how strong his potato farm was. Oh, this is a joke. This is pathetic. Only 18 minion slots. This is just sad. I've seen Irish famines with more potatoes than this farm. You might get away with this farm in some garbage vegetable like carrots, but potatoes? How dare you? Oh my god, this crystal. This crystal, it only covers 5 of these minions. Oh, I'm gonna throw up. Against a farm like that, I easily took rank number 2. It seemed like I was only 1 step away from my potato dreams, and yet Squid Kid had been so dominant on the potato leaderboards that he was still 3 million potatoes ahead. But with catalysts, such a lead could be destroyed in a matter of days. Still, to be safe, I kept AFKing on his island, until one day. I checked my alts window for a moment, and the island was full. 2 guys I'd never heard of before had called the police on Squid Kid and brought a helper to investigate him. Who called the police? Whitelisted. Are you Squid Kid's alt? No, I just AFK here a lot. As a hobby. I'm so suspicious. He doesn't believe me at all. I'm getting banned. They'd been investigating while Squid Kid was offline. I met him later that day and decided to warn him. Squid, I know we've had our differences, but the police are after you, man. I saw a helper. Squid. There were 2 dudes, Squid. They came to your island with the helper. They were snitching. I don't know why. I need names. Okay, let me get my screenshots. You gotta be careful, man. The snitches be everywhere. Anyways, I'm gonna go AFK now. Just act natural. Just and I'm gone. It seemed strange to be helping my number 1 enemy, but his sheer dedication to farming potatoes had earned my respect. I had to give him help from one potato brother to another. Also, I'm deeply scared of him. Did you see what he said when I told him the names? Names noted. That is serial killer talk. We ain't gonna be hearing from those 2 guys ever again. I kept farming potatoes, and in a matter of days, Squid Kid's lead was almost completely destroyed. And yet Squid Kid himself had no idea. He even put a billboard on his island, number 1 in potatoes. But why would he suspect? Just a few days ago, he'd seen proof on the forums that he was millions in the lead. The poor fool had no idea what was coming. Has it updated? It hasn't updated. Alright, I'm going to the hub. Has it updated? Ah! Yes! Number 1 in potatoes! To celebrate, I took my 2 alts and my main account, and then I AFK'd on all 3 of them! I think at this point Squid Kid knew that the alts were mine, but he was so confused. Why? Why had Technoblade been AFKing on his island for weeks? He was so confused that he didn't even realize that his potato leaderboard spot had already been taken, so I went to confront him myself one final time. What do you want? Why are you doing this? Your potato rank 1 spot is now mine. He's checking. He's checking.
Hold up.
For years, my machinations lay undetected. This is all I have.
This is all I have.
Squid, I found a problem with your island. A critical flaw. Get over here. Over here. Squid, get over here. This sign, it has the wrong number. Pretty bad week for Squid Kid overall, I'd say. First he got arrested, and then I cyberbullied him, but it had to be done. And let me just say, there is no chance of him catching up. I even got 23 minion slots just to bury any hope he had. This spot is mine, and that's the story of how I became #1 on the potato leaderboards, and we lived happily ever after. All the loose ends finally tied together.
It gets worse.
Well,
It gets
except for
worse,
one
guys.
thing. Oh God, there's another one. There's another Jerry. And he's staring right at me. There's another one. There's a Jerry in the water. No. There's another one out there. I don't understand. What do you want? What do you want?
It gets better. It
There's
gets
another Jerry on the bridge.
better. Hold on.
If
Hold on. So, luckily, we get two perspectives. So this is just a real short video. This is 6 minutes long, and it's from poor I'm a Squid Kid. It's from him. Poor guy. I feel so bad for him. Oh, this music is going to demonetize me.
I've had my fair share of odd things happen to me while playing Minecraft, and nothing comes even remotely close to the whitelisted mystery, which you're going to be learning about today. Yeah, I really don't know what this dude's been doing on my island the last few days, but he's kind of...
That dude is Technoblade. Could you imagine? You go on your island and Technoblade is there? Holy crap.
I'm just vibing, so I'm gonna leave him here. I looked back in the logs to see when the first time was that I acknowledged this dude, and it was October 25th. At this point, I don't know what they are, who they are, or what they want, so I'm just very confused. I wanted to find out what they wanted from me, and I tell you what, it was driving me freaking nuts. It's the first time that we went to my island at the same time, so I took the opportunity to try to talk to him. He warned me that there's a helper out to get me, and then this nutcase of a person, whoever this is, decided to go AFK in my cobble gen again. People like this really just need to be locked up, let's be real here.
Lock him up.
Who's this bozo and what does he want from me?
He wants everything from you. He's gonna ruin your whole life.
There he is! Yeah, we gotcha, scumbag. This one had me real confused. I couldn't tab its name, so I knew it was nicked, but its name was whitelisted 3, so that means a YouTuber chose the name as the nick, and it had 700 health with its armor off. And then on top of all that, it had a Time Dio skin when I right-clicked it. I quickly verified that there is no account with the name whitelisted 3. I checked the friends list of whitelisted and whitelisted 2, and the only people they had friended was Technoblade and Jin. Scumbag thought he could just leave my island, but I'm a quick thinker.
No, you're not.
So, scumbag, we got you. Jupiter police are gonna track your ass down, and guess what? We got you. Thanks a lot for letting us know who you were. And Google is all over your IP address. You're dead moose meat. And then after they disclose who you are, I'll send my boys to come see you.
Names noted.
At this point, I really just thought Time Dio was there to time-lapse my island, so I really didn't put any more thought into it. Boy, was I wrong.
Yeah, I'm so sorry. I'm so sorry this happened to you. I won to you, Technoblade.
That sign was a joke, but it's really
you're
him.
not.
Hey, Technoblade.
What is going on, and why is it happening to me? I knew it was him. He's been putting bots on my island for weeks. If only I knew then what I know now.
But potato minions are unique. When they're too close together, they'll start trying to plant in spots the other minions already planted and get stuck in an infinite loop, dragging down the overall farm's potato output by as much as 90%. Anyways, he left the door to his AFK machine open, so I left my alt in there.
How could I be such a fool? The pig caught the squid.
He got so
acting
many
like a
subs from
rat.
this.
I was too busy chasing the cheese, and I forgot about the traps.
Technoblade is big.
Yeah, he's trying to confuse you enough. He's big brain, okay?
Potato farm is superior. That's why he's visiting you. It's because of the potatoes. 1,000 years too late.
Technoblade is visiting you because of potatoes. That's the craziest thing. What does that mean?
Wait, send screenshots of this.
What?
Dude, that's why
There's no way he's number one right now. I'm number two! That is impossible!
Wait, what?
He's number one potato now, what?
What?
Oh, it's gone.
Well, Technoblade, you might have won the battle, but I will win the war.
Now the whole server is
Form
mad at
conga lines in
Technoblade.
Lobby 1 to show resistance against the pig.
Now they're all going to work together to take down Technoblade.
Team Squid is forming, and we want our spot back.
You're muted, Mama.
The other day I was farming potatoes by
And now it gets worse, guys. This is where it gets elite. This is where he goes to the depths of hell to destroy this little boy. Oh, Technoblade.
Technoblade, where have you been all this time? Well, you see, I've been farming potatoes in Skyblock. That wasn't a joke. It all started months ago. I just got in a set of superior armor and wanted hot potato books to upgrade it. I could have just bought some from the auction like a normal person, but if Hypixel taught me anything...
Wrong one. Oh, jeez. Potato War 2.
The other day I was farming potatoes by hand when a man visited my island and asked, why? Didn't you already win the potato war? But no, the potato wars never ended. To understand how things ended up like this, we've got to go back to November. When I dethroned Squid Kid and became the #1 potato farmer in Skyblock, I went to his island and laughed at him for half an hour. Then my co-op members showed up, and we all started laughing at him. It was not a good day for Squid Kid. He updated it! And then I left. Squid warned me that he wasn't giving up on rank #1, but I didn't care, so I uploaded the Great Potato War. But in the days after that, I did nothing. I'd spent so long working to become #1. Now that I had done it, I I didn't feel anything at all. I had no idea what to do with myself. I mean, the video did all right, but not nearly enough to justify the time I had spent on it. And after I uploaded it, so many people started using potato minions that the price of potatoes dropped 30% in the auction house. My plans to become rich had failed both in-game and in real life, but at least I had my potato rank. But when I visited Squid Kid's Island 3 days later, what I found shocked me. He had 23 minion slots. Now, when I made the Great Potato War, some people criticized me for violating Sun Tzu's most basic tenet. Whatever you do, don't reveal all your techniques in a YouTube video. You fool. You moron. But my belief that the Potato War was already over hadn't been baseless. Between my 3 extra minion slots, most of Squid's minions not being max level, and the price of catalysts skyrocketing due to needing the same materials as a new quest, Squid Kid would need almost 100 million coins to catch up. And I knew for a fact he was broke. I decided to do some investigative journalism. I'd seen a new sign on Squid's Island advertising his new guild. So I did what any normal person would do and bought another alt account, and then I infiltrated the guild. But what I found confirmed my worst fears. People were helping Squid Kid. I'd cyberbullied Squid too hard. People had seen the video, felt bad, and gone to his island to hand him the spare items he needed to make more slots, or in some cases just pay him millions of coins, all with the express purpose of defeating Technoblade once and for all. Now, I can't complain about other people getting free stuff, but watching tens of millions get given to my arch nemesis by my own viewers, it was a bro moment. In a week, he had a farm even stronger than my own. My worst fears had been realized. Squid was catching up. If I wanted to remain number one, I had to act fast. Once more I consulted the wisdom of ancient times. Let your plans be dark and impenetrable as night, and when you move, fall like a thunderbolt. I couldn't let Squid learn of my plans, so I boarded up the Potato Dome. I hired goons and swore them to secrecy. I knew Squid would be monitoring my actions, so I started an SMP series to throw him off the trail. And like that, I began my plan. I knew there was only one way to defeat Squid once and for all, by building a farm so powerful it reached the theoretical potato limit. And to do that, I would have to do something no solo player had ever done before. Unlock the 24th minion slot. It wasn't going to be easy. Fortunately, I'd already reached 100 million coins by selling potatoes before prices had fallen. I paid my goons to start gathering the resources we needed, whether that was by purchasing directly from NPCs or scouring the auction house 24/7. In the meantime, I headed to the Spider's Den, where I fought Tier 4 Tarantula bosses until I reached Spider Slayer 5, unlocking the Tarantula minion, which gave several new minion crafts. Progress was steady, but we soon encountered an obstacle. Enchanted mud, and it was such a useless item that even if you had the money to pay for it, nobody was selling it on the auction house. I had to go on a manhunt to find someone who was actually using sheep minions so I could trade for it directly. This guy says he has some enchanted button for me. Wait, you're not pulling a Fugle, are you? You wanted some enchanted sugar cane, so that's the approximate equivalent in value. Pleasure doing business with you, Fugle. I partially forgive you for your past crimes. Alright, it took 3 days and over 80 million coins, but we finally got all the materials we need to craft. Just look at this. It's beautiful. It's so organized. These are enough to make 50 unique crafts, and then we'll have 24 minion slots. So we're just gonna speed up the craft in here. We did it, boys! The 24th minion was up, and my farm was now producing 1,067,000 potatoes per day. I now had the maximum number of minions, but if I wanted to make the greatest possible potato farm, there was still one upgrade I needed to get. An upgrade even dumber than all the past upgrades combined. Unfortunately, the website I used to stock Squid Kid's auction bids revealed that he was already working on it. I had no other choice. I once said that the most useless item in the game is a minion expander, but that was before I learned about the flycatcher.
Fozzie, Technoblade and his dad is in the movie.
Flycatcher is an upgrade which increased minion speed by 10%, 5% more than the minion expanders I was currently using. Oh, but Technoblade, that sounds great. Wrong. You would not believe how difficult it is to make a flycatcher. First, you need a fly swatter, which drops from less than 1% of high-level tarantula bosses, and then you need over 10 million coins worth of tarantula silk. To give you guys a quick visual of how many materials we're gonna need some of this, a little bit of this too, some of this, some of that, some of these, and a little bit of that. And if we combine all of that together, we can make 1 flycatcher. I need 24 of these! It was a daunting task, but I knew we had to start immediately. I'd been stalking Squid Kid's Twitter, so I knew he was a college student, and it was late November. Exam season, Squid Kid would be at his weakest. We had to get as many flycatchers as we could before winter break. I once more gathered my goons and ordered them to acquire the needed materials. My main problem was money. I still had a few tens of millions of coins left over, but if I wanted 24 flycatchers, that wasn't even close to enough. Fortunately, the Potato Dome was making over 3 million coins per day, not including the cost of buying catalyst, which was not an issue for me. Remember when I flexed on all of you with my chest full of catalysts? Yeah, I'm gonna be real with you guys. I was holding back. One of the things I did to raise money was grind candy during spooky festivals, which is how I unlocked this skeleton horse pet, which was a huge flex back in November, and now nobody cares at all. But the important thing about this skeleton horse pet is that there's actually a bug that most people don't know about. The skeleton horse can trample crops on other people's islands. Just kidding, I'd never do something like that. Because I'm a good person. It turns out it's really easy to glitch through doors, so the people visiting my island formed an orderly queue to wait their turn to break into the dome. This community is the worst. Getting tarantula silk was taking weeks, but getting the fly swatters was actually quite easy. Sure, it's an incredibly rare boss drop, but the thing is it's only useful for making flycatchers, an item which literally only 2 people on the server were going for, which is how my alt account ended up in a bidding war with Squid Kid. Why did he sent me a party invite? Now he's in the guild chat, pomme de terre. And I've been kicked. The people breaking into the dome have now started a potato cult. I don't know how to feel about this. It ended up taking 5 weeks of constant grinding, but on Christmas Eve, we finally had 24 flycatchers. This was largely thanks to this man who used his expert business skills to outsource the work to dozens of Skyblock tryhards, ultimately contributing 3,000 stacks of tarantula webs, for which I paid over 100 million coins. We'd finally done it. We'd created the strongest possible potato farm, producing 1,129,000 potatoes per day. Unfortunately, Squid's army wasn't slacking off either, and 2 weeks later he too had the strongest theoretical potato farm. Now the only way for him to catch up would be to farm potatoes by hand, and he had already started. I spent 10 hours constructing a gigantic potato farm covering over 21,000 blocks. For the next part of my plan, I went to Pigacle. Yeah, this is mine now.
You just rob it and sell it.
I'll just be taking this. Oh, this is good. I've been pretty broke recently. If you're wondering why I borrowed one of the strongest weapons in the game, it's because the Reaper Scythe has an ability that's crucial for farming potatoes. Now that I had it, I could finally... My farm is finally complete. And it only takes 85 minutes to replant. I made an AFK machine on my island so planted potatoes would keep growing even when I wasn't online. For a few days in January, there was a bug affecting a lot of farming minions. Potato minions were only making 33% the potatoes they were supposed to. Like any normal person, I immediately asked myself, how can I use this information to destroy my enemies? Hey, Squid, notice anything about your minions lately? Yeah? I farmed potatoes for so long that I began to question my sanity. I knew it was bad when one time, after finishing planting potatoes, I took a nap, and when I woke up I had no idea how long I'd been asleep, but when I checked my farm, I instantly knew, these potatoes have been growing for 3.5 hours. Shut up, I don't have a problem. Overall, Squid ended up farming over 1 million potatoes by hand. In that same time, I farmed over 5 million. I had to replant this entire field 19 times! Every day I monitored Squid's live streams on Twitch to the point where I amassed 9,000 channel points. I made sure to farm potatoes whenever he was live to demoralize him.
Is he really planting potatoes too? We're gonna go check. This dude has a mental illness.
As time went on, you could begin to hear the hope draining from his voice.
I just can't believe how much he's farming. We need Minecraft Mondays to come back.
At this point, I was pretty confident in winning the potato war, but the problem is I had no idea how large my lead was. I can see my own potato potato count and what rank I am, but Squid has disabled the API setting that allows other people to see exactly how many potatoes he's at. Little does he know I have spent the last 4 months meticulously updating a spreadsheet of our potato counts, which I did by crawling through his farm and timing each of his minions with the stopwatch every day to calculate his exact potato output. Based on the math, I should be about 22 million potatoes ahead, which would take over 200 hours of farming by hand to catch up. At that point, I thought the potato war was truly over. But everything changed with the pet update. The first change is that flycatchers got buffed to plus 20%, instantly increasing my potato farm's yield to 1,231,000 potatoes per day. Of course, the main part of the pet update was the pets themselves. I immediately started looking for a pet that would help me win the war. Unfortunately, none of the pets seemed geared towards potato farming. The best option I could find was the rabbit pet, which gave a small boost to your farming experience. A higher farming level gives you a small chance to get extra potatoes when you farm them by hand, so I figured the rabbit pet would probably help me farm potatoes, maybe 1% faster. It could be epic at worst, but we want legendary, please. It turned out rabbit pets had a secret third ability that only legendary variants had, which increased the speed of farming minions by up to 30%. And Squid had no idea it existed! I had to level up my rabbit as fast as possible, and since pet experience is based on skill experience, I decided to grind alchemy. You see, alchemy is the rich man skill, alright? If you have the money to burn on expensive ingredients, you can level up insanely quickly. And this was almost 2 months after I'd finished spending all my money on flycatchers. I had money to burn. I spent so many hours brewing potions that I ended up ranked 4 globally in alchemy. You want to know what level my rabbit is today? 96. It's not even max. This experience requirement is ridiculous. And in this time, Squid was fishing to level up his epic squid pet. It wasn't until 4 days after the update that he learned about the legendary rabbit and got one of his own. But it was too late. His pet sucks. It's level like 65 or something. Thanks to the rabbit pet, my minions now produce 1,586,000 potatoes per day. It's difficult to calculate exactly what my potato lead is right now because the rabbit pet only works when you're online, but the pet update has definitely pushed it to at least 25 million. Since the war began, I have farmed 158 million potatoes, which in hot potato books is over 6,000. I ain't losing this spot. One last thing I'd like to mention, while I was stalking Squid on my alt, the entire lobby was just piling on him in the chat. They were just hating on him. You see, after the first potato war video, Squid got 40,000 subscribers in the YouTube rank, and ever since then he's been getting hate because, oh my god, he just got YouTube rank because of Technoblade, it's all luck, he sucks. I just like to take a moment to defend Squid Kid and say it's not all luck. I mean, luck was obviously a big factor, nobody's denying that, but the thing is, most opportunities are created by luck. It takes skill to grasp those opportunities and turn it into success. The original Potato War video would have been so much less funny if Squid wasn't #1 and it was just some random boring guy. Now I talked to Squid afterwards, he's an adult. He doesn't care at all, but I care, alright? So if you see Squid in a lobby, say something nice to him, compliment his hair or something, because he's been dealing with cringe hate for too long, man. We gotta help him. That being said, if Squid Kid thinks he can take my potato rank, he'd better go farm for 1,000,000 years. It ain't happening, dude. You think I've been insane in this video? Wrong. There's actually so many techniques and strategies that I can't even put in this video because he hasn't discovered them yet. I'm keeping them in reserve. You have no idea. This man's been playing checkers while I've been farming potatoes. He's through.
He's not lying. Okay, guys, we have 2 more short videos and then we're going to the main event. Oh my god, wait till you see what I got for you. Okay. 2 more short videos if I can get them because, you know, I'm really skilled at this. I lost it. There it is. Nope. All right, history. I gotta go to my history because I lost it. I don't know what I did. Potato War 2. There it is.
4 months have gone by and I'm still #2 in the Potato War. It wasn't supposed to be like this.
This is only 4
Technoblade was
minutes.
supposed to get rank 1 for his video and move on to something else, which isn't what happened. Going all the way back to November, immediately after Technoblade and his co-op made fun of me on my own island, I knew it had to be done. I needed coins, hundreds of millions of coins that I didn't have. Naturally, I started asking everyone I knew for loans of crystal and anything that could help me get my minion slots unlocked. I managed to get together 57
you're gonna make me
catalysts,
cry. Yes,
and
you
it
did.
didn't even last my minions 12 hours, which was pretty sad to say the least. It took a month until I was able to consistently power my minions with catalyst, causing me to fall even further behind in the war. After Technoblade released his first video, Team Squid was formed to help me get my potato rank back. I thought I was one step ahead of him finding out about flycatchers, but it turned out they're 10 million coins each, which is a lot of money. The overflux capacitor from Tier 4 Wolves was valued at over 100 million coins at the time, so I decided I'd try to be lucky and grind for it. I ended up putting over 40 million coins into trying to get this item, and I didn't even get one. Through grinding Slayer, auction flipping, selling potatoes, getting donations, and selling statues on my island, I managed to get 24 flycatchers to go with my 24 level 11 potato minions. We were both at the potato production limit as far as minions go, so it left me with one choice. I had to farm the potatoes by hand. See, it would have worked too, if he was maybe 1 million potatoes ahead of me. 2 million potatoes ahead of me, it's still doable. 10 million potatoes ahead of me, it's doable, but now it's a bit of a stretch there. And he was even further than that.
Since the war began, I have farmed 158 million potatoes.
I'm only at 129 million potatoes. I'm behind by about 30 million here, so that's kind of rough. Farming that amount would take about 50 days straight of non-stop farming, which just isn't reasonably doable.
Thank you
So
so
to
much,
win the potato
Morton.
war,
Thank
we're
you.
pretty much gunning that they're gonna buff manually farming
Thank you,
potatoes in
Isabel.
the future, because farming 25,000 an hour at max speed is just really slow. To at least stay relevant in the potato war, I'm gonna need to get 15.5 million XP for my rabbit pet just to get it to level 100. Technoblade kinda left out in his video how expensive it is to level up a rabbit pet to level 100, so I'll tell you here. I'm already 10 million XP in, and I need 15 million more XP, and it's gonna cost me over 340 million coins. No, I'm not giving up yet, but there's no way I'm gonna pass him until we get some sort of update to how farming works. I tried my best, I really tried my best, it just wasn't enough. The number 1 potato spot is going to be mine, and I'm gonna get it even if it takes me 1,000 years.
Oh, poor Squid. Okay, this is the last video that I'm going to play for this, and then we'll go on to the main event of the day. Just so you know, Squid does post another video after this, but I'm not playing it. Technoblade gets the last word. Technoblade always gets the last word.
My name is Technoblade, and I am the fastest Skyblock player alive. To the outside world, I'm an ordinary Minecraft YouTuber, but secretly, I've spent the last year fighting to maintain my spot as the #1 potato farmer in Skyblock. Opposing me is Squid Kid, the former rank #1, a man whose obsession with potatoes is rivaled only by my own. In my last video, I talked about how the newly added rabbit pet could, at its highest level, increase the amount of potatoes my minions made by 30%, but I knew Squid would watch my video to find out my tactics, so I left out a few of the finer details. You see, the boost from rabbit pets isn't the same as flycatchers or catalysts. You have to be there on the island for the boost to take effect. Once you log off or go to somewhere else in Skyblock, that boost is gone until you come back. But while I was experimenting with the rabbit pet, I uncovered a few interesting facts about how the boost works. For instance, rabbit pets can boost other people's minions if you're visiting their islands as a guest. But minions can only get boosted by 1 rabbit at a time, so you can't just get 20 accounts with rabbit pets for infinite potatoes. But the third thing I found was the most interesting, and this is what Squid Kid didn't know. If there's multiple rabbit pets on the same island, which one boosts the minions? You'd think it'd be the strongest one, but it's not. If there's multiple rabbits, the minions will be boosted by the one belonging to whoever's been been on the island the longest. So, hypothetically speaking, if someone went to their island with their level 100 rabbit when someone was already there with a level 1 one, they wouldn't get their rabbit's 30% boost, they'd get the level 1 0.3% boost. Unrelated fun fact, did you know that Squid Kids Island is still open to visitors? Yeah, that's right, we're doing this again. So I bought a new Minecraft account, slapped a level 1 legendary rabbit pet onto it, and shipped it off to Squid Kids AFK pool. I knew I had to maintain absolute secrecy. I didn't even tell my goons about this, because I knew once Squid got wind of this, it would be trivially easy for him to prevent it. I waited until the day I released the second Potato War video to start. After that video, tourists flocked to Squid Kids Island to see it for themselves. My alt blended right in. Every day my alt would sit there in Squid Kids AFK pool to maintain rabbit priority. In fact, it usually had the rabbit pet deactivated during the day, since you don't need to have the pet out to keep priority. And since the rabbit was deactivated, if Squid checked his minions during the day, he'd find nothing wrong with them. But every night around 2 AM, Squid would leave his account AFK and go to bed. And that's when I'd strike, overriding his rabbit pet boost for the rest of the night. And yes, I memorized Squid's sleeping schedule to pull this off. I mean, at this point, how is that even a question? Of course I did. But unfortunately, complications soon arose. Squid and I had both been rushing to get our rabbits to level 100. I had a pretty heavy lead, and I figured it'd take Squid several more weeks to get his there. But unfortunately, an unknown third party got there first and sold his level 100 legendary rabbit directly to Squid. Of course, he didn't forget to brag about this victory on stream.
Oh my. You know who doesn't have a level 100 pet? Yikes, he has a level 99 rabbit pet. He's poor. It's only level 99. I'm screaming. Ah!
Little did he know that while he was flexing on stream, my alt was right there on his island, overriding his level 100 bonus. But my problems didn't stop there. You see, Squid got an alt account to AFK with his rabbit pet on his island while he was doing other things, and since the alt account had no reason to ever leave his island, it became much harder to keep control of pet priority. And sometimes when I had priority, he'd end up kicking everyone from his island because it was too full for his alt account to join, meaning I lost priority for the rest of the day. I was going to counter this by spending $30 to buy his alt MVP++, since that rank can bypass guesting limits, but unfortunately, on March 20th, my alt was kicked and Squid's Island was closed forever. The jig was up. But by that point, I'd already achieved my objective. The 2 weeks it took him to realize what was going on cost him about 2 million potatoes. Bit of a tangent, but I'm pretty sure I lost a few fans over the rabbit pet because everyone would just be hanging out. They'd just be chilling on my island with their level 30 rabbits activated. And I'd come see that, and I don't care if it's intentional or not. They're sabotaging my potatoes, so I'd kick them out of my island to get priority back. And then they'd come back 10 seconds later like, "Why did you kick me, Technoblade? I just wanted to meet my favorite YouTuber." And I'd be like, whoa, relax, dude, relax. It's not a big deal. I have a really good reason. I can't tell you because it's a secret. And they'd go like, "It's okay, Technoblade. I know the reason. It's because you hate me specifically. I'll just go leave forever now." And I'm like, "Wait, come back, no!" So Squid closed his island, which meant I couldn't sabotage him anymore. But what if I told you that was also part of my master plan? You ever noticed how my island has been open to visitors during the Potato War? In the last video I explained, I made an AFK machine on my island so planted potatoes would keep growing even when I wasn't online. I was actually using an advanced technique there called lying. This clip of the AFK pool is from November. I didn't even build the manual farm until January. You might recall from the first Potato War video that minions behave differently depending on whether there's people on the island or not. Because if no one's on the island, Hypixel's not going to waste resources keeping that server online, so they're going to close the server. And then when you come back, they're going to go, "Oh, well, it's been 7 hours. It's going to run a calculation and give you 7 hours worth of stuff." But as we've seen before, that calculation isn't perfect. So I ran an experiment, and in the experiment, I found that when someone's on my island, I get 10% more potatoes. And there was only one thing boosting my minions by 10%. The farm crystal. The farm crystal is an external buff, so it's not included in the offline calculation. So if there's at least one person on my island and Squid's island is empty, I'd get 10% more potatoes. Now, it was easy to get people to AFK on my island. What was difficult was getting people off of Squid's island. You see, even months after the first Potato War video came out, when the initial hype was starting to die down a bit, there would be at least one of my own viewers AFK on Squid's island every night, you know, as a joke. Sometimes I would be on Squid's Island on an alt account and I'd see someone say in the chat, "I'm gonna go AFK to help Technoblade win the Potato War," and I'd beg them. I'd be like, "No, dude, please, he fixed that months ago. That doesn't hurt him anymore." And they'd be like, "I'm helping," and AFK all night. Squid Kid was getting boosted by my own viewers, and there was nothing I could do to stop them, because what was I gonna do? Announce that AFK and helped him? Then even more people would AFK. I realized that the only way to stop this from happening would be to get Squid to close his own island to visitors, without him realizing that that's That's what I wanted all along. It took 4 long months, but it finally happened. But anyways, back to this tweet. So Squid says he closed his island because someone filled his potion system with rookie axes. A common trolling method in Skyblock is to fill people's inventories with useless items like boats. But the rookie axe is even worse for players like Squid Kid who use the Skyblock add-ons mod, which has a feature which makes it very difficult to drop tools out of your inventory. The point is to stop people from accidentally dropping weapons worth millions of gold, but it also applies to the rookie axe sold in shops for 12 coins. So basically, someone dumping a ton of rookie axes into your hopper system is the worst thing someone can do to you in Skyblock. Now, I've always been interested in psychology. In fact, I almost majored in it, so after 6 months of stalking Squid Kid, I developed a bit of a psychological profile of this man. I know how he talks, I know how he thinks. And when I saw this tweet, I instantly knew that this man was lying. Now, don't get me wrong, I completely believe that somebody dropped rookie axes into his hopper system, because it was me, but that's not the real reason he closed his island. After all, I'd been dropping rookie axes into his hoppers for weeks, but he sent that tweet 8 minutes after he kicked my alt. So I get to thinking, why would Squid lie about that? And I realize Squid knows I monitor his tweets, but what he doesn't know is that that was my alt account. From his perspective, that could have been some random guy with a rabbit, and if that was the case, I'd have no idea rabbits could be used that way. As such, him lying in that tweet could only mean one thing. He's about to sabotage me! So I held a stakeout on my island, and guess what I found a few hours later? A brand new Skyblock account AFKing with a level 1 legendary rabbit. Truthfully, I could have stopped Squid before he even joined my island, but I wanted to catch him in the act because I'm always getting comments saying, "Oh my god, Technoblade, why are you so mean to Squid?" They don't understand. This is war. There's no holding back. I know that, and Squid knows that. The only difference is that I'm 20 steps ahead. He's playing Skyblock while I'm playing Death Note. He thinks he can outsmart me with my own strategies because he is yet to realize that he is but a puppet, and I, the puppeteer, dance! Potato Boy, dance! So anyways, I got on my secret alt account and then sent his secret alt account a party invitation. And then I DM'd him on Discord, "Yo dude, accept my invite." Well, this is awkward. He actually did accept my invite. We had a lovely conversation, and then I banned him from my island. Get out of here. He tried again with another account a few days later. I don't have any proof that this account is him, but look at that username, Stinky Bozo. That's a pretty unusual word. In fact, I've only heard one person say it.
Bozo. You are a bozo. Bozo. Nice one, bozo.
He knows how he speaks. Technoblade really stalked the heck out of him.
You're a freaking bozo.
Yeah, that's right. Get out of here. I did eventually close my island, but not before I made sure I wouldn't lose potatoes. After that, I moved on to the next phase of my master plan. If I wanted to farm more potatoes, I'd have to start farming pumpkins. But wait a minute, Technoblade. That's the wrong vegetable. Wait. What do you mean it's a fruit? Whatever, at this point we'd pretty much maxed out the output of our minions. The only thing left to work on was the speed we could farm potatoes by hand. The farming skill gives more crops as you level up, so I decided to grind it to the highest level. I did the math and found that farming potatoes is so incredibly inefficient at leveling up farming that it was actually more worthwhile to build a whole pumpkin farm. I began the construction of a pumpkin farm large enough that by the time I finished farming it in full, the pumpkins at the beginning would have already regrown. I don't even want to tell you how long it took to build this. And so I began farming day after day. At times I'd farm for so long without break that the people watching thought I was bodding. Word of my pumpkin farming soon reached Squid, who began farming pumpkins himself, but he only saw the surface level of what I was doing. You see, I wasn't just leveling up my farming skill, I was also leveling up multiple legendary rabbits. There's a reason I wanted to stop people from AFKing on Squid's island, even after he started AFKing himself, and it's because it's almost impossible for one man to AFK every hour of the day, because servers restart, the game can update, your internet can go out, and if you're asleep or doing something else, you'll be missing out on those bonuses until you get back. Even the most dedicated individual might only average 20 hours of AFK coverage per day, and those 4 hours alone without the rabbit pet and farming crystal cost you 100,000 potatoes, and over time, that adds up. To fix this flaw, I got multiple level 100 rabbits, some leveled myself and others purchased for tens of millions of coins, and then distributed them to goons in diverse time zones. I set my island so only guild members could visit and had my head goon code a Discord bot that automatically pinged them within 5 seconds of the rabbit account leaving my island, at which point one of them could log into the island themselves and boost my minions until I got back. After a few weeks, we both reached farming level 50. On May 4th, there was a pet update which added, among other things, the elephant pet, which at its highest level could increase crop yield by 25%. Ordinarily, a buff to manual farming would be bad for me, since it allows Squid to catch up that much more quickly. But I had a plan. The reason farming potatoes by hand is so inefficient is because when you break potatoes, they don't grow back. So 2/3 of the time you spend on farming is spent replanting the potatoes you just harvested. Squid Kid and his viewers spent many hours trying to find a workaround to this, even building an elaborate redstone machine in an attempt to somewhat automate replanting. But in the end, they failed to find a better method and continued farming normally.
I should be able to plant 5 at the same time. Why is it so slow? It takes forever.
What if I told you I found a way? You see, back in January, I had an idea. What if I had the minions plant for me? At the time, this wasn't practical for 2 reasons. One, I didn't have enough farming bonuses for it to be worth sacrificing the minions' normal output. But this was solved when I got
Did you not just say Dalek 2 hours ago? Didn't you?
farming level 50. Secondly,
that
potato minions were simply too slow. But since then, they've buffed flycatchers, added the rabbit pet, and added foul flesh, a new fuel source which buffs minion speed by 90%. Even then, the potato minions weren't quite fast enough to keep up. But I thought to myself, if they're only going to be planting, they don't need to waste an upgrade slot on a super compactor. So I spent another 250 million coins to get 48 total flycatchers. Squid and I both started farming potatoes, but his method could get at most 200,000 potatoes per hour, whereas my method with double flycatchers, even after subtracting the amount the minions would have made themselves, could get 410,000 potatoes per hour. For the next 3 weeks, Squid farmed hours every day, but I was farming at the same time.
What are the odds he's farming right now? 5 bits? I bet Techno's doing the same thing, just has a 130% faster way to do it. You're probably wrong.
In this time, I expanded my lead by another 5 million potatoes, but at this point, Squid and I had been farming potatoes for almost a year, and we were still farming hours every day, with no end in sight. Neither of us wanted this to continue, so we came to an agreement. Whoever got to 500 million potatoes first would win the potato war. Hypixel even pitched in, saying he'd give a surprise to the winner. Now, I was only at 300 million potatoes at this point, but I figured I had this in the bag. I mean, I'd been tracking Squid's potato count. I accounted for his AFK coverage by having the Discord bot track his alt account's logins, and I knew how much he was farming by hand because I was monitoring his farming experience. With a 45 million potato lead and a farming method twice as fast as his own, what could possibly go wrong? June 6th. Things go very wrong. It was just a small update with a few quality of life changes, you know, like an enchantment which replants crops after you farm them, and an item which automatically compacts items in your inventory so you don't have to spend time on that. You know, 2 minor changes which just so happened to buff Squid's farming method from 200,000 potatoes to 1.2 million. And my farming method becomes worthless. Suddenly, my 45 million potato lead goes from insurmountable to, yeah, Squid can farm that in a couple days. Squid starts putting in crazy hours.
If I do 12 hours a day, can he keep up? Absolutely not. People say Technoblade never dies, but I'm putting him in the grave.
Meanwhile, I'm sitting here in shambles. I was out here with my lab coat on, doing the science, coming up with new never before seen potato farming techniques, and this man just goes, admins please, replanting is too hard, and they buff his farming method 6-fold. Was that it? 8 months of plotting and scheming just to fail in the final stretch? No, I couldn't accept that. I was going to win this war, whatever the cost. I immediately drank 3 months of mystical mushroom soup and got to work expanding my old potato farm, a project which would take 25 hours over the next couple days. I knew I was playing the game as intended when I realized that the only reason I ever put on one of the strongest armor sets in the game was to use its 3% speed bonus to optimize till and dirt. For the next 2 weeks, I did nothing except eat, sleep, and farm potatoes. There were only 3 interruptions, each of which cost me millions of potatoes. The first was a dentist appointment, and the second was when I had to play in Minecraft Championships.
What do I message him? Was it worth your...
Just so you know, he just said something like, you know, I had to pause exercising my toes because I had to play in the Super Bowl. That's what he just said right there.
time losing MCC? It took me 2 hours to lose MCC, but it'll cost you 9 months to lose Potato Orch. Hey, relax! Relax, hello?
Besides that, there was only one other time. I had to go to the store the other day. I had to interrupt my potato farming because my dad was like, hey, can you go to the store and pick up my medicine? And I was like, can I really tell him that I'm not getting his medicine because I need to farm potatoes? Can I really? Look, I'm an atheist, but When God sends me to hell, I want him to hesitate, okay? I want him to hesitate for a few seconds. But Squid was also farming several hours a day, and he had even found a way to maximize his AFK coverage. He started sleeping with his headphones on and had his goons wake him up via Discord call whenever his alt left his island. As someone with a Discord bot tracking his online activity, I can tell you right now that that man is telling the truth. He was waking up multiple times per night. I don't know why he didn't just use backups like me. He actually revealed to me later on that one of my original goons betrayed me and gave him one of our internal documents. And the list of backup pet users is literally right there at the top of the first page. I have no idea how he missed it. But anyways, Squid logged off an hour and a half ago. He should be entering REM sleep just about now. It would be a real shame if someone woke him. I didn't actually wake him up because I wasn't sure if intentional sleep deprivation was legally considered torture or not, so I decided to shelve that strategy for the time being. And after sacrificing 2 weeks of my life, I finally reached 500 million potatoes. We win these! Squid was shocked.
He's at 499. No, he's not. Dude, that's actually, like, it's not possible. No. It's not. This can't be real.
Squid had been certain that he was right on my tail.
I don't know how far behind I am. 100% less than 30 million.
And yet when I won the war, I had a lead of over 88 million potatoes. How did I do it? It's just as Sun Tzu says, all war is deception. You see, I knew after the second potato war video that things were going to get more difficult from here on out. Because at this point, Squid had a full organization backing him. He had goons, a cabal of billionaires funding his every move, hundreds of stream viewers making constant suggestions on how to farm potatoes more quickly, and reporting on my every move. So in that video, I prepared my final trick. I hid my true potato count. The number shown in my video wasn't edited, but it didn't include the millions of potatoes left uncollected in my minions. I also say that my minions now produce 1.58 million potatoes, but they're actually producing 1.75 million, because the rabbit pet doesn't actually boost your minions by 30%. It boosts them by 43%. Why? I don't know, it's probably bugged. And Squid couldn't realize the real number when he got a level 100 rabbit of his own, because he was being sabotaged. But the biggest reason my lead expanded by that much was because over those 2 weeks, while Squid averaged 8 hours of farming per day, I averaged 11.
I just can't believe how much he's farming.
The admins were legit saying that Techno is just like so focused, it baffled them at how like just insane he was. He had no breaks.
I swear to God, this Technoblade dude is focused on another level.
Towards the very end, Squid had one of his goons write a program to chart how much I was farming by tracking how much experience my elephant pet had. But by then, it was too late. Once I won the war, there was nothing left to do except celebrate my victory with grace and humility.
Oh my gosh! He's doing a little emote on me! Oh my, not like this, come on! Was this necessary?
Watch me dance, Squid Kid, you lose! You lose the war! After the war, the admins added a temporary NPC to the Skyblock hub, the Potato King. It gave out a new talisman which boosted potato minions by 5%, a basket for the top 1,000 potato farmers, and to me, the potato crown, engraved upon it the words, "All men can see the tactics whereby I conquer, but what none can see is the strategy out of which victory is evolved." Sun Tzu, The Art of War. That NPC is gone now. I took too long to edit this video. I gained a lot from the potato war. Patience, discipline, carpal tunnel. I guess my main regret is that I bribed Squid's Discord admin to give my alt permission to see into his secret text channels, and then he never used them all year. With the war over, Squid took down his potato minions, and my fields have gone unfarmed. While we were enemies, I still respect Squid Kid. I understand now that it is only with a worthy rival that one can reach their fullest potential. While he may have lost the war, he's gone from 70 subscribers to having tens of thousands of fans, so it can't be said that he's lost completely. For my part, I've realized now that rank number 1 isn't an achievement, it's a prison, which forces you to dedicate your life to defending a temporary title. But now, with the war finally over, I'm free.
And to throw it out there, he even admitted in his videos that he was farming during Christmas, during every single holiday. And then he said his only regret was that he bought that document months ago that Squid Kid barely used. That was the only regret that he had.
That was so good. Tiffany, thank you for filling in all the cracks for me. Oh, Echo. Sorry. Hold on. My bad. There. The echo's gone. All right, guys. I know that wasn't court. And I know I had a 90% chance of losing everybody, and I did. I had 100 viewers an hour ago, and now I have 59. And I knew that was going to happen, and I did it anyway because I just wanted you guys to watch that with me so bad. You guys, Vibers.
Yep.
Because
And my
Technoblade was so good. There's Technoblade. Yeah, we have Technoblade merch here. No, that wasn't court. Now it's time, guys.
I'm gonna go now. Goodbye, everybody.
Bye, Tiffany. Thank you.
Mwah.
Okay. Guys, you don't even know what you're about to see right here, right now. And you don't even know how hard it was. Something happened and I couldn't get it. So, like, I had to upload it to my son's account. I couldn't get it. Do you guys see what I see? Do you see who we're about to see? Guys, not only are we about to see 4 hours of Mr. Kelly, he's gonna do a good job this time, guys. And he's not in an orange jumpsuit. He's back. The throuple is back. He's back, Lori. He's back. Can you believe it? Oh my gosh. Okay. How do I summarize this for anybody who hasn't seen this before? Oh, geez. This man was this woman's boyfriend. This woman was married. This man even lived with them for a little bit. And they had children. I can't remember how many now. It doesn't matter. Doesn't matter. And then this woman divorced that guy and she married the lawyer because he keeps court case after court case after court case after court case against this woman, against this judge, against the Catholic Church, against the doctors. Every time we've seen him so far, he's been in chains because he keeps violating his protection orders. It all started with some mason jars. Thanks, Miss Jones. It all started with mason jars and this. If you remember the last time, there was a video, but we never saw the video because all she did was show screenshots of that video. Well, he got the video. This judge is so fed up with her lawyer, and especially with him. This judge barely keeps it together. Barely. And look, I know this video is 4 hours long, but the end is epic too. The end is the whole thing is so good. I just buckle up, because his next 4 hours is going to take a turn for the worse, which is why I put Technoblade in first, because I wish there was a taser involved. Whew. Are you ready? Here we go. Don't worry, you can hear it. Just relax, just wait. Okay, so what he just said that we couldn't hear. Don't worry, you can hear this video. What he just said is they're going to go through a motion for him saying that she defrauded the court. Okay? He wants her in trouble for defrauding the court. And that's what we're doing. We're doing a bunch, but that's what this first one is. One. One binder. Oh my gosh. Remember I had to turn off the system audio because Tiffany was echoing? I never turned it back on. So I'll press play. We'll start again. The judge is really low right now, but you will be able to hear him soon. You really will. There. Now you should hear something.
Cindy Littleton Hetzer, CINDY.
This is the motion that Mr. Kelly wishes to pursue in 2024 V0088. And it is a motion
It does. The audio gets better. It really does.
in regards to new evidence of fraud upon the court. Is that correct?
There were two motions about fraud upon the court, one with new evidence and one addressing fraud generally.
All right. I've got the one on January the 21st, which is the new evidence. Give me the date of the filing of this other motion. I want to make sure it's pending, Mr. Kelly.
It was probably 3 days or 4 days before or after the other motion, Your Honor. I was in custody in county.
Copy of it?
No, sir, I was in custody and I was no longer allowed to fax my motions out. So all of my motions my originals were sent out. And I don't have any of the originals.
Now I've indicated to the court that you've been out of jail for more than 40 days. And, there's nothing that would prevent you from getting access to the clerk's office to get these motions. So I want to make sure that what we're specifically dealing with, Mr. Kelly, for the purpose of the record. So once again, I've got the new evidence. I want to know what is the additional motion that you're saying. When was it filed, and give me the name.
Yes, sir, just give me 10 seconds. I'll pull it up for you.
Hello. Yes, this is the mason jar guy. Ex-girlfriend. The wife was married to someone else and then was married to the other lawyer. It's getting there. Oh, sorry.
I believe it's entitled Motion for Hearing to Declare Mistrial, filed January 28th, 2025.
All right, and that's one of the motions you wanted to withdraw, and so now you don't want to withdraw the motion for mistrial?
Yes, sir. So on the February 10th was the motion to withdraw.
On January the 21st, 2025. Okay, the motion to withdraw. You filed a motion for a hearing to declare a mistrial. And I was under the impression that you had withdrawn that.
He has a lot of motions, Judge. Let him think. Because it's impossible to get there's hundreds of courtrooms, and they go live and then they start. So they go live, I have to find that they're live, and then I have to start recording. So there's no way I can get the beginning. It's impossible. I would need 1,000 computers just recording nonstop.
We can just proceed. Whatever the other motion is, I'll withdraw it because we can't find it, and I don't want to waste any more of the time.
All right, so the motion for hearing to declare mistrial is withdrawn?
If that's not already withdrawn, yes, sir.
All right. All right, there'll be an order entered that you withdrew that. All right, now that leaves us with the new evidence of fraud upon the court. Are you ready to proceed with that matter?
Officer Brandy Crabb has not complied with the subpoena.
All right. Can we see, is she out there or he out there?
Yes, sir.
Oh, he is out there. All right, but you've got Ms. Hetchler on the stand. You want to call him first?
Her, yes, please.
Her? Okay. You step down. Hey, if you'll come and have it, you can walk that way.
He says he's withdrawing, but he's not. Don't worry.
You'll step up and the witness stand, and before you be seated, if you'll raise your right hand for me, please. Do you solemnly swear or affirm the testimony about giving this matter the whole truth and nothing but the truth, so help you God?
Yes, sir.
You can have a seat. Upon being seated, if you'll be kind enough to state your name and then spell it for the benefit of the court.
Sure. My name is Brandy Crabb, BRANDIE CRABB.
Thank you, Ms. Crabb.
You're welcome.
Officer Crabb, were you subpoenaed to bring some records with you today?
No.
Your Honor, I'd like to introduce Brandy Crabb's body camera footage as evidence. There are 4 videos from her body camera footage from the night that I was arrested. Do I need to mark those as 1, 2, 3, and 4?
That's not how it works, dude.
Any objection, Mr. Harrington?
Having not seen them, don't know, Your Honor.
Well, I mean,
Now, he
you
did.
got to lay the foundation for him, Mr. Kelly.
Officer Crabb, was your body camera footage running the night that I was arrested on November 19th, 2024?
Yes,
Are you aware that the Cochran Police Department has previously provided me with footage from your body camera?
yes,
Have you watched the footage from your body camera?
no.
I'd like to introduce these 4 videos that were provided to me by the city of Cochran. Mr. Harrington has seen the most important one. I emailed it to him on March 5th.
The question or the issue, Mr. Kelly, is that you've got to lay the proper foundation to get them admitted into evidence. And Mr. Harrington, do you have an objection to at this point?
If he does not lay a proper foundation, which I do not believe he has done at this time, I would object to testimony about the evidence.
Until you lay the proper foundation, Mr. Kelly, the court's not going to admit the body footage. She stated that she hadn't seen it.
So I submitted a subpoena with her subpoena to appear, also with a subpoena for her to bring those with her. I
understand all of that, Mr. Kelly, and I appreciate all of that. But there are still rules of evidence that you have to comply with, and you haven't done so, sir.
All right, I think I'm going to be sick.
I'm sorry?
I think I'm going to be sick. Can I be excused for a moment?
You may.
Yep. Thank goodness he left, though, right? She has like 3 kids from her first husband and 2 kids with him. Now she's married to this lawyer. He keeps filing cases to get the judge recused, and the Catholic Church and everybody. That would be. No one's allowed to say anything till he comes back, but he comes back pretty quickly. He's almost back. Now lay the foundation. Show her part of the video. Ask her if she recognizes it. Ask her if it's been altered. You go right ahead, Morgan. No one's watching.
Officer Crabb, I'm sorry, are you ready?
Waiting on you, Mr. Kelly.
Officer Crabb, how long have you been with what is your job?
One question at a time.
What is your job?
I'm a patrol officer,
Who do you work for?
the Cochran Police Department,
How long have you been working in that role?
almost 3 years.
Are you familiar with Cochran's body camera, City of Cochran's
Be
body
right
camera
back.
policies?
That it must be worn on calls, yes.
And was your body camera worn the night of November 19th, 2024?
You already know this. You have the footage. You know it was recording.
Is the answer yes, Officer
Yes.
Crabb? And you have provided that footage, or it's somebody from the city, or the city of Cochran has provided that footage to me?
Is that a
To
question?
your knowledge, has someone from the city of Cochran provided me with that footage?
To my knowledge, yes.
Your Honor, I'd like to introduce body camera footage produced by City of Cochran, worn by Brandy Crab's from Brandy Crab's body camera footage.
Yeah, go ahead, Mr. Harrington. Your objection?
I do have an objection, Your Honor. That's not the proper way. He should have a certified or certificate of authenticity in order to produce that. This witness has particularly said she's not reviewed it, so she is not aware of what it has on it.
Mr. Kelly?
Yeah, the subpoena was submitted to her to produce that record today.
That's not what my subpoena says.
Okay. And what did your subpoena say?
May I show it to you? I have it in a picture.
Let me look at it. Show it to Mr. Kelly first.
There were two subpoenas, Your Honor, one for her as a witness and one for the production of evidence.
Was she served with both of them?
That's all I have.
Were both given to the Bleckley County Sheriff's Department at the same time.
My question was very simple.
Yes.
Were they both served on her?
They were both served on the Cochran Police Department.
Well, she's not the Cochran. This one is directed to her personally and does not command her to bring anything.
Your Honor, the other one was directed to her as well.
I haven't seen that one.
She says she hasn't been served with it.
How were you served with that document?
I was not there when it was served. It was served to an employee at the Cochran Police Department, and I was notified via text message of a copy of it stating that I had been served with a subpoena.
What's the name of that employee?
Catherine Helms.
And did Catherine Helms indicate that there was any other subpoenas for you?
No.
Have you got a copy of the subpoena?
I do. I actually emailed it to her and she stamped it.
You emailed it to her. Once again, Mr. Kelly, I'm trying to perfect the record, and there's a lot of hers involved. If you would be specific, that's the only request. That's a request the court has.
Yes, sir. I emailed the request for the subpoena to Christina McCall of the clerk's office to prepare this subpoena for me.
To prepare the subpoena for
And I
you.
came by and picked them up within a couple of hours when she told me they were ready.
All right. Have you got a copy of it, Ms. McCall?
Judge, may I show you this? I just sent Catherine Helms a message since she's the one that notified me.
No.
Okay.
Was there two subpoenas? Do what now?
I see one for Cochran Police Department.
See one for Cochran Police Department?
And for Brandy Crab for another one.
One's to the Cochran Police Department and one is to Miss Crabb.
Okay, then I have no more questions for Mrs. Crabb.
All right. You step down. Call you next week.
I'd like to call Jeff Trawick of the Cochran Police Department.
All right.
Sorry, I'm back. Do I need to fast forward? No, he's talking.
Trevor, if you'll step up into the witness box upon stepping up, if you'll remain standing to raise your right hand for me.
Yes, sir, I will.
You solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God.
I do.
You can be seated. Upon being seated, if you'll be kind enough to give us your name, and then for the benefit of the court reporter, if you'd spell it for us, okay?
Yes, sir.
All right.
My name is Jeff Stroke. I'm the Chief of Police, City of Cochran Police Department.
All right. Can you spell your name for the record?
Trawick.
Thank you. Mr. Kelly?
Chief Trawick, how long have you been with the Cochran Police Department?
28 years and some change.
And how long in law enforcement?
Almost 30.
Are you familiar with your department's body camera footage policies?
Yeah, it needs to be worn when you're on a call.
Was your officer, Brandy Crabb, in compliance with that policy?
As far as I
Yes,
know.
thank you, thank
Sorry,
you,
sir?
thank
As
you.
far as I know.
On November 19th, 2024, as far as you know. You were subpoenaed to produce that video.
Is that a question, Your Honor, or a restatement? Because he did not ask the date in particular, just asked in general. And if he's going to come down to a specific date, I think it'd be appropriate. I would object to the form of the question.
Ask him as to the date, Mr. Kelly.
Yes, sir, I was in the middle of asking to the date, and he preempted he answered before I
Asking
finished.
for the date, I didn't need an explanation.
On November 19th, 2024 was, to your knowledge, was Officer Brandy Crabb in compliance with November Department's policies on the use of body camera footage and body-worn cameras?
As far as I know.
Were you subpoenaed to produce the footage from her body camera from that night?
The one I received yesterday, I believe. Yes, sir. The reason I did not is because you've already received it twice, and I didn't want to duplicate the process.
So have you reviewed the footage?
No, sir.
Has anybody in your department reviewed the footage?
Thanks. I didn't change my hair. People have asked if I changed my hair. No, I just got rid of this big freaking headset that I had. That was horrible.
Footage?
The only one I believe is maybe the patrol. I don't even know if he watched it. I know he burned the copy, but I don't know if he reviewed it.
Did your subpoena give you the permission to ignore it if it's already been complied with in some other fashion?
I'm sorry, I didn't understand the question.
Did the subpoena give you permission to ignore the request if it had already been complied with in some other fashion?
No, sir, didn't say I did have to either. You received it twice already. That's why I didn't bring it, because you already have it in your possession.
Your Honor, I'd like to move to have Mr. Trawick held in contempt for defiance of the subpoena.
Mr. Harrington.
I want the chief
Your Honor, I think that
of
would be
police
an
to go to
extreme
jail.
Situation. Even there, he has not provided a foundation yet to introduce the evidence.
Is the body cam at your office?
It's on the server at the police department, sir.
I can't introduce the video. That's why I subpoenaed him.
Mr. Kelly, you have presented a legal issue to me that I'm trying to contemplate.
Yes, sir.
And it's so much easier to do it if you'll allow me to do it without your commenting. We've gone over that numerous times in numerous hearings. All right. Mr. Chief Trawick, I'm going to ask that you go and get a copy of it.
Yes, sir.
All right.
May I excuse your Honor?
Yes.
Thank you.
Is there somebody else that we can entertain as a witness, Mr. Kelly?
Not until the body camera footage has been played. For this particular matter, for the new evidence of fraud upon the court, no, without body camera footage.
It's worth the wait. I'm going to let it play because just small things happen. Just small things, but I want to let it play. Judge is taking a nap. Come on, Judge. Eat a Snickers. Judge is already hangry. He's very cranky today, and it's so good. He's cranky to everybody. Not yet. I don't think that'll help. He'll argue with Google. And he's going to sue Google for giving him the wrong information. He sent the chief of police away to go get the body cam because he was subpoenaed to have it. And the chief of police was like, I already gave it to you twice. You don't need it again. So they can't move on. Without this body cam, they can't move on. Because what he's saying is that she is a liar and she is committing fraud on the court. And that body cam proves it. I have a little issue with some of the things said in the body cam because it's not correct. But he scores some points. I mean, he finally scores some points here. I don't know what's going to happen. We'll find out. He's crazy, though. He's crazy, but he's so smart. Remember the last time? He remembers everything people say to him. He's like, Judge, on November 12th, you told me you made a joke about cake. And now you're telling me we can't joke in the courtroom, but you did. And he's very hostile. Yes. I don't know about the mason jars. I bet he broke them. They do have to sit and spell and think on it. And whatever you do, don't talk to him while he's thinking on something. But this lawyer here tries to take advantage of the fact that he is pro se, as I would too. Heck yeah, I would. And the judge ain't having it. He just wants it over with. All these motions. There's so many motions to go through.
Sorry. I'd like to sequester Laurel and Max Hetzer. They're not parties to this matter. I didn't realize it just dawned on me that we switched cases.
They're not parties to the OOAA.
That is correct.
Be sequestered.
If there's not parties, which means they're not witnesses,
Don't
so
go sit in the grand jury room.
why is he kicking them out? That doesn't make sense. You're allowed to go watch court.
Show them where the grand jury room is.
I would lose my shit if I had to deal with this guy. I would lose it.
We're not in 012, 0152, we're in 0088.
Yes, sir.
They're not parties to that case.
I agree, Your Honor.
Okay, now I'll fast forward it. All right, nope, something else happens. So good. Now you got to try to listen hard because it happens, but not on the stand. I question myself all the time out loud.
Your Honor, I've just discovered that there's something wrong with some of the evidence that Captain Sanders has provided with me. Can I speak to her about it?
You may.
Captain Sanders, can I?
It's honestly a good thing he's found this now. Well, because the judge wouldn't have been happy.
This part on Bradford?
No.
I couldn't hear you.
Sorry.
I agree. If they have nothing to do with this case, they can stay. She was supposed to supply him with 3 discs.
See, there's no network connection to find it.
She supplied him with 2 discs. Well, he doesn't need the first 2 discs. He only needs the third, the one that she didn't supply him with.
Because they play on mine. Because you're probably connected to your computer at work. See, if you look, see, here's the. This is the other 2 discs right here. These are the other 2 discs, and those are fine. This is the only one that is not. If I can just check this.
We can find her,
This was disc
Jen.
3.
Let's go on a driving trip and find her.
I'll show you how you have it labeled here. Is it possible for you to run over and copy this? What the hell? This is the label that you had on it.
Right, I'm going to fast forward it now. She'll fix it, don't worry. I'm going to fast forward it to where he starts to stand up.
Is to introduce these audios, these clips. I don't know. I don't remember the motion, Your Honor.
Whoops.
I wrote it in. Need this? No, I got a copy. Okay. Tina, I'm gonna, you don't need to come back. I'll just come by the jail to pick that up.
Well, I'll go get them right back. Y'all
Okay.
should be here.
Okay.
Your Honor, can I
Can you what?
go put what he requested because it stopped pulling up?
That's fine.
Your Honor,
All right. Go ahead.
I can excuse her. She's here to subpoena to produce that.
The only one that can excuse any witness under subpoena, Mr. Kelly, is the court.
Yes, sir.
And that's the reason she was asking for the court's permission. All right, we have an issue that I just discovered.
Uh-oh.
In light of the fact that Mr. Kelly has now withdrawn his motion to withdraw the motion that we're hearing now, which is the motion for hearing to address new evidence of fraud upon the court. I have reviewed that motion. And that motion makes an allegation that there is new evidence that has come to your attention that I am colluding with the plaintiff to further a fraud upon the court. Are you going to pursue that?
I don't know. I don't remember the motion, Your Honor. I wrote it in jail angry.
Well, I understand, Mr. Kelly, but it makes a difference about how the court can proceed today, and that's the only reason that I bring it up.
I don't know how to address that. I filed 6 motions to recuse you, and you've denied them all.
That's right.
Despite clear evidence that there's not something normal going on. You alternately rule and hear on motions that I have under appeal, even though it's a defective appeal, and you ultimately, you alternate. First, you can't hear it because it's under appeal. Then you can hear it because it's under a deficient appeal. Then you can't hear it because it's under a deficient appeal, and then you can hear it even though it's under an appeal.
Well,
so
Mr. Kelly, I'll submit to you that there are a variety of rules dealing with what I can and cannot rule on or have hearings on when something is on appeal. And in that light, I have, to the best of my ability, determined what I could and could not do and ruled in that fashion. I understand that it seems confusing. I will admit that it is complicated, okay? But I have ruled as I understand the law to be. And if you feel that's inconsistent, obviously you have the right to feel that way, but I'm confident in the manner in which I have ruled in those regards, as regards to the appeals.
Okay. There's been times when I've said to myself, what is this man doing? It's clear, like with James Rockefeller, it's clear that he was lying to you over and over and over. He would lie about what he had just filed. He would make a filing and lie about what he had just previously filed. And I would file motions with you because I thought that was the only way to do it. And then it would be 2 months before it was dismissed without being addressed. There's probably 40 or 50 instances where James Rockefeller has lied to you. There's 2 instances.
Mr. Kelly, I'm just merely wanting to understand in this motion that you have now wanted to go forward with after you have withdrawn it, okay, if there is still, are you still going to proceed with this concept that I have somehow colluded with the plaintiff?
I am attempting to answer your question, Your Honor,
Okay.
by laying a foundation.
Okay, I'm sorry. I didn't mean to cut you off.
So all of this that I've witnessed over a year of it seeming like, to me, outside looking in, that you're protecting James Rockefeller from his abuses of the rules of professional conduct. And then there's twice in this case where I say to myself, no, he's doing the right thing. When I filed that motion, it was, I believe it was immediately followed.
That motion, which motion?
The one that you were asking me about,
One
where
that
I
we're-
addressed.
The one we're hearing evidence on now.
Yes, sir. Particularly the motion or the element of the motion where you're colluding with the plaintiff.
Well, I hadn't heard any evidence in that regard now.
Yes, sir. I'm addressing.
Listen, we've met 3 men that have already colluded with her. The judge can too. Share.
Your concern about my position on that.
Okay, excuse me.
This woman is lying to this court, and the evidence of it is abundant. And because I don't jump over the right heel at the right time and skip the right curb at the right moment, nothing is being done about her lies. Our children's lives are being destroyed mentally because of her lies. No, I do not. I believe that you are acting with integrity since I wrote that motion.
All right, so you withdraw those allegations?
Yes, sir.
All right, thank you.
I withdraw the
Then we can
withdrawal
move
that
forward.
I didn't withdraw, but I'm going to withdraw. And then later on, I'm going to make sure that we go forward with it anyway.
So, Your Honor.
Chief, are you ready to go forward
sir.
with the chief?
He's a pro. You don't need to put a say on the end of that. He's a pro.
All right, let's come back and have a seat.
Yes, sir.
A Discord, John?
All right.
Maybe. I don't think so, though.
Purpose to expedite where we're at. Chief, the documents and I guess that's a CD?
Yes, sir, it is.
Is that copies of your official records?
Yes, sir, it is.
And you just obtained them from?
Yes, sir, I did.
Please, I'm going to admit them.
He doesn't have to lay foundation now. The judge is like, okay, I'm just going to admit him.
How do you have them marked, Mr. Kelly?
I don't know where we're at with my exhibits.
Well, let's just mark them as of starting from the beginning today, sir. It'd be easier.
I will mark them all as one.
Not all of these records.
There's 4 videos, and they're anywhere from.
All right, let's mark them then 1A, B, C, and D. Is that 4?
Yes, sir.
All right.
Have exhibit labels if it's of assistance to the court.
Well, it's.
Well, we're gonna play this CD.
Okay.
John, they are so cute, those puppies.
That's what the problem is, Mr. Kelly.
No, I understand that, Your Honor.
Is all 4 of them on one CD?
Yes, all the videos are supposed to be on this one.
Let's just mark it as, defendants 1 to the motion of new evidence. You got that, Madam Court Reporter?
Should I approach the witness, Your Honor?
You may.
Yes, sir.
You're gonna have to, if you're gonna publish it, okay, you're gonna have to come to the podium and hook it up so that we can all see it.
I'm hooked up to the HDMI here. Is that not going to work?
My technical skills are not the best in the world. It would be better if you could play it on the TVs.
Well, that's what I believe this is doing.
Okay, great. If that's what it's doing, that's fine. I'm sorry. I'm not.
Judge, I don't believe that you're not a technological genius. I just don't believe it. Prove me wrong.
Tell me when you start it and I'll.
All right, mods. Goodbye.
Okay, it's ready to be
See you
played.
soon.
Okay, it's playing the first file.
It is time for Judge Fleischer. As soon as they play it, it is time for Judge Fleischer's docket. Go, guys. I'll still be here when it's over.
So, John?
There we go. Okay.
So Cindy's down there. The office is right down. I'm recording here.
Okay. So the office is this door right here on the left?
Last door on the end, yeah.
Right.
So we've got our son's medical appointment or mental health appointment down there.
Right.
And everything's fine, honky-dory. I'm on the phone.
Thank you,
I make a
Morgan.
phone
Thank you
call
so
to a friend of
much.
mine. And I'm on the phone with her maybe like 2 minutes. And I ask her can you get that affidavit ready for me?
Right.
About our custody case. So 6 months ago, Cindy called this woman to harass her.
Uh-huh.
And she's been promising me an affidavit for months.
Cindy has.
Cindy, no, my friend.
Your friend, okay.
So I'm on the phone, and then this happened. So Cindy hears me say, "Can you get that affidavit to me by December 9th?" Cindy jumps up, grabs her phone, and comes over my face like this, and like won't leave me alone. She's trying to get close enough to hear
what she's saying.
Correct.
What you have on speakerphone.
So she stood up now. She's dropped her knitting, thrown it on the floor, and she stood up. She's just off frame. She's about to come over here and like get like right up on me like I'm on you.
Right.
Remember the last trial? He said she threw the knitting across the room. We heard it in the last trial. He is calling someone, has them on speakerphone to get them to write an affidavit saying that Cindy did something wrong. And Cindy's in the same room. So she comes close to record what he's saying.
Making me super fucking nervous.
I understand.
I get up and I leave. I go to the other side of the room. She follows me. I cross the room 3 or 4 times. She follows me. She won't let it go. She won't leave me alone. She keeps wanting to stick the camera in my face to film me. there's audio, it's just music. So I pick up my phone, the one that's recording, and walk back across the room and see
Remember, he has a PTO out against him, so he's not allowed to record her. He's allowed to be in this room with her because it's the child's going to the doctor, a psychiatrist. So he's allowed to be in this room with her. But it specifically says in his protection order that she has against him, he is not allowed to record her. So he calls the police because she is recording him. And he has it on his recording.
she follows me right back across the room. Like this far away from me.
Right,
Unnecessarily.
she's close, correct.
How it made you feel, what the substance of the conversation was. This is me talking to Nicole. She's asking to remind her what needs to be in the affidavit. And so I go outside. To me by like December 9th. And she follows me
to get away from her.
And then she follows me to the door.
Does she actually come outside the door?
She's standing right there, like it's wet, so I didn't want to go all the way.
Oh, yeah.
It was raining, so I'm just standing on the awning.
All right, yeah, they most likely, if you go to the tax assessor's
Okay, and that's just you talking about that.
And then I go back in, I go across the room, she follows me back across the room.
All this while y'all's child is in there with the counselor?
No, in the counselor in the back room.
Yeah, they were in the counselor at the time while y'all were sitting in the lobby.
Correct.
Okay.
And see, she just won't stay away from me. Yeah. The judge found her in contempt last week, and now she's being extra.
Okay, do you have a TPO against her?
No.
I would advise you to do that.
I've tried.
But
the judge won't give it because there's no imminent danger, so the judge won't grant it. But this is not appropriate behavior.
It may be where
she's triggered that so there's 5 or 6 people that she contacted that submitted affidavits. This is the one that hadn't submitted an affidavit. So she was stalking me. She was calling my bosses, calling my employers,
right,
calling everybody to say what a piece of shit I was because I broke up with her.
Right,
I'm sorry, who was this?
I'm semi-familiar with the stuff that's been going on with y'all.
I get some deputy contact.
So wait.
Hold on a second, I'm sorry.
No, you're fine.
And I don't speak to her at all until this is the first time I speak to her. I say something like, "This is harassment." And I'm scared.
That's right. She's very. She's the one. Venus, if you're still here, which you're not.
The only thing I said to her is, "It's here. It's
Knitting
recorded." I said,
aggressively.
"This is harassment. If it doesn't stop, I'm going to call off."
Right. Oh gosh, did I eat my ink pen? I got it. You know, we all got our favorite ink pens. Okay.
I love Georgia.
It's unnecessary.
JOSEPH?
Correct. And we've been in there for 40 minutes before this happens.
KELLY?
Correct.
What's your address?
163 Lucas Road, apartment H2.
Same with the police officer.
H2?
Correct.
And what's your birthday?
450.
And your phone number? And what is her name again?
Cindy, CINDY, HETZER.
Okay, so let me go in here and try to talk to her and find out why she kept walking up on you like that.
Can you pull her out of there so that I can stay in there with the kids? I don't want the kids to see you talking to her if they come out.
Well, I mean, when I pull her out, you can go in.
Sounds good.
How about that? Okay. Hi, Miss Cindy. Hi, can you step out here and talk to me for just a minute, please? Dang, I tracked stuff in.
camera still on?
Yes, sir, it is. It stays on the entirety of the call. You're welcome. Here, we'll stand over here so we're out of the rain, but not right at the door. Okay, stand right there so you're not getting wet. All right, now what's going on?
I was in there, brought my kids to their counseling appointment.
Yes.
He's been sitting there, talking on the phone, playing, he played with the boy, with Oscar until Oscar went back to
Right.
And then he was calling some friends, I don't even know who he was talking to, but he was talking to a woman who said she was going down to Savannah. He was talking about he might come up to see her, so she's someone local. He asked her what she was doing December 9th, which is the date of our next court hearing, court appearance. I had my recorder going the whole time that we were in there in case there's any shenanigans going on. And then he asked her, she said she was busy, I think. He had like the volume turned up so I could hear everything that she was saying. And he said, would you mind creating an affidavit for when Cindy contacted you in April?
Right.
And I didn't contact any of his friends in April. He has lied to the police and to the courts that I have. This woman was like, sure, I guess. And then she was like asking him what she should put in the affidavit. So I got up with my phone and I walked across the room to be closer to the conversation so I could hear it. Didn't look at him, didn't talk to him, didn't touch him. I was like facing away from him. And he's recording me the whole time with his video camera, which is a violation of the protective order. And then he turned to me and said, this is harassment directly to me, which is also a violation of the protective order. And he said he was going to call the police. And then he did.
All right, I understand about the violation of the protective order, but you getting up from your seat going next to him is also a violation of a protective order.
And which part of the protective order?
The protective order where you can't contact him or be around him either. That's why I asked him, how were y'all able to be up here together?
That's what the protective order says.
But I'm telling you, by law, just because you took the TPO out on him doesn't give you the right to walk up on him and do whatever you want to do.
No, ma'am, I agree with that.
Yes, it does.
There's no distance requirement in the protective order, which is how he's able to be here.
Okay. Well, I was kind of curious about that, and he explained the same thing that you just did. And I did suggest to him that maybe y'all can figure that out about bringing the babies up here for counseling. I mean, I
would love that. I mean, it's my parents.
Right, but what I would advise, no matter how much it may get up under your skin or whatever, do not walk up on him. When y'all were both here, it needs to be civil. You're here for the babies. Let's put our emotions to the side, and getting up from your seat going next to him is also a violation of a protective order.
And which part of the protective order?
The protective order where you can't contact him or be around him either. That's why I asked him, how were y'all able to be up here together?
The protective order says.
But I'm telling you, by law, just because you took the TPO out on him doesn't give you the right to walk up on him and do whatever you want to do.
Yes, it does. No, ma'am, I agree with that.
I mean,
there's no distance requirement in the protective order, which is how he's able to be here.
Okay. Well, I was kind of curious about that, and he explained the same thing that you just did. And I did suggest to him that maybe y'all can figure that out about bringing the babies up here for counseling. I mean, I
would love that. I mean, it's my parents.
Right, but what I would advise, no matter how much it may get up under your skin or whatever, do not walk up on him. When y'all were both here, it needs to be civil. You're here for the babies. Let's put our emotions to the side. And so what if he's on the phone?
It's not about him being on the phone. It's about him trying to get me in trouble with the court.
So what? So what? If you know you've done nothing wrong, so what?
He lied to the court, and the court believes him. And I've gotten in trouble with the court. I had a good conduct warrant signed but not issued. I'm not even sure what that means from the magistrate's office.
I'm not sure
And
either.
it's because he lied the entire time, and specifically about this sort of thing, that I had contacted some of his friends, where he's harassing his own friends and then blaming it on me and telling the judge that I'm harassing him. He's having him write affidavits. I didn't do anything. I have no idea who this person is. I've never contacted them, and I need some kind of proof.
And you stand up for yourself like that. But I'm not saying that you can or cannot record him. I'm not saying that about either one of you. It's a public place.
Right. He's not allowed to record me according to the protective order.
Okay. Well, then you don't need to be recording him, but I understand your reasoning.
That's not what the protective order says.
Okay, well, you need to go back to the magistrate and get clarification on that. Because just because
he cannot record me, but it does not.
Just because you have the TPO on him does not give you the authority or right to approach him. Oh, I'm sorry.
That's all right. No, that was just an alarm that went off here.
I apologize. I'm telling you this for your well-being. That could, in return, look bad on you when you do go to court. That's why I'm telling you this, to help you out.
That's way different than what you're saying. You're telling her she's not allowed to, which is just wrong. If it's going to look bad on her in court, oh yeah, that's correct. But you can't tell her she's not allowed to.
On him. He says that I thrust it in his face.
You were very close. I saw the video. You were as close to him as me and you are.
I mean, it's a small waiting room. I walked.
I understand, but you had no reason to get up and walk across the room to him just so you could hear better and record better.
Okay.
I mean, you get what I'm saying?
No, not really, but I understand what you're telling me, and I won't do it anymore.
Okay.
I believe that I have the right to record and defend myself against somebody who's lying about me to all the judges, courts,
but then just sit there. Sit right there where you were at.
Yes, ma'am.
Don't speak to him. Same thing I told him. And I know you hadn't.
Speaking to me. And I would like to have some sort of a consequences for him speaking to me and recording me today, because he is not permitted to do that. I can show you the protective order where it states.
Okay, and it shows the only time he spoke to you was to tell you to get back from him.
And what about
it's all recorded.
What about the recording?
Okay, that I need to. That I'm going to call as soon as I walk away from you.
I can show you the protective
Okay, I'm going to call the magistrate to clarify on things, and I believe your paper
doesn't help me. They refer me to the Superior Court because he's suing the magistrate's office.
Okay, well, I need to speak to someone higher up than I am with the courts, not with the police department, but with the courts, because I know y'all have there's a lot of dynamics going on in between you and him. There's a lot of stuff, and I just want to make sure that things are handled appropriately.
Yes, ma'am.
Now, he has the whole recording of the time he was in here. I see you approaching him. You're following him. You're standing at the door when he comes outside to talk on the phone.
I did not stand at the door.
Yes, you did. I saw the video.
I stood inside the door.
Yes. No, you didn't come outside. No.
I followed you outside.
No, you followed to the...
On the 911 call, he said that I followed him outside.
Okay, well, he did not tell me that.
Well, on the 911 call, he lied to them.
He did not tell me that. So that's... A lot of people lie to 911. I'm not really concerned about that. I'm concerned about what transpired when I got here and talked to him. But give me just a moment. Let me go call and let me see what our course of action. That's okay.
Okay.
All right, and if you want to, you can go back inside. I'm not going to make you stand out here in the rain, or unless you just want to stand here. That's up to you.
Go inside.
Okay, I'll be right back, okay?
You held the evidence open for this tape to be entered, and it was given to you. I'm not seeing any new evidence, and of course, the motion has to show that there's new
I'm
evidence.
going to let it play.
Yes, sir.
I disagree with what you're saying, Mr. Harry.
Yes, sir.
This was being withheld.
I'm letting it being played, Mr. Kelly.
Where Mr. Kelly is so used to losing with objections that he didn't realize he won that one.
Hey, I need your advice, and I have my body camera on. Okay, I'm up here at the hospital in reference to Joseph Kelly and Cindy. They were here bringing their children to counseling. Joseph was sitting on one side of the lobby, Cindy on the other side. Joseph is talking to someone on the phone. He's also recording Cindy sitting there. He said he's doing this to protect himself. Cindy gets up and walks across the lobby over to where he is, and she's recording, standing close enough to him that she can record video and sound of what he's talking about on the phone. He gets up moves across to the other side of the room. She follows. He eventually gets up and steps outside of the door to talk, and he's standing under the awning outside of Joey's office, out of the rain, talking. You can see Cindy standing on the inside, but at the door. She has a TPO against him, supposedly for recording or anything like that, too. Do you know, in a situation like this, is that grounds because he was recording her to do anything to him legally, or?
I would have to call Carol because I don't know what all the verbiage in that TPO is. Who's working for the county tonight?
Chandler and Hunter.
They should have a copy of it in the squad room.
Because see, what she's doing, what I feel like she was doing is she was baiting him. And the only thing he said to her is, "You are harassing me." And she's bringing up that he was recording her and he spoke to her.
I would see what the actual TPO says.
But wasn't he baiting her first by calling someone if he's lying and discussing the lie right in front of her?
I can't answer for Superior Court.
Okay, so call Chandler and see if they can bring me a copy of it up here.
Yeah, see if they have a copy of it. I'll try to call Carol, and if she can send me anything, I will forward it to you.
Okay, yeah, because I'm wanting to handle this, and I know as an officer we can't put our opinion out there, but she was baiting him. She was she was the pursuer in this, and I told her just because you took out the TPO on him does not give you the right to do those things to him.
Right. Well, if you don't want to be around him and you're scared of him, why are you making a point to go up underneath, around him?
Yes. But she said that she was recording to, so she could take it to the courts and show that he's been lying.
Lying about what?
Lying.
He shouldn't be recording her, but she shouldn't be antagonizing him. Is how I would perceive it. But
yes, they're both in the wrong.
The only thing she left out was that he had made a phone call. She said he had made a phone call, but what she didn't tell this other person was he had it on speaker and he was telling this other person to create an affidavit, saying that Cindy contacted him when she didn't. It's the only part she skipped.
But let me call Carol, see if you get it from Chandler or Dwayne, let me know. But
I disagree too.
All right, let me call one of them.
Okay.
All right, thank you.
Happy birthday.
Thank you.
They're allowed to
Bye.
be,
All
he's
right,
allowed
bye.
to be at the doctor's appointments with her. That's going to demonetize me, that little music there.
Hey, do y'all have the TPO order ready? Like, y'all have it available? What'd you say? Is it? Oh, shoot. Hang on, I gotta get my computer pulled up. And I got my body camera going. He was recording her because she kept walking up on him, so he started recording. And he will move and she will follow him. But she's wanting something done to him because he was recording her and told her to quit. He told her to quit following him because that was harassment. So she's wanting something done because he was recording her and spoke to her. Say what now? Yeah, she was the aggressor in here. He was on the phone talking to somebody and had that person on speaker, and she was on one side of the lobby, he was on the other side. She gets up from where she's sitting and goes across to him and is standing next to him, recording him and recording what he is talking about on the phone. They are up here for the children. The children have counseling. Okay, I can't pull, my computer's not pulling up.
Your Honor, the relevant portion of this video is already come and gone. I don't know if you want to play through the whole thing. If that's the procedure, then we'll play it, but
You can stop it whenever you like, Mr. Kelly.
okay, so
It's your evidence. You're through?
I'd like to highlight the relevant portions of the video for the court.
Well, let's take one situation at a time, okay?
Yes, sir.
Do you need to play any more of the video so you can highlight anything further?
No, sir.
All right. Mr. Harrington, do you want the whole video played?
No, sir.
All right. When we have closing arguments about this, then you can highlight to the court, Mr. Kelly. But I mean, if you're finished playing what you need to play, then we can stop.
I don't have any further questions for Mr. Trewick.
Well, the issue is, what's going to be put into the record is what you play. And so, are you through playing what you need to play?
Yes.
Okay. All right, you're excused, Chief.
Thank you, Your Honor. How about the incident report, Your Honor? Would you like this?
I have it, but I don't need it introduced. I needed you to introduce it to the court. That's why I subpoenaed it.
Okay.
I can't introduce the copy you've already given me.
Okay.
All right. Are you admitting the police report?
I'll admit it, Your Honor.
All right. Objection?
None.
All right, it's admitted. We'll make that P2 or D2.
If I may ask for
Sure.
a point of clarification. He said there were 4 parts to this, so we're not looking at the other 3 parts?
That's the other two, we're not watching parts 3 and 4, 2, 3, and 4, or B, C, and D, I guess would be better.
So for the sake of fraud upon the court, it's only contained in there's another segment. The issue is she committed perjury and said she wasn't recording, and yes, I don't need to play them, no, Your Honor.
All right, that's what we're trying to make sure. So as far as the record is concerned, what has been played to this point is all that you want admitted into the record?
Yes, sir.
Okay. Does that clarify it, Mr. Harrington?
It does, Your Honor.
All right.
And for
Madam
the
Court Reporter, you understand that?
Yes, sir, I do. I do.
Okay.
So the file that we played ends in 0157 for the record.
I mean.
0157.
All right, the chief is excused.
Yes, sir.
Thank you, sir. Yeah, give that to the court reporter.
Yes, sir. Thank you, Your Honor.
Thank you.
And this is the CD that he presented. I don't need it.
Yeah, you need to give it to the court reporter. All right, what else, Mr. Kelly?
I'd like to call Mrs. Hetzer.
All right, Ms. Hetzler. Ms. Hetzler, you've already been sworn in regards to this matter. I will remind you that you're still under oath, okay? All right.
Why were you holding your phone up when you were being interviewed by Randy Crabb?
I don't have any reason. I didn't even realize I was doing it.
Your Honor, I'd like to introduce 2 screenshots from that video. One from the 3-minute, 11-minute mark, or 3-minute and 11-second.
Well, Mr. Kelly, you can try to get them admitted, okay? You can't just say you want to admit it and that's it. But understand this. It appears from what you're saying that that evidence is duplicit, meaning it's already on the video,
Yes, sir.
okay? So you don't need to present it again.
Can I refresh the witness's memory with this?
Well, I don't know that she says she hasn't recalled.
Okay.
I mean, I'm not trying, Mr. Kelly.
There's a hot and heavy attorney disbarment case going on in Pennsylvania right now. So I had to run upstairs and start recording it.
Okay,
I'm just, you can ask her a question, and if she
And I got
doesn't
cereal.
recall,
Raisin Bran.
then we'll deal with her lack of recall.
Thank you, sir. You received a subpoena to produce a recording that you made at Joey Smith's office on December 9th. Is that correct?
I don't recall exactly what the subpoenas, there were many, many subpoenas, but I've complied with all of them to the best of my ability.
Were you recording during the incident at Joey Smith's office?
Part of it, yes.
What part of it were you recording?
I don't recall when I started the camera, and my phone turns off the recorder anytime that the microphone or the speaker is used, or if there's an alarm that goes off. So I don't know
Liar. She's
exactly what
lying.
was captured that night.
So you previously stated you only started recording, your testimony on February 10th was that you started recording after you heard me on the phone.
I don't know if that's
Your Honor,
true, and that's not
respectfully.
a question.
Hold on just a minute.
I'm going to object. He did not call her for cross-examination. I do fully understand she's a
I'm
party.
going to allow it.
Yes, sir.
The objection's overruled.
Your previous testimony to this court was you did not start recording until I was on the phone and you got up to record that interaction.
I don't recall that.
What did you testify, what did you tell Brandy Crabb in that video?
That I've been recording.
Recording what? How long had you indicated you'd been recording?
I don't know.
Can I refresh the
Some of it.
the
So- I don't
witness's memory?
Yes.
Good job, Mr. Kelly. You're doing good.
I need volume, Your Honor.
If you putting it,
Yeah,
what are we doing, Mr. Kelly?
I'm just going to play the clip where she says, "I've been recording the whole
Gave the
time."
disc back to the court report.
I have that clip segmented out. I can get the disc
we
back.
use
Yes,
the
sir.
official record, Mr. Kelly.
And it better still be hot.
Friends, I don't even know who he was talking to, but he was talking to a woman who said she was going down to Savannah. He was talking about he might come up to see her, so she's someone local. He asked her what she was doing December 9th, which is the date of our next court appearance. I had my recorder going the whole time that we were in there in case there's any shenanigans.
How long had you been recording at that point?
I don't recall. What I said to her was the whole time, but I don't know at that time if it was the whole time that you were on the phone. I didn't, it wasn't like I knew exactly how long I'd been recording.
She knows.
Can you see the video there? What's in your hand?
It's a cell phone, Joseph Kelly.
And what is that at the bottom of the cell phone?
I can't read it.
56 minutes and 26 seconds is what it says.
Your Honor, respectfully, he can ask, but he's not testifying right now.
You can ask a question in regards to the specific amount of time, Mr. Kelly, but you can't testify
Yes,
at
sir.
this point in time.
She was recording him for a whole hour at that point.
You can't read that?
That's correct. I can't tell what those letters are.
Are you ever going to accept responsibility for your actions, Mrs. Hetzer? So we can put this behind us?
I'm sorry, I don't understand how to answer that question. I've accepted responsibility, and I haven't done anything that I haven't been appropriately reprimanded by the court for.
You lied to this court, didn't you?
No, I did not, but you have many, many times.
Were you aware that your attorney had been giving me legal advice?
Your Honor, at this time, I'm going to interpose an objection. Mr. Kelly has previously told me he was going to introduce our telephone conversations when we were trying to work out either settlement negotiations or resolve discovery disputes. These were done while he was in jail. He called me. I responded to him. I can't tell you what everything in the conversation was, but...
Yes, you can, you liar. I got this, guys. Don't worry. Okay, Todd, here's what happened. Mom married a guy. They were married for a while, had 3 kids together. Husband got in an accident where either neck down or waist down didn't work any longer. So they decided, we need another man in this relationship for you, dear. Because nothing works. But they found Mr. Kelly. Mr. Kelly even lived with them for a while. She had 2 children by Mr. Kelly. Then they got the divorce, even though they weren't married. So they stopped being boyfriend and girlfriend. He moved out, and then the custody battles began. 4 years. And then, yep, that's the word. And then they started to go to court for the custody battles. But there were mason jars. And he told her that he was going to give her the mason jars back. So she came to the car, and then he decided he didn't want to give her the mason jars back. And she told the police that he tried to run her over with a car. Protection order installed. He's not allowed near her. He starts suing everybody. He sues the judges, the lawyers, the police, the magistrate office, the Catholic Church, because the kids went to a CCD thing or whatever, and he tried to come in and see them, and the Catholic Church would not let him see his children. Remember, protection order. So, suing them. Doctor's office won't let him see the kids when the kids are at the doctor's, suing them. This judge right here, he tried to get recused over and over and over and over again. And some of his motions to recuse have already been denied. Some are still at the Supreme Court level or whatever. He's got hundreds of motions out right now for this case. Hundreds and hundreds. Today we're going through a few of them. What he has now is that she is committing fraud on the court because she lied to them. And he wants her in jail for this. He has violated the protection order so often that every time we've seen him before, he's been in an orange suit. This is the first time I ever saw him not in jail. So he went to jail now. He wants her to go to jail. He wants him to recuse himself. He wants him to go to jail. And he's crazy. I think I didn't hit everything. I only hit like 20% of what's going on, but you get the gist.
I would state in my place that if I'm trying to resolve discovery disputes or possibly settle this case, that none of that is appropriate to be entered in evidence nor questioning my client. he has withdrawn, well, the court's ruled that he's not gonna
Well,
entertain.
the court didn't allow the filing of that motion. But your question was what, Mr. Kelly?
Are you aware that your attorney was giving me legal advice in this case?
I'm not aware that that ever occurred, no.
I'm gonna allow the question and the answer. But you're not gonna get to dig too much further, if at all, Mr. Kelly, in that regard.
Your Honor, if I may, the plaintiff has on numerous occasions offered communications between myself and her attorney, James Rockefeller, particularly on August 29th, 2024, and again on September 20th, 2024. In this record, beginning on page 27 and page 689 of this record, Mr. Rockefeller selectively used.
What record is that now?
2024 V-0088HCK, the case that we're on right now.
You say a record, and that's what I'm trying to understand.
The clerk's record.
Oh, the clerk's, what's been filed with the
What's been
clerk.
filed with the clerk.
Okay.
So on communications between, Mr. Harrington is arguing that communications between us during settlement negotiations are not admissible. This is not, so OCGA 24
Well, what his objection is, I believe, is that she doesn't have knowledge of what the conversations were between the two of you. She's testified that she didn't know that there was such conversations. So she can't testify as to what those conversations were. Now, whether I let you get into that when you testify or not, Mr. Kelly, we'll have to decide that at that point in time. You follow what I'm saying? Was she a party to the conversation?
No.
Okay. I mean, how can she testify about what you and Mr. Harrington talked about if she wasn't a party to it?
How are you going to feel when you learn that he was giving me legal advice?
I don't believe that that occurred.
What are you going to do when I prove that it has?
I guess we'll see when we get there.
Your Honor, I'm going to object to the relevance of this. If we're here about new evidence, this is not new evidence. It's a completely different issue that's not before the court today.
We're also addressing fraud upon the court, Your Honor.
Well, I'll entertain it just for the sake of entertainment.
Yes.
Have you ever agreed to change the children's name during these proceedings?
No, only during negotiations, which are not admissible.
Okay, Your Honor, I'd like to introduce this letter from James Rockefeller from the plaintiff to me on June 10th, 2024.
And for what purpose?
Fraud, to address her fraud, Your Honor.
What, I mean, I understand, but what fraud are you trying to establish, Mr. Kelly? That's what I'm trying to understand. I've ruled about the children's names. You know,
The last court case we were doing, he cried a lot. I don't know. I'm not going to tell you if he cries this time or not, but he's close right now. Yeah, I'm counting all the minutes that was purchased and how much content I have.
what you contend had occurred was not part of the record for me to rule on. And so because of that, okay, the record being void, I made a ruling. And that, I don't see where that's new evidence.
Okay, Your Honor,
Hell no.
I'm finished with this. She's not going to admit that she was recording the whole time. She's not going to do anything.
You've established evidence.
Okay, so I have no more questions for Mrs.
And I'm
Hetzer.
going to weigh that. and make a decision on that, Mr. Kelly. Any examination, Mr. Harrington?
No, sir.
All right, you can step down now.
He won that one. She lied. He proved it.
Call you next week.
I don't have anything else. I don't have anything else, Your Honor.
In regards to this motion?
In regards to that motion, Your Honor.
Okay. Argument? You got the right to open and conclude, Mr. Kelly.
There are over 13,000 frames, video frames, in the interview with Cindy Hetzer at 30 frames per second. And not all of them are clear. They're all blurry. But if you go through them each one by one by one by one, you eventually see that she is recording the whole time. When she says, "I've been here recording the whole time," 58 minutes and 43 seconds is on the timer. A minute before that, it's 56 minutes and 33 seconds is on her timer, her recording timer. That's what that is. Mr. Harrington made a big deal about it on February 10th, accusing me of not being able to see what was on her phone. You mean you could see what was on her phone? Yes, I could see what was on her phone. I testified that she was antagonizing me, calling me names for 30 minutes beforehand. And while I was in jail, I was relying on her being honest and producing that recording. But instead of producing the whole recording, the 58 minute and 41 seconds at this particular moment, she produces a recording that's less than 8 minutes long. I believe it was like 7 minutes and 37 seconds long.
She did, and he objected. And the court did not go in his favor for that. And Donald, I'm measuring my minutes like you measure inches.
And she says that's all she recorded. In the final video, she tells Brad Childers, yes, again, I was recording throughout the entire...
Wait a minute now. We're going to talk about the evidence, Mr. Kelly, and you didn't go into the final video.
And I regret it because I thought she was going to be honest and she was going to be caught red-handed.
Mr.
And
Kelly,
yes, sir.
The rules cut both ways.
Yes, sir.
And you're not able to argue facts that are not into evidence, okay? And
She lied to this court. She defied the subpoena to produce the record, and then she testified about it twice on December 10th and again on December 9th and February 12th. She committed perjury in this court, saying that she wasn't recording the entire time. In that camera, she clearly tells Brandy Crabb, I was recording the whole time. She's showing her camera to show that I'm recording the whole time, indicating to Brandy Crabb that she's recording for 58 minutes and 25 seconds in this.
I got it, Mr.
Okay.
Kelly.
And that's all.
I know don't look like I'm that smart, but I got it, sir. All right. Mr. Harrington.
Very briefly, Your Honor, she did testify to that. I have asked her about it, and that is what she had. We did present it. You may remember in the hearing, he declined.
No, I remember somebody saying there wasn't but 7 or 8 minutes of it.
Yes, sir.
And that was you, Mr. Harrington.
Well, yes, sir. That's what I was told by my client, and that's what she presented. And he chose not to go into it at that time.
Was it though? Was it though? Did the lawyer know? Oh man, if this lawyer knew.
I think we had issues about whether it was admissible at that time, and it has been admitted now.
Yes, sir. And I believe you held the record open, and before you made your decision, if you don't remember it, I will not.
I don't think that is the way it went, Mr. Harrington.
Yes, sir.
I remember we left the record open in regards to a certain video, but I don't think it was this video.
Certainly may be wrong. That's my memory.
I'll review the record before I make a ruling in regards to this matter.
Yes, sir.
Ooh, you're in trouble.
All right, Mr. Kelly, what, in your closing remarks,
2.5 hours.
Is let's say that there is new evidence and that there's a fraud upon this court.
We
What
know,
is
Amy.
it that you
We
want
know
this
you.
court to do?
Hold her accountable.
Well, I understand that, but I mean, what do you want me to do? You want me to reconsider if I can, and I'll have to look at the law, reconsider my ruling in regards to custody? You want me to hold her in contempt and put her in jail?
Sir?
What is it what relief do you want?
Your ruling on custody
Contempt.
is the best choice for my children. Hands down, I appreciate that ruling. So far, she hasn't been held accountable for anything. Put her in jail. Put her in county jail for 7 days. And let her know that her lies have consequences. There's nothing that she can do. I mean, that she does what she wants to do because nobody will hold her accountable.
It's normal for a judge to ask the parties what they want. That's normal. That's fine.
Like the give her some consequence, have some sort of meaning, that she can't play these games and continue to get away with it without repercussions. Because I've had repercussions. Not all of my choices has been perfect. There's been some bad choices, and I've had a lot of
jail time
consequences for some of my choices, some extreme, some that I don't believe fit. But so far, she's had none.
Okay. All right, I'm going to take this
That's
under
not true.
advisement. There's some legal issues in my head that I need to address and look at.
The judge
And I'll
knows
do
this.
that.
Don't worry.
I'll get
He
an
knows.
order out as soon as possible. All right, do we have any other matters today? You need to give the court reporter back the disc. Anything else that you want to have heard today?
We were scheduled for matters of contempt that haven't been addressed yet.
All right, you may proceed. You need to tell me which contempt matters they are and what motions are involved.
Particularly matters related to,
I'm sorry,
sir.
I want the specifics, Mr. Kelly, so that the record is complete.
We're also supposed to have a family violence protection order hearing today. Can we start
I
there?
asked you what you wanted me to hear, Mr. Kelly, and I'm here to hear everything you want me to hear.
I'd like to address the family violence protection order.
Okay. All right. What date was that from?
I'm looking, Your Honor. It was filed February 4th, 2025. Petition for hearing to show cause for issuance of a family violence protective order.
And that was in 0088, right?
Yes, sir.
All right, you may proceed.
So Cindy Hetzer has been abusing the legal process to deprive me of my life, liberty, my children. She is vindictively filing police report after police report for over a year now, making false assertions to this court.
Like maybe filing motion after motion after motion, making false assertions to the court?
Until every member of law enforcement she has contact with. And my position is all of that contact constitutes stalking.
He's arguing.
All right, so let me make sure I understand. You're saying the pleadings that she's filed in this case or these cases constitute stalking?
Yes, sir. So stalking is any contact, but not limited to any physical contact. Any contact for the purposes of harassing and intimidation. Georgia courts have ruled repeatedly.
But I understand, I do have a little knowledge of the law, Mr.
Yes, sir.
Kelly. And what I'm more interested in is appreciating the factual basis for your claim. And as I understand it to be, and if I'm wrong, correct me, I'm just trying to understand, sir. But it's my understanding that the fact that she's been filing these, or the fact that she's filed pleadings in these various cases is the basis for your claim of stalking.
Not the sole basis, no.
Okay,
They
all right.
play a role.
But that is one basis.
That is part of it, yes, sir.
All right, what is the other?
Contacting friends, family, coworkers, approaching me in a
All right, slow up now. I'm taking notes. Contacting friends and coworkers.
accusing me, defaming me, brushing up on me in a lobby of a waiting room, knowingly making false statements to law enforcement anytime she sees me in public.
Okay.
And a lot of these issues are going to be addressed in the civil process in 152, but they also, I mean, there's, for family violence, Your Honor, I don't know if.
Well, let me, I don't mean to interrupt you, but I want to make sure. But your allegations that you have in this pleading that you have filed on February the 4th of 2025, you have made those allegations to this court on numerous occasions.
Not in the context of seeking a family violence protection order, I have not.
Okay. Well, and I'm just trying to recall, Mr. Kelly, because I have a lot of cases in 6 counties, okay? And I'm just trying to recall part of what you've stated in this case in some form or fashion was the court not granting you a protective order who probably sometime May, June of 2024. And aren't these the same allegations?
No, sir, no
Okay.
hearing has ever
All
been
right.
held.
Well, no, you presented a protective order to me, and I denied it, and that's what I'm getting at. Are these the same allegations?
Some.
Okay. All right, well then, let's just deal with the new ones.
Well, sir, particularly there's video that the court hasn't seen related to these allegations.
Okay, and
So-
what?
So far, everything has been my word against her word.
All right, what videos do you have?
There's a video of the altercation where she approaches myself and Ruth Skaggs on April 2nd, where she
And that's the video that I held the record open for, and
sorry.
Oh, no, mistake.
I apologize.
Mr. Kelly, I'm trying to be as patient as I can be, and we've always understood that you wouldn't talk over me, okay? But it was my understanding that was the video that was not admitted into evidence because you didn't lay the proper foundation. You're talking about the video that I believe was the basis for her getting the initial TPO against you. Is that not right?
No, sir, that's
Okay.
not right.
Okay, I'm sorry.
So the April 2nd incident
Yes,
is the video that I'm talking about, where she accuses me in her TPO of,
Yeah, that's the one I'm talking about.
no, there's multiple videos, Your Honor. I recorded everything. I recorded all of our.
I understand that.
The one that you're referring to is the February 19th incident that I've been trying to get you to review and get into the record. And
February the 19th.
Yes, sir, when
Of what year, sir?
of 2024, I apologize.
So over a year ago.
Yes, sir. Okay. So it was the basis, it was the very first thing that she includes, and this is all a lie. This is her affidavit, and it's all a lie. And this video shows that it's all a lie. And everything that she's done since then has been based off of that incident. And it's between her and I, it's less than 40 seconds. The video itself is 2 minutes and 11 seconds. Most of it's me driving up her driveway and setting up a camera.
Well, the question is, one, do you have the video?
Yes.
And two, evidentiary-wise, can you lay the proper foundation for it to be admitted into evidence?
Yes.
Okay.
I also have Mrs. Hetzer's video that she recorded, and you recall she presented screenshots. I believe it was Plaintiff's Exhibit 2 or 3 or something, where she lied about what they showed, but I have that video as well.
And that's what you want to present to the court in regards to this.
He's
this motion.
super smart.
I want to show this court that she's a liar.
Well, I understand that that's your motivation, but I'm more concerned about the basis for your protective order, okay? And what you're asking the court to do is to grant you a protective order on events that took place over a year ago.
And events that go on now. So what the November 19th incident, if I had been granted a hearing
November 19th.
of 2024.
You're talking about the one that we just saw.
Yes, sir.
Okay.
Had I been 5 times prior to that incident,
This
I
has
begged everybody.
absolutely nothing to do with him gaining anything in any way, shape, or form. Nothing. He's not going to gain anything. He only wants to hurt her. Period.
Enforcement, I had begged judges, give me a hearing so I can show what this woman is doing, and nobody would hear me. You had scheduled it when we first. When I first came to you on May 10th, and you threatened to arrest me.
And then he did.
Mr. Kelly, what I told you, that your behavior was such that I could hold you in contempt for your behavior.
And I was begging for help.
I understand, but let's make the record correct, okay?
And so far, the only thing anybody cares about is Joseph Kelly's an ex-con, and here's this poor woman claiming, woe is me, let's protect this woman. And that's all that's been going on from the day one. And I want to lay that foundation. I want her to, if she comes up to me with a cell phone and thrusts it in my face again, I want to be able to be protected. I want her ass in jail. I want her to be snatched up and taken out of her lives and away from her children
$1 million
for her actions.
All right, well, let's present evidence then.
Present evidence that she committed a crime. You have committed crimes. You have
Call Cindy
violated
Hester.
protection orders.
Ms. Hester, come back to the stand. It's in the same case. I see no need to administer another oath to her. Anybody have any objection?
None, Your Honor.
Mr. Kelly? Mr. Kelly?
Yes, sir.
Dude doesn't even understand what he just did there. And I don't even know if they all understand. She can so easily get it's been almost 7 hours, my brain. Peaceful something that stops the other person from filing any suits against you. I think it's already done. Never mind. It's already been put in place the last time. Joseph Kelly is not allowed to file any more suits or motions against Cindy or the lawyers or the court unless he brings it in front of the judge first and the judge agrees that it's valid. And he just strengthened that because all he wants is for her to go to jail. So he's not doing it because she committed a crime. Vexatious too. He's not doing this because she committed a crime. He's doing this because he wants her in jail. And he's going to keep trying and trying and trying until finally she goes to jail. But the problem with that is she lied. She lied about that tape being 8 minutes. Yep. You don't really go to jail for that. You don't go to jail for saying you don't remember if it was more than 8 minutes long when it was 56 minutes. You get trouble, but you won't go to jail for that. She hasn't committed a crime that will put her in jail. He has broken protection orders. You're not allowed to talk to her. You're not allowed to go near her. You're not allowed to record her. He knows he's not allowed to record her. And he recorded himself recording her to try to get her to go to jail. That's the only reason he's doing it. So he's in trouble. He can't file any more suits. He just said all he wants is for her to go to jail.
I asked you a question.
I'm sorry, sir.
This is the same case. Do you see any need for me to administer the oath to her again?
No, sir.
Yeah, but he has to prove that she lied. Okay, we all know she lied. But what she said was, I don't remember if it was any longer. How are you going to prove what she remembers or doesn't remember?
Your Honor, this is a... Mrs. Hetzer, did you file an affidavit with this court to petition for a temporary protective order?
Yes.
What date did you file that petition?
I don't remember.
I'm sorry?
I don't remember.
Court will take judicial notice of the affidavit that's been filed.
No objection.
I don't know that you had the right to object to me taking judicial notice. Mr. Harrington?
You are correct, Your Honor.
Can you please, Mrs. Hetzer, describe our custody schedule prior to April 17th, 2024?
It was about 67:33. You had the boys Mondays and Tuesdays most weeks, except for the third weekend. You had them Friday through Monday.
April 15th, 2024, a Monday, and my birthday at 9 a.m., where were you?
I don't recall.
An hour
It's a
and
Monday,
42
and it's my
minutes
birthday.
backwards.
Where do you think you were? At
I
9
don't
a.m.?
recall.
What do you do at Mondays on my custody days, Cindy?
I don't know if that was the third Monday or the second
Party.
Monday. I don't know unless I'm
Drugs.
looking at a calendar.
Oh.
What the schedule
Men.
was for custody.
What's the date of your birthday?
April 15th. Does April,
That's tomorrow. Oh my gosh, that's tomorrow.
does April 17th sound like the day that the court gave you a protective order?
The court's gonna take judicial notice of that protective. What I'm getting at, Mr. Kelly, is I'm not trying to circumvent your examination, but I'm gonna look at that file, and those dates and everything are gonna be as if they came out of the Bible. Do you follow?
Yes, yes, sir. So the issue, Your Honor, is on a Monday morning at 9
1 hour
a.m.,
and
we're at
43
custody
minutes.
exchange. She knows this, but she's trying to pretend like she doesn't know it.
Well,
April,
hold on just a minute. Is that reflected
Yes,
in
Donald.
the dates reflected in her affidavit and in that court order?
yes. Well,
Well,
yes.
I'll take judicial notice of the calendar and as to the dates that it falls on. Okay?
So on April 15th, if that's my Monday, you're at Wednesday's exchanging children with me at 9 a.m.
I don't recall because there were many times that you refused to bring them to exchange, said you were going to be there, but you didn't show up. I don't know what happened that day.
On the
I
day-
don't remember.
On the day that you filed for this temporary protective order, were the children in your custody or my custody?
They were in your custody.
So it's safe to say that you brought the children to me prior to filing that protective order?
I don't recall. They were not in my custody.
Let's kind of cool it. You're getting a little agitated. You know, let's ask her questions, but let's don't get agitated with her, okay? Take a breath.
You told Judge Michael Johnston that you were terrified of me and you were afraid of what would happen to your children and your safety if he didn't grant you that temporary protective order. Isn't that correct?
I don't believe I used the word terrified. I accurately described events that had occurred and that I was scared of you.
Did you believe there was imminent danger?
I did, yes.
Why did you take the children to me and then go get a protective order?
Because I can't take the children with me into a hearing with the judge.
So you would leave them with somebody that you think they're in imminent danger of?
I never said that they were in imminent danger from you. I said I was afraid of you.
You asked the judge to take the children away from me because you indicated that you felt they were in imminent danger. Your Honor, I've given her a copy of her temporary protective order if she needs it to refresh her memory of her affidavit.
I'm not sure what the question was that you just asked.
You petitioned this court saying that you needed the children to be taken away from me in sole custody and so that I have no contact. Isn't that correct?
That's not what my request was, no. I walked in there with the information and the records that I had, and the judge helped me along.
Did you check boxes?
I don't recall which boxes I checked and which ones.
Did the judge grant you an order that took the children away from me?
The order was granted, yes, with a temporary protective order, with an ex parte protective order.
Do you think the judge did something that you didn't ask him for?
I never said that.
So you don't know who asked him to take the children away from me?
I didn't say that you are demanding me to admit that I walked in and asked the judge to take the children away, and that's not what I did.
Imagine if he would take all of this energy and put it into potatoes.
Misrepresenting the facts.
What did you do? What did you ask him for?
Hold on just a minute, Mr. Kelly. Did the order in fact take the children away from Mr. Kelly?
No.
What did the order say?
It changed the custody schedule.
Huh?
It changed the custody schedule.
Right. It prevented him from having visitation, didn't it?
It changed the visitation. It didn't prevent him from having visitation for the fifth until
I get
the
picture,
hearing.
Mr. Kelly, let's go on to something else.
For the record, it did change. It did change everything. It didn't change the visitation schedule. I had no contact with my kids for 18 days.
Your Honor, if that's excuse me for not standing, that's a question. I would like him to rephrase it. It sounds like an argument.
Ask it in the form of a question, Mr. Kelly. Isn't it true that I didn't have visitation with my children for 18 days?
Isn't it true that I didn't have visitation with my children because of your temporary protective order?
I don't recall the time frame that there was before the callback hearing, but there was a period of time where, yes, there was no contact, and that was ordered.
Do you remember? You don't remember. You don't recall what you put in this petition to destroy mine and my children's life. You don't recall this, right?
I'm sorry, I don't know which part that you would like me to answer. I didn't destroy your life.
Your Honor, can I present this to the witness for her refresh her memory?
Show it to Mr. Harrington first.
Refresh her memory how she destroyed his life? Is that what we're refreshing our memory? What's going on? I don't understand.
All right, for the purpose of refreshing her memory, you can look at that document and respond to his question, Ms. Hess.
Yes, I understand, sir.
You previously testified that...
Did she answer the question? Don't ask her another question. You gave her a document to refresh her memory, Mr. Kelly.
Sorry.
I'm sorry, I don't remember the question. Could you
All
please
right,
repeat?
restate your question that you wanted her to refresh her memory to, please, sir.
Do you remember filing this document with the court?
This looks familiar, yes.
Is that your narrative?
I believe so, unless you've altered it.
Do you have any evidence that I've altered it?
No, I just made a statement and answered your question.
Do you often accuse me of doing something negative when I ask you a question?
Absolutely, yes.
No,
100%.
I accurately state the facts.
All right, we're not going to have a debate about the veracity between the two of you. The court's got a pretty good picture of that. So let's go on to something else. Let's
Yes,
go
sir.
to the facts of establishing your entitlement to a family violence protective order, Mr. Kelly.
Can you look at page 3 there, Mrs. Hetzer?
Page 13, Williams.
The incident on April 11th. Why did you include that in this petition?
Because it scared me when you asked me to meet you in the woods in the dark.
I asked you to meet you in the woods in the dark. You said I asked you to meet you in the woods in the dark?
That's correct, yes.
How else would you describe that location?
It was in the woods in the dark between our homes.
Would you call it the property line between our homes?
In the woods, in the dark, yes.
Is it at the property line between our homes?
I've answered the question.
You might not want to do that, Donald. I would highly suggest that you're careful, because that judge will kill you.
Your Honor, I'd like to introduce screenshots from...
If you're going to use her to do it, she's got to identify it.
Yes, sir.
You got to show it to Mr. Harrington.
I've given you copies of these, sir.
I understand you gave me a mound of copies. I want to see what you want to talk about now.
I also subpoenaed her to provide these. I don't know that she has.
Let's stay on.
You subpoenaed her to provide
All right, what are we marking
things
these?
you already have?
Kelly, 3 today.
Sure.
My maiden name
that
is
all right,
Kelly, so
Madam
this
Court
hurts my
reporter?
feelings for hours. He keeps saying Kelly, and it hurts.
Have you ever asked me to meet you at the property line?
I'm sorry, is this?
An improper question until they're admitted.
I'm sorry.
No? It's not an improper question.
It's not. It's a good question.
He can ask her if she's ever been asked to meet, she's asked him to be met at the property line.
Withdrawn, Your Honor.
I don't understand what your objection was, Mr. Harrington.
I thought he was testifying as to the exhibit he just gave her. I was premature. I'll withdraw, Your Honor.
See, Donald?
Can you please repeat the question?
Have you ever asked me to meet you at the property line?
Probably. Back when we were together and dating, not 3 months after we had broken up or 2 months after we had broken up.
How many times have we met at the property
Yes.
line, Mrs. Hetzer?
I don't know.
Too many to count?
I don't have an estimate for you.
Did you ask me to meet you on the property line on December 19th?
I don't recall.
You can review the text messages before you and that exhibit.
Well, first off, there's a difference between her recollection being recalled or admitted them as an exhibit.
Okay, are we?
If you want her to look at them to see if it brings back her memory, then you can do that. Or you can see if she can identify those documents and we can make them and see if you can get them admitted into evidence.
Do you recognize
Don't worry. The judge is about to get her.
these documents, these text messages?
Rules of the court he's allowed to talk
I can't be
about.
sure that they're complete, but they do look familiar, yes.
Were you subpoenaed to produce some of these records?
I've provided everything that you subpoenaed me to my lawyer.
So can I have the records that they were subpoenaed? Then we wouldn't have to worry about her accepting that mine are complete. We can use her records.
Ma'am, are those text messages between you and Mr. Kelly?
I believe that they are, yes.
All right, they're admitted. And I'm getting very weary, Ms. Hetzler, of the dancing that you're doing.
Why wasn't it a dark and secluded place when you're asking me to meet you there?
Excuse me, Mr. Kelly. When she is getting yelled at by the judge, you shut up. You know how slow he talks? I bet he had more. I bet he was going to yell at her more. Damn it.
Because it was 8:15 a.m.
What about the next day?
That was 9 a.m. in the morning.
Are we broken up during this time frame?
February 6th, we had broken up February 2nd.
December 19th, we were broken up?
I'm sorry, there's several different text messages here. So one of them was February 6th. December 19th, I don't know if we were broken up. We had broken up some of the December and November. I don't know of those days.
So how about on February 19th? February 19th. It's the last 2 pages, Mrs. Hetzer.
Yeah, I brought the boys over. You didn't come to the property line. I walked the boys to the property line and they walked to your door. And you demanded that I come to your back door, and I refused to do that because I didn't want to be around you.
Are you sure that you walked the... Why don't you read the text messages, Mrs. Hetzer?
What I did was I offered to walk the boys over.
Ozzy bought another hour. 60 more minutes. Thank you, Fuzzy.
Okay,
And asked you-
You were deathly afraid of me at this point, right? February 19th, you were deathly afraid of me?
I would like to make some clarifying statements without interruption, if that's okay, please.
Jen, just put
The answer is questions, ma'am.
Yes, sir, I'm trying to. The property line is probably from here to the corner of the courtroom, between the property line and your back door. And it's very far. Probably even farther than that, actually. So I wasn't going to be around you if we had exchanged the boys, as we had discussed in this text message. You were going to be at your house, and I was going to walk them to the property line and then watch until they went into your back door.
You're asking me to meet you to get the jars.
No, I asked you
Your
to
Honor,
please send them back with the boys.
Well,
I said, can you
let
please
me
send
see-
one of the
let
boys
me
back
see
out
what
with
they
them?
say. They've been a minute.
Excuse me, sir. He's mouthing
No,
curse
sir.
words at me.
Ma'am, I'm telling you, I'm getting very weary of your behavior.
Whoa, Judge. Don't agree with you on that one. He was mouthing curse words at her. He was swearing at her. So when the judge wasn't looking, and he's getting weary of her behavior. They're in the South where they jar everything. Preserves, jelly, jam.
All right, which?
That attorney ain't saying nothing to that judge. She got yelled at a couple times. My bad.
In this exchange, who says, "I'll be there at the property line"?
She does.
I didn't ask you, Mr. Kelly. I'm getting a little weary of you.
Me too, Judge.
I said, I'll be at the property line. Yes.
Springsteen, thank you. We can maters in July.
It was a dark and scary place only for the purposes of this protective order, isn't that
It
correct?
was 8:30 for this discussion, and they were going to be coming at 9.
Mr. Kelly, I think you need to go on to something else.
Okay. I eventually brought the boys to or came to your house to pick the boys up, isn't that correct?
You did drive to my home, yes, to pick up the boys.
And that incident was recorded, wasn't it?
You recorded it? Yes.
And did you record some of that incident?
Only after you started driving your car towards me, or seemed to be that you were about to drive your car towards me.
I'm sorry.
I restarted recording whenever your vehicle began moving towards me.
That's a lie.
Your Honor, I'd like to introduce Mrs. Hetzer's recording of that incident.
Well, before we do that, let's verify that it is what it is, meaning what she's got to identify it.
So I don't know, do you want me to take a computer over there to play it for her so that she can identify it? I don't know.
She's got to say that's her recording.
If I was her, I'd go to jail before I said that was my recording.
If she does that, then we can play it for the court.
So I'm going to approach her and play this video for her, Your Honor?
I'm sorry?
I approach her and play it for her so that she can verify it's hers?
Or you can, let me ask you this, Mr. Kelly. Was this video played at the initial protective order?
No, sir. She presented screenshots that I'll get to in a minute.
Two screenshots, 2 little pictures.
Are you ready to view it?
No, I'd still like to finish it. I just didn't want to move.
How long is this video?
This is 30 seconds, Your Honor.
Oh, okay.
I've never seen this before in my life. No, I don't remember ever seeing this before in my life.
And you don't have any objection, the court would appreciate your letting the court know that. so
Well,
we can
okay.
just
When
go ahead
2
and
people
play it.
love each
Yes,
other. Just kidding.
I have no objection.
All right, let's play it. Submit it without objection.
I'll just send you a video, Nan.
Madam Court Reporter.
Sir.
I don't know that you got it.
I've got it queued up, Your Honor.
I don't know that you do. It's not
You're
in the
right,
system.
JK.
There it goes.
Oh, guys, please watch this video. Please, please, please. This is the video of him almost running over her.
I'm ready. I was just waiting for you to say go.
This is the video of
I
him
was just waiting for you to say
driving
play.
towards her.
I'm waiting on you, sir.
I'm not sure why there's no audio, Your Honor.
Well, that pretty much looks like she's walking right towards that car, who is driving off the road to get away from her. Maybe I'm wrong. They're going to play it again. You tell me. With this mic here.
The audio
Ready?
is up.
Yes, sir. It's up on my machine.
Hold on. just
She's
a
in the
minute.
middle of that road.
Kelly,
She is standing in the middle of that road.
it's not showing up on this monitor. You know why?
When I say P's or S's, does it sound bad in this microphone? Like,
Hang on just a minute, Mr.
or
Kelly.
psst.
Marlon, can you come see if you can?
I can try the other computer, Your Honor.
Well, I want to see the video. Or the,
To me, it looks like she's in the road
I
walking
don't know
towards
if
him.
I'm doing something wrong or. The one you used before worked perfectly.
Yes, sir. I can switch back to that computer.
Let's
if you'd
do
like.
that then. Well, hold on just a minute, Marlon. Let's make sure
That's 4 24-ounce cups of coffee done.
All right, now.
And we're still going.
Now it's working for some reason, Mr. Kelly. I'm good. Well, thank you. Okay.
She's
I
a
don't know why.
liar.
I don't know why it's not playing audio. Can I try another video to see if another video is playing?
No, so this is the video that's been admitted. So that's the one that we have to use.
I just want to use a video to test the sound, to troubleshoot, Your Honor. I can play the Officer Crab video that's already been
That'll be
admitted.
fine.
So it could be that the video that she gave me has no sounds. That's the video that they provided to me on Discovery and February 10th, I believe.
That is a video of somebody driving a car.
That,
Is that
yes,
your car or you're driving it?
Beep, beep.
that's me driving that car.
All right, let's play it one more time for the court, please.
Looks like she walks towards him, though. She is on the road, guys. She is on the road.
Date of this incident,
February 19th, 2024.
and you're driving down her driveway or your driveway?
Her driveway.
Okay.
That's the exit of her property.
Okay. All right.
She lied.
Mrs. Hetzer, you wrote in your petition for temporary protection.
And that is the incident that started it all. What we just watched is the incident that got her a protection order.
Order that,
That he
I began
violated.
driving on the grass. Do you see that? It's about 8 lines down from the February 19th.
Okay.
I was continuing to move backwards and then I stopped because he was continuing to drive toward me on the grass. Did you write that?
Yes, I did.
And you said you weren't sure what I was going to do.
Correct.
And you said I drove right next to you, very near to your body.
Yes, you did.
Did you walk towards my vehicle at all?
No, I did not.
You
And
did
that's
not
what you've
walk-
lied to the court over and over again. My
have-
feet
Yes,
were
you
on
did.
the driveway. Your hand was pulling the wheel this way as you were holding the GoPro with the other hand towards my body. And when you cut in front of me, I was in the middle of my driveway. My feet were in the middle of my driveway.
Where the car needed to be, lady.
And my driveway curves towards the road, and I submitted that photograph to the court last
Yes,
hearing.
you did.
Yes, I did.
So in that.
There's your hand.
Are those exhibits here, Your Honor?
Do what, sir?
The exhibits that she presented, that she's referencing now?
The question is,
Are those exhibits available for this hearing?
are they filed in that TPO file?
No, they were submitted on December 9th.
In regards to this matter?
Yes, sir.
Madam Court Reporter, do you have all the exhibits?
I do.
All right, find it.
He moved out and moved next door.
Do you know the exhibit?
No, I'm talking, Mr. Kelly, you find them.
December 9th.
Yes, ma'am.
All right, let's deal with them at the court reporter's table, please.
Sorry.
To save time, may I approach and do watch it at the same time?
Well, it's my understanding these are exhibits that's already been admitted.
Yes.
Oh, no.
This is it right here.
Okay.
These 6 photographs.
All right, you want to show them to her? And whose exhibits were these?
These were her exhibits, plaintiff's exhibits, Your Honor.
All right.
The judge is very smart, just like him. He sees everything. He sees everything. Her lawyer's about to get in trouble, by the way.
May I approach witness? Because my labels are usually not green. Those are what plaintiff's exhibits.
Were you questioning the integrity of the court reporter, Mr. Harrington?
No, sir. No, sir.
Well, they came out of the court reporter's evidence or exhibits files.
Your Honor, I
I
wasn't.
take it that you were.
No, so there's a green label on that. Mine are usually yellow, and that's all I was.
But my point is it came directly from the court reporter out of her envelope.
Yes, sir.
And so, to me, you were questioning the integrity of the court reporter.
Respectfully, no, sir.
All right, let's go on.
You previously testified that you did not select these screenshots, that your attorney selected these screenshots.
No, I never made that testimony.
Who selected these screenshots?
I did.
You did?
Yes,
And did you print them out?
I did.
Did you give them to your attorney?
I did.
Was it this attorney?
I brought him to court. I didn't give him to an attorney. I brought him to court and pulled him out whenever we were discussing this situation.
This attorney?
I believe so, yes.
And these photos show me swerving my vehicle towards you.
This photograph is not labeled. I'm not sure what you're asking me. Yes, in this photograph, your hand is pulling the wheel all the way towards the right, towards me, with one hand, with your left hand, and with your right hand. You're holding a GoPro while you drive your car towards my body.
Thank you. Can you go to the image, the other image of my wheel? That you testified that these show me turning my vehicle towards you. Here it is right here on the screen, Mrs. Hetzer. Here's the wheel right here, Mrs. Hetzer, up on the screen, Mrs. Hetzer.
Hi.
You said I'm turning my wheel to the right. You said I'm turning my wheel, right? Here it is right here.
Yes, you're turning your wheel in this photograph right here.
Can my hand be on the steering
I don't
wheel
have a
without it being
photograph of your
turned?
wheel being turned, but I have a photograph of your hand turning the steering wheel.
Here's the video right here,
Sure.
Mrs. Hetzer, of all the frames, Mrs. Hetzer.
Excuse me, sorry.
She can see it.
My wheel never turns. My wheel.
Ask questions, Mr. Kelly.
Can you stop me when you see my wheel turn towards you, please?
I don't have a photograph of your wheel turning, but I have a photograph
here.
of your hand turning the wheel.
All right, let's go on to something
Is
else.
it possible?
Mr. Kelly,
Yes.
let's go on to something else. I've got the concept.
We all got it. We all know she's a liar. I don't want no
You
husbands.
testify, or you
Sheesh.
stated in this affidavit that I approached you in the street
I'd
and was
rather get a
screaming
hemorrhoid.
profanities at you. Is that correct?
What date?
On April 2nd.
I'm sorry, I don't see April 2nd. Do you have the page number? Oh, yes, I see it. What I said was that as Ruth passed me, you said she's crazy twice, and I believe you also used an expletive. I said, I believe you also used an expletive during the second instance.
I yelled loudly.
That was my recollection, yes, at the time. Yeah.
Your Honor.
And whenever you played your video for the court, I do believe that you may have edited that video with your professional editing software. That's your job, is editing video and photographs.
What video did I edit?
No, Micah, you're my husband tester. You have to test them first to make sure they won't annoy me.
The one where in the street, April 2nd, that we're talking about, sir.
Do you have evidence of that?
No, I don't. I
Okay.
just said I believe that that it was edited, because it's not as I recall.
Oh, damn, I don't know.
So, Your Honor, I need to call her. I'd like to. I have no more direct examination for her. I'd like to recall her on cross after I testify.
Well, Mr. Kelly, you need to go ahead and ask her the questions you need to ask her, please.
I need to introduce a video of her walking that related to that incident. And she's not going to say that she's not going to admit it into evidence. So if
All right, I'll consider your request at the point in time that you make it, but not at this point in time. And I'm telling you, I may not grant it.
I would like to introduce a video of Cindy Hetzer's encounter on April 2nd.
All right? Can this witness identify it?
She's in it, Your Honor.
How long is this video?
1 hour.
Less than a minute.
Have you seen it, Mr. Harrington?
I have not, Your Honor.
All right, show it to Mr. Harrington.
This man is complaining to high heaven about discovery issues. And he's about to try to admit a video that the other attorney has never seen. They're down south, of course. Nothing will happen to a mason jar
It's
down
10
south.
seconds, Your Honor.
Ooh. Ooh, that's 5 more than I'm used to.
I have no objection to showing to her. If she can identify it, that's fine.
Any objection to the video itself?
No, sir.
It's omitted. This will be 5. Go ahead, Mr. Kelly.
I feel very scared for everybody in this courtroom right now because the judge just seems done. He's done. He's about to throw the bailiff in jail.
You're crazy. Do you think it's acceptable to thrust your camera in people's faces as you walk them by them?
I don't believe that it's any problem whenever I was trying to get a photograph of her, because you had said that she was going to be picking up our children for an exchange, and I hadn't seen her, I hadn't met her, I didn't know what she looked like, and you said she's crazy right in front of our children.
Why didn't you just introduce yourself to her?
Because you do crazy things like say I'm harassing your friends.
That's true. That's a solid point right
Your
there.
Honor, I don't have any more questions about that incident. Now I'd like to introduce my point of view of the February 19th video. The show-
Well, you can do that when you take the stand,
Okay.
Mr. Kelly.
Then I have no more.
It's hard for him to say he has no more questions for her because he just wants to bury her.
Are we on the family violence right now, or are we on the contempt?
We're We're on the family violence thing, Mr.
Then I have no more questions for Cindy Hetzer.
All right. Examination, Mr. Harrington. Ms. Hetzer, I was not your attorney during that time, but did he file any counterclaim to the petition for protective order?
I believe he did, yes.
And was this covered in the counterclaim?
I don't recall.
All
We
of
watched
this
it.
existed
It
prior
was
to the
November 12th.
February 25th, I mean.
We got the February one too.
25th hearing?
It did.
And we got the
So
April
this
one.
has all been considered by the court before?
Many times.
Yes.
Every time we're in court.
Okay. All right, she testified that he did file a counterclaim? Well, that's what she said, but I'll be honest with the court, I did not see a counterclaim filed. Well, that's my point. She testified that it was filed, and I don't see one being filed either. And that's the reason I'm asking you to direct my attention to the one that she claims was filed. Well. No, sir, not well.
In her defense, I'm going to defend her on this one. She lies, but I'm going to defend her on this one because he has filed hundreds of things. He keeps filing them. He filed so many things when he was in jail that he would forget which ones he filed, and then he would file duplicates because he would forget that he already filed it. So how is she supposed to know? How?
Well, tell me where I can see it in the record. I don't see it in the record. All right, very good.
Oh, no, we're only addressing like three things today out of the hundreds.
That's all I have, yeah. You can step down, ma'am.
I'd like to call Deputy Rios if he's available.
Who?
Deputy Rios.
Deputy Rio?
Rios, yes, sir.
This is just like McDonald case. It just keep going on and on forever.
Yes, I've got a thumb drive for you. Can I give it to you at the end?
Yes, sir, that's fine.
He's being called, Your Honor. I can call somebody else. It's 4 o'clock.
Yes, sir, I can call myself, I guess.
All right. Come up here
Let's
and tell
go.
Is it possible to testify from here?
What did I just get through saying, Mr. Kelly?
Your Honor, I really also have to leave. Is it possible to take
We'll take a break. We'll take a 10-minute break.
He needs to go vomit.
Yeah, you can go to the law library.
We can all go vomit. I don't think that I cut this break out. I don't. Look, I didn't. I'm sorry. Oh, I did. I'm sorry, I did. I don't know what I did. Quit hitting on her, Judge. Go sit down. Leave her alone. That's a pretty black sweater you're wearing today, ma'am. It would look good on my bedroom floor. Why? Why do they have to stamp? In courtrooms, all they do is stamp all day. Nothing's happening. Put your stamper away. sorry, puppy. I'm sorry. Oh, and there goes the coughing to go with the stamping. Another Smith. Thank you so much. TSD. I love it. I love it. Come on, lawyer. We were just getting good. We were just getting into it.
Here now, do you wish to have him testify first?
Yes, please.
All right, let's have the deputy come in, please. You'll come up here and, when you reach the witness box, if you'll stand in there for me for just a second, raise your right hand.
Yes, sir.
Please try not to tase him on the way there, sir.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God? I do.
Can I please have some videos of that, please?
If you'll have a seat, state your name for the record, and then for the benefit of the court reporter, if you'd spell it for me.
Deputy dog.
My name is Abel J. Rios, A-B-E-L, initial J-R-I-O-S.
Thank you.
And what is your job, Mr. Rios?
I'm a deputy sheriff with the Bleckley County Sheriff's Office.
And how long have you been in that position?
Just over a year.
And how long have you been in law enforcement?
Give or take most 20 years.
Are you familiar with Bleckley County Sheriff's Office incident report policies?
I don't see how that's relevant. I typed the report, so there's this incident report system in place, so yes.
So do you comply with those incident report
Yes.
policies? So you're familiar with them and comply with them?
Yes.
Did you have a chance to encounter me on
I didn't get there and you did.
April 17th or April 22nd, 2024?
I have a report listed for April 22nd of 2024.
Did you review that report before coming here today?
I have the copy of the report with me.
Outstanding, thank you. Can you describe what that incident was about?
Basically, you walked into the LAC to report a false statement. When asked, you said you wanted to provide some information regarding false statements made by Miss Cindy Hetzer.
No, Jude. Bye.
And did you review any evidence before you conclude or made that report?
The only thing that I believe at that time was the video that you sent. I can't remember if you had the copy with you or you had emailed me because I asked you for the email be sent with that video. But based on that information, it describes, I'm sorry, I'm backtracking. Based on your statements, according to that video, that you began driving on the grass. This is what she said. And I continued to move backward, and then I stopped because he was continuing to drive toward me on the grass. And I wasn't sure what he was going to do. He drove right next to me, very near my body, and then he cut his car over in front of me onto the driveway. I felt very afraid, and I immediately sent him an email telling him to not enter any part of my property again, and that we need to exchange at Wendy's for all exchanges from then on.
And did you view evidence that contradicted Mrs. Hetzer's assertions?
Based on the video, what I saw in the background was that you had walked around the vehicle to the right side passenger door, you knock on the passenger door.
I'm sorry, Mr. Rios, me or Cindy Hetzer?
I apologize, Mr. Kelly. Exited your vehicle, you opened the left rear passenger door, got out, and went back into the driver's side seat. And I saw in the background that you walked around the right front passenger door. You knocked on the door. There was something inaudible said. Then you placed the vehicle in gear, start to drive off. As you are driving off, Ms. Hetzer is walking down the driveway as you are, the same driveway as you are, and then you are seen maneuvering away from Ms. Hetzer.
So the video that you saw doesn't show me swerving towards her?
Correct.
That's only all the questions I have for you, Deputy Rios.
Cross.
Why isn't anybody saying the obvious? The car is supposed to be on the driveway. She is not supposed to be standing in the driveway where the car is supposed to be. He was just driving his car onto the driveway. Like, you're supposed to do that, right? If he would have driven down the lawn the whole way to the road, she would have got him for vandalization or something.
No questions, Your Honor.
Thank you, sir. You're excused.
Thank you, sir.
You want to come on up, Mr.
Yes, sir.
Kelly? If you'll,
Computer up here, Your Honor.
I don't know whether you need it or what. I mean,
I need to play a video to introduce the video.
all right, you will bring the computer up here. Well, I tell you what, let's just let you testify from there because I don't know that you can hook up with the system down up in the witness room.
Maybe she could teach him how to hook up.
Raise your right hand for me, please. Do you solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God?
I do.
All right, you may proceed.
On February 19th, Cindy had instigated a fight over some mason jars. And I didn't want conflict with her anymore, so I just decided to go and pick the boys up and not engage with her any further.
I need to back that. No,
I get to the property, I know there's going to be conflict, so I set up a camera in my car. Once I put the boys in the car, she approaches me aggressively, asking me where the jars are. I ignore her, I get in my vehicle and start to leave. She walks around my passenger side, she bangs on my window, not taps, not knocks, she bangs on my window, repeatedly demanding, where are my jars, where are my jars? My children are seeing her behave this way. I put the car in drive, and I see her walk away and stand in the middle of the driveway so that I can't leave. She has a history of doing this, blocking my exit from arguments. So I slowly drive around her, and as she sees that I'm driving around her, she starts walking towards my vehicle to close the distance between herself and my vehicle, as the deputy described. And I'd like to introduce that video of that incident.
You seen it, Mr. Harrington?
No, sir.
How long is the video?
It's 2 minutes.
1 hour.
All right, let's let him see it.
Do you want to take it off of the big screen while we do this?
No, sir. That's not the way we do it, Mr. Kelly. We've done it several times now. He's got to look at it, and then I've got to see whether he's going to allow it to be admitted. No, sir. Take it off.
That's what I asked you, if we wanted to take it off of the big screen.
I said, take it off. I thought you said, do you want me on the big?
No, sir. I was asking if you wanted me to take it off.
Take it off.
Could you get us some videos of some Canada court cases? Oh, it would I'd love that. I know you can't, but take it all off. No, no, please. he, he needs one of those 7-finger pork chops the posse sent me. It's 4 o'clock. You need to get this going. I need my nap. In the video, it does look like he turns the wheel over, though. Did you see when they played it for a second?
Okay. All right, this is 5, Madam Court Reporter.
6.
6, okay. 6 is admitted. You can play it, Mr. Kelly.
Are you ready, sir?
I said you could play it, sir.
That once people get used to it, they're not going to want to go back. Wall Street Journal technology reporter Christopher Mims, thank you so much. Thanks so much for having me. In New York, I'm Sabrina Short with the Marketplace Morning Report. From 8 p.m., American Public Media.
From the campus of Mercer University, this is 89.7 FM, WMUM and WMUM HD, Cochrane, Macon, part of the Georgia
I will
Public
never
Broadcasting Radio
agree
Network.
he's right, ever. Ever.
You've been listening to Morning Edition on GPB. I'm Pamela Kirkland. Thank you for joining me this morning. Stay with us for the BBC NewsHour coming up next. Have a beautiful day, and we'll see you right back here tomorrow.
Support for GPB programs comes from our listeners and Georgia State University. GPB Atlanta is licensed to Georgia State University, the largest university in Georgia and one of the largest in the nation. More information is available at gsu.edu. Georgia has such a rich history and continues to grow and change. GPB offers you diverse stories with diverse voices you won't hear anywhere else. We'll show you the wonderful places and people in the state.
Welcome to NewsHour from the BBC World Service. I'm Rebecca Kesby. Today, a defiant stand. Alexei Navalny's widow Yulia accuses President Putin of killing her husband and calls for supporters to keep fighting his regime.
The most important thing we can do for Alexei and for ourselves is to all fighting. I will continue Alexei Navalny's work. Continue to fight.
She was pounding on that window.
A Western journalist tells us of his encounter with Russian special forces behind the front line in Ukraine.
There was this huge bang on the door and shouts. And these
We just heard a huge bang on the door and shouts too.
Russian humour that they started talking about eating my liver.
Plus, we'll have more on the latest EU attempts to take on big tech, this time Apple.
After I left her property, I was looking in the rearview mirror, and she continued to follow me down the driveway as I left. That's visible in her version of the video, where she continues to chase me, to film me. And yet she reports this incident as she's afraid of me, and that I swerved to hit her when she's clearly walking to my vehicle, and I'm trying to get away from her. She's made a big deal that I parked perpendicular to the driveway. I did that so that I was visible, she was visible, and the children were visible when they approached the vehicle in my camera's view, so that there was no chance that she could argue something happened that didn't happen. And I don't have any more.
He's getting tired, guys.
Questions for myself about this incident.
Cross-examination,
Let's
Mr.
have our
Harrington.
questions for ourselves.
Mr. Kelly, you were present at the hearing that was held on April 25th?
I was.
You had an attorney?
I did.
You had an opportunity to bring all these matters up at that hearing?
I did.
And that was at a hearing, and this was all done in the court system?
I don't know. I don't think I understand your question.
You have stated that there were a lot of things that she has done that you complain of. This and everything you've talked about today was through the court system, correct?
OSHA.
Correct, but this is the first time that the judge has been able to witness this video compared to her testimony about this incident.
I understand, but you're here today asking for a family violence protective order.
That's correct.
But everything, are you acknowledging and agreeing that everything has been from court litigation?
No,
Okay.
it has not. Not from the perspective
I'll
of
rewind
me
it.
petitioning for a protective order. This is the first time any of this evidence has been presented as family violence against me.
And there's been any family violence that you're suggesting, what has occurred after the Judge Wall's order granting her family violence petition?
A number of things, Mr. Harrington.
But you haven't testified to him today. Have you presented anything other than the
Don't-
waiting room incident?
Don't say
Good
that.
point.
You're
I'll-
going to
I'll
lose your
address that
case.
on redirect, Mr. Harrington.
Thanks, Mr. Harrington, dumbass.
He's asking you, have you?
Have I? Yes.
What else have you presented other than?
Today, you're right. I naively believed that this is enough evidence to prove this woman lied to obtain a protective order.
Okay, fine, maybe, but you want a protective order against her. How did she harm you? What did she do that you need protected from? Videoing you? You are literally videoing her videoing you. Is that what you're saying she did? I'm not 100% sure what he's saying she did. I just don't know.
Understand, we're not here about that today.
No, I
We're
understand.
here about issuing you a protective order.
Yes, sir.
What has she done to threaten you?
Hey, I just asked
after
that.
the ruling by Judge Wall in April of 2024?
She falsely reported to Deputy Ruiz that I pointed my camera right at her. You have since made a filing saying that she mistaken it. That's what she believed. But when she testified to that officer, she told him, no, he definitely pointed his camera right at me and my daughter. And then in your filing of March 13th, she's walking that statement back. Do you want me to go on, or do you want to ask me questions about that incident?
And what about that made you in fear of your life, health, or physical safety?
Because she's abusing the legal process to have me arrested. Her goal is to have me arrested and put in jail, affecting my mental status, my psyche, my relationship with my children.
Understand
That's
that in
legit.
family violence. I don't want to educate.
No, so you don't lecture him, you ask questions, Mr. Harrington. You know better than that.
Yes.
Judge is about to spank you.
Physical act has she done that made you in fear of your life, health, or physical safety?
There doesn't need to be a physical act, according to the laws of the state of Georgia, for stalking to occur.
What physical act has she done that has placed you in fear of your life, health, or physical safety?
She's made a number of false reports to law enforcement. She's invited her 16-year-old daughter to also make false reports to law enforcement. Those are physical acts.
Okay, are you in fact in fear of your health or physical safety?
Every day. Every day I'm afraid of what she's done now. Every day. I don't sleep.
He is literally terrified of exactly what he is doing to her. He is constantly filing motions against her every day. And he is in fear that she is lying to get him thrown in jail. Oh my gosh.
I'm dreadful afraid.
He's dreadful afraid.
Of Cindy Hetzer's lies and her manipulative behavior.
I'm asking you, what physical harm are you afraid of?
Her manipulating the courts and her manipulating law enforcement.
All right. Now, in the course of you defending and or prosecuting these various civil cases, have you in fact also asked questions of and talked to people that she's had as witnesses?
I don't understand your question.
You've tried to talk, for instance, to the pastor.
What do you mean I've tried to talk to him?
Have you tried to talk to anybody that she's held as a witness in any of these cases?
No.
None.
She hasn't called any witnesses in this case. And that's the problem. It's been her word against mine this whole time. And there's a slew of evidence that she's lying. And attorneys come in and they mangle words and they twist things to pretend like she doesn't remember. Just say you don't remember and it'll be okay. Just say I don't recall. Just say you don't recall, Cindy. That's all you need to do.
And
That's all facts.
I'm asking about things that are not in the court system.
Perhaps you could ask me a question about a specific witness and I can answer. But she has not called any witnesses to testify in this case against me. To answer your question directly.
Do you not think it's prudent for her in preparing for your witnesses to ask them questions?
What are you talking about?
Have you been physically harmed? I understand you're talking emotional. Have you been physically harmed at all by Ms. Hetzer?
Yes.
Describe with particularity what physical harm you have been subjected to.
She has pounded her finger into my chest when I try to walk away from arguments with her. Repeatedly from 2019 to 2023.
And she's still doing it. She hasn't stopped. She's doing it right now. Look
She won't
out.
let me leave her property until she's heard me or until I've heard her.
And since 2023, has that happened or occurred?
No.
Okay.
But Georgia courts have also recognized that psychological abuse and emotional abuse is just as damaging as physical abuse.
Have you had to go to a doctor, physician, or counselor about
Yes.
it? Who, when, and where?
Would you like to submit her name is Miranda, and she's the County Behavioral Services out of Dublin.
It's his PO, I bet.
Time frame.
Time frame? I don't know. I had my first in-person meeting with her last week.
Okay.
I'm gonna
Although
feel it for the rest of
you
my
say none of these physical behaviors have occurred since 2023.
Yes, sir.
Okay. And are you suggesting that the psychiatric harm is part of your case against Ms. Hess?
She's actually the spider in the corner of the wall.
So will you waive any conflict or privacy issues with your counselor?
I don't know what you're asking me.
Can I have all of her records in discovery?
And let's go on about the facts of this case, Mr. Harrington.
That's all, Your Honor. I'm sorry, if you'll give me just a minute.
I'd like to introduce
Hang on just a minute, Mr. Kelly. Let me get through with Mr. Harrington.
sorry.
That's all, Your Honor.
All right. Now what, Mr. Kelly?
I'd like to He pointed out that I hadn't pointed out any sort of harm that's come to me, so I'd like to address that.
All right, you may testify and redirect
I'd
based
like
on the issues that he has just raised to you.
So I'd first like to introduce a video of me journaling. And this is following
You doing what now?
journaling, talking, describing my feelings, my thoughts.
No, sir, that's,
It's related to Mrs. Hetzer.
I understand that.
I want content, but I do not want to see you journaling. I do not want to see this.
But that's perpetuating. If you want to say the same things now, you can, but you can't introduce who are you talking to?
I'm talking to Cindy.
Oh, you were talking to her when you made these remarks?
Yes, sir. It was a video journal intended for her.
No, sir, that's not what I'm talking about. Was she present when you made these remarks?
No.
You're not going to be able to bolster your case by something. You can testify now about what you said, but you're not going to be able to use that video.
It's not about what I said, Your Honor, but it's about my emotional state. It's a visual representation of the harm that she's caused.
And once again, you're not going to be able to do that.
Thank you, Judge. I love you, Judge. Thank you.
Anything else?
He's going to sue you now, Judge.
That's a little bit self-serving, Mr. Kelly.
Well, he indicated that I haven't suffered any
I
harm.
understand that, Mr. Kelly, and I'm giving you an explanation of why I'm not allowing it.
And I've accepted it, Your Honor.
Okay. Anything else?
Yeah, so I was walking. No, I don't have anything else, Your Honor.
All right. Anything on recross?
No, sir.
All right. You got any additional witnesses in regards to this matter?
I'd like to recall Cindy Hetzer.
All right, Ms. Hetzler.
What questions is she going to avoid answering this time? What is your name? I don't recall.
Remind you you're on the roof, ma'am.
Yes, sir.
I don't know.
On February 19th, 2024, were you walking towards my vehicle as I was driving?
No, I was walking down my driveway.
No further questions, Your Honor.
All right.
It's never done. He has hundreds of cases.
Anything else?
It's never going to be done.
Mr. Harrington, you have any evidence you wish to present in this matter?
Ms. Hetzer, I would remind you, you've been sworn. Excuse me, Ms. Kelly. Ms. Hetzer, I remind you, you've been sworn, and I apologize. Have you physically threatened Mr. Kelly in any way?
No.
He talked about you pointing in his chest. Did all that occur before 2023?
The incident that he's referencing was in 2019. There was one incident.
Tell the court your belief
She's telling the truth.
or memory of that.
What I remember is that he was getting onto my kids, and I told him to stop yelling at my children. And we were fighting, and he shoved me into a couch. And when I told him that that's not acceptable, he said that if you call the police, I'm going to tell them that you were poking me in the chest with your fingers, and we're both going to jail.
Have you stalked him?
Never.
And now she lies. Like, I thought she was taking responsibility for at least that, but she's not.
Have you physically threatened him?
No.
And have you tried to use the court system to protect yourself and the children?
To protect myself and the children? Yes. Yes.
What, if any, self-help remedies have you attempted to do?
For myself?
Yeah.
I'm in counseling once a week. I've tried to get the children counseling.
Yoga with goats.
Everything you've done as action has been through the courts.
Action towards him? Yes.
No, her last attorney,
Anything on
it
record?
was 2 videos ago. We have a couple videos of this. It keeps going on. Roethlisberger or Rosen or whatever, he's her new husband.
Cross,
Do you remember testifying? I'm sorry. Yes, Your Honor.
excuse me.
Do you remember testifying about that incident in 2019 at your temporary protective order hearing?
I don't, no.
Can we give her the transcript so we can refresh her memory?
I didn't bring anything up about the transcript, but
You brought up an incident. She's already testified.
You brought that incident up.
She testified about that incident already, and she didn't say that.
True, Sheila.
He brought it up. It's fine.
Where's it at in the transcript, Mr.
I'm going to
Kelly?
give it to you right now, sir.
Oh man, I didn't even think about that. I didn't even think about that.
Do you embellish, Mrs. Hetzer?
No, I don't
Never.
try to embellish anything, no.
His memory is on point, but so is the judge's. So got to remember, the judge sees everything. He knows what's going on. Donald, by now you should understand that nobody here can help you with your TV. Because every day you tell me you can't see your chats.
I'll find it and I'll submit it to the
And
court.
never have we had an answer.
No, sir. It's today or never.
All right.
I told you he had some valid points this time. He wasn't just crying and stuttering and crazy. This time he had some valid points. He presented solid evidence that she's a liar, and her attorney might also be. And back on. You forgot to say and back on. Definitely. 100%. 1,000%. You should call Samsung. They will help you. Call Roku. I am never mean to you. Come on, Mr. Kelly. We just hit the 3-hour mark. Let's go. Let's go. Poor Cindy's just stuck in the witness box. It's just insane that everything he's complained about is what he excessively does.
Mr. Kelly, we need to move on. It's 4:45.
Just told him that, Judge. He don't listen to me.
I'd just like to submit that she testified something different now than she did on the 25th. It's going to take me, there's 1,100 pages of documents.
I understand, but
I'm-
there's a
I'm not-
matter of preparation. If you knew you were going to ask her about it, you could have had it available to you. We need to move on.
No, Judge.
I didn't ask her.
It's recross, Judge. How the hell is he supposed to know what questions he's going to ask on recross? He asks questions based on what the other lawyer just brought up. Come on, Judge.
About it. He brought it up.
I understand. We need to move on.
Okay.
What else, if anything, do you have?
Our son ran away from home one day, didn't he?
You have two sons. Can I have an appreciation of which one?
Oscar, our 5-year-old son, ran away from home, didn't he?
He did.
How long before you discovered he was gone?
I believe it was about 20 minutes, but I'm not sure.
That is a great idea.
How did you discover he was gone?
When the police pulled up to my house.
Who directed the police to go to your house?
I believe it was you, but I'm not positive about that.
What was your reaction when the police came to your house asking you about your children?
Respectfully, Your Honor, what does this have to do? I would object to.
Where's the family violence in this?
It's her exaggerating things. When she's told that her
Wait.
son has ran away, she tells the officer.
She exaggerates things. Stop. I feel like he's trolling me right now. I feel like somebody put this video in front of me just to troll me.
Sir, I don't know that he didn't lure him off the property.
That's incorrect, and I'd like to testify.
It needs to relate to some felony or the alleged misdemeanors that constitute family violence, Mr. Kelly, and I don't see it.
So stalking, Your Honor, it's contact.
How is her response to law enforcement stalking to you?
Siebert versus State. Siebert was arrested for aggravated stalking because he sent a letter to the protected party's
Go
attorney.
on to something else. I'm not going to allow it. Let's go on to something else.
Okay. I don't have anything else for her.
Anything, Mr. Harrington?
No.
Step down, man.
Maybe she can stay down. Nope, I don't think so.
Any further evidence?
I'd like to call Deputy
Dog.
Benjamin Shepard.
Present.
I don't think he was in school today. I don't know if he's here. He's out of town.
Ooh, he's out of
What
town. Ooh. Judge, calm down. Breathe, Judge. We are past the 8-hour mark. Who has been with me from the very beginning and has not left? Who has watched all 8 hours except for maybe a bathroom breaks? JK? Who else? Anybody? Anybody? And Lori? I'm so sorry, guys.
These other folks, the priest and.
Let me verify.
That was for contempt. They're here to testify about contempt, Your Honor.
And how long are those hearings going to last?
It depends on how many people say, I don't remember and I don't recall.
Okay.
They put a little lump in my throat right here.
Sergeant Shepard's not available.
Patty and her husband.
Jeff Simpson introduced the video that he provided with me.
That who provided?
I subpoenaed the Buckley County Sheriff's Department for Benjamin Shepard's body camera footage. He presented that to me at the start of this hearing. That was
Pursuant to the subpoena?
Yes.
Do you have any objection, Mr. Harrington?
I just don't know what it is.
Well, I understand that, but I'll show it. How long is that video?
It's like 30 minutes, but there's only like a 30-second clip that's relevant. It's when she tells the deputy, I don't know that he
No,
lured
sir,
him
I
up.
didn't ask you to testify about it. I asked you, how long was it? You're gonna play a 30-second clip,
Roughly 30 seconds, yes, sir.
and you know where it's at?
Yes, sir, I should be able to find it. Yes, sir.
2
I
more
should be able to
hours
find
and
it pretty
15
quickly.
minutes.
I'll show it to Mr. Harrington. Court's inclined to admit it because it came directly from the sheriff's office and part of their records.
Yes, sir.
Yay, Donald. Thank you. I believe you. I believe you. Oh shit, no. Yes. You need to shut up. You need to go to bed. Don't you have to feed your cats or something? No one would have known. Never argue with Kelly.
Your Honor, I am going to object because it's the very same.
Now I have to stay on for 2 more
Directed
hours.
him to move on
I got
from.
4 hours to go.
Apparently, the interview that the officer was talking about the child that ran over his house. And I would still say
Is that
it's
right?
not relevant.
She just testified under oath.
Sure,
that she
come
didn't
get
say
it.
this.
Is it the video of the officer dealing with
I'll
your
give you
son
anything
having
you want, Micah.
ran away?
Yes.
All right, I'm not gonna allow it. Let's call on something else.
I'd like the record to reflect that she perjured herself, and this video shows that she
No,
did.
sir. We're going on to something else, Mr. Kelly.
I don't have anything else, Your Honor.
All right, we need to have argument in regards to this matter. You got the right to open and conclude, Mr. Kelly.
I'd like to reserve.
All right, Mr. Harrington.
Your Honor, respectfully, he started out by saying that there was a whole lot of things going on, including specifically court records. As the court is aware, there is a mixed bag here, but things that are done in court are not actionable per se, except for what the court may do in sanctions in that hearing. I will tell you, quite frankly, I looked to find out whether there is any case law.
Thank you,
saying
Mike.
that you're required
Too
to
bad
do a
you didn't say that's
compulsory
per minutes.
counterclaim as far as the
Woo!
petition
Thanks
for
the tip.
protective order that was done on April of 2024. The code section does require, if you're going to make any response or bring up any defenses, you should do it 3 days before the final hearing.
I'm familiar with the statute.
I would argue that that is tantamount to a compulsory counterclaim, and all of these things he's talking about, with the exception of the waiting.
What do you mean,
room
neighbor,
incident,
Donald?
in fact, occurred prior to that hearing, and I
Yeah,
would think.
but my thoughts are the fact that the waiting room incident occurred.
You shut up.
Does that circumvent his ability to show her behavior previously? Maybe not, what I'm getting at is not base the
Just 'cause I'm
protective order
handling
on
my
the incidents that occurred during the period of time that she was getting the.
The other
protective
Donald.
order, but the subsequent acts
Damn it.
are enough when you take in the cumulative facts of what she's been doing all along.
And I, of course, agree that that was in the court's purview. But I would argue a lot of these things in his suggestion that he's been in physical fear of his life, by his own testimony, ended in 2023. It doesn't meet the near time standard.
Well, I don't know, and I'll have to look, but I don't know that it's,
We are officially at like 11 hours and 5 minutes. Right now we are 8 hours and 13 minutes in.
necessarily requires fear of your physical harm. I think it also requires or can deal with one's mental harm.
Now, addressing the incident in the waiting room, by his own testimony and by his own videotapes, they are in a very small contained waiting room. He sets up a camera.
Oh, you're so
after he's been ordered
close.
not to, and he engages in a public phone call to someone to arrange testimony or witness testimony in this case. He certainly could have done that any other time, and I would suggest that he is baiting her by doing it in her presence.
And I have a lot of problems with your client's testimony dealing with the length of that recording that she made and her veracity of this whole situation, Mr. Harrington. I'll be glad to hear from you to address that, the court's concerns.
Well, I presented what I was provided, Your Honor, and that's all I can say.
No, you were right. I forgot about those 2 hours for free.
I'm talking about.
And that's right. That's correct.
The court's perception of her veracity of misleading this court or
Hi,
what
Uncle
appears,
Dan.
we'll look at it, appears to be misleading. And she said it was a 7 and 8 minute tape and it was some 50 some odd minutes of tape.
Okay. Pause right there. Let's just say that she lied. There was a 1 hour tape. She said it was 8 minutes long. Okay? What should the punishment be for that? Now, if the lawyer knew, he should be disbarred. That's bad. Wait. Yeah, he should be. That's bad. But if she lied and got caught, what is the proper punishment for saying that it's a 7-minute, 8-minute tape when really it is a 52-minute tape? Is that jail time? I don't know. I don't think that matters. She said it was 8 minutes and it was 52. Does that, for all of us who watch court every day, is that jail time? Lying on the stand, perjury. Does she go to jail? We see people lie every single day, all day in court, every day. Right. But what is the punishment for that? How should she be punished for that? Probation? 30 days? A year? For perjury? I mean, he can't get a protective order against her because she lied about 40-some minutes. That's what he asked for. He asked for her to go to jail because of that. Nope. She said it was 8 minutes, about 8 minutes. And it was 52 minutes. I don't think he can. She didn't misunderstand. He said it was longer. She said it was not. I love it. $1 million.
All I can do is disagree based on what my client has told me, Your Honor.
Oh, I love that one. I love that one, Twitchy. That sounds right.
At least in that 7 minutes.
Ooh, that's
what he has presented.
Good one too.
He clearly baited her into trying to record it.
I understand that that's your position.
Yes, sir. Now,
he could. The judge will eat him up.
It can be handled in a different manner than a family protective order if the court chooses to add to its open case and do a restraining order. She is a federal employee. I asked the court to take into consideration the effect it would have on her ability to support the children if a TPO is entered. And I know the court understands the distinction because we've dealt with that before.
Sometimes life falls where it falls, Mr. Harrington.
Well, if the court should see fit, I would respectfully request that you consider doing it as a restraining order in the main case rather than a TPO. And even if the court feels she is acting inappropriate.
The lawyer knows she just got caught. Perjury. She just got caught. The judge knows it. Everybody knows it. Now he's just trying to get her out of losing her job and going to jail.
The fact that he is not contributing now because of his affidavit of indigence. She's the only breadwinner these children have. They need somebody to be able to work.
I told you it was going to be
TPO
good.
would
I
end
told
her
you.
ability to work for the federal government. I know the court is
The
aware
end
of
is
that.
better. The end
I'll
is
leave
great.
that at that, but I would respectfully suggest that I don't believe he's presented evidence today. That is, of course, up to the court. But if the court should see fit to have some sort of restraint, I would request that it be in the form of a civil matter, not a TPO, because that is a special animal requiring registration with
I'm very familiar with them. I
Yes,
do them on a daily basis,
Yes, sir.
or at least a weekly
Donald.
basis.
Donald just had a recent head injury, so try not to listen to him.
Yes.
Mr. Kelly?
Your Honor, every incident that she describes in her family violence protection order occurred to a certain degree. She adds language to make it seem nefarious, like meeting her at a dark, secluded wood, where that's where we always meet.
We can't relitigate that order, Mr.
I'm closing, Your Honor.
For what?
I thought I was making a closing argument, Your Honor.
But I've got, it's 5 o'clock. You're telling me we got some more hearings we're gonna have to have. I'm not gonna inconvenience these witnesses. They've come again from Savannah or wherever. And so I'm just telling you, your argument is not proper because those matters have been litigated and there's been an order issued.
Mrs. Hetzer lied to obtain a restraining order. She lied, and she's repeatedly done things that have put me in fear of my safety. She sat there for 35 minutes while my son was in my lap, calling me pathetic, desperate, loser.
What evidence did we have today about that? Let's talk about the evidence that's been presented today, Mr. Kelly.
She recorded for 58 minutes and then refused to turn that over because it showed that she was committing the instigating incident. I didn't begin recording her. I never recorded her. I never stated that I recorded her. I was very aware of that protective order when I set my camera up to film me, to film myself because of her behavior in that waiting room. I filmed myself like I did in my car to protect myself from her allegations. I did it with the spirit of the order in mind. It was 4 minutes into the phone call before my friend brought up the court date. We weren't talking about anything related to Cindy Hetzer until she asked me when the next court date is. How's it going?
Nope.
I'm not responsible.
Nope. He asked her, when are you going to get your affidavit done? She was like, well, you know, what am I supposed to put on it? He was about to tell her exactly what to put on that affidavit, which would have been so damning if Cindy would have just stayed sitting down.
Responsible for how she responds to me saying something. I wasn't attempting to bait her. Maybe it wasn't the best. Maybe I should have said, let's talk about this another time. Maybe I should have, but it doesn't justify what she did. She did what she did because she's had no consequences for a year. And for Mr. Harrington to argue that please don't give this woman a family violence protection order because it will hinder her ability to care for her children and provide for her children. They didn't care that they took away my ability care for and provide for my children with a family violence protection order based on
Address
lies.
the court, Mr. Kelly, not Mr.
Based on lies.
Well, the issue is what Mr. Harrington is bringing up is that I can do the same thing under an injunction as I can under the Family Violence Act. The injunction doesn't go to the extent that it could possibly affect her ability to work. And that's, what he's saying is she has a family violence protective order against her. She may not be able to get on the base.
I have a family violence protection order that's prohibiting me from working in certain areas.
No, I'm not saying that I'm going there. I'm just trying to explain to you what.
Yes, sir, I understand.
Okay.
Her husband has an income of $130,000 a year.
Facts.
They have more than 400,000.
That's not evidence. We could talk about.
But it's true. I mean, it's true.
He brought up her ability to provide care or provide for her children.
You sure did.
She's the only breadwinner. She's not. Her husband has $130,000 worth of annual income. They have over $450,000 worth of property.
That is not evidence in this case, Mr. Kelly.
Nothing.
And I'm going to refrain. You need to refrain from arguing things that are not in the record. I restricted Mr. Harrington. Same way.
Your Honor, respectfully, Mr. Harrington got to show how poor and desperate and destitute Cindy's going to be if you prevent a family violence protection order against her.
And there was evidence to that effect, but there wasn't any evidence to what her husband made or their assets or anything like that.
So I don't want to be here.
I don't think so. I think it was
I
the
don't
worst.
want to be trying to put my foot on her throat and punish her. I don't want to do this.
Yes, he does.
I don't want her having detrimental things in her life, hindering her life. I don't want it. Every time I back away from her.
Did he not just say the only thing he wants, the only reason why he's doing all this is because he wants her in jail? Is that not what he said? Maybe I've been streaming so long that I'm hearing things wrong.
And say, okay, I'm done. She sends me another email telling me how this is all my fault. Over and over and over again. I withdraw.
Right. Mr. Kelly, when you say things like that, are you telling the court you don't want me to issue a protective order?
No, sir. That's not what I'm saying. I'm just saying I want her to stop.
Okay.
Her to stop.
I appreciate your argument. Let's go on to the next case. All right?
Mr. Kelly, I need that disc.
I'm sorry?
I need the disc. I need, 4, 5,
She
6.
needs the disc.
The disc.
Did you get all your other exhibits back in your envelope?
Yes, sir.
You mean the thumb drive?
If it was on thumb drive, I'm not sure what.
The
it was
videos
on.
that I presented?
Yes, sir.
I don't know because he's the one that's doing it. How is she supposed to stop?
D4, D5, and D6.
Okay, I got
She can't lie to the court if he doesn't keep dragging her into court.
you. Yes, ma'am.
The first husband was handicapped. He was paralyzed either from the neck down or the waist down, so he couldn't have sex with his wife. That's why she got him as a
boyfriend. Drive
boyfriend.
and just give you those 3 videos.
A disc? I think it's something you like a frisbee. He is scared that she's going to poke him. Oh, God, I hope he doesn't have Facebook. You made me do this to you. It's okay, guys. Relax. Nothing's frozen. Don't start complaining. And here comes Donald. It's frozen. or 4. Come on. Don't worry. All right. Looks like we went offline for just a little bit. Their court is offline right now. Not me, their court. It says so right here. That it's offline. Boom. I didn't call him this time. It comes right back on.
Like it's frozen.
Gaming chairs are comfortable up until hour 6. I don't know where he went, but I'm gonna fast forward it. He's back. He comes right back. We're good.
If it's helpful, Mr. Kelly, you didn't ask for emails, you asked for text messages. And the text messages are wrong. But if you got them yourself, you can certainly introduce them.
Okay, thank you.
Text messages? Did they say? I know it went offline, but do we know which case he's moving on to?
I guess I'll call Cindy Hetzer.
All right. This is in the 0088 case.
Yes, sir.
All right.
Not for
I'll
long.
remind you, Ms. Hetzler, that you're under oath.
He has the mason jars
All
in
right,
his.
go ahead, Mr.
Okay.
Kelly.
What happened was, and he admitted to this. She was in the house. It was his turn to get the kids. He pulls up to get the kids, right? He sends her a text and he says, I have your mason jars. Come on out to the car with the kids and get your mason jars. She goes out to the car to get the mason jars. And he said, I changed my mind. You can't have the mason jars. So it was the hearing in November. So I think you will have to scroll back to November through my lives to find it. Somewhere in November, I think. And he says to the judge, yeah, even though I said I was going to give her mason jars, what, does that mean I have to legally give her the mason jars? I changed my mind. And that's why she was at the car. And then he drove away. And she told the police that he tried to run her over. That's how it all started.
Have you had a reasonable and adequate good faith discussion with me about the religious formation of our children?
I attempted and you refused to have discussion. We've had many, many, many discussions about religion.
Did you address any of my concerns about the baptism of our children?
I attempted to, yes. But none of my answers were good enough for you.
I'd like to introduce a email exchange on the religious discussion between Cindy Hetzer and myself on.
And this is the exact same argument, only with something different. She stopped replying to him unless she absolutely had to, because everything she said turned out to be an argument. Everything she did, he argued and he litigated. Everything he took her to court for, over and over again. So she stopped. Nope, you can't remember this because I haven't played this. This is brand new content. Now we're moving on to religion. So now he's saying she won't answer him and he's tired of all the arguing, and all she does is argue.
June
Same thing.
29th, I believe, June 30th. It began on June 29th. It starts at the bottom here, the first message, going up to the left.
Let her look at it.
We're going to call him Kelly McDonald.
You've done it enough to know how to do it, Mr. Kelly.
Put him in jail.
Go to the second page.
No, sir. Ma'am, can you identify that?
Wouldn't that be funny? If he's trying to throw her in jail and he goes back to jail for contempt of court.
Email exchange.
His head would explode right off his body.
Yes, I believe that this,
No, sir. No, ma'am. It
Yes.
doesn't have to do with whether you believe. My question is, can you identify it?
yes.
Because that's why I'm telling you, I am tired of your dancing. When this court asked you a direct question, you answer it. Do you understand?
Yes.
I'm so sorry, Judge. I'm so sorry.
Any objection to the exhibit, Mr. Harrington?
Oh, no, sir.
Just admit it. What is it, 7, Madam Court Reporter?
8.
8. All right.
That just made my palms sweaty. Knees weak. Arms are heavy.
Do you consider that an adequate and reasonable good faith discussion?
Yes.
How many of my questions did you answer?
Your questions weren't about the children or their baptism. They were about me and beliefs that I held previously in the past years ago.
Do you think your beliefs affect our children's beliefs?
They're not my current beliefs.
So
So
why
no, I don't.
I don't have any more questions about that email. I'll just let the judge read it himself.
No commenting, sir. I wouldn't bring up a Snickers to him. He would bite my arm
Who are
off.
Kim and Mike Brox?
They are the people who were the godparents for the baptisms of our children.
And how do you know Kim and Mike Brox?
I believe we met years ago. We were acquaintances for years through my daughter's soccer team.
Is the appointment of the children's baptism or children's godparents a major life or a significant decision, a major decision in the children's lives?
No, I did not consider it so because I didn't know if I knew any Catholics. And when I was speaking to the deacon about this, he said, "Don't worry, my wife can just stand in for that position." So no, I didn't consider it to be a major position.
Does the Catholic faith consider the appointment of godchildren or godparents an important decision?
I don't know, and I've told you how I understood it at the time that I made that decision.
Do you believe differently now?
I don't know. I can't speak for the Catholic Church
lying.
and what their beliefs are.
But
I'm not asking you what their beliefs are. I'm asking you
I'm really outstandingly confused about what he's trying to argue here. It doesn't make any sense. He's not Catholic. He's the father.
what you understand of the Catholic religion.
Can you please repeat the question?
Is the appointment of a godparent a major life decision for a child?
I don't know. Apparently not, because the deacon said my wife can just stand in that day if you don't find anybody else.
Do we have an agreement not to spank our children?
That's in the original custody order, yes.
Why exactly did you start spanking our children?
I didn't.
Your Honor, I'd like to submit.
For those of you who aren't Catholic or do not know, godparents are extremely important for your children. Extremely. They're the ones in charge of their religious upbringing. And if you die, they get the kids. I mean, that's not legal. That's not, what the Catholic Church says is supposed to happen isn't what the law says is supposed to happen. But in the Catholic Church, they are equally in charge of the upbringing of your children as you are, or even more so, because the spiritual upbringing of these children wrestle upon their shoulders. And if anything were to happen to you, the godparents have to take those children and raise them. So it's extremely important. And she should have just said that, because the judge isn't stupid. He knows. Everybody knows. I mean, we all saw The Godfather, didn't we? I have so many godchildren, and it's not funny. And the reason is just like she said, I didn't know if I knew anyone Catholic who could be godparents. So the pastor's wife stepped in. Well, all the kids in the family didn't know anyone who was Catholic. Now, I am a recovering Catholic, but back when those kids were born, I was a Catholic. And there was nobody else who was a Catholic in good standing in a church that could be godparents to these kids. It's a big deal. The church has to say, yeah, you can be a godparent because you're okay. You come to church, you do this, you do that. If you don't do that, then you can't be a godparent. But the thing is, why is he asking that? That doesn't make sense to me why he is asking that. He can't possibly say that if they die, the children, or if she dies, the children go to the godparents because the Catholic Church that says so. He's not Catholic. He doesn't believe that law is, what should be followed, right? He can't possibly think that because she had someone become a godparent, that means he doesn't get custody of the kids or whatever if she dies. He can't possibly be arguing that. He's not Catholic. So, like, if she would die, he would get those kids. Anyway, I don't get it. I don't understand.
Discussion between her and myself.
I would agree with you, except they're not subtle about it. Wait, I miss there. They're not subtle about it. They don't. This isn't like something that you just know. You grew up as a Catholic and you know this. No. When you become a godfather or godmother, or when you get your child baptized, they pound it into you. They pound it into you over and over and over and over again. So she understood. I mean, she just did.
Do you recognize this email, Mrs. Hetzer?
Your Honor, I'm going to object to the introduction of that email, having read it.
Let's see if she can identify it.
Yes, sir.
He hadn't tendered it yet, Mr. Harrington.
Yeah, this is the email.
All right.
I'd like to enter it as Exhibit 8.
All right. Objection, Mr. Harrington.
My objection to this, Your Honor, is the email specifically refers to what other people who are not here and not subject to cross-examination are saying.
So
She
objection,
denies
hearsay.
What it says.
I'm going to admit it, submit it over objection.
Okay, Your Honor.
Respectfully accepted, Your Honor.
In this email chain, do you deny hitting our children?
Yes, I say I don't recall ever doing that.
Oh, I recall.
This is a email that I just sent to her 4 days ago. You stated you don't recall ever hitting
Pictures or it never happened.
Today? I said, no, I don't.
Email, ma'am.
I think, yeah, I said, I don't recall. I don't. I haven't.
Thank you.
All right, children. You were harmful to me. I'm letting you go. Take the cats with you. Bye. Bills, debt, you are harmful to me. I'm letting you go. Wrong button. That's not the mute button.
Recognize this?
Yes.
I'd like to enter this as Defendant's Exhibit 10.
Oops, my bad. Can they still go though? Can they still leave? Bye, kids.
Without objection.
So what are you doing in Exhibit 10? Are you denying something?
I'm not sure. Can you ask me a better question? I'm not sure what you're asking
No,
me.
sir. No, ma'am, you don't get
Am
to
I-
tell him what to do.
Am I
The only
denying?
person that tells him what to do is me.
Yes, sir.
You respond to his question as best you can. I'm waiting on a response, Ms. Hatzler.
You asked me if I was denying something. No, I wasn't denying something. I was saying the context in which what you alleged had occurred and everything that you were alleging did not occur.
That's denying something.
Ask our children, put them in front of a camera and record them reciting the act of contrition.
This was part of their religious education as provided by the church, and yes, I did follow that religious education.
You put the children in front of the camera and had them record. I didn't understand your answer, ma'am.
The church required that as part of one of the lessons of religious education through the Google Classroom that they have created was for the children to recite this act, the act of contrition, which is an integral part of the Catholic faith of confession. And one of the things that they were required to do is to recite the act of contrition. And I had it on a screen and they read it and I videotaped it and uploaded it as requested by the church through the religious education program. One time.
What does the act of contrition require the reader to do, the reciter to do?
Memorize the sentence and repeat it for
To say that they're
1,000
sorry
million
for their
years.
sins and that they don't want to sin anymore and because they love God and that they're going to try to do better, basically. That's a paraphrase.
That checks out.
What did I ask you to not do in this email?
You asked me not to do the, can I see it, please?
When it comes to North Carolina, I swear to God, or is it South Carolina? I don't know. I'm tired.
You accuse me of emotional and psychological child abuse.
I'm sorry, can you point that out where
Shit, guys, that's a great question. Is it? No, I don't think it can be civil because he is asking for jail time. Because I don't know which one this is. I don't know. Good question. Maybe you should pay attention. Just kidding. I don't know.
I make an accusation?
I am writing to demand the immediate cessation of requiring both Oscar and Connor to recite the act of contrition when they have committed no discernible wrongdoing. This practice constitutes a form of emotional and psychological child abuse. You also,
What?
You can read it, the rest of it.
Would you like me to?
Sir, if you're a Catholic, there's never a time where you haven't done something wrong. Don't you understand? You do something wrong every second of every day. Even if you just think it, you're really in trouble. So he doesn't want them to say the act of contrition because that is mental and emotional abuse. Hold on. I am a recovering Catholic, so I am conflicted here. I don't want to agree with him, but I want to agree with him. Oh.
Admit it, and the court can read it when he is making its decision.
You made a pretty
See?
substantial
Told
response to that quote, how you call it an accusation.
You accuse me of emotional and coercion and control over Connor and Oscar through this single act of following the curriculum. And you referenced repeated pressure to confess non-existent transgressions This happened one time in response to the lesson that was required.
Your response to my request was pretty substantial, wasn't it?
Yes.
How substantial?
I have to stop now. No, I'm not stopping the stream. I have to stop the direction the chat is going in. And I'm the blame. I did this. We're not going to have no more discussion of religions. We're not going to say how one is good or bad or ugly or anything. We're going to talk about the weather. We're going to talk about pizza, but we're not going to talk about religion because we're going to create enemies. And this is a safe space where you don't have to worry about that.
How many paragraphs would you say are there?
I don't know.
How does that go into the religious stuff, Mr.?
I can answer that. That's not really a talk about religion. That's a question of what they're talking about. Active contrition is, oh my God, I'm sorry for my sins in choosing to do wrong and failing to do right. I have sinned against you and the church. I firmly confess with the help of your son to make up for my sins and to love as I should. Amen. And that's what you'd say when you go into confession. You go into the confessional, you say those words, and there's different ones that are similar to that have a little different words to them. But that's just what an act of contrition is. It's just a Catholic saying, I'm sorry for whatever I did wrong and I'll do better. It's not good, it's not bad, it's not ugly.
Mr. Kelly, I've already said I'm going to read it and consider it. I'll determine. Yeah, I mean,
I'm making the point that she's denying something in that letter.
And I'm telling you to go on.
She's dancing around something in this letter.
I'm saying go on, Mr. Kelly.
This judge is just getting more and more angry every second.
Do the children ever ask you to call me?
Yes.
When do you let them call me?
Usually it's at 7 p.m., but usually when they ask, it's in the middle of the school day. If they ask any time that's not the school day, then I let them call you.
How often do they call you when they're in my care?
A few times a day, up to between 1 and maybe 2 or 3 times a day.
Have you ever told the children no, they can't call me?
Only during school time.
Do they take breaks?
I didn't know.
Yes, but talking to you can sometimes take 30 or 45 minutes, and that's definitely a disruption. And if I try to shorten it, then
it's true. She's right. Real quick breakdown because some people just walked in, and this case is absolutely complicated. This man, Mr. Kelly, just think of the McDonald trial. Okay, he has hundreds of motions and cases in civil and criminal, mainly against her, but also against the judge, also against her lawyers, also against Catholic Church, also against the magistrates, also against the police. Today, we're going through a couple of his motions, I think. So the first motion we went through was he wanted to prove that she perjured herself and was defrauding the court. This one we're doing right now is about all right. She had a husband. She was married. The husband got into an accident and was either paralyzed from the neck down or the waist down. I can't remember. But because of his condition, he couldn't have sex anymore. So they decided to bring in a boyfriend for her. And this is the man they chose. And they had 2 kids together. Her and her husband had 3 kids together, I think, or 4. I want to say she has 6 kids. So I think she had 4 with her husband, 2 with this man. So they're fighting for custody and all that. It's been going on since 2019, I think. She has a PTO out against him because of mason jars. And that's all I'm going to say about that. He's crazy. He has hundreds of cases going right now. And we're just going through a few of them. We're talking about religion right now. However, try not to get into a religious discussion in chat because you're just going to make people mad. And it's enough to see this guy act crazy. This is the 4th time we've had him here on Court Vibes. Only I get him, no one else. No one else gets him. Now, the third time, I sent to Law Talk with Mike so that he could show other people this guy. And I'm probably going to send this to Law Talk with Mike too, so that they get an update. But you can only find him here because I don't know if you guys you know my channel at all because it's so damn early in the morning. But I only do judges that no one else does, except for Judge Fleischer. He's mine. Mine. He's always been mine. So this is Judge something. Can't remember his name right now. It doesn't even matter. We are in Georgia. This judge is cranky and hungry, and he's yelled at all of them so far. He's yelled at her. It was kind of scary. He's yelled at him. He deserved it. He's yelled at him. He absolutely deserved it. This lawyer should know better. He's not done yelling at people. Don't worry. This judge is going to continue yelling at people for another 20-some minutes, 30-some minutes. So we're going to continue talking about religion for these kids.
Then you file a motion with the court.
This is another discussion about children's homeschooling.
It's all about the
Do we
charge.
agree that violence is not a good way to discipline our children?
That's what's in our custody order. Yes, we agreed to it.
Approach the witness, Your Honor.
Oh, so
Right.
listen, I had this judge on my channel, Judge Reeves, or Reeves. I can't remember. He was amazing. He was awesome. And he did some naughty stuff in Georgia. So we're not, he doesn't do it anymore. Sorry, we'll never see Judge Reeves again, I think. He was such a good judge, though. Oh, that one hurt. Well, the day we lost him, that hurt, didn't it, Micah?
You recognize this email, Mrs. Etzer?
Made the female court staff feel a little uncomfortable.
Yes?
This is Exhibit 11.
Objection, Mr. Harrington.
None.
It's admitted.
What do I ask you for in that email, Mrs. Etzer?
I'm going to read it,
Oh, sorry.
and
Are
I'm pretty comfortable I will be able to appreciate what you asked her.
you in a habit of not directly answering the questions that I ask of you?
No.
I can get him. The only problem is he is sort of a YouTube judge. I hardly ever get YouTube judges. I don't get my content from YouTube because everybody else gets their content from YouTube. So all the other channels are sort of just replaying the same cases over and over again. You will not find my cases on any other channel. Sometimes I do. I mean, I'm allowed. I can get whoever I want. You're not my mom. But I try not to, except for Judge Fleischer. He's special.
I try to answer your questions. Your questions are often
Do you
crazy,
believe,
and I don't understand them.
do you believe that you answered my question?
I would need to see it again. I can't. I tried to answer your questions to the best of my ability, including describing the concept of spelling, which is pretty simple, all over again at the very end of the email. Yes, I tried to answer your questions. Are you waiting for an answer from me? I'm not sure.
I asked you a question. You
What
said
was
you
your,
needed
I
to see
feel like
it.
I've answered the question, so could you please repeat it?
I'm sorry, I've lost my train of thought.
Let's move on, Mr. Kelly. You've got
I
other
have
witness.
nothing further for the witness, Your Honor.
Anything on a cross-examination, Mr. Harrington?
No, sir.
All right, you can step down, ma'am. Call you next.
Mr. Harrington is
I
learning.
call myself
Yes, let's go.
9.
He called himself.
I'm going to get out of here with something that belongs to you today.
No, sir.
I doubt that. All right, you're still under oath.
Fozzie told me he did.
Cindy took the children to church. For years, I've been trying to get the children into church for social programs. And her position is no. The moment she has this final decision-making authority over religious matters, she takes them to church. Well, she takes them before she gets that, but she takes them to church without discussion. Then she decides to have them baptized. You'll see the discussion in that email where she's already made up her mind. She's going through the motions of, do you have any input? I'll ask her all kinds of questions. How do we get from, and that's just one of the emails, but that's the most concise, that she says, thank you for your input, or thank you for the discussion, and we've had no discussion. She chose, the appointment of godparents is a lifelong thing. Children or godparents are required by the Catholic faith. I grew up Catholic. I've been away from the church for 30-something years. The appointment of the godparent is a solemn duty. It's a sacred duty. You have to choose somebody that's going to be there, going to commit to being there. If she dies in a car accident, or if I die in a car accident, they take over as our children's caregivers.
He went there,
making
guys.
sure that our children are cared for
Why
when
would
we're
he
not
go
available.
there?
They're there to teach our children. When I asked her who these people were, she didn't invite my parents, my family, to the baptism. She tells me, she schedules their baptism the day after I was arrested. And I don't hear about it until it's afterwards, because she doesn't, there's a jail communication system that she voluntarily, she signed up for it and then removed herself from it. I've contacted the company, and they said that she disconnected her.
Your Honor, I will have to object if he's going
Can't say what somebody else said, Mr. Kelly.
But for the whole time that I'm in jail, she's emailing my email account, knowing that I can't access it, to have religious discussions with me, knowing that I can't respond to it, telling me that the baptism is going on, showing me pictures, my email address, pictures of the baptism. When I get out of jail, I ask her, did you invite my mother? She said, no. Only the people that there for the ceremony were invited.
I agree.
My mother calls my... I asked her who the people are in the photograph. She sent me pictures of Mike and Kim
I added
Brox.
it, and I think
And I asked her who they are. And she says she said, and I quote, they stood in as godparents for the ceremony. So I asked her, I said, so who are we going to choose for the godparents? She said, I've already told you, Mike and Kim stood in for the godparents. I said, yes, I understand that you asked Mike and Kim to stand in, but what are we going to do about godparents if we're going to go this route? And she says, I've already answered that question. I said, Cindy, just to clarify, you're saying that...
I got
okay.
the drill.
And this went
I got
on...
it the first time.
This went on for 9 days.
It's getting late in the evening. If you want to finish up today, we got to...
This went on for 9 days, and she wouldn't admit to choosing godparents.
I understand. She wouldn't commit to the godparents.
Same with religious education classes. Moving them from one church to the next. Anytime I try to be proactive and involved in my children's lives, she tries to interfere and find some way. She's called the police because I took them to church, knowing that I was taking them to church. She called the police and said that I was stalking her. Perry Police Department came down there and said, No, he's not.
Yes, she does.
And I try to make a compromise to get our children back into the religious education classes with their peers. But she won't do it because it's not in her best interest. And I think it's just she's choosing not to agree with me on things. And this was a disagreement that prompted me to file the clarification of your order granting us the permission to modify the 7 p.m. phone call. So that I offered.
I think that was 17 different hearings.
Classes tomorrow night. Let's move our phone call to 8 o'clock so they can go back to the classroom. She said, no, court doesn't allow us to do that. I said, yes, it does. No, it doesn't. Yes, it does. I file a motion that you take me as I don't get it. I get it. She didn't. Everything needs to be by the letter for her. She tries to manipulate things so that if it's.
Okay, I got that. Just go on to something.
Your order said that we have to do custody exchange at the law enforcement center in the county in which the receiving parent lives. She asks me, where would you like to do custody exchange in Houston County? Would you like the jail or the sheriff's office? I said, I would prefer the Warner Robins Police Department Law Enforcement Center. She says, that's not a county facility, that's a municipal facility, even though it's in the county. These are the word games that she plays all the time. On my son's birthday last year, my mother called twice, texted 3 times. She wouldn't return my mother's phone call to my son, so my son could talk to her on his birthday. Her mother called 1 time and had a conversation with my son on his birthday. When my sons, if they say, I'd like to call mom, here's the phone.
To restore my objection to hearsay, Your Honor, we're getting a little far.
I understand, Mr. Harrington, but I'm going to let it happen.
Yes, sir.
Who knows?
When I'm asked by the kids to call their mom, I give them the phone. They tell me I tried to call, but mom wouldn't let me. They try to call before school. They try to call on breaks, but she won't let them.
I got the calls. Let's go on to something.
And that's it. That's it, Your Honor.
All right,
Hey, Robert.
cross-examination, Mr. Harrington.
Mr. Kelly, did the children call you every day?
Yes.
More than one time a day?
No.
Just one time? Now, during the course of y'all's relationship, you didn't go to church, did you?
No.
You go to church now?
Yes.
Where'd you go?
I study myself. I don't go to a physical church. I participate in online groups and. Our court order, though, it requires that the children be allowed to call at any time that they want to.
So is the judge.
So long as it doesn't interfere with their schedule.
You would agree that she has a fairly rigorous schedule for schooling during the daytime?
No, I wouldn't agree with that at all.
Fair.
Well, yes, yes, sir, I am. I'm conducting homeschool during my parenting time for a month now.
I don't mean to cut you off or interrupt you. I'm talking about when the children are with her. She is on business on School Beach.
Robert,
No,
thank you
she's
so
not.
much. Thank you, Robert.
Would you like some examples?
And I cut you off from explaining your answer.
Okay, so no, she's not all business when it comes to school. During school days, when she wanted sex from me, school would wait an hour until we had sex several times in the morning, repeatedly, 2 or 3 times a week. So no, she's not all business when
Like
it comes to
rabbit,
school.
they're Catholic.
Just to be clear, I'm asking about time periods after the court's entered its order.
I don't know. I don't know anything about what goes on in her household, except that she doesn't allow my children to call me when they
I've
ask to.
got that. I understand that's your position.
Did I do something?
No, we just have system problems. Go ahead.
Mr. Kelly, even though she discussed these things with you, she answered a lot of your questions, didn't she?
No, she didn't.
And if those emails that you submitted evidence show her answering the questions, you would disagree with that?
I would disagree with it, yes.
Okay.
I disagree that, no, let me take that back. She was answering my questions, but she was not having an adequate, reasonable, or good faith discussion as required by the court's order.
Did you give any alternatives to her religious education in any of those emails?
Not the ones that I presented. Would you like to present some evidence yourself, Mr. Harrington?
No, sir. Mr. Kelly, you answer his questions. You don't ask them to do anything. Do you understand?
Yes, sir. I selected the emails that I thought would best represent our discussions on this topic.
I understand. That wasn't my question. My question is, you didn't provide any other alternatives, did you?
In what context, Mr. Harrington?
I always want to
Maybe
drink.
You just didn't want to do it the way she wanted to do it. You didn't give her an alternative.
No, sir, that's not true at all.
Have you presented any evidence otherwise?
Yes, I've given testimony repeatedly about it.
Today, here?
Today and on February 10th and on December 9th.
November 12th.
I just remember I filed a motion with this court and asked her to enjoin it. She wouldn't enjoin on it, and the court told me that, no, he doesn't need to clarify his court order, that it was pretty clear. And then I filed another motion to clear up this, to let him know that it wasn't me that was finding his order unclear, it was Cindy.
Okay, if the order that they're talking about right now, the judge said whoever had custodial gets to claim them on their tax return. I'm pretty sure. I hope I'm not mixing up my cases. And he sent her questions saying, you know, am I going to do custodial? And she didn't answer. Or was that other case? And she replied, like, I'm not telling you what to do. You do what you want to do. I can't tell you what to do. You either follow the court order or you don't. That might have been another case. I'm getting confused.
I gave an alternate. I gave an option to her. I said, let's do this. And she says, no, it's not in my best interest.
Well,
Girl, you've been around much longer than 1 month.
communicating with her by email.
Yes, 100%.
And the court ordered you to do that, didn't it?
When I have something to communicate to her, I will communicate to her with an email.
Call telling me and sending me correspondence saying you would now send all correspondence to her through me?
If she and I go back and forth 1 or 2 times and we're still arguing, I'm sending them to you. Yes, sir, 100%. I'm not doing the back and forth with her.
Are you sending them to me with the anticipation that you no longer have to send anything to her?
No, I emailed her yesterday. When I need to email her something or communicate something to her, I use email. When we don't have a resolution quickly or we're just going back and forth, I forward it to you and let you deal with it. And if you don't want to address it, maybe in the future I'll address it through a motion. But I'm not going to argue with her through email anymore. She uses email to harass and just harass.
Are you familiar
No,
with
that's
the
you,
email
dude.
program called Talking Parents?
Yes.
And you have alternately agreed to use that and then disagreed to use that?
Yes and no. She is the one that's refusing to use it now.
Right. Would you agree that Talking Parents allows one stream of emails for the court in the future should it have to straighten anything out?
Yes, I agree with that.
Would you agree, if this court should make it part of its order, to do all of your communication through Talking Parents except in the event of an emergency?
Yes. But the problem is I suggested that, and we agreed to it. And then she said, I will only respond to you through the Talking Parents app, to which I responded, we have a court order that says we must use email. Just meaning that if something happens to Talking Parents, we still have to communicate. And she responded by saying, no, if you're not going to agree to only using Talking Parents, then I'm only using email. She plays games with words.
Let's go on to something else, Mr. Harrington.
So, just a second.
He lied there, by the way. He's blaming her for stuff that he does. He's literally sitting there blaming her.
What is your problem with the Sheriff's Department in Houston County for the exchange?
Who's indicated that I have I've never indicated that I have a problem with the Houston County Sheriff's Department.
You're suing them.
Responding to your testimony, you said you didn't agree with meeting at either the Houston Johnston County Sheriff's Department or the jail.
That's not what my testimony was.
Okay. Do you have an objection to meeting at the Sheriff's Department?
We've been meeting at the sheriff's department. I don't know what you're trying to, I don't know what you're trying to get at, Mr. Harrington.
Just answer the question.
Responding to your testimony that you wanted to do it at the.
Let's go on.
Yes. That's all I have, Your Honor.
Anything else, Mr. Kelly?
Yeah, so to the point of the not using emails anymore, the email that I presented about Oscar spelling is the reason why. Like, I'll ask her a simple question and she flips around words like, I just.
I've already got that.
Okay,
You know,
he brought it up again, so I'm just doubling back.
I know you don't think I've got much intelligence.
I believe you're very capable of reading those emails. I don't know how, I don't know what I need
You
to
can
do.
go back to the table. Call you next week.
I don't have any more witnesses.
Then those folks can be excused.
Yes, sir.
Tell them they're free to go. Do you need to call them?
I don't need to call them, but one of them wanted to address the court.
Okay.
Do you wish
After
me?
we get through with the hearing, we'll let anybody address the court that wants to address the court.
Yes.
What about the other two witnesses from the sheriff's office?
Mr. Kelly?
I didn't know anybody was here, Jeff.
Yeah, they've been here.
The people that you subpoenaed,
I apologize, Jeff. I didn't know that they were still here. When I
Release Kobe and release.
Everybody who just came in missed it. 4 hours ago, at the beginning of this hearing, or maybe a few minutes in, he had a sheriff's deputy, I think, a woman, as a witness that he subpoenaed. Okay? And he only needed one little disc from her. And he got the disc. So he said to the judge, I can excuse her. Mr. Kelly said, I can excuse her because I don't need her to testify now that I have this disc. And the judge, cranky, said, no, Mr. Kelly, no, Mr. Kelly. I am the judge here. Only I get to excuse people who have been called by a summons. Only the court can do that. You don't get to do that, Mr. Kelly. Now, Mr. Kelly has a whole group of people waiting outside that he called into court today, and they're out there waiting. So Mr. Kelly just said that, yep, I guess I don't need them anymore. Well, one of them wants to say something to the judge. All right. Now that you know all that, now we can continue.
when he didn't want to hear the testimony, when the judge didn't want to hear the testimony at the start of the case, I knew that I wouldn't be able to call most of these deputies. And I tried to tell her she could go, but he told me that it was up to him.
all right? Mr. Harrington, do you have any additional evidence, Mr. Kelly?
I don't have anything else, Your Honor.
All right, Mr. Harrington, do you have any evidence you want to present?
No, sir.
All right. We need to have argument on the contempt aspects.
I'll reserve, Your Honor.
Mr. Harrington?
Very briefly, the religious education, I think the emails speak for themselves. I will point out that if he's not doing any form of organized religion and she is willing to do that, this is
Do
not.
what now?
She is willing to do that through.
Do what?
Have religious education through the Catholic Church. If I was indistinct, I apologize.
No, I just didn't hear you. I wanted to make sure I understood what you said.
Yes, sir.
He's misrepresenting what's been tested. That's not what happened. That's not what's going on.
Mr. Kelly, it's getting late in the day, and he gets to argue what he wants to argue unless I say, that's not the evidence, Mr. Harrington. So you don't interrupt him.
Yes, sir.
Go ahead, Mr. Harrington.
As he stated, he has no organized form of religion. He's self-taught, and that is fine. However, she is going to the Catholic Church. It is an accepted and form of religion. The emails speak for themselves, and I can go back and try to parse all that. But she's providing, she did try to talk to him about it. These parties' level of communication is such that they never agree, so somebody has to make the decision, and she is, under the court's order, allowed to make the religious decision. I would argue, not making it independent. She tried to talk to him. It didn't go anywhere. As far as making sure the kids love the other parent, he presented no evidence of that, no competent evidence of that. Court's heard it. I'll let the judge make that decision, as is your purview. And then as far as conflict going on, we're not initiating it, so I would just suggest if he wants this all to go away, a lot of it's within his control.
That's so facts.
Mr. Kelly?
I have offered numerous compromises on religious education. And unless it's done exactly her way, she doesn't have a discussion. She stops talking about it. She stops responding. If I don't agree exactly what I've compromised so much, I don't have any soles on the bottom of my shoes anymore from compromising with this woman or offering
He
compromise
doesn't
with this woman.
compromise. He just doesn't.
When I was a teenager, I was molested by my Catholic priest. When I told about it, everybody spanked me, told me, "How dare you?" Now, this priest, and their religious education director lied to her and said that I attempted to kidnap my son.
He did.
To cover up their failings to...
That's not in evidence, Mr. Kelly.
But it was, and we saw the case. And he was not allowed to have contact with his children for 18 days. And during those 18 days, they went to CCD or whatever at the Catholic Church. The kids did. And he went in and he tried to take them.
He just
He hadn't argued anything about that.
He just made an argument that I don't have any formal religion. It's not true.
He made the argument that you do not go to the way I took it was what you testified to, that you don't go to a church. And you don't dispute that, do you?
I was going to a church until she made it a point to tell everybody that I was a bad guy. So every time I showed up, everybody was apprehensive of me.
Okay. Don't know that we had evidence to that effect, but.
She doesn't want a compromise. She wants control. You'll see the emails. You read the emails and you'll see her level of wanting to communicate with me about things. You'll see my level of trying to communicate with her through those emails. And her...
The last case we were at, the judge nailed him for pointing. The judge had enough. And then it's because he was pointing at the lawyers, he was pointing at her and everything. And then he turned to the judge and he pointed at this judge. I can't believe he's pointing right now because even I won't point after that.
Just thank you for the discussion. Thanks for the input. Never responding with any substance to anything that I try to talk to her about. When I email her to ask her about schoolwork and I don't understand something that she's doing, she uses it. She'll send me an email as if it's like, if you can't handle the job, you just tell the court and we'll petition the court and take it. You've asked for this, now you've got to do it. And she's been doing this for 17 years. In my first week, we had a couple of hiccups. And she's talking about petitioning the court to take away my ability to teach my children at home. Everything is a conflict. I ask her about the kid's spelling that's in evidence. And we have a list that they do every week, that one child does every week. I ask her for clarification. There's two lists, one word, or one list of words, two different documents. My son's telling me I'm using the wrong one, so I ask her. And you see, and if you look at the exhibit, the highlighted part is what is her previous instruction to me on spelling. That was it.
Speak to the teacher,
I was
speak to
asking
your
her for
son.
clarification. She can't clarify. I've already told you, I don't know what the problem is, but I was specific.
I get it, Mr. Kelly. I mean,
I'm
I don't know what makes you think repetition gets into my head.
It's not you, it's me. It's being narcissistically abused for 9 years. I feel I have to explain myself to the nth degree because this is what she's done to me.
Okay.
I have to. Because that's what standards she set for me. Our children deserve us to be able to communicate without everything turning into conflict. And we have a huge problem communicating with each other. It's massive. I assume things, she assumes things, and things explode. And I'm tired of it. I just want to be able to have her read what I write and not read into what I write. I want to be able to read what she writes and not have to read into what she writes.
Then stop.
I just want peace.
It's you.
I want my kids to be happy, have her and me present, period. And I'm tired of her initiating conflict over nothing.
Hi, Bill.
Okay. All right, I'll reserve rulings on both of these last things like I did the first thing. All right. Evidently, somebody wants to speak to the court, and let's let them speak to the court.
Bill, you don't understand. We fight Nan at noon.
May my remaining two defendants in case
What now?
number 152 come back in the room since evidence is
I think we'll just leave it like
He
it is.
keeps dragging
because
her
I
into
think
court.
they were here on this case, Mr. Harrington.
Okay. Yes, sir. Excuse me. Not
I'm
okay.
sorry. He wants to address the court for what purpose?
I don't know, but.
In this matter,
I don't know, Mr. Kelly,
I'm going to object to it.
and I'm gonna let him address the
Okay,
court.
that's-
You subpoenaed them to be here. This is the second or third time, and out of courtesy to these people, if they've got a grief, I'm gonna listen to it. You can sit down. I hadn't said anything about I was gonna consider what they said, but I'm gonna give them the benefit of speaking.
Your Honor.
The lady left, but the priest is still out there.
Well,
She was the one that was wanting to speak.
all right, let him come.
Well, he didn't want to speak.
Oh, he didn't want to speak. I thought you said he was the one that wanted to speak. So the lady's left.
Right, she left.
The lawyer's left.
The lawyer's still out there.
He doesn't want to speak.
No, sir.
Okay. Problem solved, Mr. Kelly.
Your Honor.
Darn it, I wanted
may I
that.
please address the court?
Sure.
I chose not to call them because I felt
I
like
don't care what, that's your choice.
I
It
felt
doesn't
like
make any, Mr. Kelly, it doesn't make any difference. It wasn't a reflection on you or anything else. But these people have been here since 1 o'clock. And if they didn't get called, that was your choice. No problem with that. Okay? But if they got something they wanted to tell this court, I was gonna let them talk. But now nobody wants to talk. So you don't have a problem. So, okay? But I'm gonna tell both of you this.
Stand up when the judge addresses.
I may very well reconsider, if I can, the custody order. I may very well go back and revisit it and issue a modified order.
Because he didn't drive the car into her. He's going to go back and revisit the custody agreement. The thing that started this all, the reason he spent all that time in jail, because he didn't drive that car into her. She lied.
In that regard.
Do you wish any written argument on?
No, I do not want any argument.
Yes, sir.
This matter is concluded. Have a good evening.
Obviously, he didn't issue his written,
Here's what you wanted.
That's her. Anyway.
You got all your evidence, Mr. Chairman?
Yes,
I need to copy that.
Obviously, he hasn't issued any written judgments on this yet. And if they follow the schedule that they're on, we're either gonna have them back next month or in 2 months from now, because he still has a whole bunch of cases and a whole bunch of motions open. All right, we are at hour 9.5. We got about 2 hours left of paid time for this stream. So we're going to Pennsylvania next. We're going to an attorney that was suspended. And he was suspended for X amount of days, months, whatever. Okay. I think he was suspended in he was suspended in 2020. All right. So his suspension is over. Bill, his suspension is over. But the day that he was suspended, he took out a PPP loan. And now he's pulled in front of the disciplinary council to see if he can still be a lawyer because of fraud or something like that. All right. Jen, go to bed. Get out of here. Kelly, you shut up. Ooh, okay. So we're going to go to Pennsylvania. Somewhere in here. And we don't have to see. I think I have like 12 hours of this. We don't have to see the whole thing because he is arrogant and we're going to see this lawyer in action. But I already know the verdict. So whenever the stream is done, we're not going to I'm not playing it to the end of this. This is going to play until I end it. And then I'll let you know what the verdict is. But you can, if you want to, you could figure it out and use your internet to figure it out before the stream is over. But here we go. Let's go to Pennsylvania. I freaking love Pennsylvania. It's my favorite state.
Yes, ma'am.
You met him in his office?
Yes, ma'am.
What did he tell you at his office?
When I walked in,
Okay. This is the panel of judges. So this is the disciplinary panel. Okay. I think that's the reporter. That is the lawyer who wants his job back. She's the prosecutor for the disciplinary panel, and that's his lawyer. All right? We good?
told me that he had agreed that morning to reopen the hearing with Danny White and asked me if I had ever gotten a PPP loan.
And Danny White, just for the record, he is an Office of Disciplinary Counsel attorney?
Yes, ma'am. Your predecessor, if you will.
What was your reaction to Mr. Stratton agreeing to do this?
Well, I wasn't happy.
My office, the Office of Disciplinary Counsel, was concerned that you had not disclosed this PPP loan on your first reinstatement petition.
Those were the words that I was told.
And you were upset that Mr. Stratton had basically done this without talking to you first. You were so upset that you had to leave his office that day.
No, I eventually left his office, but not until we had a call with Mr. White.
You previously testified that you went home after learning this information and researched PPP loans.
Done a lot of research on PPP loans, yes, ma'am.
It was at that time that you discovered that PPP loans are actually public record.
I would say that it was probably when Mr. White filed his petition to reopen the hearing and attach that I learned that.
You had obtained this PPP loan for your law firm, which is your law firm, John Gallagher Law Firm.
Yes, ma'am, an S corporation.
At that time, you were not prepared to address the PPP loan situation.
At what time, ma'am?
Back around July, August 2022.
Well, I had been addressing that for months before that with the SBA, and later learned that I truly should have been directing it to Citizens Bank, the lender. But I had done a lot of work because I only had gotten partial forgiveness and I didn't understand why.
We are going to get into that, but before we get into that, I want to talk about the procedure for your reinstatement hearing. You actually had a hearing, second hearing, scheduled for October 6, 2022 to address this PPP loan situation.
I can't swear to the date, madam, but if you say so, but there was definitely a second hearing scheduled.
Instead of going through with that second hearing, you decided to withdraw your petition.
Yes, ma'am.
Why?
Well, there were two reasons. One, during that phone call that I had with Sam Stratton and Mr. White on September 25, July 25, I don't know. Mr. White made clear that the words were kind of burned in my brain, so I can actually recite them, that they intended to vigorously oppose my application for reinstatement on the grounds that I lacked integrity because of my debt, end of quote. And in addition, when I saw the petition to reopen my hearing, I saw in there that Mr. White had said that whether or not my PPP loan was totally forgiven was relevant to ODC's or to that committee's decision on whether.
I added Micos to the time. I just forgot to add it to Discord. But I absolutely added Micos 50 minutes.
I should be reinstated. So
60 minutes. Something. I don't remember.
Decided to get out of my own way. Where my lack of
50
responsibility
minutes.
Had
Wrong button.
existed, and to take very seriously what Mr. White said, and to
There, it's in Discord now.
put my recovery into action, not just words at meetings or in my home, but to affirmatively and vigorously address my debt in an effort to remove concerns that I lacked integrity. While I knew or believed at that time I couldn't get rid of all the debt.
No, that was my fault.
I hadn't taken adequate steps to address. In addition,
I added yours, Jen. 25. I added it.
Why I was only given partial forgiveness for both of my PPP loans. So that's why I withdrew the petition.
To summarize, you withdrew in order to work on your debt situation.
Well, I thought my debt, and to attempt to get the PPP thing clarified once and for all.
At some point, you did file a second petition for reinstatement.
Yes, ma'am, I did.
You filed it on April 1st, 2024.
If you say so, I have no reason to doubt that. It was.
No, I gave him a penny.
On that reinstatement, you mentioned nothing about a PPP loan, number 1 or 2.
I don't believe that's accurate, ma'am. In fact, I would be stunned if that was accurate. I recited all of my debts, and that would have included my obligations to SBA, which at that point were roughly $23,000 for each loan. In fact, when you wrote to me after my application was filed. Anyway, I don't want to say anymore. I'd be stunned if that was the case, to be candid with you.
Do you recall getting a letter from me on April 9th of 2024?
I remember getting 2 letters.
Do you know? How much was it for?
And I can't say the dates right now.
Mr. Gallagher, you have a very large binder in front of you. Can you please turn to tab 17, which is Office of Disciplinary Counsel's Exhibit 17?
I'll add it.
Yes, ma'am.
Do you recognize what that document is?
Well, it appears to be the April 9 letter that you sent to me.
Can you go down to number 4
Yes,
on
ma'am.
that letter, which is on the second page, and read what that says?
Yes, ma'am.
What does that say?
Tina, I am so sorry. I got it. I did get it. I didn't put it in Discord when you sent it to me by accident, so I forgot. Tina, I did get it, and thank you so much. It is in Discord now. Thank you so much.
Any participation in the Paycheck Protection Program, PPP, for loan forgiveness. And I'm reminded also that attached to the application, at a minimum, was the copy of all payroll checks that had been cut from PPP Loan 2. I'm 62.
Oh my God, that's
so
hilarious.
I don't always remember things perfectly, but I would say that it's unfathomable to me that I'm mistaken in my recollection of attaching those checks because I considered it exceptionally important.
Is your testimony today that in the original April 1st, 2024 petition that you attached checks?
Yes, there were about 700 pages of documents attached, and among them were the PPP draw checks. Yes, not draw checks, the checks that were cut from law offices of John A. Gallagher to my wife and myself, totaling approximately $16,000 that were cut from PPP Loan 2 during the month of March 2021. And on each of them states from PPP Loan 2. Not only were those checks in my April 1, if that's the date, application, but they were also attached to my initial petition for reinstatement as evidence, well, my checks were, as evidence of earnings that I had received since my suspension. So I recited those checks and attached them to my initial petition for reinstatement, and I'm certain, all but certain as I can be, to my second petition for reinstatement, because the checks cut to me were earnings since my suspension, and I was mandated and required to provide that.
In response to the letter you received from me, dated April 9th, 2024, did you provide my office with your PPP loan information?
Well, ma'am, what I did is, and I think it's our PPP binder 4, if that's the one it is, I looked on my computer and found everything.
I'm not sad.
I could find. Emails, letters, things from the portal, PDF documents that I assembled over the years. I tried to put them in some kind of order, and I assembled them all and provided them to your office. Yes, ma'am. And hopefully I did so in what your office views as a timely and diligent fashion.
I'd like to now move to the actual PPP loan. We've been referring to it as that, but it's called the Paycheck Protection Program loan, correct?
That is my understanding, madam.
This was a loan that was offered during the time of the pandemic around 2020, correct?
Yes, I got the first one. I applied for the first one on May 3. and I was given $30,100 via direct deposit on May 7th from my bank, Citizens Bank, 2020.
And that was in 2020?
Yes, ma'am. That's what I call PPP 1.
The funds that this loan would provide to small businesses were supposed to be for businesses to keep their employees employed during a pandemic.
That is certainly one principal feature, without question, of the PPP loan program. Yes, ma'am. And sole proprietors and small business and men like myself were entitled to receive that, and were entitled to use that for S corporations to fulfill our statutorily mandated responsibility to pay ourselves W-2 earnings.
How many employees did you have in 2020?
Well, I was the only full-time employee. My wife did an awful lot to help, and she would say that she was a full-time, part-time employee. But in 2020, I couldn't afford to, or really any year, couldn't afford to pay her everything that she had earned, end of quote. But principally it was me, and she helped out a lot.
Just to clarify, is this the same wife that you originally blamed your IOLTA accounts on?
I don't object to that characterization. Originally blamed?
Basis, I mean, I think that's what he's, do you want to
That's what it, that's
specifically
what.
refer to? The record?
Well, it's a characterization, it's an interpretation of what his testimony was.
You don't like the verb.
Pardon me?
You don't like the verb.
Well,
I think there was testimony in the record that her actions were the cause of some impropriety that became an issue.
yeah, that's a lot different than blaming someone else for your misdeeds.
Okay, also saying that, can you come up with a better verb?
Mr. Gallagher, is this the same wife, the same woman who you had concerns had access to your IOLTA account at one point?
I attributed responsibility to my wife, who's not a lawyer, and I am ashamed of that. I stated that at my first reinstatement hearing. Not only did I blame her, if you want to use that word, and not only am I ashamed of that, but I actually obscured my own addiction by doing so and hid that from the initial panel, and I'm ashamed of that as well. I regret that my wife is not a lawyer.
So what this guy continually does, she will ask him a question. This is just an example. This is not what happened. Did you shoot Micah in the leg? Well, what happened was, the gun was there and it was in my hand, and then, a tree fell and a car blew his horn, and, then I looked at the law books, and the law said that, you're not allowed. So I did what the law said, because it didn't say I was not allowed. So, I did what the law said, and I struggled, and I had so many difficulties, and then yes, though, yeah, I did look at the law, which is not an answer. So she's like, did you shoot Michael in the leg? That was a mistake. I did it. It was just a mistake. I shouldn't have done it. Oh gosh, I'm so sorry. I did that. Oh, so if his whining and blathering on and on about things that have nothing to do with nothing doesn't work, then he'll say, oh yeah, that was just bad thinking on my part. Bad thinking. And this goes on for the entire thing.
I alone had sole responsibility for my books, my records, and my accounts. To have done that to her while hiding my own personal responsibility, my full scope of my personal responsibility, which would have required me to state that I was addicted, was wrong. And I regret it. And I'm sorry that I did it.
When did she start working for you?
Well, my wife started working for me back in 2010 or 11. Soon after I don't want to spend a lot of time discussing my wife, but of course you have the right to ask me everything you feel is appropriate. So
I'm just looking for a date, Mr. Gallagher.
Roughly 2011.
I'm ready.
Was she working for you?
Hurry up, Kelly, be
2021?
ready.
Oh yes, during those 2 months yes, in January and in February, yes, she was.
Was she working for you in 2020?
Yes, she was working a lot for me in 2020.
You previously testified that you obtained, we'll call PPP loan number 1 in 2020. A few days after you get the Supreme Court order dated January 22nd, 2021, you reached out to the Small Business Administration for a second PPP loan.
Actually, a couple days after I reached out to Citizens Bank to ask them if my PPP loan 1 had been spent appropriately and would be forgiven, because one of the requirements for PPP 2 was that it had to, you had to have gotten PPP loan 1 and had to have used it for its intended purpose. So I put
Answer
together a
her
spreadsheet
question.
record of everything I had used PPP 1 for and sent that to Citizens. They said that applications for forgiveness for loan 1 were not open yet. So then, yes, ma'am, sorry. The answer to your question is absolutely. Shortly after that, within 4 days, 3 days of knowing that I was suspended, I made that application for PPP loan 2.
What was your purpose for applying for this second loan? In a few sentences,
Sure.
What were you looking to do with that money?
While I was significantly behind on, first of all, my earnings had dropped by $180,000 in between 2019 and 2020. I was behind on a lot of business bills, and other than the PPP loan I got in May, I hadn't received any W-2 earnings. So my intention was to pay myself. I figured the money would be in by January 24th or whatever. Pay myself for the next month, going back also, and to pay off business obligations that I had, rent and other things that I just was behind on because of the pandemic.
Do you understand that the purpose of the PPP loan was to maintain employees?
Well, let me just say first of all this. First, let me get this out of the way. The application says that the purpose is, it doesn't say what the purpose is. The standard is you can get this money through to pay employees, to retain employees and maintain payroll, or, I think there's a semicolon, or to pay business expenses such as rent, etc. So I'm certain there may be some people who got the PPP loan and only used it to pay business expenses. And there are probably other people who got it and only used it to pay their employees. But let me just say that the money did come in within a few days of when I was suspended.
All right, we're gonna get into that. Let's go through the
Okay.
actual loan.
Yes, ma'am. So that,
The amount of the loan was $30,100.
yes, ma'am, same amount as the first one.
The loan was for law offices of John A. Gallagher, PC.
Yes, ma'am.
Address 5 Great Valley Parkway in Melbourne.
Yes, ma'am.
You submitted your loan application on January 25th, 2021.
Yes, ma'am.
This was 3 days after you received notice of the Supreme Court's order.
Yes, ma'am.
The loan was approved on March 6th, 2021.
I think it was the 5th, but yes, ma'am.
On March 5th and March 6th, 2021, you were suspended from the practice of law.
I was.
You had to sign a document in order to retain the money the loan disbursement money.
I don't remember that. I know it showed up on my bank account. I can't disagree with you, but I don't know that.
If I show you a 2-page document, would that refresh your recollection?
I don't know that it'll refresh my recollection, but I don't know the answer to that, but I would like to, but I'll look at it.
If you can go to tab 18 and then go to page 698.
Okay.
I'm thriving. Are you okay, Nan? Just a couple more hours to go. Nope, a few more hours to go, not a couple.
Oh, I see. Yes, ma'am.
Does that refresh your recollection?
No, but I have no reason to dispute.
JK, go to bed.
I made that electronic signature on 3/10/21.
You signed for the loan disbursement on March 10th, 2021.
Yes, ma'am. Based on this document, I did.
You were suspended on March 10th, 2021.
Yes, ma'am, I was.
While you have the binder in front of you, can you turn a few pages before it's page 694?
Yes, ma'am. I'm there, ma'am.
I agree with you guys only up until a certain point. Yes. There were people who frauded the government and got money when they shouldn't have. They didn't deserve it. They shouldn't have gotten it. There were 100%. But there were also people that desperately needed it and were able to pay their employees and were able to get through that where their business was closed down and they couldn't make any money. Oh, geez, it would have been catastrophic. So there were, so many people who needed it and got it. If that means some people frauded to get some, I would rather that some people frauded and got money they weren't supposed to get and the other people are, made it through than nobody got anything because of fraudsters and then it just would have been bad. So, I hope they can find the people who frauded, but I'm so thankful that business owners got something to help.
Do you see where it says disbursement date March 11th, 2021?
Yes, I do.
And in the middle of the page, there is a section which indicates what dates this loan was eligible to cover. It's labeled covered period. Do you see that?
I do.
The covered period for this loan was March 11th, 2021 to May 31st, 2021, correct?
That's what the words say. Yes, ma'am.
Between March and May of 2021, you were suspended from the practice of law in Pennsylvania.
Yes, ma'am, I was.
You used this money to pay wages to you and your wife during the time of your suspension.
Yes, ma'am. I used it to pay retroactive wages in between November 2020 and ending prior to the date of my suspension. Some of the loan monies were used for that purpose, and I wish I had not have done that. I don't think I exercised.
It was a bad decision.
In doing that, I think it was something that I wish I had not done. I wish that I had only paid my business bills and sent the rest of the money back. I believe that I made a bad decision to do that. It was lawful to use PPP money for back pay, but it was not.
It was not illegal.
Exercise of judgment, and I regret that. I wish I had not done that. I was wrong in doing that.
You understood that you could not pay yourself during the time of your suspension.
I understood that I could only pay myself back wages prior to the periods that preceded the suspension for which I had not been compensated for the work that I performed. Yes, ma'am, I understood that.
Where the loan has a date range that it's called a cover period, you did not pay yourself within that cover period. You paid yourself and your wife retroactively.
My understanding of the cover period now So,
I'm not,
no,
Mr.
no,
Gallagher, I'm not asking you about now. I'm asking you about.
my understanding then of the covered period was that you had 60 days to disperse the money for appropriate uses. That is what I understood. That didn't have to be for debts incurred during the covered period, but rather had to be spent during that 60-day period. And I've never seen anything that contradicted my understanding in that regard, and I have spent many, many, many hours on this topic.
Can you please turn to page 761?
Yes, ma'am. Yes, ma'am, I'm there.
Do you recognize that document?
Yes, ma'am, I provided that yes, ma'am, in this case.
What is that one-page document?
That is a date that all the checks were cut subsequent to my receipt of PPP Loan 2.
So tired.
Approximately 12 paychecks, correct?
Okay, let's see. Yes, that looks right. Yes, ma'am.
The date range is from March 12th, 2021 to April 2nd, 2021.
Yes, ma'am.
And those are paychecks that you paid to yourself and your wife during that date range?
Yes, ma'am. That's exactly what that is.
That's you, John Gallagher?
Yes, ma'am.
And that's your wife, Catherine M. Lane?
Yes, ma'am.
And those are paychecks from this PPP Loan 2 that you paid yourself and your wife thousands of dollars.
Yes, I think it's about $16,000, if I'm not mistaken.
And I'm not going to go into this.
I usually have a lawyer getting disbarred or trying to get his license back, I don't know, once every couple months at least.
In detail, but the following pages, which would be pages 762 to 773, are the actual pay stubs that correlate with those paychecks.
Let me take a look here. Yes, and these are what I provided with my initial application for reinstatement and also my subsequent, and the payroll periods and the memo back pay from second PPP loan. Yes, this is an accurate copy of those pay stubs, madam.
And the back pay that correlates with these paychecks, the range is from November 2020 to February 2021.
Yes, ma'am.
Essentially, the 3 months prior to you being suspended.
Yes, ma'am.
Did you understand that once you were suspended, you were to promptly cease and desist from using all forms of communication that expressly or implicitly conveyed eligibility to practice law in Pennsylvania?
Yes.
You understood that you could not be operating as the law firm of John A. Gallagher.
Unless I had referral fees or things of that. I couldn't operate as a law firm, but I was required under federal law to take referral fees and use and place them in an appropriate business account. And I knew I had referral fees coming in, and so other than receiving referral fees, I had no reason to have my business. Well, I was suspended for a year and a day. But yes, I completely understood that I could not hold myself out as an attorney or operate or give legal advice.
The math doesn't add up to me, but maybe we'll find out why. I don't know why. He was suspended for a year and a day in 2020. And it is 2025. And he's still trying to become a lawyer. Now he wasn't suspended because of the PPP. He was suspended. I can't remember. I think he says it. I can't remember if he was drunk or he gambled the money away or, he took money he wasn't supposed to take. I don't remember. Maybe he'll say it, but he's been suspended way longer than a year and a day. And I don't know why. Maybe they'll say.
Or do anything that would suggest that I was an attorney once I was suspended, and I have not.
Or applied for a loan using your law firm name.
Madam, I'm going to respectfully disagree with you on that, but I was in business when the application came in a couple days before I was
A good
suspended.
start.
And I was in business when I applied, but I can understand why you're questioning me on this, and I understand what you're saying. I wish, really on all reflection, that I had never applied for this loan, not because I'm here being questioned about it, but because it just doesn't look good. It doesn't. It may have been lawful, and it was lawful. It may not have been a violation of the rules of professional conduct. It wasn't, but it was not sound judgment. I've just been suspended, and I did not exercise sound judgment, and I regret that. I agree with you on that, ma'am.
You were sober in 2021.
I was 100% sober. Not only that, I was outside the 2-year window of, where your brain's getting rewired. I was sober, and I made a bad decision as a human being. I have no excuse to that extent. It was the pandemic. As the Citizens Man said to me, it was like flying an airplane while it was being built. I can't pretend I understood everything about PPP loans and everything like that, but I wish I hadn't done it now.
You previously testified that you applied for, or I should say appealed, based on a partial forgiveness.
Yes, ma'am. I appeal both of them.
Just so the record's very clear, PPP Loan 1 and Loan 2, you only received partial forgiveness.
Yes, ma'am.
I want to focus only on the second
Yes, ma'am.
loan. It's a $30,000 loan, and you were only granted about $7,000 in forgiveness, correct?
That is correct.
So you chose to appeal that decision in 2021.
I can't specify the date, but I ultimately did appeal it for sure.
Why did you appeal that?
I can give you the benefit of my thinking then was that I had no idea why they hadn't forgiven the whole thing. I used the money for the proper purposes. I proved it with receipts. I paid about $12,000 in
What is she looking at?
and I used it for retroactive payroll, which was completely lawful. I didn't understand why I wasn't being forgiven.
Can you please turn to page 758?
758, I'm sorry.
Yes, 758.
That's tab 18.
Yes.
Yes, ma'am.
Do you recognize that one-page document?
Certainly do.
What is that?
That was during the pendency of my appeal, and it's an email I got from a gentleman who was, I don't know, working for the SBA.
And an SBA is Small Business Administration?
Yes, ma'am.
This is an email between you and the sender is Anthony Davis II.
Yes, ma'am.
And from his signature, Anthony Davis works for the Office of General Counsel for the U.S. Small Business Administration.
Yes, ma'am.
And you testify that this document related to your appeal of your PPP loan number 2?
The numbers, they always give you these 8503 to this day. I don't know if that's PPP 1 or 2, ma'am. I don't know.
I should add this, the email is dated May 5th, 2023. In 2023, you had both of those loans at the time.
Both of those what, ma'am?
Loans?
That was probably when I appealed them to, so first you appeal it to citizens, and then so it was a work. So, but I probably had both appeals pending at that time.
There are several requests that Mr. Davis is asking. I want to focus on request H.
Okay.
It says, we see that John Gallagher was suspended from the practice of law on February 21st, 2021. Was the practice in operation at the time of second draw application? ? Has the practice permanently closed ? If so, when ? Did I read that correctly?
You did, ma'am.
I'm going to turn to the next page, the next 2 pages, which is a 2-page letter. And that letter is from your attorney, Mr. Quinn, who is also seated here today, correct?
Yes, ma'am.
And at the end of the letter, the last line of the letter on page 2, which is for the record,
Grapes.
date stamp 760 of Exhibit 18, it says, consequently, no further response beyond this one will be forthcoming on Mr. Gallagher's behalf. Did I read that correctly?
You did.
You, through the advice of your attorney, Mr. Quinn, decided not to address the questions that the Small Business Administration had asked you.
Let me say this. I had already told SBA and citizens that I had been suspended. I also told them, yes, I was in operation when the application was filed, and no, business was not permanently closed. I turned over to Mr. Quinn. In fact, it was at the Peer Volunteer LCL conference, and I first really sought help from somebody else with all of this. Mr. Quinn.
I think he's starting to mix up his words, like his wordy answers, with his, oh, I'm sorry, and that was a bad decision on my part answers. I think he used 2 wordy ones in a row instead of a worried one, and oh man, that was a bad decision.
Agreed to help me, and so I turned it over to Mr. Quinn. So the letter, it speaks for itself.
I always do.
I provided this to you like it's an accurate reproduction. That's what I
pineapple all the time, and I tell him.
When did you tell the Small Business Administration you were suspended?
I had many conversations with citizens.
Many.
SEA trying to understand why I hadn't gotten full forgiveness. I'm talking over X months, years, many efforts and letters and emails and portal inquiries trying to figure that out. And it was during them that I told them that.
Mr. Gallagher, can you please point to one piece of paper in either ODC's exhibits or your own exhibits where you tell the Small Business Administration that you were suspended from the practice of law?
Well, I guess my guess is that this man's referring to notes on one of those conversations in H, but beyond that, I can't say. When I got it, I assumed that he had just caught up on, but no, ma'am. There was so many communications. I can't point to a written one right now. I'm sorry.
Can you point to an email?
Right now, ma'am? No. I don't know how many pages. No, ma'am. I don't. Not right now. I can't. No, ma'am. I'm sorry.
You even have notes that you took during this time. You provided all those notes to me, correct?
Ma'am, I did everything I could to provide a diligent and immediate and full response
Answer the question.
to every writing that I could find on my computer relating to the PD.
Thank you.
Can you
Thank
go
you.
through your notes of that time and show me what day, who you spoke to, and notify them of your suspension?
I don't even know where the notes are in this collection of documents right now. Where are they? I don't know. I have not reviewed, I should probably say, I didn't get a copy of your exhibits at the first hearing. Appropriately, I've never seen them before I got here, and I saw them on Mr. Quinn's desk. I've never looked at any of your exhibits.
Did you receive these exhibits on January 27th?
That sounds right, and in fact, most of them are from me. I would say probably all of them are originated from my office, in fact. But other than compiling them and trying to do my level best to provide you with everything I had on everything in response to your inquiries, most of these things, ma'am, I didn't print out. I just assembled them on my computer.
All he has to do is say yes or no to a lot of these questions. The answer is already clearly evident. They already have the proof. All he has to do is say yes or no. I don't understand the diarrhea in the mouth.
In totality and trying to date organize that, they stamp that for you. I never really looked at any of these things. I wrote them or received them, but I never examined them.
Mr. Gallagher, in your testimony, you have not had enough time to review the office's disciplinary counsel's exhibits.
No, I never said that I hadn't had enough time. I'm just saying that I didn't do it.
You are not able to produce today one piece of paper indicating you notified the Small Business Administration of your suspension. Is that your testimony?
Yes, ma'am. That is my testimony.
Good girl. Oh, my mic is on.
I want to talk about a hearing that you had approximately 1 year ago in Chester County, Pennsylvania.
Pennsylvania.
That hearing related to a second mortgage that you had obtained for your home in 2005.
Yes, ma'am.
Your home is in Malvern, Pennsylvania, which is Chester County.
Yes, ma'am.
The loan was for $49,000.
Yes, ma'am.
At some point, you fell behind on the monthly payments for that loan.
2014.
So you had the mortgage since 2005. 2014, you fall behind.
Yes, ma'am.
And
it was charged off in 2014.
Oh, we're going to get into that.
Okay.
A foreclosure action was filed against you in Chester County. That complaint date is August 24th, 2022. Correct?
I don't know about the precise date, but a complaint was filed against me. Yes, ma'am.
You fall behind on payments in 2014. The complaint is filed against you approximately 8 years later in 2022. Does that sound about right?
Yes, ma'am, it sounds about right.
At some point, there's a hearing scheduled for this foreclosure matter.
I called it a trial, but yes, ma'am.
A trial. Instead of conceding that you owed that money, you chose to have a trial in that matter.
Well, can I explain?
Yes or no?
Sure. Well, the law says that you can't, after charging off an account, charge that a subsequent purchaser, what's known as a zombie mortgage, which I never heard of until this happened, is not allowed to seek interest going back to the date of the charge-off in the absence of regular bills having been sent on a monthly basis to the borrower. And so my principal contention was that I owed $45,000 because that's the amount that was charged off, but I didn't owe $58,000 in interest, some portion of that, because after it was charged off, I never heard anything for like 4 years. So so that was my principal contention. Yes, ma'am. That was my legal argument, and yes, ma'am.
So essentially, your argument was that you thought the loan had. Well, let me ask you this way: what do you mean by charge off? When you say that, what do you mean?
Yes, I got a notice, and I actually found an old credit report. I got a notice in 2014 saying that the account had been charged off. As I testified at the hearing, first of all, this is not my area of law practice. So, to me, when I got that, I'm like, well, that stinks. So I'm going to have 7 years of crappy credit. But, I don't know the $45,000 anymore. So, okay. So that was my understanding when I got the charge off in 2014.
So you didn't think you owed anything in 2014 once you stopped getting these notices?
Well, getting a notice or not getting a notice was not material. I didn't even realize that until I started preparing this matter. But yes, when I received the charge off, my understanding of the charge off was that the debt no longer existed where you are concerned. I was wrong, I learned many years later, but yes, ma'am, that was my understanding.
And essentially, that was your testimony last year in front of the Chester County Court of Common Pleas that you believed that this loan was no longer in existence. It had been charged off.
That I believed that in 2014 all the way through 2018 or 19, when suddenly I got a notice from someone I'd never heard of before saying that they had purchased this charged off loan and that I now was required to pay $450 a month on it.
You actually testified to that in the courtroom. You said,
I'll write you an excuse.
in February 2019, when a company that I never heard of called SN Corporation just sent me a bill.
Yeah, that's funny, but yes, I testified that way, and that's accurate. Yes.
You said I probably cobbled together that it had to do with the second mortgage.
Okay, I believe you're reading my testimony correctly.
You told the judge at first you thought that notice was spam.
I never. That's right. I believe I did tell the judge that. Yes. Yes, ma'am.
In conclusion, it was your testimony to the judge that you believed that this loan was charged off in 2014.
Well, I did believe it in 2014, but during the year and a half or 2 years that this was a fundamental part of my life, and
I love spam.
Because my house is listed for sheriff's sale, and on May 15, I've made a lot of offers, but I just don't have the money. But I acknowledged that I hadn't paid since 2019, and that I got a bill every month, and that I did come to learn. I didn't know what a zombie mortgage was then. It didn't feel good to me inside that this had happened, but I knew that I owed the money, and I just didn't. I did not exercise sound judgment or financial responsibility in 2019, 2020, 2021 when this was.
He just sat there and said, man, I made bad decisions this year, this whole year, put this year in there too. Just bad decisions year after year. Make me a lawyer.
Closure actions filed. I've come a long way, and I've grown a lot.
My new job starts
But I
Monday.
haven't always made good decisions just because I got sober, or just because I tried really, really hard.
It was the hair dye.
This was a bad decision to not confront this. It was bad judgment. It was a bad decision, and I'm paying for it. And there's no way around that. I've tried, but I sometimes have failed.
Make me a judge.
Let's say 2014 to 2019. It's your testimony today that you believe that loan had been charged off in that 5-year span.
Yes, ma'am, because I never received a single inquiry or document or communication of any kind that would have suggested otherwise to me.
And that's your testimony today, and that was also your testimony in front of the Court of Common Pleas.
Yes, ma'am. You're using the date 2019, so I'm going to go with that as to when the first thing I got was from S&M, but that is 100% my testimony.
You're using the date 2019. I'm going to stick with that because it really started in 2016, but I'm not going to tell you.
Ma'am, to the best of my knowledge, information, and belief, then and now.
Are you sure about that?
Yes, ma'am. That is, I'm sure as a 62-year-old man can be talking about a 5-year period in between 2014 and X date when I received something in the mail. Yes, ma'am.
Can you please turn to ODC's Exhibit 22, and it's date stamp 982.
Okay. Okay.
Just let me know when you're there.
Yes, ma'am. I'm here.
Do you recognize that document?
Yes, that's one of the two bankruptcy petitions that we filed in order to protect our home. They never went anywhere, but yes. I don't know what year, 17. Yes, ma'am.
On the top of the page, can you tell me what date that bankruptcy was filed?
3/13/17.
Part 1, what is the first thing that you list there?
I said 16, but it was 17.
Well, number 5, where I live, 8 Harvey Lane, is that what you refer to, ma'am?
There's a black box that says Part 1 under Schedule D.
I see.
It should
Yes.
be page 982.
I'm sorry, on page 982, ma'am?
Yeah, it's page 982.
All right. Yes, ma'am, I'm there.
What is the first thing that you list as a secured claim?
FCI Lender Services, Inc.
What is listed as describe the property that secures this claim?
Real estate mortgage,
And the amount?
45,060.
What is that for, Mr. Gallagher?
You know, I would imagine this was pulled by my bankruptcy lawyer on a credit report, but I'm certain that's the second mortgage.
Now can you turn to page,
But it says last active 11, so last active 11/13/13, that's probably the charge-off date.
okay.
Yes.
Can you now turn to page 1033? It's ODC's Exhibit 23.
1033.
Just let me know when you're there.
Yes, ma'am. I'm there, ma'am.
Do you recognize that document?
I do.
What is that?
It's a 2018 dated bankruptcy petition. My wife and I dated
Technoblade is a pig.
9/18.
Can you please go to the bottom of the page? It's secured claim 2.2. Can you please tell me what that is?
This refers, I've never heard of FCI Lender Services until this, I know I signed this, so, but that is the second mortgage. Same, I don't even know. Yes, it's the same lender, FCI. Yes, ma'am.
Did you have an opportunity to review this bankruptcy filing before you filed it?
Yeah, and I yes, ma'am, I did. I did have a full opportunity.
And that, just to be very clear, that refers to your second mortgage, correct? This FCI
Yes, ma'am, it does.
lender?
Yes, ma'am.
We're not gonna get into the actual Chester County hearing, but there was an order in that case, correct?
Yes, ma'am. I don't know that you can get into the hearing of the order without getting into the hearing and specifically my direct testimony, but I'll leave that to you as you see fit.
Before it kind of pleases, I'm not sure where this, why we're relitigating a mortgage case, foreclosure
I
case.
don't think we are. She's asking about representations made under oath elsewhere that are
In
relevant
2017,
in 18-ish.
18.
Well, the trial was in, somebody help me,
2024.
or 2024,
Okay,
right?
so there's a trial transcript, and I guess you're gonna have to read the whole transcript of the
Well,
of
we
the
may
trial.
if it's up record, but, and that certainly, you know, obviously you're free to argue it, but I'm gonna let her lay a foundation as
Okay.
to representations made under oath.
Okay,
It's prior sworn testimony.
okay. I don't think that's what we're gonna hear about prior sworn.
Well,
that
I'm anxious to
testimony.
hear, so objections overruled.
For the record, the transcript is Exhibit ODC 20.
Did you previously object to the transcript being admitted into evidence?
First of all, we have not discussed any admissibility of any exhibits. I'm
Okay,
reserving we
There was a stipulation by between counsel before we started regarding the evidence as prepared for us to view.
by us, we sent having to do with his financial condition. Has nothing to do with all these exhibits. I mean, I've never stipulated to that.
Do you object to, what's the transcript? ODC exhibit what?
20.
20. Do you object to the ODC exhibit 20?
I want to know what its relevance is. I mean, we're going to try to replace the judgment of a court? I don't know where we're headed with this.
State your basis, counsel.
It is my office's position that Mr. Gallagher was not forthcoming to a court of common pleas judge. My next line of questioning deals with the judge not finding Mr. Gallagher to not be credible. I think this is highly relevant. I think this is something that our Supreme Court is going to want to know when weighing the decision whether or not to reinstate Mr. Gallagher.
Response to that?
I've seen the order. The order is not specific at all as to, there's no
exhibit,
findings of fact.
it's a transcript.
Yes. So we're going to have to, because I've seen the order, there's no opinion, there's no specific reference to anything in the transcript that says that the court did not find this credible or that credible. I know exactly what it says.
Okay, well, your objection right now is overruled as to the basis for its relevance, and we're in a position to give it the appropriate probative value. And you're gonna have an opportunity to redirect your client in this regard. I mean, to the extent that there's a general objection to OGC 20, the transcript itself, and, I would have expected that you would have brought a motion to eliminate to strike its use.
Well, I wasn't sure it was going to be used after having conversations with counsel.
Well, okay, okay,
Yeah. Okay. Yeah, so far.
You've had proper notice of Exhibit 20.
Sure.
Okay, go ahead. Objection's overruled.
But you don't understand. They gave us notice that they were going to use this, but we didn't think they were really going to. So we didn't prepare for it.
Now we'll jump ahead to ODC Exhibit 21. Are you there, Mr. Gallagher?
I am now.
That is a 5-page decision and order from Court of Common Pleas Judge Anthony T. Verway.
Yes, ma'am.
That was dated March 22nd, 2024.
Yes, ma'am.
That's less than a year ago.
Yes, ma'am.
The judge, having an opportunity to observe you, did not find you credible.
That's shocking. What?
For the judge's words.
Where specifically is the reference?
If we could look at base stamp 961.
951?
960.
61, excuse me.
Are you referring to paragraph 21 on base stamp 960?
Sorry. Yes. Yeah.
Yes.
Yes, I see paragraph 21, ma'am.
The judge.
No, I don't think so. PPP was to pay business expenses as well.
Did not find credible.
Right?
That's what I was going to read from it. Let him read all the words, please.
Sir? Well, we have the entirety of of Exhibit 2021. And again, we'll give it the appropriate weight that it's due.
Well, there's a very important word that continuously is left out by counsel. Reserving defendant's demeanor.
So I think what happened here is I, like a fool, represented myself, and during my cross-examination, as you'll see in the transcript, I hadn't written down the pages, but there's at least Judge Verwood. I told him I was a formally admitted attorney, and I later learned that he worked for your office for like 20 years. And I'm
referring to who?
Judge ODC. I didn't know that, but in any event, when I cross-examine people, and sometimes when I testify in a room like this, unfortunately, trying to do a better job today, because I really was not happy with my demeanor the first time around. Even entirely with my prior reinstatement hearing, or even my first one, because I put my lawyer coat on. I'm not here as a lawyer. I'm the only one in this room that's not a lawyer, if you will. But in any event, when I cross-examine people, I can be assertive, And we had a lot of colloquy where he mentioned my.
He's probably a jerk.
At least twice during my cross-examination. But I'm befuddled because in my direct examination was
I'm befuddled
extremely
too.
short
Mr.
and
Gallagher.
almost no
The record should
cross-examination.
reflect
I'm sorry, go ahead.
Okay,
Sorry,
Time-
my
everybody,
bad.
time out.
My bad.
We're gonna behave. I think we should take a break. Everyone can huddle, right? You're still gonna remain on cross-examination. Mr. Quinn's gonna have an opportunity to re-examine you on redirect,
I
okay?
apologize, yes, ma'am.
That should give everybody an opportunity to review the particular exhibits that you've fairly been on notice of, that she's been in use. To the extent that we're gonna object, you're gonna object to line of questioning, please let me know.
No, because I'll withdraw that objection, because now that the.
I think a
order-
couple
the
times.
relevant portion of the order has been read into the record.
Hold my beer. Hold on.
I suppose what's being asked of you is to read the entire transcript of a trial and see if you can figure out where there's a reference to demeanor and whether the judge actually said anything during the trial. And where you can see that there's any lack of credibility.
Okay, I'm not opening this up to debate or argument right now. Generally, my rulings, so that we're clear. Exhibit 20 is prior sworn testimony. That is, law school 101 is relevant for purposes of cross-examination. As to exhibit 21, which is the judge's order, I'm willing to entertain an objection about, the conclusion, which we are free to accept and or reject. We'll revisit that as we look for it. Generally speaking, I think the exhibit would speak for itself.
I'm seeing if I can dig him up.
Why don't we take a break?
Okay.
And everybody, let's get our blood sugar in check, and then let's resume in 15 minutes.
Madam,
No, there's no question. You're not to direct.
can I consult with my attorney?
Go. We're on break.
Okay.
It's for you to consult with your attorney.
So I don't want to switch to the first page so that you know what's going to happen, but this only starts at 2024. The pending proceedings. Oh, I just saw. I thought it was on the first page. It doesn't show me everything. But I think he was in trouble a couple times before. Or a couple times since. He was suspended for 1 year and 1 day in 2022. And it was 2025. I get that confused all the time.
To that order before. Mr. Gallagher, prior to break, we were discussing an order from a Chester County judge dated March 22nd, 2024.
Yes, ma'am.
I'm referring to exhibit 21.
Yes, ma'am.
I only have one question relating to that order. The bottom line, that order states that there was a judgment against you entered in the amount of $102,000 plus interest for your second mortgage, correct?
Whoa.
I'm gonna move on to another topic. This is actually the final topic that I will ask you about. It's your recent bankruptcy filing.
Yes, ma'am.
When we were here last time on January 27th, 2025, I believe you've already testified that you filed this bankruptcy petition on August 30th, 2024, correct?
Yes, I know he got in trouble for drinking. I also think that he didn't give someone back their money. They gave him money for something and he didn't give a client back their money. They use a word that I can't think of, and it's Ito. It's not Ito, but that's as close as I can get after streaming for 10.5 hours. Ido, he had money in an account from a client. Iota, no. It's so close. I'm so close to it. Maybe they'll say it.
For the record, this is
Iola count.
ODC Exhibit 25. Prior to filing your bankruptcy petition, did you review your bankruptcy petition?
Certain that I did, yes, ma'am.
It was prepared for you by an attorney?
Yes, all of them were, ma'am.
The attorney who prepared the August 2024 petition, his name is Bob Lohr.
Lohr, yes, ma'am.
You were able to review it prior to Mr. Lohr filing the petition?
Yes, ma'am.
Did you sign your bankruptcy petition?
I believe so. I believe I did. I think I was, yeah, I mean, I think I was required to.
There is a section in the bankruptcy petition that discusses your active or pending litigation, correct?
Yes, ma'am.
You did not list this reinstatement hearing as one of your pending actions.
Not initially, ma'am. We amended to add it.
We previously discussed at the last hearing that my office was not notified of this bankruptcy filing until early November 2024.
Okay?
Correct?
I remember that. Yes, ma'am.
When
Donald likes to complain a lot.
I received the bankruptcy petition from your lawyer, Mr. Quinn, I brought it to Mr. Quinn's attention that this reinstatement hearing was not listed on your bankruptcy petition.
You did.
As a result of that, your lawyer then filed an amendment on November 9th, 2024, which is Exhibit 26, correct?
Immediately he did that.
It was almost,
26, can I just look, madam?
yes, take your time.
See if it's the full. Yes, ma'am. That looks like it. Sorry, I'm taking your word for it in the interest of time, but I know we filed an amendment immediately after you brought that to Mr. Quinn's attention.
And the amended petition then discussed or listed this reinstatement hearing.
Yes, ma'am, it did.
I could have one moment. I want to draw your attention to date stamp page 1104, which should be in tab 25, which is ODC Exhibit 25. Just let me know when you're there.
Great. The number again, madam?
Sorry, 1104.
Thank you. Okay, I'm there, ma'am.
At the very bottom of the page, there is question 13.
Yes, ma'am.
The question is, do you expect an increase or decrease within the year after you file this form? Did I read that correctly?
You read those words correctly.
And again, this is your original August 30th, 2024 bankruptcy petition filing.
Yes, ma'am.
You answered that question no.
Yes, ma'am.
It was your position. It was your position.
At least
that
one, Fozzie. At least one.
From this filing, August of 2024, within the next year, which would bring us to August 2025, you do not expect your income to increase at all.
Like 2.5 more hours.
I don't even know at this moment what an increase or decrease means. I've read the question at 13. So I need to take a minute to see what that question refers to, if you don't mind.
Sure.
Thank you.
Take a minute.
Let's see.
included the 2 free hours. Yep.
I can't really, so this is prepared in consultation with Mr. Moore?
Yes, sir.
So I don't know what the standard is for stating an increase or decrease. In other words, for example, my wife, certainly we were hoping when we filed this that she would get a raise in 2024 within a year, right? I don't know what the standard is. I would only be guessing to try to recall conversations, if any, with Mr. Lohr about that concept. So I'm afraid that's the best answer that I can give to that, madam.
Did you physically meet with Mr. Lohr to prepare this bankruptcy filing?
5 or 6 times.
You had adequate time to review this petition for bankruptcy?
Yes, ma'am.
Mr. Lohr was very thorough with you in filing this petition for you?
Let me just say, you sit on one side of the desk and the attorney then does things like go on a website to find a credit report that's not one of the 3 major credit reports. It's called something else. You deliver all of your paychecks to them and they input them in and the light's either green or red. They fill out all these forms based on software that they have that takes all of the information you provide to them and creates these schedules. I have to say that probably we spent a lot of time, I'm going to say, discussing the tax issue. And as I said, my wife elected not to. I probably, it could have been known based on the IRS standard that I came to later learn existed. He found the judgments by going online and the cases. He certainly knew that I was a suspended attorney. This is a man I spent a lot of time with. It's something that I recite to all attorneys to meaningful relationships. It's part of the fabric of who I am, a suspended attorney. I don't keep it secret. The fact that he didn't include that, this matter upset me. I didn't notice the omission. I could have, would say that I should have, but I didn't. He said, well, what I do is I go online and he found something from Capital One that I didn't even know about, a judgment of $3,200 from 2014. So he was thorough with me. He's a great lawyer and a very good man, good human being. But there were some things that I was very upset about not including this. Very, very upset with him about that, to be candid.
Mr. Lohr knew about this hearing coming up.
Yes, he knew everything about my status as a suspended attorney. Yes.
He is listed as one of your potential witnesses in this hearing.
Yes, he is. And he wrote a letter to the trustee explaining that it was solely his omission, the failure to list this. And I know you had that because I know Mr. Quinn sent it to you right away. So I was very upset about that. I appreciated his letter, but I could understand your point. Like, why didn't you include this? I was with you 100% on that. I was upset. I should have noticed it. It's my responsibility.
Moving ahead to ODC Exhibit 29.
Yes.
There should be 1 page there.
All right. Okay. Yes, ma'am.
This is an order dated December 12th, 2024.
Actually, my 29 is an email from Bob Lohr to the trustee explaining the amended statement of financial affairs and saying that I neglected to include the administrative proceeding, etc. It's not an order, it's his email to the trustee.
You're correct. Can you turn, and I apologize, can you turn to the next page, which is base stamp 1144? Do you recognize that document?
Okay. You don't mind, let me take a moment. Do I recognize it? I mean, it's part of it's page 2 of 2 of the order of discharge, so I recognize it to that extent. I mean, got my docket number on it. Yes, ma'am.
It has your name on it?
Yes, it is something that I was given when the bankruptcy was discharged on December 12th. Yes, ma'am.
The date is December 12th, 2024.
Yes, ma'am.
The judge is Ashley M. Chan, United States bankruptcy judge.
Yes, ma'am.
On December 12th, 2024, where were you working?
Where was I working? Delaware Valley Tennis Academy. I was the receptionist.
You were a receptionist at a tennis
Yes, ma'am.
club.
In Brimley. Yes, ma'am.
You have provided my office with pay stubs from that tennis club.
Yes, ma'am.
You were making $17 or $20 an hour at that tennis club.
Yes, ma'am.
Do you know why some pay stubs said 17 and some said 20?
Yeah, I was on a temporary assignment.
He's a liar.
From Kelly, and it turns out that Kelly had a side agreement with Delaware Valley Tennis to pay me $20 an hour, but the contract that they gave me or whatever said 17, and
Okay, that's true.
So when I left,
Kelly Services is a temporary employment agency here in Pennsylvania, and they find you a job, and the employer pays $10 an hour, but Kelly Services is only going to pay you $7 an hour, and they're going to keep $3 an hour just for finding you that job.
that assignment, they sent me a check out of the blue for the extra $3 an hour that went back to whenever I started.
Your salary at the tennis club was either $17 or $20 an hour.
I think it's fair to say that it was $20 an hour. I just didn't get paid that when I was working there until afterwards.
You could turn to ODC's Exhibit 32.
Yes, ma'am. My 32 is blank, madam.
I can give you mine.
Perhaps you get 30. Perhaps you be 33. One of my stubs from Bureau Law Offices.
No, I will give you mine.
Okay.
For the record, it's actually ODC 31 and it's date stamp 1152. May I approach the witness?
We have ODC 32 at Bates 1152.
I believe that's what it should be. There may be some confusion with the binder, but I can give him my copy.
I think as the page before it might be.
May I approach the witness?
Yeah, go ahead.
Thank you.
We could all be playing Skyblock right now.
Okay.
Do you recognize what that is?
Yes, the offer letter I received dated December 16th. I don't think it was given to me December 16th, but that's the first date that I worked there.
December 16th, 2024 is 4 days after you get your bankruptcy discharge order.
Yes, ma'am.
The letter is addressed to you, Dear John Gallagher.
Yes, ma'am.
Who is the letter from?
Dear John.
Jim Ruggiero.
Who is Jim Ruggiero?
He's the president and principal of Ruggiero Law Offices, LLC.
The letter states, Dear John Gallagher, thank you for expressing interest in the legal assistant position at our Paoli location. We have reviewed your experience and skills and would like to extend an official offer to you. Did I read that correctly?
Jim didn't write this. Cynthia Irwin wrote it. She's our HR person. But yes, I see that.
Did you apply for this job?
No.
How did you get this job?
Well, I know Jim from I can't say precisely where, but I've known Jim for several years. And
the bar.
He had in the past talked to me about having some side work, principally working in the off-site storage area to organize boxes, that I've since come to see why he needed help like that. And I just wasn't making enough at the tennis club. And so I had, over the months preceding this with Jim and other people, consistently reached out to lawyers to say, hey, if you need anyone on a pro hoc basis, we'd have to file something with the disciplinary board, but I'd be glad to do anything. Jim said, why don't you come by if we have a calendar on a Monday? It would have been, if I could look at my phone, I believe I'll find it December 16th is a Monday. I'm not sure about that, but I wouldn't be shocked if it is. Does anyone have a calendar today?
I'll look for you.
Thank you so
Okay,
much,
No
Madam.
problem.
Mr. Gallagher, we were actually scheduled to be here for your reinstatement hearing on Monday, December 16th, 2024, correct?
Yeah, but at that point, it'd be continued.
Right, correct. So December 16th is a Monday.
Oh, thank you. So I'm kind of out of the blue, so I see Jim regularly. I don't want to, it's not fair for me to say hours.
No, and I'm not
Okay.
asking you that.
So-
How regularly do you see him?
At least once a month. We sit in the same room, and we've done so for several years.
I understand.
Same at every
So,
AA meeting.
Kind of totally out of the blue, while I was working at Delaware Valley Tennis, he said, why don't you come by Monday at 12? And I said, oh, Jim, I'd be willing to, I wrote back and said, that's great, Jim, I'd be willing to do anything as long as it's moral, ethical, and legal, and I don't need a big, I'm just looking to make some extra money.
Liar.
And what happened,
He's a
was
liar.
Friday, December 13th, someone quit. Someone who worked the front phones. I didn't know that. And I walked in and he said, how would you like to start working for me tomorrow for $60,000 a year? And so I resigned, and as bad as I felt in not giving 2 weeks notice to DVTA, Delaware Valley Tennis, I did that afternoon. I have it on my cell phone. I could show it to you because I texted them saying, I'm so sorry, because they're great people, the Raniers. So this was one of the great things that has happened to me over the last 4 years, and there have been many. It was life-changing. It was a life-changing meeting at noon on December 16th that I never expected in a million years. That's how that happened, madam.
You got the job.
I was offered a job at 12 o'clock on Monday, and I started Tuesday morning at 9 o'clock, 8:30.
You provided my office with your first pay stub
I'm sure I did.
promptly.
I tried to be diligent and prompt and transparent in all my communications with you.
You're making about,
It's my obligation. It doesn't make me special.
you're making about $61 an hour working for that law firm.
I don't know. I don't think so.
As the receptionist,
I don't think so.
what?
I don't think that would, I don't know, I've never done the math. I don't think 61,000 divided by, well, I work, I work from 8:30 to 5, obviously a lot of overtime, I'm salaried, but just standard, since I did this for years, I'm pretty certain that you're incorrect in your math, but if you give me 1 minute, I've done millions of wage calculations, thank you, madam. So you do 61,000, just dividing it by 52 would be about, let's call it 1,300 hours a week, right? Yeah. It's actually make about 2,400 hours a week at 40 hours. Sorry, how much a week? $1,300 a week. Yes, at 40 hours. It's like $32. I think it's like $32 an hour. I'm under a little pressure. So if I had Brian, did you calculate it?
32.5.
Okay.
Can you turn to ODC Exhibit 32? And if you don't, I don't think you have that. I can provide you a copy.
Yes, ma'am.
It should be.
Yay, Patty, thank you.
Making
You are awesome.
$64 an hour withdrawn, or?
I don't think the line of questioning has concluded, but I think there was a question that says you made $61 an hour. The answer I hear, this in common parlance, is no, it's about $32.50. But we have a letter that says $55,000 a year salary. I think that was also.
Yeah, and actually that letter, I think they pay me a little more. I think we did calculate it out. I think Madam Preventure's correct that it actually is more than what Tania put in this letter.
Okay.
I think she's right. I think it is closer to $60,000 when you take my paychecks, about $32 an hour. Well, I didn't know, obviously I didn't know that on August 30th or anytime before December 16th, 2024.
If you could refer.
Now we're at ODC 35, which is Bates, 11?
It should be ODC 32. It should be Bates 1154. Mr. Gallagher, if you don't have that, I can provide you a copy.
Okay, madam. You know, I do have 1154, madam.
And I'm mistaken, it's ODC 33.
Yes, ma'am, I have ODC 33 in front of me.
Do you recognize what that is?
It is my first paycheck for this year, 2025.
How many hours did you work?
Well, how many hours did I work? I'm sorry, you asked me what the paycheck says?
Yes.
37.50.
How much was your gross pay?
Gross. $22.91. It's a 2-week period though, so it's actually 75 hours, and the gross pay is $22.91.
That's not what your paycheck says, though.
I can't account for that, madam. It says this, I understand exactly what you're saying, but it's for a 2-week period as per the top.
You'll agree that your income has increased since working at the tennis club, correct?
Yes, it has. And it's very rewarding work as well. I love the tennis club, but I'm thrilled to be a full-time employee in the legal industry again.
I want to refer back to your bankruptcy petition, the one you filed on August 30th, 2024.
Yes, ma'am.
That'll be ODC's Exhibit 25. And please draw your attention to Bate Stamp 1083.
I have found 1083, ma'am. I'm looking at it.
Can you look at number 25, which is in the middle of the page?
Yes, ma'am.
Question 25 has to deal with trusts, equitable or future interests in property.
Yes, ma'am.
You list something there, correct?
Yes, ma'am. I do.
What do you list?
My remainder man interest in my mom's home. My mom, God rest her soul, passed away in 2022. I had set up her will so that my disabled sister could have a life estate after my mom passed away. And God willing, my sister will outlive me and my brother. But whenever my sister passes away, either I or my children, if I should predecease her, will be entitled to a 1/4 interest in the property, the other 25% going to my other sister who's deceased, my oldest sister, her 3 children. So I provided to my attorney the evidence of that remainder man interest, and it was included in here.
Your attorney listed that value, your value of that estate is $1.
I don't know about that, ma'am. I don't know what the, yes, ma'am. I see that is listed as $1. I see that, madam.
That's not correct, though.
Well, it is today to me. No, well, I don't know how much I can sell my interest in on the, I don't know how much I can sell my interest. I'm hoping my sister outlives me. I don't know what a remainder man interest has in a life estate that may or may not ripen where I'm concerned someday in the future, madam.
The tax documents in Delaware County indicate your value of that estate is $75,000.
What tax document?
Your mother's estate documents indicate that the value of your estate, John Gallagher, is $75,000.
I would have to see that.
I'm going to object unless we have a document to look at and we can get an explanation.
Do you have a document to look at? Okay.
I'd like to see it. This is an inheritance tax return.
I haven't seen the document.
Okay.
We also haven't been, is this somewhere marked? Is this an exhibit?
It is not.
Okay. Is it for illustrative purposes? Like, what's the relevance of this?
The relevance is to show that Mr. Gallagher has an interest in an estate that he did not disclose on his bankruptcy petition.
Okay. Is this a public document?
Yes.
Are you marking it for illustrative purposes only?
Yes, I'll mark it as ODC 34.
Mr. Quinn, I'll give you ample time to take a look at it. And then hear any basis for an objection.
I'm going to give you the basic.
Yeah, go ahead. Go ahead.
A Pennsylvania inheritance tax return, you list values of property for purposes of paying, for the estate paying inheritance taxes. It has nothing to do with, it can't project the life expectancy of John Gallagher, of his sister. That's all speculative. If he dies first, his value is worth zero.
Okay, and I'll note for the record that at Bates 1084, there is a disclosure regarding this property. Yes. So I'll sustain the objection and ask you just move on, counsel.
As a result of your discharge, bankruptcy discharge order, you had essentially hundreds of thousands of dollars discharged.
My understanding is that bankruptcy can't be used against a person seeking a license in Pennsylvania, but I'll answer the question anyway. That's unlawful under the United States Code, but I'll answer the question.
Is there a motion regarding that
Well, there's
statement?
not a motion other than the fact that I raised this at the last hearing, that to use a bankruptcy filing to deny someone a license is in violation of federal law. I thought that I handed that up, that statute, but I'll be glad to provide it.
So my understanding, just so we're all clear, is that this line of questioning is regarding the representations made in the bankruptcy proceeding, and that's what he's been asked. That's what Ms. Provencher is asking him about, are the disclosures, representations made to the court. And again, I'll remind everybody that this committee's it will give this evidence what weight it's properly due and weigh its probative value as with respect to.
Based on case law where there are scores of lawyers who have filed bankruptcies and have been discharged in bankruptcy who have been reinstated, and that there's specific law that says that the failure to pay financial obligations is not a condition of reinstatement. So despite the law.
No, time out. I take issue with that characterization. That's not at all what I just said.
I know.
So let the record be very clear that I accept counsel's line of questioning regarding representations made in a court of law and prior sworn testimony to the extent that it is relevant to exploring assertions made for purposes of this reinstatement hearing. No one has asked this committee to accept, in whole or in part, full judgments, any that have occurred anywhere else, nor are we using it, or is it being proffered for the basis that you just asserted.
Okay.
Okay?
Yes.
So I again, notwithstanding the fact that your client is answering it in a way that's with respect to that. So if there's a responsive answer, to regarding the representations made in a court of law and under oath that are subject to penalties of law, they are relevant for purposes here.
I understand.
You can talk about the responsive nature of your client and his understanding for those things, but that's for the purpose for which we are accepting these questions and the answers given in the record today.
Thank you.
So, Madam, what part of the application were you referring to when you just asked the last question, which I understood to be, as a result of your discharge of bankruptcy, you had hundreds of thousands of dollars discharged?
Strike that.
Yeah.
Strike that. You're not.
No.
Time out. Time out.
Sorry.
Again, we're not going to accept questions from the petitioner to the lawyers. We're not gonna accept direct commentary to the committee. When there's a question, and I can appreciate that you may require clarification given this interruption, there's gonna be a question from counsel that you can answer. If you require something by way of clarification in order to answer, we'll accept that. But questions directed to counsel are just not gonna be entertained.
Yes, ma'am. Can you repeat the question, Madam, please?
Thank you.
As a result of your bankruptcy discharge order dated December 12th, 2024, you've had hundreds of thousands of dollars in debt discharged. Yes or no?
Is there a part of the, are you asking me about something that's represented in my petition?
Mr. Gallagher, have you and your attorney provided me countless liens that have been released for you? Have you provided my office with an updated credit report?
Yes, ma'am.
Have you updated my office with voluminous financial documents?
Yes, ma'am.
Up and until yesterday?
Yes, ma'am.
As a result of your bankruptcy order in December, a lot of debt has been relieved from your life, correct?
Yes, ma'am.
Hundreds of thousands of dollars.
Yes, ma'am.
Including PPP loan number 1.
Yes, ma'am.
Including PPP loan number 2.
Yes, ma'am.
Including your second mortgage, which Judge Fairway ordered that you were responsible for.
Not the lien, but the personal obligation. Yes, ma'am.
At our last hearing, you testified on direct examination that you believe that you have a very strong support system moving forward should our Supreme Court reinstate you as an attorney.
Yes, ma'am.
Your wife is not here today, correct?
No, ma'am, she's not here today.
Are you still together with your wife?
Yes, ma'am.
Who are you currently working for?
Jim Ruggiero.
You still have that same job that you retained in December?
Yes, ma'am.
Is it your plan to work for Mr. Ruggiero should you get reinstated to practice law?
Ma'am, I'll say this. My goal today is to come in and do a good job, stay clean until midnight, and make good decisions. I never spend any
Don't answer the
time
question. Just talk.
thinking
Blah, blah,
about
blah, blah, blah.
anything that may or may not happen. I try to make good decisions every day, and that's how I live my life. So I don't have plans for the future, except to try to do a good job for the next 1 minute and so on and so forth in this room, and do contact some people when this is over in my support system to talk about things, and to stay clean until midnight tonight, and to honor my, I was recently told I was diabetic, so I honor that diet rigorously, and I go to the gym, and I love my wife, and I'll go home and let her know that I love her.
No one cares about any of that.
That's my only forward thoughts today.
Today you are employed by Mr. Ruggiero, correct?
Yes, ma'am.
He's not here to testify on your behalf.
No, ma'am, he sent a letter in, as you know.
We just got a letter. We just got a letter.
Let's start with the letter, where we set it up, with your wife. What occasion occurred approximately a week ago in your family?
Belated celebration of my wife's 50th birthday
And
at my home.
And who was there?
Even my daughter Dylan from Colorado, my grandson Cameron, who was with her, my daughter Amanda, and my granddaughter Lola and her husband Frank. You were there, and my brother was there, and a lot of my nephews were there, and
You?
a very couple of dear friends that I have.
Wicked Witch of the West.
And a couple of dear friends that Catherine has were there.
You have friends that are dear?
And
Nice.
Children?
Oh, yeah. Yeah. Parker, Olivia, and Callie.
Are all those people that you just mentioned part of that support group of yours?
Oh, yeah. Yeah. Yeah, Bob.
You still going to the meetings? that you referred to on direct examination a month ago?
Fundamental to my life. I am.
Including the lawyers' meetings?
They're fundamental more than regular meetings to me now.
Are all those lawyers part of your support system?
They are. They sometimes are annoyed by the, I'll take a text with a thought for the day and I'll send it out and copy and paste it over and over again.
Oh, no, don't.
25 of them.
Lock him up.
I don't do that every day. But
Somebody sends me an inspirational quote every day. I'm not going to say what I'm going to do because it's highly illegal, but I'm going to do it. And then you're going to get in trouble for it.
that, 12, 15 times a year maybe.
Now, let's talk
And I
about that.
talked to a lot of them on the phone.
Let's talk about that SBA loan, the PPP loan, and the appeals. But before we do that, there was a reference made to a letter that I sent to the Office of General Counsel dated May 30th, 2023.
Yes, sir.
What's the date of the SBA decision?
Think it's July 17th, 2023, based on what I saw on the break.
Okay, so the SBA knew about your suspension, correct?
I think it was somewhere between 2 weeks ago and this minute right now. And that's the best I can narrow it down.
Yes.
Did the judge mention anything in his order? It's part of our exhibits. It's already been admitted.
I looked at it again during the break to the best of my ability, but it's consistent with what I've always understood. He did not mention it in his 11-page decision.
And have I ever advised you that I got a response from the Office of General Counsel to my email?
Yeah, I'm not waiving attorney-client privilege to say you never told me that. You never mentioned a response or sent me one.
Have you ever gotten one?
No.
Moving back to the Chester County case.
Yes.
And the decision of, I don't remember the judge's name.
B-E-R-W-E-Y.
Okay, and we're talking now about the transcript, ODC Exhibit 20.
He's not qualified.
Yes, sir.
It goes from page 849 to approximately 956. Now, part of that proceeding, you were acting as your own counsel, correct?
Because I'm a fool.
Well,
I could not afford counsel, but yes, sir, that is correct.
What portion of the transcript contains sworn testimony by you, which was subject to cross-examination? Where does that begin?
9:45.
9:45. And on the cross-examination begins on 9:53, does it not?
I'm going to take my time on this. Yes, it does begin on page 953.
Okay. Did the judge ask you any questions?
Nothing is better than potato farming. Nothing.
There were only about 4 questions from Mr. Sulon, S-U-L-O-N. I don't want to get bogged down with 4. Very few questions and no questions from the judge. And during my direct, I don't think the judge interposed anything. He overruled an objection from Mr. Sulon on page 947.
Okay. Now,
and I just, and he didn't ask me any questions or interrupt me or correct me or criticize me or say anything to me other than overruling one of my opponent's questions.
Okay. So other than those several pages that we just mentioned, the rest of this transcript is anything that you say is in your capacity as your own attorney, correct?
Yeah, and I'm afraid I poisoned the well during my direct cross-examination in that matter, unfortunately.
Okay, just
Yes, sir. The rest of the transcript is either opening statements or direct testimony secured by Mr. Sulan or my cross-examination of the plaintiff's witness. Yes.
It looks like this lady here is reading blank papers. There's nothing on them.
Let's direct your attention to page 905.
Okay. Let me get there, please. I am on 905.
Okay, about halfway down the page, the court interrupts you. It starts with you saying so, and the court said, let me finish. So we're going to take a 10-minute break. Give some consideration to how you continue your cross-examination and how you're going to handle your presentation, because we only have about an hour and 20 minutes when we come back to finish, and we're going to finish today. So think about how you want to finish your presentation, your cross-examination of this witness, and make sure you
13 and a half hours, Kelly. 13 and a half hours.
Pro se litigant to go all over the place. Focus yourself. Come back and be prepared. You call that?
I do. And I told him I was a former attorney, not to secure favor with them, but because I have been very careful about making sure wherever I go, wherever it's appropriate to say that.
I'm going to direct your attention to 9, and so you were acting as counsel. You were not under oath.
No.
Let's say he was acting as a pro se litigant,
Pro se
so
litigant.
that the record's
Yes.
clear and there's not
Yes.
any
Yes,
confusion.
I
I think that's
apologize.
accurate.
Thank
That's
you.
what he was doing.
My mistake.
No. I just don't want there to be any confusion later. He was a
I-
pro se litigant who represented to the court that he was a former attorney.
Yes, ma'am.
Okay. First, let's go to 9:23.
Okay. All right. I am on page 923.
Strike that. I meant 922. I'm
Sleeping.
wearing non-prescription eyewear today. I apologize.
Good.
Yes, 922.
I see it.
The court in the middle of the page. Let's move along. You're basically beating a dead horse here. Their only obligation really is to show that they have the note, that the mortgage wasn't paid. They pretty much presented their case, and you're all over the place. You recall the court saying that to you?
I do.
And in your capacity as a pro se litigant, correct?
Yes, it was at this point that I was trying to discuss Act 6 requirements and also the charge-off issue, but it wasn't going well for me.
Okay, moving on to the next page, 923 at the top. You said, it sounds like there's nothing for me to say, so I'm making a record for appeal. Because it sounds like you've decided in your wisdom and as it is your right. And the court said, I have not decided yet, but you are not presenting any coherent. And then you interrupted the court and said, are you familiar with the Taggart decision? And the court once again said, you are not presenting a coherent defense. Are you familiar with the Taggart decision? You responded. So, would it be fair to say that you were not getting along with the judge that day?
Yes, and that comment about appeal is something I learned from Steve Usum at High Sports. I was really in a full attorney mode. I lacked common sense and exercised bad judgment in representing myself and being in attorney mode, as from time to time I've done in front of this.
Last question on this.
Yeah.
924. At the top of 924. Mr. Gallagher, I apologize, Your Honor, if an apology is not, well, it says if necessary, and the court, an apology is not necessary, but you need to comport yourself with appropriate behavior before the court, and you need to move along.
I remember that.
Okay.
Happy
So,
birthday, Terry. Again, happy birthday.
Mr. Gallagher, I'm gonna ask you a direct question. In your sworn
I didn't hear him
testimony
say that.
to that judge,
What?
did you lie?
Yes, sir.
Okay.
And I want to say that I presented myself in even tones and as a
I
witness.
asked you the question if you lied.
I did not lie.
All right.
Liar.
At the last reinstatement hearing, you were asked by counsel about your credit scores. Remember those questions?
I do.
Okay, it was pointed out to you that on April 8th, 2024, your credit score was 673, and on January 15, 2025, several days before our last hearing, I believe, it was 548. Remember that?
Actually, it was to Ms. Malavi, that was our expert. I remember our expert being asked that, yes.
Why do you think it dropped?
Because I filed for bankruptcy.
Okay. What's your score today?
In the range of 660?
All right. Let me, your sobriety date is when again?
April 25, 2017.
And when did you last violate the rules of professional conduct?
August 30, 2018.
Now, are you asking this panel to rely only on your word?
No, that date is based on the board decision. The committee found that I didn't violate on that date, but the board did, and in its wisdom, I accept that as a violation. August 30, 2018.
And that's the disciplinary board's decision?
Yes. Report and recommendations after my first hearing.
Okay. Turning now to the supplemental exhibits.
In multiple counties. If Sandy.
Sure.
Oh, yes, I'm sorry.
No.
Mr. Quinn, are these yours? Help us over here.
Yes.
Yours or theirs?
These are mine in a gray binder that I placed at everyone's table.
Okay.
Together with a trial brief, which is not. Commissioner's index and supplemental exhibits. And I think we've agreed.
Collectively, these are 10.
Collectively, these are this is exhibit 11. Let's start with pages 1 through 4.
Yes, sir.
Let's start with page 1. What is that?
It's my statement of net worth updated subsequent to the bankruptcy and getting a, all the documents from the IRS and using the values of my home I found on Zillow and Redfin on the date I prepared this.
And you signed it on what date?
February 26, 2025.
And is that information still true and correct?
Some question about whether there is a lien from 2013 by the Pennsylvania Department of Revenue. I couldn't find it, but I'm willing to say that it still exists for purposes, but otherwise it is, I don't have $1,000 cash because we paid the mortgage since then, but otherwise it is accurate as far as I know.
It's now a positive net worth.
I know, it's an amazing feeling.
Okay. Moving on to pages 5 through 18. What are they?
I filed my federal tax return on February 2, 2025, and that's it. Filed that through a software system I've been using the last few years, Tax USA.
And I note that on page the second page of the return, page 7, says you were entitled to a refund
Yes.
of $888.
Yes.
Have you ever been entitled prior to this year to a refund?
Oh, yeah, every year since, 2015 and every year in between 2018 and 2024, except for last year, because I got a big referral fee. So, yes, 5 or 6 times, and the evidence is in the record.
Okay. In the past, what happened to those refunds?
They were taken to pay past tax obligations.
All right. Now I'm going to direct your attention to page 19.
Yes, sir.
What does that represent?
That's a screenshot from my bank account, showing that the refund was deposited into our account, my account. Yeah.
So that money was received?
Yes.
Okay. Is it your, like that. Moving on to pages 21, 22. What is that?
So, so 21 and 22, by comparison to 20. So 20 is, so I went on the IRS website the other day. I go on there all the time just to see if there's any updated information. And the other day, they have a thing where you can check their refund status for the last 3 years. So 20 is 2024. It says at the top, your refund was sent to your bank on February 12th for direct deposit. 21 and 22 is the third year I could check because I wasn't entitled to a refund in 2023. And it says at the top, your refund has been applied to past IRS tax obligations. That's what that is.
Is it your understanding that as long as you owe the IRS money, you don't get a refund put in your bank account?
That is my understanding.
If you got one this time.
And that has been their practice. I did?
Yes. Okay, moving on to page 23 to 27.
Yes, sir.
What do we have here?
It's just time we filed my 2024 Pennsylvania 202440. I think it's
all right.
Yes, sir.
Now, I want to get to the beginning on page. That's Pennsylvania return.
25, we're saying?
It is, yes,
Okay, I'm lost. Okay.
first page is page 24.
Okay,
24, 25, and 6.
I see it.
and 7. Now we get to page 28.
Yes, sir.
What begins on page 28 and ends on page 30, Mr. Gallagher?
So 28 was something, and 29 and 30 is something we had at the first hearing. It was a certification of release of the federal tax liens from 08 and 09. They were the big ones, and we had them at our first hearing.
Okay.
Oddly enough, and I was really feeling down when I got home from our first hearing. I just didn't feel like I did a good job. But in my mail that day were certifications of release of all my other tax liens. So I knew my personal obligations had been released by the IRS, but they actually released the liens on my home as well. It turns out that they'll do that sometimes for people who file bankruptcy. Mr. Lord told me that the only way I could get the liens released in bankruptcy was to have a case within a case in the bankruptcy case. And I'm like, I don't want to do that. I'll live with the liens. They're going to expire someday, and I'll just keep paying the payment plan. Then I got these, and all the liens are gone. And it was these that prompted Kath to decide, well, I'm going to file for bankruptcy too, because
well, we'll get to that.
Yeah, okay, I'm sorry.
Let's talk about what
I'm sorry, let me take a simple word.
John, excuse me, Mr. Gallagher.
Yes, sir.
Okay, let's talk about, so from 28 to 30 is the 2008-2009 certification of release of liens from the IRS.
Yes, sir.
What's on pages 31 and 32?
That's a release of leads of 2011.
And 33 and 34?
It's a release of leads for 13 and 14.
And 35 and 36?
That's a release of liens for 18.
Okay, now. We get to now, page 37 and 38. What's that?
Well, I think this is the first example of me.
Identify what it is.
Oh, I'm sorry.
Lying.
It's a June 29, I'm sorry, it's a, what's the date of it?
Let's start with 37.
I'm sorry. Yeah, it's the release of a municipal lien that I had incurred back in 2014 during my addiction, one of the early vestiges of my problem. And the second page, it's September 7, 2017, the lien was satisfied.
And why did you ask?
I've played,
You know, I got clean in April 25.
I've played attorneys who've misbehaved in Pennsylvania in this very room before.
2017. And I think this is the earliest example I can find of me taking personal responsibility for the wreckage.
Oh, shut up.
Created for my addiction.
No, you didn't.
And reaching out to someone and having more money now that I wasn't using, and saying, how can I fix this?
He is saying how he is taking responsibility for what happened while he was addicted in the same breath that he just got, what, $200,000 of liens just forgiven? Is that what just happened? Yep, that's what happened.
Problem. This is the first problem I fixed after I got clean.
Okay, and then we,
The first problem he fixed.
Page 39.
Yes, sir.
39.
Yes.
Now, please explain to us.
Hey, Zach, guess what I'm recording right now?
Well, in simple terms, it's me satisfying an obligation to TD Bank that related to a business account that I overdrew during my addiction to the extent where it was closed. And this
Sir, come on. You just used addiction for the last excuse. It's time for the wife. Your wife did it. He needs help with his lies because he's not doing it right.
Me satisfying that obligation.
And what's the date?
April 13, 2018. This is within a couple days of me going into Acme and making the last deposit I ever made to IOLTA of earned funds. I felt terrible about that as I testified at my first hearing. And I said, you've got to change your life. Not doing drugs and alcohol, that's not enough. You need to address your life constructively.
Okay, and the next page 40.
Same day, again, right after I came out of Acme, probably with that money, I paid off Citizens Bank. So at my first hearing, I testified, and this is the snippet that appears about me, that I deposited money into IOLTA that day in Acme because I was overdrawn on my business accounts. But that wasn't accurate. It was partially accurate.
I do all the time.
I actually did it because I didn't have a
Take
business
those
account. And so I knew that more money was going to be coming in, and that if I wanted to live right, since I did that while I was being investigated, even though I'd been sober for nearly 9 months.
9
If
hours.
I wanted to live right, I needed a new business account. And I needed to get a new IOLTA account too. So Citizens and TD.
I already found the word.
I opened up a new business account on the 17th, as per the board's report and recommendation. I opened up a new IOLTA account, closed my old one, took my new IOLTA checkbook, and hired an accountant and dropped it off on May 1, 2018. It was a way of making sure that I was living right. And that was the last IOLTA violation. The day I intentionally went into Acme under investigation.
Last
and
one.
knowing it was wrong, deposited earned money into IOLTA because I didn't have an open business account.
Okay.
I didn't seek help. I
That's
could
the reason.
have, but I didn't. Thank you, I'm sorry.
The
Next yes or no question.
Discussion about your wife and why she did not join in your bankruptcy petition.
Yes, yes.
And you kind of exhausted that. But I know you may have already explained, since that filing of yours and since its conclusion, what, if any, action has your wife taken with respect to her debts?
Because I got suspended, my wife is changing her ways. She did all this. She's trying to live her life better every day.
My wife and I sleep in the same bed, and we did it together, and I just to go back to Mr. Venture's earlier question. But we talked about it, and we decided that although it would cost nearly $3,000, that she should go and see Bob Lohr, and Bob did the math and said, you're eligible, and so God willing, my wife will have her tax obligations discharged, and any others that she has. So she filed bankruptcy.
And so on pages 42 to 44 in our supplemental exhibit binder.
Yeah.
Is that her bankruptcy petition or notice, excuse me?
Yeah, and he filed it in a hurry, so that 44 shows all the stuff she had to provide, and because the date was critical for our earnings. So anyway, and she's done that. Yes, sir, that's what that is.
All right, getting back briefly to your credit score.
Yes.
Pages 45 and 46.
Right.
Can you talk about those, please?
Well, I just,
identify them.
I'm trying to obviously I'm trying to go back to the way I was for my 26 years of my legal career, and the first 30 years, and be responsible again. And so I check my credit score every day, and I have all these notices, and I got this notice saying it jumped up 98 points since February 15th. And this was probably like February 16th. And so, and then I'm like, well, let me check my other one, and that one was up 6. That one was down 3 points, but apparently it had also jumped 95 points recently. So I provided them to you, and I guess you provided them to Mr. Venture.
Okay. And there's been some questions to you about the timing of certain notices and revelation of your bankruptcy and other matters related to the bankruptcy to the Office of Disciplinary Counsel. I believe you were questioned on cross-examination at the last hearing with regard to how quickly you provide information, that when you receive it, you try to be diligent and you send a lot of documents to ODC.
And polite, I remember that term.
Yeah,
Yes,
okay.
sir.
And then there was, I believe, a question posed to you in the form of, there was an exception, and that was the fact that you filed a bankruptcy.
I don't need bad news every day.
Of 2024, and it was not received by ODC until November of 2024. Remember that?
Yes, August 30th. Yes, sir, I do.
Okay. Let me direct your attention to pages 48.
Tell him I'm sorry. We have. I'm tired.
A this document before today?
You sent it to me at the time.
Whoops, wrong one. 13 and a half. We have 13 and a half hours. We're a little over 11 and a half.
This is an email.
So an hour, 45 minutes.
November 25, 2024.
Okay. And from whom?
From you,
To whom?
Ms. Prevention.
Panel's permission, I'm going to read it.
This part one is an hour more. And then there's part two of this hearing. You shut up.
What?
You shut up, Fozzie. I already got it. You shut up.
Alleviating negative inference about any
I'm gonna start banning people.
role my client had in notifying your office of his bankruptcy filing and sharing some emails from John and his attorney, Robert Lord. And then the last paragraph, the so-called bottom line is that the timing falls directly on my decision, not John Gallagher's. And that any negative inference toward him, if any exists, is misplaced.
I'm gonna try to get through the next hour and a half without telling JK to shut up, but it's not looking good.
Like I do that, well, the other.
Shut up,
Bob filed on August 30, that's page 49. He was leaving, so he didn't actually send me the petition, it was Labor Day. And then he got it to me on Tuesday, September 3, at 9:05. And I was working at the tennis club, I don't know, but anyway, September 4 at 9:54, I sent you Bob's email, and I said, hey, I'll get you the petition shortly. And then page 51 is my email enclosing the petition to you.
I gotta work a double tomorrow.
Yes, it says September 8th, but I thought it was September 5th, but be that as it may, it was September 8th, that's what it says. That's when I delivered the petition. Oh, yeah, to you. And then 52 was the scheduling order that I sent to you on September 24th, which, and other things, which indicated, among other things, that the trustee was not going to conduct his hearing, I think, until October 12th, and that was fundamental as to whether the petition was going to go forward. But in any event, that's what those documents are.
Give me a moment, please.
Three days ago, I started an event in a video game. And I was in like third place. The event ended about 20 minutes ago, 10 minutes ago, something like that. And I had to keep at 25th place. I had to keep, I couldn't go below 25th place. But since I started this stream, I dropped to 30th place. So while these lawyers are going on, I was frantically trying to get my spot back in this event that I've been working 3 days on, which is why I kept looking at my phone. It ended 24th place. Woo! I did it. I'm so proud of myself.
To the best of your knowledge, did Mr. Lohr also explain to the Office of Disciplinary Counsel, or were they provided with a copy of Mr. Lohr's explanation to the bank?
Oh, I require two at least, please.
Pending the reinstatement was not included?
I was very grateful for that, and they were advised immediately.
And Mr. Lohr, to summarize, said that it was inadvertently left off by him?
Yes, that is what he said.
The TPP application.
Yes.
Referenced during cross-examination. There was a box that you checked off having to do with what you referred to today as your second mortgage. Is that what FDC is?
Oh, the bankruptcy petition? Oh, yeah, that's what FTC is. Yeah, apparently, I never heard of FTC really before today.
Okay.
Granted, I should have probably read it, and maybe I did, but I haven't.
He's such a
That's
liar.
what
Oh my
FTC
God.
is, That's the amount.
Okay, the 45,000, give or take. Okay, and you were questioned about whether you believe you owed that money after it was written off, and you had said that you did not think that it was a debt, yet you included it on your 2017 and 2018 bankruptcy petitions. Did
Yes.
you not? How did that occur?
The lawyer pulls. They have a special credit thing they go to, and if it's on your credit report, it goes on there as a debtor. And it said that it had last been active in 2013, and it's on there for 7 years. So he says it has to go on there. It goes on there. I don't remember the conversation about it,
Okay.
but that's the answer.
Okay, so you took the advice of bankruptcy counsel?
If it even came up as a discussion point, yes, I did, of course. Yes. Yes, I never handled a bankruptcy.
That did not change your opinion as to your feelings as to what a write-off meant?
No, it did not. I knew it was so.
Fozzie. Do you know what would end my YouTube career in a minute flat? Me getting lit on a 13-hour stream. Because the filter goes away. Like, completely goes away. And that would be the end of my channel. Canceled.
On my credit report, and I understood why it would be on the petition to that regard, but it did not
But it would
change
be
my
fun.
understanding in between 2014 and 2019 that I did not owe that money anymore.
There was also some reference made as to whether or not your wife worked for you.
Yes.
And did you and or your wife keep records of her work? She did.
I probably have to this day 100 little composition books or whatever, and so I'd write on the front of them, 9/1/15 through, whenever they got filled up, and then I would grab another one and we'd do that again, red, green, yellow, whatever.
Okay.
We didn't use computers.
If the panel pleases, I'd like to just consult with counsel for ODC.
What color pen did you use? Lefty or right?
Pardon me? Well, if we're going to take the same position that she's an employee or. Okay. All right, after this, I wanted to make sure that there was no allegation that Mr. Gallagher's wife was not a legitimate employee who performed services, because I've got this and reams more of timesheets, that I don't want to clutter the record.
Thank you. Can you give us the time period?
Well,
Just the year?
2020,
I think the months are on there. She always would date the first page, so
12/7/20, 2/17/21. Another one, 6/17/20.
those are the start dates.
Yeah.
2021?
It's 20, and into 2021 as well, early 2021.
How about 22?
2022, I don't have them here.
No, there are none. They end on February 21, 2021. I was, sorry.
No.
That was not, didn't come out the way I wanted.
That's fine. No, I appreciate just in taking it in turn so that rather than just having to go through the list of documents.
Well, we're not gonna, as I said, I'm not gonna clutter the record.
Right, but so the last time that she is, Mr. Gallagher's wife is a attorney, is working for him as an attorney is February of 2021. Is that right?
Yeah, those are February 17th. There's probably.
But that's not a 13-hour stream. I won't get lit on a 2-hour stream.
There's a lot of those. There was a lot going on between the 17th and the 21st to become compliant. With my suspension order, there's a lot there. Calling courts all over the country, making sure files were transferred.
Okay.
Did your wife assist you in sending out the notices required by rules of disciplinary and conduct law?
I prepared all of them. I would never trust anyone else to do that, but yes, she did, and also confirming. You needed acknowledgement from the